अच्छा चलिए ठीक है, let's start. Okay, so yesterday we were taking a look at what is known as the, what you can say, procedure under the anti-defection law. ठीक है, ये हमने कल पूरा समझ लिया था that how do you create a procedure under the anti-defection law. And before completing this part, before we were taking a look at the procedure under the anti-defection law, we have seen how, for example, there are certain aspects of the anti-defection law where you go from what you can say, what is known as the 10th schedule. You have the 10th schedule of the constitution, and the 10th schedule of the constitution is dealing with, for example, paragraph 1, which deals with the definition, paragraph 2, which deals with the grounds of defection, right? Paragraph 3, which used to deal with split, but there is no such thing as split in the anti-defection law anymore. Paragraph 3 had the concept of split. Paragraph 4 had the concept of what you can call merger. Paragraph 5 we have not covered, it is not important. Paragraph 6 we have the power of the speaker, and correspondingly with paragraph 7 we have what are known as the, with paragraph 7 we have the, what you can say, Quixote Holohorn case, which had declared that the ouster of judiciary from the, what you can say, the ouster of judiciary from the possibility of taking a review upon the decisions of the speaker is unconstitutional, right? So that's what basically was given in the Quixote Holohorn case by the Supreme Court of India, in which the paragraph 7 was struck down. Right? Okay. Are we clear about this class? The anti-defection law. And then applying the anti-defection law, we had taken a look at the Maharashtra Legislative Assembly case yesterday. Right? Clear? Take. Now, when I'm taking a look at, for example, this part, do we have any questions from the Maharashtra Legislative Assembly case yesterday we discussed, class? इसमें आपके कोई questions हैं? Any questions you have in this part, class? If you have it, tell me now. Okay. What is the difference between a legislature party and political party? अच्छे से मैंने कल समझाया था पहले. Class, I dealt with this very deeply yesterday. The difference between a legislature party and a political party. When we take a look at, for example, in the context of what is a legislature party is that what you can understand as a legislature party, it means that the number of members from a political party who form the members of a house are known as the legislature party. ठीक है, आप एक बार उस लेक्चर में वापस जाइए, आपके पास वीडियो होगा, वहां पे मैंने बहुत अच्छे से एक्सप्लेन किया था कि लेजिस्लेचर पार्टी और पॉलिटिकल पार्टी के बीच में क्या डिफरेंस है. Vidhi, earlier BJP didn't accept any member from MBA as CM, then why later accepted Eknath Shinde? If before leaving to Guwahati, Eknath Shinde faction had obtained the proof as the real Shiv Sena, then the merger can't be challenged as defection. Earlier BJP didn't accept any member from MBA as CM, then why later accept Eknath Shinde? Because Eknath Shinde is making BJP come into power, right? And Eknath Shinde is ideologically and politically inclined towards the policies of the BJP. It is more like the BJP within its understanding. So, वो तो political point है ना कि Eknath Shinde is more. Even yesterday only, Amit Shah was in a rally somewhere in Maharashtra, yeah, Nanded. You see, just let me show you this particular thing that is happening politically here. So Amit Shah was in Nanded yesterday. You can see that this is the political convention in which he's a participant. Take a look at this part. Seeing all of this, I think you should be able to understand and see the politics of what is happening in the background over here, right? Take a look at this, please. Now take a look at this part. Do you see the point which is happening here internally in a political sense? Right? This is basically the answer to the question that you're asking. Since a speaker has to decide on the disqualification of 36 MLAs as on 21st June, now speaker disqualifies them since they went to the ECI and proved their legislature majority on post 20. So logically, original Shiv Sena couldn't be that of Eknath Shinde. No, see, that's the point. That's a good question. And as I will explain to you as a concept in this sense, when we have to ask the question, who is the original Shiv Sena? When we ask the question, who is the original Shiv Sena? Okay, if we take a look at a question like this, then the answer is a kind of a duality. For the purposes of anti-defection law the decision has to be made by the speaker. Okay, do we understand? For the purposes of anti-defection law, the decision as to who is the real Shiv Sena has to be made by the speaker. And for the purposes of, let's say, for the purposes of elections, and control of the political party, for the purposes of election and the control of the political party, the decision has to be made by the Election Commission of India. This is basically how we can answer it. So जहां तक एंटी डिफेक्शन लॉ प्रोसीडिंग्स की बात है, वहां पर एंटी डिफेक्शन लॉ का क्वेश्चन अगर पूछा जाएगा तो द डिसीजन हैज टू बी गिवन बाय द स्पीकर. दैट इज व्हाई द क्वेश्चन व्हिच इज प्रेजेंटेड बिफोर द स्पीकर is who was the original Shiv Sena or the real Shiv Sena on the date of what you call alleged defection. तो जो डेट है ना जून 21, इस दिन को डिस्क्वालिफिकेशन प्रोसीडिंग्स के संदर्भ में स्पीकर की पावर है डिसाइड करने की. स्पीकर की पावर इस चीज में आती है पैराग्राफ 6 में, एज आई हैव ऑलरेडी टोल्ड यू दैट पैराग्राफ 6 में यू हैव व्हाट वी कैन कॉल एज द quasi judicial powers of the speaker. मतलब in this sense the speaker is exercising certain judicial powers. Okay, मतलब it has a kind of a tribunal like activity. और यहाँ पे हमारी जो पावर्स आती हैं इलेक्शन कमीशन ऑफ इंडिया की, वो हमने कल देखा था कि यू हैव द इलेक्शन सिंबल्स ऑर्डर 1968, ये वाला जो रूल बुक है, इसमें इलेक्शन कमीशन ऑफ इंडिया की पावर आती है टू डिसाइड बिटवीन द कंटेस्टिंग व्हाट यू कैन कंटेस्टिंग क्लेम्स अपॉन अ पर्टिकुलर पॉलिटिकल पार्टी. जो एक पॉलिटिकल पार्टी के कंटेस्टिंग क्लेम्स के बीच में जो मतलब डिफरेंसेस होते हैं, उनके ऊपर जो बात होती है, दैट इज गोइंग टू बी गिवन आउट दैट है. तो वाई 38(6) की जगह 30 होते तो क्यों डिफेक्शन का क्वेश्चन नहीं आता? क्यों होता है ऐसा 30? आप जो कह रहे हैं ऐसा क्यों? व्हाट इज योर रीजनिंग फॉर दिस? ठीक है, स्प्लिट को क्यों हटा दिया? क्योंकि बेटा स्प्लिट इज, आपको दिख रहा है ना साफ साफ कि स्प्लिट से तो कुछ भी हो सकता है. मतलब स्प्लिट से तो हॉर्स ट्रेडिंग बिल्कुल इंस्टीट्यूशनलाइज हो जाएगी. स्प्लिट क्या कहता है कि अगर आपके पास 1/3 मेंबर्स हैं किसी भी तरह से, तो आप उन 1/3 मेंबर्स को लेके बाहर निकल सकते हो और पॉलिटिकल पार्टी को स्प्लिट कर सकते हो. 1/3, अब मान के चलो कि कोई एक पॉलिटिकल पार्टी है जिसके कि 6 मेंबर है ना. अब 6 में से अगर 4 चले गए तो पॉलिटिकल पार्टी टूट गई, है ना. तो मतलब दिस काइंड ऑफ बड़ी पॉलिटिकल पार्टी जो होती है, जिनके मान के चलो कोई बड़ी पॉलिटिकल पार्टी है जिसके 43 मेंबर है, और अगर कोई छोटी पॉलिटिकल पार्टी है जिसके 6 मेंबर है, तो बड़ी पॉलिटिकल पार्टी अपने अंदर 4 मेंबर और इंक्लूड करने के लिए यहाँ पे हॉर्स ट्रेडिंग कर सकती है ना स्प्लिट के माध्यम से. इट वाज इनफैक्ट द अटल बिहारी वाजपेयी गवर्नमेंट ओनली व्हिच हैड रिमूव्ड द कांसेप्ट ऑफ स्प्लिट इन 2003. अटल बिहारी वाजपेयी जी की सरकार थी जिसने स्प्लिट को हटाया था वहां से. ठीक है, चलिए अब मैं आज एक करंट अपडेट उठा के ख़त्म करना चाहता हूँ थोड़ा सा, जिसमें कि इनफैक्ट पहले पार्ट में 2 छोटे छोटे करंट अपडेट्स हैं जो इस बार थोड़े से इंपॉर्टेंट रहे हैं, which I feel are going to be relevant for the perspective of the prelims examination. First is the concept of tribunals. ट्राइब्यूनल्स का जो एक मतलब सेक्शन है, द सब्जेक्ट ऑफ ट्राइब्यूनल्स. हाँ, पर ये मर्जर थोड़ी कर रहे हैं. अगर 2/3 कर भी लेंगे तो यहाँ मर्जर नहीं किया ना इन लोगों ने. देखिए मैं भाई तो बता रहा हूँ आपको, दे हैव नॉट मर्ज्ड इनटू द भारतीय जनता पार्टी येट. दे हैव ओनली डिक्लेयर्ड द, मतलब व्हेन दे वर डूइंग इट, जब ये लोग गुवाहाटी में थे तब इन्होंने भारतीय जनता पार्टी के अंदर मर्जर नहीं किया था. दे वर ओनली लुकिंग एट द व्हाट यू कैन से the activities which were done in that sense. Okay, तो इसको हम merger नहीं कहेंगे. ठीक है. Now take a look at this tribunals. Now when we are taking a look at tribunals, I'll let's say for example divide it into two parts, क्योंकि इस पे काफ़ी सारे करंट अपडेट्स हैं. सुप्रीम कोर्ट के 2-3 जजमेंट्स भी हैं और कुछ लैंडमार्क जजमेंट्स भी हैं जो हम कर सकते हैं इस चीज़ को लेके. तो when we take a look at tribunals, if we let's say for example take the understanding of the static portion of tribunals, this is a part which has been very much in news this time. If you take a look at the static portion of tribunals, then the first thing that we can understand in tribunals is the 42nd Constitution Amendment Act 1976. Now you know for a fact that in India the Indian Constitution Amendment 42nd Constitution Amendment Act 1976. This was the most major amendment to the Constitution of India, and in this amendment you had introduced Article 323A and 323B. Article 323A and Article 323B were inserted in the Constitution by this particular amendment, and it is these articles that in a way created the concept of tribunals, right? So we are going to take a look at meaning the institution of tribunals in the Constitution. How does it happen? We are going to take a look at the institution of tribunals in the Constitution as to how does it happen, and then we are going to in a way just reflect upon the concept of what is known as a quasi-judicial body. Okay, just take a little bit of a reference within the Constitution as to what is known as a quasi-judicial body. What is a quasi-judicial body is what we try to understand in this particular sense. Okay, then we take a look at the constitutional positions constitutional positions and landmark judgment, constitutional issues and landmark judgments with relation to what are known as tribunals. ठीक है, क्योंकि ट्राइब्यूनल इस बार थोड़ा सा न्यूज में रहा है. The reason why the tribunals has been in news is for one particular reason, that is the Tribunal Reforms Act 2021 and the challenge to the Tribunal Reforms Act, the constitutional challenge. This is a law passed by the Parliament in 2021, and currently the Tribunal Reforms Act आज के समय में ट्राइब्यूनल रिफॉर्म्स एक्ट है वो इट इज सब्जेक्टेड टू व्हाट यू कैन कॉल जुडिशियल रिव्यू with the Supreme Court of India. ठीक है, तो this kind of a case is pending over here. This is a case which is pending today in the Supreme Court. Okay, so there we'll take a look at this particular part. इसका एक synopsis बना दीजिए. हाँ, मराठा ओबीसी का है. हाँ ठीक है, अभी इस ब्रेक के अगले वाले सेशन में विल टेक अ लुक एट द मराठा ओबीसी. एक बार मुझे ये खत्म करने दीजिए, छोटा सा टॉपिक है, जल्दी खत्म हो जाएगा ये. एक बार इसका आप साइनॉप्सिस बना लीजिए. इसमें से वी आर एक्सपेक्टिंग maybe a question or two this time in the prelims examination because of this part having been in the current affair quite prominently. Now, as I have told you, even in the classes which preceded today, that our objective is to ensure that we are able to do those parts of the constitution which are relevant from the perspective of the prelims examination this time. ठीक है, जो भी हमको लगता है कि प्रीलिम्स की एग्जामिनेशन के हिसाब से जो चीज़ें रेलेवेंट है इस बार के लिए, हम उन पे थोड़ा सा फोकस करना चाह रहे हैं. वी आर ट्राइंग टू गिव अ लिटिल बिट ऑफ फोकस अपॉन द questions which can come directly or indirectly in the prelims examination this time, and therefore we are going to focus upon the current updates which have appeared on the subject of tribunals, and also correspondingly how the, what you can say, the static portion of the subject of tribunals relate to these parts. ठीक है, तो कोशिश करते हैं कि कुछ कुछ डिटेल इसमें इस तरह से निकाल लें जिससे कि आपका रिवीजन ट्राइब्यूनल्स के बारे में पूरी तरह से हो जाए. ठीक है, this is the law that we're dealing with, ट्राइब्यूनल रिफॉर्म्स एक्ट 2021. ठीक है, इसको हम ट्राइब्यूनल रिफॉर्म्स एक्ट कहते हैं और इसमें काफ़ी कुछ गतिविधियां हुई हैं, और उसी के साथ साथ we will take a look at this judgment of the Supreme Court which is pending, which is known as the Madras Bar Association versus Union of India. The court will decide whether the Tribunal Reforms Act 2021 is unconstitutional for reenacting provisions that were struck down in the Madras Bar Association, etc., etc. It's a 3-judge bench which is going to come up very soon in the, matters which are to be decided by the Supreme Court. This is currently pending in the Supreme Court, and we will take a look at how this particular activity is being dealt with properly. ठीक है, all right. अच्छा, ठीक है. Now my request to you at this point of time would be that I want to make this session as open as and as transparent in terms of coverage possible. If, for example, you feel that there are going to be certain parts, let's say if you feel that there are going to be certain parts according to current updates that you want me to cover, you can put them in the chat box. ठीक है, अगर आप जैसे आपने बोला फॉरेस्ट एक्ट, ठीक है, so what I'll do is I'll take a review of whatever you are saying in current updates, ठीक है, and allot 1 or 2 sessions specially to cover all those parts of the current updates which you think are prominently important according to your own understanding, which may not be in my list, but if you think those are important, if you want a coverage on them, you want a kind of a revision on them, I'll dedicate a couple of sessions specially to covering those parts. ठीक है, तो अगर आपको लगता है, मुझे तो जो लगता है मेरे हिसाब से whatever my reading of the UPSC is and how I have seen the previous year question papers etc etc, तो उसके हिसाब से मैं तो अपने हिसाब से वो करा रहा हूँ जो मुझे अच्छा इंपॉर्टेंट लगता है सारा, जहाँ करंट अपडेट और स्टैटिक पोर्शन का अच्छा मिक्स है, वहीं से क्वेश्चंस आते हैं. अगर आपको लगता है कि कुछ कुछ चीज़ें हैं जो कि मुझे आपको समझानी है, आपको थोड़ा सा अच्छा लगेगा अगर आपको रिवाइज करनी है, करंट में है, स्टैटिक में है, डायनेमिक में है, तो आप वो मुझे टैट में लिख के दे दीजिए, और उसमें से फिर मैं एक बार रिव्यू करके डिसाइड कर लूंगा कि व्हाट ऑल वी कैन टेक अ लुक एट. ठीक है, तो जैसे आपने सजेशन दिया फॉरेस्ट एक्ट का, ठीक है, आई कैन इनकॉर्पोरेट इट. So if you have any activities around that, please let me know. I'll be happy to make a special session on those things with things so that you feel that these things can also be done according to what your understanding is. हाँ, तो आप लिख दीजिए कि किस किस, आप यहाँ चैट बॉक्स में डाल के दे दीजिए, मैं उसको फिर एक बार रिव्यू करा लूँगा कि किस किस तरह से हम सारी चीज़ें कर सकते हैं. ठीक है, that's I think a fair approach to making it a kind of a interactive mode of how do we want to do this kind of an activity. ठीक है, तो मेरा जो करंट अपडेट में अभी द करंट अपडेट दैट आई एम ट्राइंग टू in a way decide today is Tribunal Reforms Act 2021 is unconstitutional. मतलब this is a claim, judgment pending है, लेकिन claim ये मिला हुआ है कि Tribunal Reforms Act है that is unconstitutional. और इसके सेंटर में the central question at the core of this issue is that of the quasi-judicial body. What is the nature of a quasi-judicial body basically, and how does a quasi-judicial body function in a way that it can create some kind of a activity in this regard. ठीक है? I think effect of dissolution of house on lapsing of bills. ठीक है, good. Parliamentary proceedings, especially all types of motions. Okay. मतलब you mean the budgetary motions, the cut motion and everything. ठीक है, ठीक है. All the bills in parliament. ठीक है, आप सारा इसमें लिख के दे दीजिए मुझे. I will sit with this list after the class and I will select the ones that I want to feel that we can discuss it together in the classroom. आप लिख दीजिए जो भी आपको लग रहा है important है, यहाँ लिख दीजिए. चलिए, अब समझिए ट्राइब्यूनल्स का. थोड़ा सा दिमाग अब फोकस करिए इस चीज में. हाँ, फीटस वाला जजमेंट करेंगे. यस, हम एक बार थोड़ा सा जो मैं हायरार्की मेरे दिमाग में है उसी हिसाब से एग्जीक्यूट करेंगे. वो फीटस वाला जजमेंट तो मैंने पहले ही बोला था. कौन उसका जो द rights of fetals under Article 21 of the Constitution, that we'll take a look at. Election Commission Act, हाँ, Election Commission Act करना important है. ठीक है. CBI और ED वह कैसे इतना तो prelims के लिए important. हाँ, ED कर सकते हैं. हाँ, we can do a Prevention of Money Laundering Act also. Digital Personal Data Protection Act, हाँ ठीक है, ये वाला कर सकते हैं. Telecommunication Act. ठीक है, ठीक है, लिखिए आप जो भी आपको लग रहा है आप लिख दीजिए. फिर उसके बाद मैं फाइनल करूंगा इस लिस्ट में से क्या क्या निकाल के डाल सकते हैं. अब देखिए ट्राइब्यूनल्स के बारे में अगर हम बात करते हैं. इफ यू टेक अ लुक एट द कॉन्सेप्ट ऑफ व्हाट इज नोन एज ए ट्राइब्यूनल, if you want to understand what is the what you can call the reference and the understanding of the concept of tribunals. ठीक है, tribunals के बारे में I am going to write us let's say kind of a set of basic facts. ठीक है, थोड़ा सा इसको नोट करिएगा. प्रीलिम्स में इस पे डायरेक्ट क्वेश्चन आ सकते हैं. मैं आपको इसीलिए करा रहा हूं क्योंकि सुप्रीम कोर्ट के सामने एक कॉन्स्टिट्यूशन क्वेश्चन इन्वॉल्व है ऑन द वैलिडिटी ऑफ द ट्राइब्यूनल रिफॉर्म्स एक्ट 2021. 2021 में ट्राइब्यूनल रिफॉर्म्स एक्ट लगाया गया था पार्लियामेंट के द्वारा, और इसी ट्राइब्यूनल रिफॉर्म्स एक्ट में सुप्रीम कोर्ट का जो जजमेंट है वो पेंडिंग है कि ये कॉन्स्टिट्यूशनल है कि अनकॉन्स्टिट्यूशनल है. तो इसीलिए आई एम फोकसिंग अपॉन द ट्राइब्यूनल्स स्लाइटली मोर स्पेसिफिकली. ठीक है, क्वासी जुडिशियल बॉडीज में आपका ये आता है, तो ध्यान से देखिएगा. Certain basic facts about the tribunals in India. Number one, the tribunals were not mentioned. Tribunals were not mentioned anywhere in the original Constitution of India. इन द ओरिजिनल कॉन्स्टिट्यूशन ऑफ इंडिया. तो मतलब जो भारत की जो ओरिजिनल कॉन्स्टिट्यूशन है उसमें कहीं पर भी ट्राइब्यूनल्स का कोई भी मेंशन नहीं था. देयर वाज नो मेंशन ऑफ ट्राइब्यूनल्स इन द ओरिजिनल कॉन्स्टिट्यूशन ऑफ इंडिया. राइट, मतलब जो कॉन्सेप्ट है ट्राइब्यूनल का वो बिल्कुल भी भारत के ओरिजिनल संविधान में नहीं था. द ओनली जुडिशियल बॉडीज, the only judicial bodies that were mentioned were the courts of law. ठीक है, जो एक जुडिशियल बॉडी थी जो मेंशन करी गई थी वो कोर्ट्स ऑफ लॉ था. आर्टिकल 370 and 35. एक्सेलेंट. पार्लियामेंट्री प्रिविलेजेस, महुआ मोइत्रा का जो केस है वो. ठीक है, रोल ऑफ गवर्नर रिसेंटली, यस, तमिलनाडु में जो वाली बात हो रही थी. गुड. मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी. गुड, डालिए आप इसमें लिखिए. आई एम गोइंग टू टेक अ लुक एट इट प्रॉपर्ली नाउ. So this is, I'm just doing this in a kind of a multiple choice question format for you. Okay, in a kind of a MCQ format, I'm taking a look at this part. when we are taking a look at what is known as the questions around tribunals, you have point number one: tribunals were not mentioned anywhere in the original constitution. The only judicial bodies that were mentioned were the courts of law. Courts of law meaning your Supreme Court, High Court, District Courts and Subordinate Courts. तो ये जो आपका कोर्ट्स का जो पूरा स्ट्रक्चर है वो इस तरह से क्रिएट हुआ था, लेकिन किसी भी प्रकार की जुडिशियल जो भी जुडिशियल फंक्शंस थे या जुडिशियल पावर्स थे किसी भी प्रकार के, वो ट्राइब्यूनल्स तरह की किसी बॉडी को नहीं दिए गए थे, वो सारे के सारे कोर्ट को ही दिए गए थे. देयर वर नो जुडिशियल फंक्शंस व्हिच वर गिवन टू ट्राइब्यूनल लाइक बॉडी. दे वर ओनली गिवन टू what you call the Supreme Court, High Court and the what you can call the lower courts and the subordinate courts. Now it was the Swaran Singh committee. It was the Swaran Singh committee which was a committee which had given what you can say the recommendation for the 42nd Constitution Amendment Act 1976 that suggested the creation of tribunals It was a Swaran Singh committee that suggested the creation of tribunals as alternate judicial bodies. Or what are also known as the substitute judicial bodies. Swaran Singh committee suggested the creation of tribunals as alternate judicial bodies, or what you can call the substitute judicial bodies, okay, that were composed of expert members who would decide the matters to deal with the rising pendency of cases in Indian courts. To deal with the rising pendency of cases in the Indian courts. ठीक है, ध्यान से इसको देखते रहिए. अगर आपके पास थोड़ा उसमें if you have a copy and a pen with you, please note these down. I'm giving you certain basic facts about a tribunal which can come as a multiple choice question directly. Okay, so if you can just take a look at this part. Tribunals were not mentioned anywhere in the original Constitution of India. The only judicial bodies that were mentioned were the courts of law. The Swaran Singh committee suggested the creation of tribunals as alternate judicial bodies, substitute judicial bodies, that were composed of expert members who would decide the matters to deal with the rising pendency of cases in the courts in India. Right? Okay. Now take a look at the third one. The recommendations of the Swaran Singh committee were enforced in the 42nd Constitution Amendment Act 1976, which inserted Article 323A and 323B in the tribunals in the constitution, creating the provision for administrative and other tribunals. ठीक है, देखिए जरा, just a brief history of what we are trying to say over here. Please take a look at this clearly, class. A kind of a historical background upon the tribunals which may be asked as a question in the prelims examination. तो मैं बिल्कुल उसी तरह से लिख रहा हूँ जिस तरह से कि आपके मल्टीपल चॉइस क्वेश्चंस आ सकते हैं. Okay, the way that your multiple choice questions may be formed, exactly in that sense I'm laying out the, what you can say, the description of the questions around tribunals. Okay, have you taken this down? Okay, okay, I'll just wait 1 minute till you take it down. Okay, let's take another question after this. When we talk about the next point here, let's say we write something like this. The provisions of tribunals इसको ध्यान से समझिएगा. The provisions of tribunals under Article 323A and 323B have the following features. Okay, first important feature which is there within the tribunals is that only the parliament by law, which means by a simple majority, can establish a tribunal. Class, I'm doing it all in a multiple choice question format. Okay, only a parliament by law, which is by simple majority, can establish a tribunal. Only a parliament by law by a simple majority can establish a tribunal. Okay, which means, for example, that the state legislatures, in fact, let's say, let me be a little more clear about it, can establish an administrative tribunal. Just take a look at the sentence. Only the parliament by law, which is through simple majority, can establish an administrative tribunal under Article 323A of the Constitution. Okay? So I'm going to take you through the Constitution over here. If you take a look at Article 323A of the Constitution, Article 323A talks about administrative tribunals, and to set up what are known as administrative tribunals, the power which has been given to set up an administrative tribunal is only given to the parliament. Right? So, for example, if a statement is made like this, I hope you can take a look at it. Article 323A of the Constitution. This is part 14A of the Constitution. This was inserted in the Constitution by the first Constitution Amendment Act 1976, made by the Indira Gandhi government, and it was then uh, done on the recommendations of the what you can call the Swaran Singh Committee. And Article 323A talks about what are known as administrative tribunals. And what Article 323A states is that administrative tribunals can be set up only by the parliament. So parliament may by law provide for the adjudication or trial of by administrative tribunals of disputes and complaints with respect to recruitment and conditions of services of persons appointed to public services and posts in connection with the affairs of union or of any state or of any local or other authority within the territory of India. Right? So any kind of an administrative matters which are, for example, presented, let's say for example, if I am let's say a police officer working for the state government of Haryana, and let's say for example, after retirement my pension has been not delivered to me. If I have to take up the matter that my pension is not coming to me to a court, then it has to be taken to an administrative tribunal. Okay, do you understand the point? Administrative tribunal instituted under Article 323A, the question that we are taking a look at means that the administrative tribunals are the bodies which are going to have the judicial functions to look at all the matters which are dealing with what you can say services. So for example, you have the public services, the state services, the union services, and all of that. So all the matters which are with regard to any kind of an activity which is taken up by a particular government office, those matters are going to be dealt by as administrative tribunals, and such administrative tribunals can be set up by the parliament by making a law through a simple majority. Simple majority as it is given under Article 100. You see the point? Okay. So, as an understanding of this, we can write that state governments or state legislatures cannot set up administrative tribunals. I hope you get a point of this clearly. State legislatures cannot set up administrative tribunals. Okay. Then just related to this point again, because administrative tribunals are in question this time also with the current updates, we can say that the Tribunal Reforms Act, sorry, I'll come to this later. Let's say the Administrative Tribunals Act 1985. Okay, please take a look at this very clearly and concurrently. It is the Administrative Tribunals Act 1985. Administrative Tribunals Act 1985, which was the first act to establish a tribunal. First time a tribunal was established. Okay, it is the Administrative Tribunals Act 1985 was the first time a tribunal was established, and the name of the tribunal was Central Administrative Tribunal, the CAT. Central Administrative Tribunal, CAT, as we know it. So this was the first tribunal which was instituted in independent India, and this first tribunal was instituted by a law made by the Parliament known as the Administrative Tribunals Act 1985. Okay, so again, I want to be very clear about this historical background, and all of these statements I'm writing as if they were coming as sentences in your multiple choice questions directly. So any of these details are specifically intentioned to make sure that you are able to attempt the multiple choice questions which may come in the examination, right, about tribunals. And the reason why I'm focusing upon that intently is because tribunals are a part of your current affairs this time, because the Tribunal Reforms Act and the judicial review which is pending before the Supreme Court on these particular matters. Okay, so if you take a look at this particular aspect, if we say, let's say, tribunals were not present in the initial part of the constitution at all. The original constitution did not have the concept of tribunal at all. In fact, there was nothing like a tribunal mentioned inside the constitution until 1976 Constitution Amendment Act inserted the concept of a tribunal. Now, basically, the history of this is slightly, what you can say, interesting. Tribunals were created as alternate judicial bodies or substitute to courts. So the idea was that by the time 1950s, 1960s, it was appearing to everyone that the rising pendency in the judicial bodies, the rising pendency of cases in the judicial bodies, which is the Supreme Court and the High Court and the lower courts, the rising amount of cases which are meaning which are not solved, which are pending, which are not disposed by the Supreme Court and the High Court, that is in a way telling that there are certain administrative or certain constitutional provisions that need to be made to make sure that the pendency of cases is not so high. Okay, and it was a Swaran Singh committee report which for the first time mentioned very heavily and pressingly that we have to create bodies which are expert oriented. So for example, if a judge of a Supreme Court is taking a look at a matter with relating to technology, right, so for example, electricity laws are being taken up by a judge of the Supreme Court. If electricity laws are being taken up by a judge of the Supreme Court, then the judge of the Supreme Court, of course, is very well read in law and constitution and jurisprudence and contract and everything. But the Supreme Court judge may not understand very clearly how electricity works, what is the science and mechanics of electricity, etc., etc. So the recommendation of the Swaran Singh committee report was to create bodies which are dedicated and created of experts. These are supposed to be bodies which are dedicatedly to be created of experts, and these bodies need to not only have lawyers and judges but also have people who come from the domain. For example, electrical engineers should sit upon electricity tribunals so that they can understand the matter properly, more scientifically, more academically, better than only a set of lawyers and judges. And this gave rise to what is known as a demand for creating a alternate judicial body which would be created of experts, known as a tribunal. Now, this what you can say social and this kind what you can say social and political, this social reasoning with regard to tribunals later translated into a political reasoning also in 1970s, because you see the 1970s were fraught in one sense that you had the division between the judiciary and the parliament very severely, right? So it was very clearly in the 1970s known as the parliament versus the judiciary. Okay, and the parliament versus judiciary kind of a war what's most prominently seen in things like these. You had the Golaknath case, and as a return of Golaknath case, the Parliament had done the 24th and 25th Constitution Amendment Act, right? Then you have the, let's say for example, from the Golaknath case, you have the Keshwananda Bharati case, and also there was a Allahabad High Court judgment in Indira Nehru Gandhi versus Raj Narayan. Okay, and as a response to this, the Parliament did the 42nd Constitution Amendment Act 1976. तो ये जो पार्लियामेंट और जो सुप्रीम कोर्ट के बीच में बहुत घमासान मची हुई थी 1970 के दशक में, ये इसका एक पॉलिटिकल बैकग्राउंड भी क्रिएट करती है, क्योंकि जब फॉर एग्जांपल सुप्रीम कोर्ट ने गोलकनाथ केस में, when the Supreme Court in the Golaknath judgment had curbed the powers of the Parliament to amend the Constitution, and then in the Keshwananda Bharati judgment, the Supreme Court had declared that there is a basic structure of the Constitution, which means that the power of the Parliament to amend the Constitution are going to be limited or restricted by the Supreme Court by subject to judicial review. And in Indira Gandhi versus Raj Narayan, Allahabad High Court had actually declared the election of Indira Gandhi to the Rai Bareli constituency as illegal, and in a way said that the Indira Gandhi shall be convicted and she shall be disqualified from contesting elections for the next 6 years. In these cases, it was very clearly seen that Indira Gandhi, and especially the government of Indira Gandhi and the Parliament of Indian National Congress at that time, had taken a very clear view that the, what you can say, the judgments which are given by the Supreme Court and the High Court are against public conscience, against public will, against the will of the people represented by the Parliament. So they had got, the government and the Parliament had become very impatient with the powers that were being exercised by the Supreme Court and the High Court. And in fact, if you know anything about this particular part, in the 42nd Constitution Amendment Act, there were many amendments which were made, which were directly an attack upon the power of the Supreme Court and the High Court. So, for example, you had Article 332A, which was introduced, Article 31D, which was introduced, Article 226 was amended to reduce the powers of the High Court. Article 226A was inserted. Article 329A was inserted, right? These were all the amendments which were made to the Parliament, to the Constitution by the Parliament under Indira Gandhi during emergency, stating that these amendments to the Constitution are being made specifically. These amendments to the Constitution are being made specifically to, in a way, curb the powers of the Supreme Court and the High Court, right? Because it was the Allahabad High Court judge who had declared Indira Gandhi's candidature as unconstitutional, and also it was the Supreme Court of India who had declared that the powers of the Parliament to amend the Constitution are subjected to very, very heavy judicial reviews. You see the point? So, in that sense, the Supreme Court and the High Court were the natural villains in the eyes of Indira Gandhi and the government and the Parliament in 1976. And one of the, what you can say, ways in which they also cut down the powers of the Supreme Court and the High Court were Article 323A and 323B. So they use the reason of pendency before the Supreme Court and the High Court. They use the reason of pendency before the Supreme Court and the High Court. Again, I'll repeat it. They use the reason of pendency before the Supreme Court and the High Court to ensure that alternate judicial bodies meaning alternate courts, which are known as tribunals, can be created, and the work which is assigned to the Supreme Court and the High Court can be taken away from the tribunals and taken away from the Supreme Court and the High Court and given to the tribunals. You see, that's basically what they precisely wanted to do. They wanted to take away the work of the lawyers, of the judges, and they wanted to give it to tribunals. Now you see, for example, if I take a look at this, if you take a look at Article 323A, try to understand this very clearly. If, let's say, for example, an IAS officer has been suspended by the government because, let's say, for example, he was not agreeing with the if an IAS officer is suspended by the government because he was not agreeing with the activities of the government, if the IAS officer is being suspended by the government because he was not agreeing with the activities of the government, then what you see is, then this IAS officer would generally go to a, let's say, a high court or a Supreme Court to complain against the government and to restore his services and cancel the order of suspension. Okay, so let's say, for example, the case of the IAS officer would be listed before a high court or a Supreme Court. But what basically happens now is that after the creation of the administrative tribunals, Article 323A, if the parliament creates an administrative tribunal, then this case, which is considered a matter of public services, shall be transferred from the court to the tribunal. Okay, this case shall be transferred from the court to the tribunal. Am I making my point clear over here, class? In the case of, let's say, an IAS officer who's suspended because of the activities of the government, who does not agree with the activities of the government or finds them unconstitutional, and he goes to the High Court or the Supreme Court challenging his suspension order. This case will not be heard by the High Court and the Supreme Court, but it will be heard by the Central Administrative Tribunal. You see the point? Now, take a look at this. The Central Administrative Tribunal, the CAT, is created by, let's say, for example, the Administrative Tribunals Act 1985. Central Administrative Tribunals is created by the Administrative Tribunals Act 1985. Okay, and the Central Administrative Tribunal has members. So the tribunal doesn't have judges, it has members. Okay, some of these members are retired judges of the Supreme Court and the High Court. Some of them are retired IAS officers, and the others are expert bodies. For example, if it is an electricity tribunal, it is a person from the electricity department or a person who has electrical engineering experiences, etc., etc. Right? So this is what you can call very simply the this part is what you can call very simply is the what you can call the membership of the tribunal. These are the people who are, let's say, for example, judges in the matters which are coming before a tribunal. So tribunal doesn't have judges, it has members, right? And all the members of the tribunals are going to be appointed according to the Administrative Tribunals Act. All the members of the tribunals, according to the Administrative Tribunals Act, are going to be appointed all the members of the tribunals are going to be appointed by the government of India, which is the central government, which is basically in political terms known as the union executive. Okay, all the members of the central administrative tribunal are going to be appointed by the government of India. Right now, if you take a look at this very simply, if you have, let's say, for example, the High Court and the Supreme Court, right? You have the High Court and the Supreme Court, and let's say, for example, the judges of the High Court and the judges of the Supreme Court, even in 1976, they were not entirely made by the government of India. The judges of the High Court or Supreme Court enjoyed a reasonable amount of independence from the executive, enjoyed a fair amount of independence from the executive. Okay, so the appointment of the judges of the High Court or the Supreme Court was not done by the executive, whereas the appointment of the members of the tribunals was done directly and exactly by the executive. Do you see now what is happening over here? What is happening over here is this, that the government of India, let's say for example, the government of India says that if, for example, these are the High Courts and the Supreme Courts, and these are, let's say for example, these kind of matters are given to the High Court and the Supreme Court. ये सारे matter High Court और Supreme Court के पास हैं, जो कि administrative matters हैं. These are all administrative matters. The government of India is trying very hard to control the High Court and the Supreme Court. ठीक है, तो what Indira Gandhi does is she says that Chief Justice ये बनेगा, ये नहीं बनेगा, और एक जज को निकाला, दूसरे जज को bypass किया, and all of that. But nonetheless, Supreme Court is resisting very heavily from letting the government of India control its appointments. The Supreme Court of India is resisting very heavily from letting the government of India control its appointments here. And to some extent, the Supreme Court is able to maintain itself. For example, even in the Keshwananda Bharati case, looking at independence of judiciary as a basic feature of the constitution, Supreme Court was able to maintain itself independent from the judiciary, from the executive, sorry. Right? There was some amount of independence that the Supreme Court was able to assert for itself from the executive. Okay, so by this I mean to say both the Supreme Court and the High Courts were able to maintain some amount of what you can say independence from the executive. Even though executive tried very hard, they could not completely control the Supreme Court entirely. Right, the judges of the Supreme Court were not necessarily listening to the executive. They were taking their own decisions independent of the will of the executive, as it was given in Golaknath case, Keshwananda Bharati case, etc., etc. Right. On the other hand, what the government of India did was, government of India, by Article 323A of the Constitution, 323A of the Constitution, and even 323B of the Constitution, what government of India did was, it took all these matters. Let's say for example, if you take a look at this very simply, it took all these matters from the High Court and the Supreme Court and necessarily transferred them into what is known as an administrative tribunal. Okay, let's say in this particular case, these matters were necessarily transferred from the particular parts of what is happening over here into administrative tribunal. So again, I'll repeat, if you take a look at this very simply, the government of India, it took matters, let's say for example, all these matters which are related to services of IAS officers, IPS officers, IRS officers, etc., and transferred these matters to the CAT and directed that any further matters with relation to services must be given to the CAT, not to the High Court or the Supreme Court. This was the first thing. And the second thing that the government did was, government exercised a complete control on the appointment, or what you can say appointments, of the members of tribunal. Do you see the point? So you see how the power of the Supreme Court and the High Court, when the Supreme Court and the High Court could not be controlled by the government directly or indirectly, the government moved away from the Supreme Court and the High Court and created a kind of a snatching. It kind of took away the powers of the, what you can say, judiciary on certain matters, for example administrative matters, and transferred all of those powers to the bodies which are known as the quasi-judicial bodies of the tribunals. Okay, transferred all these matters to the tribunals, the quasi-judicial bodies of the tribunals. It took the matters from the judiciary and transferred all of these matters to the quasi-judicial bodies of the tribunals. Right, and this particular transferring of the matters from the, what you can say, judiciary to the quasi-judicial bodies of the tribunals, this was even more further giving the government powers to control the results of these matters. because the appointment of the members of the tribunals was to be done by the government of India. So just imagine, for example, if an IAS officer goes against the will of Indira Gandhi, let's say if Indira Gandhi wants the IAS officer to catch hold of some people and put them in jail, right? And if IAS officer says, I'm not going to do it because it is unconstitutional, and if, let's say, for example, Indira Gandhi suspends that IAS officer, and if that IAS officer goes to the High Court or Supreme Court, High Court or Supreme Court will not accept the petition of the IAS officer, and they would be told, or the IAS officer would be told, that any petition with regard to your service has to be made before the Central Administrative Tribunal. And Central Administrative Tribunal is being manned by people who are appointed by the government of India. It doesn't enjoy the independence that the judiciary has, and thus this kind of an activity will eventually lead to outcomes which are determined, influenced by the government of India. You see the point? And this is what basically becomes the kind of a political reasoning or the political logic as to why the tribunals were instituted in 1976 by inserting article 323A and 323B. Do we understand the point? So I'm going to take you to the first page now. Please take a look at this again. Read this entirely. Right. So if, for example, a question is asked, what are the bases on which tribunals were set up? The first basis, of course, sociological, that the judiciary was unable to respond to the calls of dealing with the cases at a high rate. There were a lot of pendency of matters which was building up, and since there was a lot of build up of the pendency of these matters, the judiciary was not able to exercise its activities in that manner in which the pendency could be curbed. Okay, therefore you had to create alternate judicial bodies or substitute judicial bodies which could, in some cases, take the matters from the courts and deal with those matters unilaterally, apart not having the foundation of only having judges on the membership of the tribunal, but even domain experts can have a presence on the, what you can say, membership of the tribunals. So for example, if it is an electricity tribunal, it's a tax tribunal, chartered accountants and electrical engineers can become members of the tribunal, and thus the justice delivery mechanism can be expedited, can be made better, because it is basically leading to the activity of creating a just uh, it is leading to the activity of creating a system in which the concept of tribunals is acting like a judicial body and performing the judicial functions faster than the traditional judicial bodies. So this is a sociological reasoning, but there was also a political reasoning. Political reasoning was the point in 1976 when the government of India and the Parliament of India, frustrated by the judicial activism, according to them the judiciary was acting out of its own control and its own powers, doing the Keshavananda Bharati judgment, Golaknath judgment, Indira Gandhi versus Rajnarayan judgment, etc. So to be able to make this kind of an activity, redundant, the rising power of the judiciary, and when the judiciary could not be controlled entirely by Indira Gandhi, Article 323A and 323B under the 42nd Constitution Amendment Act 1976 ensured that the powers of the judiciary was taken away and given to a body which was directly under the government of India, and the appointment of that body, the members of the body, are to be appointed directly by the government of India. So this was one of the ways in which the power and control of certain matters which are judicial in nature came directly under the government of India by the tribunals, which is its biggest criticism. The biggest problem that we have with tribunals today is that these are judicial bodies, but they are controlled by ministries, they're controlled by ministers, they're controlled by the government of India. Now, for example, the government of India can determine the results of these tribunals in accordance with its own will. And what I basically mean to say is that the political party which comes at the center of the government of India can determine the judgments given by tribunals by controlling the people who are manning the tribunals. This is a direct violation of the principle of independence of judiciary. If tribunal is a judicial body, then it should be independent of the executive, because for every judicial body, independence from the executive is its hallmark, is its essence. Do we understand this, class? Class, am I clear to you the point that I'm trying to make over here about tribunals? right? So I'm trying to create a kind of a sociological and political background in which the tribunals had arrived in the horizon of the Indian Constitution. Am I making sense, class? Do we get a point that I'm trying to come across, to communicate across to you? Class, are we clear? Okay. So the Administrative Tribunals Act 1985 was the first tribunal to be instituted in India. The Central Administrative Tribunal was created under Article 323A of the Constitution, right? Now, for example, let's say this was the act which created the first tribunals, and you can see, for example, the reason why all of this is in current updates is because it was last updated on 29/2021. So recently only the Administrative Tribunals Act has been amended. Okay, so for example, just very simply, if you take a look at this, Section 4 of the Administrative Tribunals Act. Let's take a look at this. Now, when the UPSC CSAT paper last year was a little off the mark, with the mathematics portion becoming very difficult, applicants had reached the CAT, the Central Administrative Tribunal, against the UPSC. So you kind of get a sense of the kind of questions which are asked before a Central Administrative Tribunal. All the questions which are related to services, administration, administrative services, central government services, etc., etc. Okay, this is a law made by the Parliament. Central government by notification established an administrative tribunal to be known as the Central Administrative Tribunal to exercise the jurisdiction and powers and authority conferred on the Central Administrative Tribunal by or under this act. The central government may, on receipt of a request in this behalf from the state government by notification, also establish a state administrative tribunal. Right? So the parliament has the power to create administrative tribunals both for the center and for the state. I hope you're getting the point. This is a very simple question in the prelims examination. Again, the reason why I am focusing upon this part is specifically because the Central Administrative Tribunal has been recently updated, recently amended in 2021, and the amendments to the Central Administrative Tribunals Act, they are in appeal or petition before a Supreme Court for their constitutional validity. Okay, so if, for example, I want to expand upon the concept of a Central Administrative Tribunal, you think about it like this very simply. A Central Administrative Tribunal, CAT, which is going to deal with, let's say, the services matters, public services matters. A Central Administrative Tribunal, CAT, is going to be dealing with the public services matters of central government. Right? It is established by the central government, which has been given the authority of establishing it by the Administrative Tribunals Act 1985. Okay, now the central government also has the authority under the Administrative Tribunal Act 1985 to set up what are known as state tribunals, state services tribunals. So the point of understanding here from the perspective of a multiple choice question is that both the central administrative tribunals and the state administrative tribunals are to be set up only by the central law, which is the Tribunal Reforms Act 19, oh sorry, Administrative Tribunals Act 1985, and the central government. Do we understand this point as a simple focused point for a prelims question? Again, I'll repeat it. With regard to the central government, with regard to, let's say, administrative tribunals, the power to establish administrative tribunals can only be exercised by the central, the union. The Union Parliament makes a law, Administrative Tribunals Act 1985. The source of this law is Article 323A of the Constitution. 323A was inserted in the Constitution by the 42nd Constitution Amendment Act 1976. Okay, so 42nd Constitution Amendment Act 1976 inserts Article 323A, gives the power to the Parliament to set up administrative tribunals, both for the center and the state, right? And then the central government by notification can institute these tribunals both for the center and the state. Do I make my point very clear to you, class? How an administrative tribunal is set up and what is the, what you can say, hierarchical and constitutional background to understanding how this aspect is really working out. Are we clear? Take. Now if I come to this part specifically, the one that I was making over here, do you understand this diagram that I'm making over here? That it is the government of India which is setting up a administrative tribunal, and then the government of India makes a provision that all the cases which were previously going to the judiciary, the High Court and the Supreme Court, they would be taken away from the judiciary and transferred to tribunals. Do I make my point clearly? All the cases which are pending with the judiciary on these particular matters, they are going to be taken away from the judiciary and be transferred to what is known as a administrative tribunal. Okay, now the question is, as the question that you're asking is, that what is the nature of appeal that can happen from the decisions of the tribunals to the Supreme Court and the higher court, right? So the question that we're basically asking is that, let's say for example, if you take a look at this like this, you have the Supreme Court, and let's say for example you are the High Court. Now the idea which is given in the Swaran Singh committee report is generally that tribunals are going to be bodies like the High Court, but these are bodies which are expert oriented bodies. So for example, income tax tribunal should be a body which is a substitute to a High Court. Okay, so you see the point about being an alternate or a substitute to a High Court in income tax matters. So for example, let's say, I'll write it down. An income tax tribunal is supposed to be a substitute to a High Court. Income tax tribunal is supposed to be a substitute to the High Court, right? On matters related to income tax. So the idea is very simple, that if any matter related to income tax has to go to a lower court or to a High Court, rather than going to a lower court or a High Court, it should go directly to the tribunal. This is the idea. Okay, so it is a substitute of the income tax it is a substitute to income tax matters in the, let's say, in the level of a state as a counterpart to the High Court. Okay, and therefore what basically Article 323A and 323B, both of them provide, 323A and 323B, both of them provide that appeals from tribunals shall not lie before the High Court. And in addition, what Article 323A and B provides is that appeals can also not lie to the Supreme Court. Appeals can also not lie to the Supreme Court except by way of Article 136, which are known as the Special Leave to Appeal, SLP. Except by way of Article 136, which is known as a Special Leave to Appeal. Okay, so in this way, Article 323A and 323B practically barred the appeals to be given by the judgments of the High Court. Specifically because they, again, if I repeat it, Article 323A and 323B practically barred the judgments given by the tribunals to the High Court or the Supreme Court. A very narrow way was kept that an appeal can be made from the judgments given by the tribunals not to a High Court but only to a Supreme Court, and that to Supreme Court under Article 136 of the Constitution, which is what is known as a SLP. Okay, so again, this kind of a question can come as a kind of a single sentence in a multiple choice question format. That if you take a look at Article 136 of the Constitution, it talks about the special leave to appeal. An appeal under Article 323A and under Article 323B can be made to the Supreme Court only, not to the High Court but to the Supreme Court only. That too under Article 136 of the Constitution, which is a special leave to appeal, SLP, special leave petition, which is called under Article 136 of the Constitution. Right. So this is what is given under Article 323A and 323B. So what is the impact of this? What is the effect of this? The impact and effect of this is this. Again, going back to this part. First of all, the matters from the High Court and the Supreme Court are going to be taken before the Supreme Court of India, taken from the Supreme Court and the High Court and given to the CAT. The CAT is supposed to be an alternate administrative body, alternate judicial bodies, which is supposed to take a look at the matters which are given over here. Right. So all these matters are now going to be transferred to the administrative tribunal. Number one. Second, though the judges of the High Court and the Supreme Court can be independent from the influence of the executive, the members of a tribunal, as they are called, are directly going to be under the influence of the ministries of the government of India. Which means that with regard to tribunals, there is a clear and categorical issue in understanding what is known as independence of judiciary. Again, I'll repeat it. With regard to tribunals, there is a clear issue on the question and the context of independence of judiciary. Right? You have a very clear issue with regard to the context and the concept of independence of judiciary on the matters of tribunals. Am I clear? And third, an appeal from a, what you can say, order of a tribunal cannot be made to the High Court and almost cannot be made to the Supreme Court. And even if it can be made to the Supreme Court, it can be made only under what is known as Article 136, which is a special leave to appeal. Which basically means that the judgment given by a tribunal almost completely negates an appeal which is going to be made from the judgment of the tribunal to the High Court. So High Court is rendered insignificant in front of a tribunal. Now, the difference is that the High Court judges are independent of the executive. The members of a tribunal are appointed by the executive. This is the core difference. And therefore, thus arises the problem that we are basically looking at. Again, I'll take a look at this. Matters of a High Court can be taken away and given to the tribunal. Number one. Second, the tribunals are going to be appointed by the government of India. High courts may be appointed independent of the government of India, but the judges of the High Court are not chosen by the government of India, but the members of a tribunal are chosen by the government of India. Number two. And number three, the decisions which are given by tribunals cannot be appealed into high courts, and almost also not in the Supreme Court also, which means that the judgment of a tribunal, once it has been given, may have the influence of the government of India, and the judgment could be given in accordance with the government of India. You see, so for example, if there's a tax case going on between Vodafone and the government of India, and the government of India says that the tax case would be heard by the income tax tribunal, and the composition of the bench of the tribunal is made in such a way that the bench decides the judgment in favor of the government, and the judgment which has been given by the tribunal is not even appealable to the High Court or the Supreme Court. By this, the government of India can influence the judicial decisions, all of them in their favor. And therefore, the whole idea of judiciary, in which the most serious litigant in the judicial bodies is the government of India. Most amount of cases are made against the government of India. And who are government of India? Political party which is sitting inside the government of India. It is people of India who have won elections who are sitting inside the government of India, right? They have the control of all the resources and all the powers. Now, if they are able to select judges who will give decisions according to their own fancies and wills, people sitting inside the government are going to keep winning cases in favor of them. And the cases which are going to be made against the people of India and in favor of the government will start seeing a rise. And therefore, the judicial activity can very simply and easily become a mockery from this example. Therefore, it is necessary that you must keep an independent judiciary from the control of the executive. But tribunals don't have that kind of an activity. They are not independent of the executive. Do I make my point clear, class? Do we understand this point? Okay, now I'm going to take you through Article 323A and 323B in terms of a few points over here. Okay, so if you take a look at this part, just take a look at these two points within 323A and B. Let's say 323A subpoint D and E. If you take a look at both of these, what are these trying to say over here? Jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136 with respect to the disputes or complaint referred to a tribunal. And he provide for the transfer to each such administrative tribunal of any cases pending before any court or other authority immediately before the establishment of such tribunal as would have been within the jurisdiction of such tribunal if the causes of action on which such suits or proceedings are based had arisen after such establishment. So basically it means that the judgments of the tribunals are not covered under the jurisdiction of any other courts except for the Supreme Court under Article 136, ruling out the High Court completely, right? And it is necessary to transfer all the cases dealing with administrative matters to the tribunals, and none of these cases shall be retained or remained with the High Court or the Supreme Court or the lower court. This is what Article 323A says, right? So Article 323A envisages the creation of what are known as administrative tribunals, and Article 323B, as you can see over here, envisages the cases of creating of other tribunals by appropriate legislature. So just take a look at this again. Article 323B says that the appropriate legislature, over here appropriate legislature means two things. If it is a union subject, then the appropriate legislature is the parliament. If it is a union subject, then the appropriate legislature is the parliament. And if it is a state subject, then the appropriate legislature is the state assembly. I hope you understand this point. If it is a union, the appropriate legislature is the parliament, and if it is a state subject, the appropriate legislature is the state assembly. Now, what Article 323B talks about? Tribunals for other matters. Matlab, Article 323A talks about tribunals for administrative matters. Article 323A talks about tribunals for administrative matters. Article 323B talks about tribunals for other matters which are not administrative in nature, right? So, for example, environmental tribunals, tax tribunals, customs tribunals, tariff tribunals, labor tribunals, election tribunals, all of these matters which are apart from the administrative matters, these tribunals can be set up by the parliament or the state legislature, as the case may be, the subject matter being in the union list or the state list. Do we understand this properly? Class, take a look at this Article 323B, please, again, in a very specific sense. The appropriate legislature may by law provide for the adjudication or trial by tribunals of any disputes, complaints or offences with respect to all or any of the matters specified in clause 2. So clause 2 talks about, for example, A, taxation tribunals, customs tribunals, industrial and labour tribunals, saving clause tribunals, sealing on urban property tribunals, election to either house of parliament, Article 329, 329A, production, procurement, supply and distribution of tribunals, rent regulation tribunals, offences against laws with respect to any of the matters specified in the fees of those cases. So all the cases which are not mentioned under Article 323A, environmental tribunals, tax tribunals, customs tribunals, tariff tribunals, all of these cases can be covered under what are known as the tribunals given under Article 323B. And again, even with these tribunals which are given under Article 323B, this kind of a provision still applies. The provision over here means that any judgment which is given by a tribunal, shall exclude the jurisdiction of the High Court and can only go to the Supreme Court under Article 136 of the Constitution. So the effect of this is, for example, this, that if you have, let's say, for example, the National Green Tribunal, NGT, if you have the National Green Tribunal, NGT, which has been created by the Parliament by the NGT Act. National Green Tribunal has been created by the Parliament by the NGT Act, right? This NGT Act can say that the orders made by the National Green Tribunal cannot be appealed before a High Court and can only be appealed before a Supreme Court under Article 136 of the Constitution. Are we clear? Do we understand the point? Okay. So by Article 323A and 323B, you have a creation of all the tribunals in the country. Okay. So let me just kind of put it out in a context. Article 323A talks about administrative tribunals, which can only be created by the Parliament. Okay. Article 323A talks about administrative tribunals which can only be created by the Parliament, and Article 323B talks about all kind of other tribunals that can be created by appropriate legislature. All kind of other tribunals that can be created by appropriate legislature, right? So for example, let's say you can have a variety of tribunals. You can have, let's say, for example, the Income Tax Tribunal, ITT. You can have the National Company Law Tribunal, NCLT. You can have, for example, the Customs and Tariff Tribunal. right? Then you can have, let's say for example, a debt recovery tribunal, DRT, and all of these tribunals are created by laws made by the parliament or the state under Article 323A and B. And the important point about questioning over here is this: if a order is given by such a tribunal, can this order be subjected to appeal before a high court? That is a real important question before a high court. And that basically beckons the question that what is the nature of a tribunal in terms of it being called a quasi judicial body? That how can you call a tribunal a quasi judicial body? How is it that you can call a tribunal a quasi judicial body? Am I clear with this explanation, class? The nature of a tribunal as a quasi judicial body. Okay, so we have in a way created the first framework of understanding the tribunal, right? So if you take a look at this particular synopsis, we have come to this part: 42nd Constitution Amendment Act, Article 323A done, and now I'm going to deal with these two things, and then quickly with the Tribunal Reforms Act 2021 and the Supreme Court point which has been made over here. When Administrative Tribunals Act, the Administrative Tribunals Act was created in 1985, by which the Administrative Tribunals was created, it said that the order which is made by the tribunal, cannot be subjected to an appeal to a high court, and can only be subjected to an appeal to the Supreme Court. Cannot be subjected to an appeal to a high court, can only be subjected to an appeal to the Supreme Court, and that too only under Article 136. Right? This is what it basically done. So the Administrative Tribunals Act had in a way declared that tribunals will not fall under the jurisdiction of the high courts, and the order of the tribunals can only be taken up by the Supreme Court, that too under a very specific article, which is Article 136. ठीक है, अब आप खुद सोचो कि इतने सारे ट्राइब्यूनल्स अगर देश में बन गए और उनकी डायरेक्ट अपील सुप्रीम कोर्ट के पास चली गई, तो सुप्रीम कोर्ट के पास और पेंडेंसी बढ़ जाएगी, है ना? सुप्रीम कोर्ट उनको सॉल्व कर ही नहीं पाएगा. सुप्रीम कोर्ट वुड आइडियली वांट that this kind of a thing should go under the High Court first and go to up. You have so many tribunals, all of them come to the Supreme Court. Again, the Supreme Court is sitting on a pile or a mountain of cases which it has to decide, and of course overwhelmed by it, it may not be able to decide it, and then again the allegation would be made on the Supreme Court that you are sitting upon matters and pendencies creating, and then later on you will say that even the Supreme Court shall not have appeal of the orders of the tribunals. So the question that was basically made, now this is the first landmark judgment. Okay, I'm taking a look at what are known as the landmark judgments upon the tribunal cases. Now please pay good attention to them. You can get a direct or an indirect question from this particular part very clearly. Okay, the first landmark judgment that I'm dealing in relation to tribunals is a very important part of your static portion of polity, which is the SP Sampath Kumar case. It is a SP Sampath Kumar case, and you can take a look at the bench. You have a 5-judge bench Supreme Court with Justice P.N. Bhagwati as a Chief Justice of India, 1986. The name of the case is SP Sampath Kumar. You can see Superintendent of Police Sampath Kumar versus Union of India. Okay, so this is what basically we are trying to understand. The first thing is, which is an important landmark judgment on the issue of tribunal, is Sampath Kumar versus Union of India. Okay, in this case, in 1986, a 5-judge bench of the Supreme Court in 1986, a 5-judge bench of the Supreme Court in SP Sampath Kumar versus Union of India. In this case, the Supreme Court was basically looking at this question. Take a look at this. Challenge to the constitutional validity of Article 323A and 323B. Challenge was made to the constitutional validity of Article 323A and 323B that these articles. Challenge was made to the constitutional validity of Article 323A and 323B that these articles violate the basic structure doctrine by hurting the basic features of independence of judiciary and judicial review. Okay, so again, please pay a little bit of an attention to this, what is happening over here. Now you see Article 323A and B of the Constitution have been inserted inside the Constitution by a Constitution Amendment Act, right? Article 323A and B have argued that any kind of a order which is given by a tribunal cannot be subjected to a judicial review of the High Court in terms of barring the appeal to the High Court. Also, as we have seen, that the appointment of the tribunals members is not done by an independent method, but the appointment is done by the government of India, right? So you understand the 2 points of contestation over here. Appointment made by the government of India. Appointment is made by the government of India. And second point of contestation is that High Court cannot entertain appeals. तो ये जो दो चीजें दे रखी थी आर्टिकल 323A और 323B में, उनको चैलेंज किया गया था सुप्रीम कोर्ट के सामने इन द केस ऑफ व्हाट इज नोन एज द एल चंद्र कुमार केस. And this became basically a question before a 5-judge bench of the Supreme Court whether Article 323A and 323B, which are amendments to the Constitution made under Article 368, whether they violate the basic structure doctrine by hurting the basic features of A, independence of judiciary, and B, judicial review. Independence of judiciary, why? Because the appointments were made by the government of India. So if the tribunal is performing judicial functions, why is it being manufactured by the executive? You see, that's the whole point. The point over here was that what kind of a body is it? What is the nature of a tribunal? That became the real important question. Okay, is it a judicial body? And the answer is yes, because it is performing functions of a judicial body. Okay, or is it an executive body? And that also the answer is yes, because it is composed by and of the executive. मतलब इसकी जो मेंबरशिप है वो कौन डिटरमाइन कर रहा है? एग्जीक्यूटिव, है ना? तो यही क्वेश्चन बन गया बेसिकली कि ये बॉडी है किस प्रकार की, व्हाट इज द नेचर ऑफ अ ट्राइब्यूनल, इज बेसिकली वी ट्राई टू अंडरस्टैंड इन दिस पर्टिकुलर क्वेश्चन. यू सी द पॉइंट. तो सबसे पहले जो प्रश्न था क्वासी जुडिशियल क्या होता है, वो इस प्रकार से पूछा गया था. यू सी, एनीवे यू फॉर एग्जांपल even are asked a conceptual question of what is a quasi judicial body. This is exactly what you understand in terms of a quasi judicial. A quasi judicial body is a body which may be performing judicial functions, but its existence is owed to the executive. You see, if you take a look at the Supreme Court of India or the High Court of India, the Supreme Court or the High Court are not dependent upon the executive for anything. The judges of the Supreme Court and the High Court today are not chosen by the executive at all. You get the point? The judges of the Supreme Court and the High Court are not chosen by the executive. So the Supreme Court and the High Court judges do not depend upon the executive at all. Right? So they are a judicial body. They are independent of the executive and they perform judicial functions. So they are a purely judicial body. Okay? But what is the case with tribunals? Tribunals are performing judicial functions, but they are appointed by the executive. Am I making my point clear, class? Tribunals are performing executive function or judicial functions, but they are under the wings of the executive. They are under ministries. The Ministry of Environment has the NGT. The Ministry of Finance has the Income Tax Tribunal. So they are under ministries, but and also the members of the tribunals are decided by the ministries. But these members are performing judicial functions. So what is the nature of such a body? And then came the term quasi-judicial body. You see, a quasi-judicial body is a body which you can very simply understand if a conceptual question comes in this regard. A quasi-judicial body is a body which is structurally executive. मतलब उसका स्ट्रक्चर जो होता है वो एग्जीक्यूटिव का होता है. इट कम्स आउट ऑफ द एग्जीक्यूटिव, इट इज बॉर्न फ्रॉम द एग्जीक्यूटिव, इट इज कंट्रोल्ड बाय द एग्जीक्यूटिव, बट द फंक्शंस दैट इट इज परफॉर्मिंग इज not executive. Function is judicial. So you know, for example, what is the role of the executive? The function of the executive is to implement laws, right? To enforce laws. If a law is made by the parliament, the executive enforces the law. That's a function of the executive, right? The function of the judiciary is to adjudicate upon laws, how the laws have been applied to certain facts. Now the question is, what is the function and structure formula for a tribunal? And the answer is that structurally it is an executive, functionally it is a judiciary body, right? तो ये वाली बात कह के सुप्रीम कोर्ट के सामने बोला गया था कि आर्टिकल 323A में कुछ चीजें हैं जो कि क्लियर नहीं है कि वेदर इट इज अ जुडिशियल बॉडी. अगर स्ट्रक्चरली एग्जीक्यूटिव है और फंक्शनली जुडिशियल है तो इसके लिए स्कीम अलग से बनानी चाहिए. या फिर अगर मान के चलिए कि इफ वी कंसिडर फॉर एग्जांपल दैट ट्राइब्यूनल इज एन एग्जीक्यूटिव बॉडी which is performing certain judicial functions, that is fine. But since it is an executive body performing judicial functions, the orders of the tribunal can be appealed to a high court. क्योंकि eventually only a purely judicial body shall have a look into judicial matters. Class, am I making the point clear? Class, are we getting the point over here? The question that we're asking is, if a body is structurally executive and functionally judicial, then it's fine. It's okay to make a body within the administration and the executive which may have judicial functions. There's no problem with that. There's no problem with making a body which has administrative control but has judicial functions. But eventually an order made by this judicial, by this quasi judicial body shall be subjected to a review to a purely judicial body, which is the High Court. And therefore, the contestation which was made in the Sampath Kumar case was that the barring of the jurisdiction of the High Court under Article 323A and 323B of the quasi-judicial bodies is a violation of the concept of judicial review and independence of judiciary. Okay. This was the basically the case that was made before the Supreme Court in the Sampath Kumar case, right? और Supreme Court ने इसमें judgment दिया था that this is where the Supreme Court basically in a way made the point. The Supreme Court said in the Sampath Kumar case, and this is again relevant as points for your prelims questions and answers. The Supreme Court said that point number A, that tribunals can act as real substitutes to high courts. Okay, point number A. Second, it said that tribunals must be placed as according to the principles of independence of judiciary. Okay, and it was in this particular part when the tribunals were placed as independent judiciary came one of the biggest propositions. The proposition was that a National Tribunals Commission what you can call an NTC, which is supposed to be a body like the UPSC. National Tribunals Commission, NTC, which is supposed to be a body like the UPSC, should lay out the methodology National Tribunals Commission NTC should lay out the methodology for selecting the members of tribunals. Which is free from executive influence, and is objective and fair. तो यहाँ पे recommendation दी गई थी, ये आपके prelims के question के लिए important है. What is the concept of a National Tribunals Commission? Right. So because the question at this point of time had become that how do you appoint members of tribunals? तो जो ये वाला case है Sampath Kumar वाला case, the case which is given over here, the case of SP Sampath Kumar. In this, the question that was raised before the Supreme Court, as I have probably tried to explain you properly, that how can you have a body which is functioning as a judicial body but it is controlled by the executive? How can you have such a body? So if you're creating a judicial body, you should really create a proper judicial body which can act as a real substitute to the High Court. So your argument is that High Court is made of judges which may not have expert opinions upon these particular matters, and therefore because they don't have expert opinions upon electricity, upon engineering, upon medical sciences and all of these things, then what you do is you create alternate bodies, substitute bodies to the High Court which have expert members in them, so that they can take up these matters, and because they have a better understanding of the technicalities, they can execute these things properly. So what you have to do is basically take up the matters from the High Court and give it to these bodies, and these are supposed to be equivalent, alternate substitutes to the High Court, as good as a High Court for these particular matters. So Income Tax Tribunal is supposed to be as good as a High Court for the income tax matters, and then the burden of the High Court can be relieved, and then you can create tribunals for these specific purposes as alternate judicial bodies. You've done that, very good. But the question still remains that unlike the High Court, the government still has control over the tribunals. If a case is made against the government and government is choosing the appointment of the members of the tribunals, then surely the appointment of the members of tribunals can be made in such a way that the government gets to have a kind of a influence or a prejudice upon these matters. So again, the term quasi judicial body cropped up. A quasi judicial body is a body which looks like which is created by the government, is under the control of the government. It is structurally executive but functionally judicial, and therefore it is a problem. You see, it is neither here nor there. Neither is it a government of India, nor is it a, what you can say, the nor is it given with entirely judicially. तो इसमें जो एसपी संपत कुमार केस में कहा था सुप्रीम कोर्ट ने that it is correct that you under article 323A parliament has all the power, the legislature has all the power to create what you can call a separate judicial body. अगर लेजिस्लेचर चाहे तो हाई कोर्ट जैसा एक बॉडी बना सकता है, वो लेजिस्लेचर की पावर के बाहर नहीं है. That is a power which has been given to the legislature under Article 368 of the Constitution, known as the constituent power. If the legislature wants, it can create an alternate judicial body like the High Court. Okay, but to be sure that it is a judicial body entirely, it has to also ensure that the members of the tribunals are elected or appointed in a transparent and an objective manner. So what they proposed was that UPSC जैसे IAS का एग्जाम कराती है बच्चों के लिए who want to become the Indian Administrative Services officers, etc., etc. Similarly, you create a National Tribunals Commission. अब ये question आएगा आपके prelims में. You create a National Tribunals Commission as a body which is supposed to conduct an examination for people who want to become members of a tribunal. So let's say, for example, if you have 25 years of experience working in an engineering sector company, you see, if you worked in an engineering company for 25 years, then you can become eligible to write an examination which would be conducted by the NTC, and then on the passing of that examination, you can be given membership of a National Tribunals Commission, membership of a Electricity Tribunal or Energy Tribunal under the organization made by the NTC. So the number one, what you can say, reform which is in a way demanded at this point of time in the context of tribunals is NTC, and even today the NTC is still under demand only. It is under a heavy demand, and this demand is most vociferously being pushed by the Supreme Court of India, what is known as a National Tribunals Commission. Okay, so you, for example, take a look at this editorial from the Hindu. Now this is the point at which I'm trying to arrive at the most specifically as to why a National Tribunals Commission is supposed to be the need of the hour. Take a look at this editorial. It is time to set up a National Tribunals Commission, NTC, and this is exactly the kind of question that you are going to take a look at in terms of understanding the prelims based questions upon this matter. Even the Chief Justice of India has advocated for this particular activity recently when he's talked about all kind of commissions to be made for the securing of independence in judiciary, and he's been talking about specifically the National Tribunals Commission. Okay, so this is the point that I'm trying to arrive at least in the static portion about what is known as a commission which has to be made, which can appoint the members of the tribunals, and thus you can create tribunals as bodies which have judicial functions and are also independent of the executive, and then they can become expert bodies finally, which have the ability to deal with these matters on an intellectual level like experts, but also completely independent from the executive influence, from the political influence in terms of deciding these matters, right? That's what basically we're taking a look at. Okay, so I'll pause here and I'll come back and quickly, within 15-20 minutes, wrap up this part about the Tribunal Reforms Act and the Tribunal Reforms Act, the case which is going in the Supreme Court, along with a little bit of a subject upon the NTC. Again, I'm pointing it out as a fact that the National Tribunals Commission, or the what you can call the Sampath Kumar case, are extremely important. And also we'll take a look at how does appeal from an order of a tribunal work today in a high court or a Supreme Court. Today, can you make an appeal or not? That is the question that we're going to take a look at. Okay. After the portion of tribunals are over, I'll take up two of the questions what you have mentioned over here. I'll take up a look at what is known as the concept of an election petition. Since it is a Lok Sabha election year, you will get a handful of questions from election petitions as to the disputes to Lok Sabha elections. And I'll take a look at the Election Commission judgment given by the Supreme Court, and then the bill which has been passed by the Parliament of India, which is thwarting the Election Commission judgment of the Supreme Court. So there's a committee, one of you mentioned, a committee was made by the Supreme Court for the appointment of the Election Commission, which would include the Prime Minister, the CJI, and the the leader of the opposition. But this particular committee has been in a way delineated, has been kind of struck down by a law made by the Parliament, and we'll take a look at this from the perspective of the independence of Election Commission of India. Okay, so we are taking a look at the subject of tribunals here. We're taking a look at the subject of tribunals over here, and while we're taking a look at the subject of tribunals, we are positioning ourselves to understand that Article 323A and 323B we have understood clearly. Okay, this is what we've understood clearly. After this, we're taking a look at what is known as the nature of a quasi-judicial body. So I hope that you understand, if for example a conceptual question comes in the prelims, that which of the following is the best description of a quasi-judicial body. You see, best description of a quasi-judicial body. Prelims में इस तरह के बहुत questions आते हैं. Best description of a quasi-judicial body. If this is a question that comes, which is a best description of the quasi-judicial body, then the answer that you are supposed to write is what I have made you understand previously, that we are very clearly expecting this time a kind of a conceptual question that can come from this part of what is the meaning of the quasi-judicial body and what is the understanding of the quasi-judicial body, right? So if a question comes, what is the best description of a quasi-judicial body, the answer is very simple. They are created by and under the government of India or the state government. Okay, so they have what you can say executive origins. They have executive origins, but they also have what you can say in terms of functions. So for example, if this is a tribunal which has been created, it has the origin and control by an executive, but the functions that it is performing is what is known as the legislative functions. Sorry, the functions it is performing is a judicial function. So any kind of a variant of describing what is a quasi-judicial body should be understood with you very clearly. Now, if we take a look at the third part of it that we covered, which is for example the L. Chandra Kumar I'm sorry, we haven't done L. Chandra Kumar. SP Sampath Kumar case. I'm sorry. If you take a look at the SP Sampath Kumar case, then in the SP Sampath Kumar case, when we take a look at, for instance, the ability to understand what are known as the aspects of a quasi judicial body, in the SP Sampath Kumar case, we see that the court said that it is within the power, it is within the power of the parliament to create alternate judicial bodies to the High Court. It is within the power of the parliament to create alternate judicial bodies to the High Court. But independence of judiciary within these bodies are to be maintained. So they have to be free of executive influence, and therefore the Supreme Court suggested that there should be a National Tribunals Commission, NTC, which is supposed to be a UPSC like body, which will take an understanding of what we are going to take a look at, which is basically a kind of a body which is supposed to be engaged in creating what are known as members of tribunals, just like UPSC creates IS officers. So by which reform, whenever we talk about the tribunal reforms, in fact the law which has been passed recently is called a tribunal reforms only. This law which is talking about tribunal reforms is supposed to create a kind of a special body which is supposed to decide on the selection procedure of the members of tribunals, so that the selection of the members of the tribunals is free from executive influence. Okay, I hope you get the point I'm trying to make over here. Okay. Now the next case that comes in this line is what is known as the L. Chandra Kumar case. Right, you have for example the L. Chandra Kumar case, another landmark judgment on this matter, and it is one of the landmark judgments of the Supreme Court in general senses. Yeah, so this is the case that we're talking about, L. Chandra Kumar versus Union of India. Again, a 5-judge bench of the Supreme Court. You may see Justice M. Punchi later on. Previously, we have seen in our classes of polity sometime or the other when we're dealing with the Punchi Commission, right? So it is the L. Chandra Kumar versus Union of India 1997, in which a kind of a question was again in a way raised with regard to the validity of Article 323A and 323B. Okay, so take a look at this. Just try to read the first part of the judgment over here. This is again a landmark judgment. It may be important in your prelims paper this time. Okay, now here is a real question. Let's say for example, इन लोगों ने बोला था संपत कुमार में कि आप एक एनटीसी बना दो और बात खत्म करो, उसके बाद हम कुछ नहीं कहेंगे आपसे. यू क्रिएट अ नेशनल ट्राइब्यूनल्स कमीशन which can appoint tribunals, and we will not object to the fact that the tribunals can exist as alternate judicial bodies which are not subjected to any kind of a, what you can say, judicial review, which are not subjected to any kind of a judicial review in terms of appeal. तो आप बना दो ट्राइब्यूनल्स. तो हम हाई कोर्ट और ट्राइब्यूनल्स को साथ साथ रख लेंगे. ट्राइब्यूनल से भले ही हाई कोर्ट में अपील ना है, वी आर ओके विद दैट. बट इसकी एक कंडीशन ये है कि आपको एनटीसी बना के ट्राइब्यूनल्स की जो इंडिपेंडेंस है उसको असर्टेन करना पड़ेगा. अब ये जजमेंट आया 1985 में. 10 साल तक एनटीसी का कोई नामो निशान नहीं था. उसके बाद सुप्रीम कोर्ट की 5 जज की बेंच दोबारा बैठती है. इन द एल चंद्र कुमार केस, सुप्रीम कोर्ट अगेन हैज व्हाट इज नोन एज अ 5 जज बेंच which sits upon the matter. Okay, and in this particular question, the judgment of the Supreme Court ने बिल्कुल साफ साफ बोल दिया कि देखो, आपके पास ऐसा कोई इरादा लग नहीं रहा है कि सरकार ट्राइब्यूनल्स के मेंबर्स को अपॉइंट करने में, अपनी पावर कम करने में इच्छुक है. It doesn't appear to us, what the Supreme Court said, that the government is interested in, let's say, what they said was, it doesn't appear to us that the government is interested in not in diluting its powers in terms of appointing the members of tribunals. So हमको दिख रहा है साफ साफ कि सरकार अपॉइंटमेंट को नहीं छोड़ेगी, सरकार ही अपॉइंटमेंट करेगी, मिनिस्ट्रीज ही अपॉइंटमेंट करेंगी ट्राइब्यूनल के मेंबर्स के. सरकार अमूमन क्या करती है ना, सारे रिटायर्ड आईएएस ऑफिसर्स को उठा के ट्राइब्यूनल्स में डाल देती है. So if you are an IAS officer who's working very good with the line of the government and all of that, the government will take you and post you after your retirement as a member of a tribunal. And then of course, being in the member of tribunal, being put there by the government of India, it is expected of you that you act in a way which is convenient for the government of India, right? In terms of deciding upon matters, right? So in this sense, the government was not showing any interest in letting go of the powers of appointing the members of the tribunals in which it had given itself some kind of a tradition, right? You understand that? And also, with the same respect and the same idea, the government of India did not create the NTC. तो अब सुप्रीम कोर्ट ने ये आर्ग्यूमेंट बोला, देखो, let's say for example, if we consider the case of a tribunal. Now this is the real point about the tribunal being a quasi judicial body. यहाँ पे सुप्रीम कोर्ट ने बोला कि let's say, if you think of tribunal as a executive body, then it is an executive body because it is coming under, what you can say, it is an executive body because it is coming under a, what you can call executive functions, right? And on the other hand, there is a judicial body or judicial function of the tribunal. तो क्वेश्चन यही तो है ना कि ट्राइब्यूनल एग्जीक्यूटिव है या जुडिशियल है या बीच में फंसी हुई है कहीं पर. दैट्स अ पॉइंट. तो एल चंद्र कुमार केस में सुप्रीम कोर्ट ने कहा था नहीं, ठीक है, वी अंडरस्टैंड ट्राइब्यूनल्स कैन बी क्रिएटेड एज ऑल्टरनेट जुडिशियल बॉडीज, बस ये है कि आप इनका अपॉइंटमेंट इंडिपेंडेंट करा दोगे. तो जो एक जुडिशियल बॉडी का एक इंपॉर्टेंट फीचर होता है दैट इट इज इंडिपेंडेंट ऑफ जुडिशरी, वो भी असर्टेन हो जाएगा. इफ यू आर गोइंग टू मेक द appointment of the members of tribunals independent of the government, then if you mark the feature of independence of judiciary also, then truly in all senses it will become a independent body in all basic understandings, right? So the इन्होंने कहा था कि आप एनटीसी बना के ऐसा कर दो, तो इन्होंने कुछ किया नहीं. तो एल चंद्र कुमार ने, सुप्रीम कोर्ट ने फिर फाइनली ये डिसाइड कर लिया, ठीक है, अगर आप इंडिपेंडेंस ऑफ जुडिशरी, मतलब इंडिपेंडेंस ऑफ द ट्राइब्यूनल मेंबर्स अगर आप असर्ट नहीं करोगे, if you're not going to assert the independence of the members of tribunal, then we have no option but to consider tribunal as an executive body, क्योंकि आपसे बाहर निकल के आ रही, it is coming out of you. Therefore they started saying that tribunal is after all an executive body. Now you take a look at this entire activity. This is important. It says that because or since tribunal is an executive body, or a large part of a tribunal is controlled by the executive, every action of an executive body is subject to writs which can be filed before a high court under Article 226 and Supreme Court under Article 32. Now, as you know for sure at this point of time, that in a high court, when we take a look at it, in a high court under Article 226, writs can be filed if the government order violates a fundamental right or a legal right. Right? I'm sure that you're aware of this. Writs can be filed if the government order violates a fundamental right or a legal right. And under Article 32, writs can be filed if a government order violates a fundamental right. Okay. Under Article 32, writs can be filed if a government order violates a fundamental right. So basically, अब देखिए इसमें logic क्या दिया. एक बार इसको पढ़िए. Just take 1 minute to read this, and then I'll explain to you the logic of L. Chandra Kumar case. And by this, we'll understand the current status of how appeals can be filed from the orders of the tribunals before a high court or a Supreme Court. Okay, please take a look at this part. Please, clearly, class. Now, what this basically suggests is that, देखो, अगर तो tribunal, if a tribunal is purely a judicial body, तो it must be independence of judiciary. And if it is not a judicial body and if it is an executive body, then it is given that every executive body, any kind of an order made by an executive body, if it violates a fundamental right or a legal right, can be challenged before the High Court in a writ petition, and if it violates a fundamental right, can be challenged before a Supreme Court under Article 32 of the Constitution. तो बात सिंपल है, बिल्कुल बहुत समझने योग्य बात है, बहुत मुश्किल नहीं है. अगर मान के चलिए कि स्टेट बैंक ऑफ इंडिया कोई ऑर्डर निकालती है और ये कहती है कि हम इलेक्टोरल बॉन्ड्स निकालेंगे, वी से फॉर एग्जांपल इलेक्टोरल बॉन्ड वाले केस में हम कल देखेंगे, that if for example the State Bank of India makes an order which violates my fundamental rights, या State Bank of India का मैनेजर बोलता है कि आपको अंदर नहीं घुसने दिया जाएगा क्योंकि आपकी जाति है, जिससे कि मेरी fundamental right violate होती है. You see, if my fundamental right is being violated by the order of a State Bank of India manager, then I can take that order of the State Bank of India manager and go to the Supreme Court under Article 32 and under Article 226 to the High Court to file a writ petition for the enforcement of my fundamental right. Now, the argument which the Supreme Court made in the L. Chandra Kumar case is very simple. Supreme Court stated that the administrative tribunal is a executive body, of course, because it doesn't have independence of judiciary, so it is not a judicial body, it is an executive body. And just like every other executive body, it passes an order. Okay, and just like every other executive body, the order of an administrative tribunal, if it violates a fundamental right or a legal right of any person, such a person can make this order come in appeal to come in a writ petition to Article 226 and Article 32 of the High Court and the Supreme Court. Do you understand this logic, class? क्लास आपको ये लॉजिक समझ में आ रहा है तो बताइए, बहुत सेंट्रल लॉजिक है, इस पे आपका कंसेप्चुअल क्वेश्चन बन के आएगा प्रीलिम्स में इस बार. So please tell me if you are able to understand this logic, otherwise I'll repeat it again. Right? I am trying to give you an understanding of this statement again because tribunal reforms are going to be an important part of the examination this time. I want you to be sure that you understand the meaning of this paragraph. ये समझ में आ रहा है कि नहीं आ रहा है आपको? with regard to what is known as a quasi judicial body. Class, please tell me yes or no. The argument that I am making, do you understand it or should I repeat it again? सुप्रीम कोर्ट ने एल चंद्र कुमार में ये कहा कि देखो, अगर आप ट्राइब्यूनल हो, ठीक है, अब क्वेश्चन आपकी आइडेंटिटी का है। आप कहते हो आप एक क्वासी जुडिशियल बॉडी हो, लेकिन उसका क्या अर्थ होता है? या तो आप जुडिशियल बॉडी हो, अगर आप जुडिशियल बॉडी हो तो योर अपॉइंटमेंट मस्ट बी फ्री फ्रॉम एग्जीक्यूटिव इन्फ्लुएंस। Okay, if you are a judicial body, your appointment must be free from executive influence. उसके लिए हमने आपको बोला था इस वाले केस में संपत कुमार में कि आप एक एनटीसी बना दो, अपॉइंटमेंट एग्जीक्यूटिव इन्फ्लुएंस से फ्री करो और बना दो ट्राइब्यूनल को जुडिशियल बॉडी, और फिर हाई कोर्ट की अपील हटा दो, कोई दिक्कत नहीं है. We are happy to hear the fact that you have a high court like body which can function as an expert set and high court is relieved of its powers. दोनों की पावर अलग अलग कर दो और कोई अपील मत डालो हाई कोर्ट पे, बस सुप्रीम कोर्ट में एक अपील डाल देना अगर चाहो तो. जुडिशियल बॉडी बना दो, कोई दिक्कत नहीं है. वी आर नॉट अगेंस्ट इट, इज व्हाट द सुप्रीम कोर्ट सेड इन संपत कुमार. बट बिकॉज नो इंडिपेंडेंस ऑफ जुडिशरी वाज असर्टेड, तो एल चंद्र कुमार में 1997 में, दिस वाज 1985, in 1997 the Supreme Court in what is known as the L Chandra Kumar case then started thinking कि देखो भाई, अगर ट्राइब्यूनल्स आपके जुडिशियल बॉडी नहीं है क्योंकि इंडिपेंडेंस ऑफ एग्जीक्यूटिव नहीं है, तो इट इज नॉट अ जुडिशियल बॉडी, राइट? तो अगर ये जुडिशियल बॉडी नहीं है तो एग्जीक्यूटिव बॉडी होने चाहिए. और क्योंकि हर एग्जीक्यूटिव बॉडी, मतलब कोई भी अगर एग्जीक्यूटिव बॉडी है, अगर उसके ऑर्डर से किसी व्यक्ति का फंडामेंटल राइट या लीगल राइट, किसी व्यक्ति का फंडामेंटल राइट या लीगल राइट वायलेट होता है, तो वो हाई कोर्ट में और सुप्रीम कोर्ट में अर्जी लेके जा सकता है. उस अर्जी को हम कहते हैं रिट पिटिशन. तो सिमिलरली इफ अ पर्सन हु गोज टू द ट्राइब्यूनल, जैसे मान के चलिए मैं ट्राइब्यूनल के पास गया और मैंने ट्राइब्यूनल के पास जाके अर्जी दी कि मेरे को इस मैटर में रिलीफ दीजिए, ठीक. अब ट्राइब्यूनल ने एक ऐसा ऑर्डर दिया जो मुझे पसंद नहीं आया, मुझे लगा इट इज अगेंस्ट लॉ और इट इज अगेंस्ट माय फंडामेंटल राइट. देन अंडर आर्टिकल 32 and article 226 of the constitution I can take that order and file a writ against that order under article 32 and article 226, because the tribunal is just another administrative body. You see, you go to the bank, you apply for loan. If the bank doesn't give you loan, let's say for example because it is discriminating against you, you take the order of the bank of rejecting your loan and you file a writ petition to article 32 or article 226 saying that I have been discriminated against, right? So the Supreme Court and the High Court shall have the jurisdiction. But what the Supreme Court is saying is that the tribunal is then like a bank. It is not a judicial body, it is a bank. It is a kind of an executive body. If it gives an order, that order shall be subjected to a writ under article 226 and article 32 of the what you can call the Constitution of India, because we will consider this order of the tribunal as a what is known as a kind of a writ petition based appeal, that under 226 it can come टू द हाई कोर्ट एंड द सुप्रीम कोर्ट। ये सुप्रीम कोर्ट ने कहा था एल चंद्र कुमार केस में। और इसीलिए आज के समय में भी अगर आपको एक ट्राइब्यूनल के ऑर्डर से अपील लेनी है तो आप नॉर्मल अपील नहीं कर सकते, क्योंकि नॉर्मल अपील का कोई फंक्शन नहीं है, राइट। इनकम टैक्स ट्राइब्यूनल की जो अपील है वो इनकम टैक्स एपेलेट ट्राइब्यूनल पे जाती है, तो अपील के लिए अलग से ट्राइब्यूनल बना रखे हैं। लेकिन अगर आप ITAT इनकम टैक्स एपेलेट ट्राइब्यूनल के ऑर्डर से आप खुश नहीं है तो आपको रिट फाइल करनी पड़ेगी आर्टिकल 226 के अंदर हाई कोर्ट जाने के लिए और आर्टिकल 32 के अंदर सुप्रीम कोर्ट जाने के लिए। यू गेट द पॉइंट? दिस इज व्हाट आई एम ट्राइंग टू इन अ वे आइडेंटिफाई फॉर यू वेरी क्लियरली। If you take a look at this, UPSC Civil Services 2023, plea in Delhi High Court challenges Central Administrative Tribunal's refusal to stay prelims result, right? So people who went to the, what you can say, the High Court, first they went to the CAT, which says that CAT को बोला था कि CSAT का पेपर 2023 में बहुत डिफिकल्ट आया है, इसीलिए इस प्रकार का डिफिकल्ट पेपर अगर आपको देना है तो पहले से सिलेबस में डाल दो कि बच्चे अपीयर ही ना हो, ठीक है। अब ये लोग गए कैट के पास, सेंट्रल एडमिनिस्ट्रेटिव ट्राइब्यूनल के पास। सेंट्रल एडमिनिस्ट्रेटिव ट्राइब्यूनल ने बच्चों को बोला गो टू हेल, मतलब कुछ नहीं हो सकता इस मैटर में, जाओ यहाँ से। अब जो कैट है, ट्राइब्यूनल है, उसका ऑर्डर लेके बच्चे गए हाई कोर्ट के पास, दिल्ली हाई कोर्ट के पास, रिट पिटिशन डाल के आर्टिकल 226 के अंदर। तभी यहां लिखा है अ पिटिशन हैज बीन फाइल्ड बिफोर द दिल्ली हाई कोर्ट challenging Central Administrative Tribunal's refusal to grant interim relief in the plea seeking reduction in the cutoff from 33% to 23% for qualifying part 2 of the CSAT examination. You see the point? This is a example I'm giving because you can relate to it. और ये current updates में भी है, क्या पता UPSC अपने पे प्रश्न पूछ ले. It is a very mysterious body. It is a very humorous body also sometimes. So in that sense, this is how you go to the High Court today. If a question comes, let's say for example in a prelims examination, if the question comes, can a appeal be filed from an order of a tribunal to a high court? The answer is yes and no, because it is not an appeal, it is a writ petition. Okay, but that writ petition has a function of an appeal. So the order of the tribunal can be reviewed by a high court or by the Supreme Court, not by a standard of appeal. जैसे आपने लोअर कोर्ट से ऑर्डर लिया, लोअर कोर्ट की जो अपील है वो आपकी हाई कोर्ट में जाती है और हाई कोर्ट की अपील सुप्रीम कोर्ट में जाती है, तो ये तो अपील कहते हैं। लेकिन यहां पर जो होता है एडमिनिस्ट्रेटिव ट्राइब्यूनल या फिर कोई और ट्राइब्यूनल, अगर इसका कोई ऑर्डर होता है वो पेटिशन के माध्यम से जाता है ऊपर, क्योंकि एडमिनिस्ट्रेटिव ट्राइब्यूनल को एक एडमिनिस्ट्रेटिव बॉडी की तरह ट्रीट किया जाता है। इट इज नॉट कंसिडर्ड अ जुडिशियल बॉडी। और अगर कोई भी एडमिनिस्ट्रेटिव बॉडी अगर किसी प्रकार का ऑर्डर देती है तो उस ऑर्डर के प्रोपोजिशन में, मतलब उस ऑर्डर के एक्टिविटी में जो पेटिशन फाइल होती है हाई कोर्ट में जाने के लिए, उसे रिट पेटिशन कहते हैं। Do you get the point? So that's basically what we understand from the context of what is known as the L. Chandra Kumar case, and this is the case which prevails today in terms of understanding how high courts and the Supreme Courts can have a appeal mechanism by which these decisions of the tribunals can be taken to these respective courts. Do I make myself clear, class? ठीक है, तो ये वाला जो एक आप देख रहे L. Chandra Kumar में, if you take a look at this, whether the power conferred upon parliament or state legislature as the case may be by subclause of 2, मतलब मैंने आपको पढ़ाया था 323A और B में, totally exclude the jurisdiction of all courts except that the Supreme Court under Article 368 in respect of disputes and complaints referred to in clause 1 or with regard to all or any of the matters specified in Article 323B runs counter to the power of judicial review conferred on the High Court under Article 226 and on the Supreme Court under Article 32 of the Constitution. तो यहाँ पे इस वाले केस में इन लोगों ने बताया था कि जो आपका हाई कोर्ट और सुप्रीम कोर्ट का रिव्यू की पावर्स है आर्टिकल 32 और आर्टिकल 226 में, उनको ट्राइब्यूनल्स नहीं वायलेट कर सकते। अपील ना लगाओ तो ठीक है, लेकिन क्योंकि ट्राइब्यूनल जुडिशियल बॉडीज है ही नहीं, ये एग्जीक्यूटिव बॉडीज हैं, इसीलिए आप ये नहीं कह सकते कि जो हाई कोर्ट और सुप्रीम कोर्ट का जुरिस्डिक्शन है वो नहीं आप हटा सकते। ठीक है, ये वाला देखो, इसमें क्या लिखा है इसमें केस में, द jurisdiction conferred upon the high courts under article 226 and upon the supreme court under article 32 of the constitution is part of the inviolable basic structure of our constitution. While this jurisdiction cannot be ousted, other courts and tribunals may perform as supplementary roles in discharging powers conferred by articles 226 and article 32 of the constitution. The tribunals created under Article 323 and 323b of the Constitution are possessed of the competence to test the constitutional validity of a statutory provision and rules. All decisions of these tribunals, however, will be subject to scrutiny before a division bench of the High Court within whose jurisdiction the concerned tribunal falls. The tribunals will nevertheless continue to act like courts of first instance in respect of the areas of law for which they have been constituted. It will therefore be open for litigants to directly approach the High Courts even in cases where they question the bias of statutory legislations, except where the legislation which creates a particular tribunal is challenged by overlooking the jurisdiction of the concerned tribunal. Section 5 subsection C is valid and constitutional and is interpreted in manner we have indicated. ठीक है, तो बस this is basically what we understand with regard to a question which is going to be a very important and a complicated question, that how do you have an appeal by which you can go and take an order of a tribunal to a high court or a supreme court. The answer is article 226 and article 32 of the constitution. This is how orders of a tribunal can be subjected to appeal before a high court or the supreme court. Do you get the point? And also the question is very simple, that it is a division bench. Okay, so just in a kind of a little bit of a passing remark, if I can tell you, when we take a look at article 145 clause 3 of the constitution, right? So now I'm taking a look at article 145 clause 3. When we are taking a look at article 145 clause 3 of the constitution, वन 45 clause 3 of the constitution says, अच्छा ठीक है, जो डिवीजन वाला बेंच वाला है ना, इसको थोड़ा सा भी रखिए अपने दिमाग में, मैं इसको दोबारा समझाऊंगा पूरा कि डिवीजन बेंचेस क्या क्या होती हैं और इसमें कॉन्स्टिट्यूशन बेंच क्या होती है, कैसे बनती है, कौन से मैटर्स होते हैं, इन सब चीज़ों पे मैं एक छोटा सा पॉइंट अभी इसके तुरंत बाद डिस्कस करूंगा। एक बार हम ट्राइब्यूनल वाला पूरा चैप्टर खत्म कर देते हैं, ठीक? तो अब आप समझ गए इसके बाद क्या क्वेश्चन आता है। तो आज के समय में हाई कोर्ट की जो पावर है वो किसी भी तरह से यूसर्प नहीं की जा सकती है आर्टिकल 226 और आर्टिकल 32 के अंदर सुप्रीम कोर्ट की बाय अ ट्राइब्यूनल। पेटिशन कैन बी फाइल्ड in that sense, right? Now let me just get a sense of what we have to do next about this. भारत सरकार ने 2021 में एक ऑर्डिनेंस निकाला था जिसका नाम था ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस। ठीक है, अब हम ये सारा जो हिस्टोरिकल बैकग्राउंड है इसको थोड़ा कवर करने के बाद हम थोड़ा आज के समय पे आते हैं। भारत सरकार ने, द गवर्नमेंट ऑफ इंडिया इन 2021 मेड एन ऑर्डिनेंस नोन एज द ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस 2021। ठीक है, और ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस में भारत सरकार ने दो चीजें करी। पहली चीज जो इन्होंने करी वो थी रैशनलाइजेशन ऑफ ट्राइब्यूनल्स। बहुत सारे ट्राइब्यूनल्स जो बने हुए थे उनको बंद कर दिया और उनके काफी सारे फंक्शंस को बाकी बचे हुए ट्राइब्यूनल्स में दे दिया। तो भारत सरकार का कहना यह था कि देयर हैज बीन अ प्रोलिफरेशन ऑफ ट्राइब्यूनल्स, बहुत सारे ट्राइब्यूनल्स बन चुके हैं और एक के बाद एक सरकार ने बहुत सारे ट्राइब्यूनल खड़े कर दिए। तो व्हाट गवर्नमेंट ऑफ इंडिया डिड वाज 50-60 ट्राइब्यूनल उठाए, उनको बंद कर दिया और उनके पावर्स 3-4 ट्राइब्यूनल को दे दिए कि इसकी पावर ये देखेगा, इसकी पावर ये देखेगा। इट काइंड ऑफ रैशनलाइज्ड द ट्राइब्यूनल्स। दिस वाज द फर्स्ट थिंग दैट दे डिड इन क्रिएशन ऑफ व्हाट इज नोन एज रिफॉर्म्स। और उसके बाद क्या किया, द सेकंड थिंग that the government of India created. Now please take a look at this in a very simple specific manner. I'm pointing it out as very important for the prelims examination. The government of India created what is known as a search cum selection committee. They created what is known as a search cum selection committee. A search cum selection committee has been created by the government of India under the Tribunal Reforms Ordinance, which is supposed to be the principal body that will decide the appointment of members to various tribunals. ठीक है, तो मतलब आप ये समझिए कि इफ यू नो फॉर एग्जांपल व्हाट द एनजेएसी इज, नेशनल जुडिशियल अपॉइंटमेंट कमीशन, एक तरह से आप इसको मान सकते हैं इट इज लाइक एन एनजेएसी फॉर ट्राइब्यूनल्स, कि भारत सरकार ने कहा कि जो भारत के जितने भी ट्राइब्यूनल्स हैं उनकी जो अपॉइंटमेंट होगी वो एक कमिटी के द्वारा होगी, उसका नाम होगा सर्च कम सिलेक्शन कमिटी. Okay, I am repeating it again. The government of India said that all the tribunals in India shall be given appointments by a committee which is known as search cum selection committee. Clear? And this search cum selection committee, I'll show you the composition of it, will be the principal body that will decide the appointment of the members to various tribunals. So मान के चलिए ITAT के ट्राइब्यूनल की भर्ती करनी है तो ये बॉडी करेगी, बॉडी नाम सजेस्ट करेगी और उसी नाम को रेकमेंड करके भर्ती किया जाएगा, राइट? तो जैसे कोलेजियम आज के टाइम में है वो सुप्रीम कोर्ट के जजेस की भर्ती कराता है, उसी तरह से एक एनजेएसी व्हाट यू कैन कॉल अ सर्च कम सिलेक्शन कमिटी विल बी क्रिएटेड. तो अगेन आई एम हाइलाइटिंग दिस नेम एज इंपॉर्टेंट. द ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस क्रिएटेड द 2021 सर्च कम सिलेक्शन कमिटी. ठीक है, अब I'm going to show you the composition of the search cum selection committee very quickly to take a look at this. देखिए इसको थोड़ा सा, ट्राइब्यूनल रिफॉर्म ऑर्डिनेंस में सर्च कम सिलेक्शन कमेटी बनाई गई थी. अब आप चाहें तो इसका स्क्रीनशॉट ले लीजिए, ये आपके प्रीलिम्स के लिए इंपॉर्टेंट है. सर्च कम सिलेक्शन कमेटी का नाम आ सकता है, एनटीसी नहीं बनाया सरकार ने, नेशनल ट्राइब्यूनल्स कमीशन नहीं बनाया है, उसकी जगह सरकार ने सर्च कम सिलेक्शन कमेटी बनाई है. ठीक है, तो जो सुप्रीम कोर्ट का सुझाव था कि एनटीसी बनाना चाहिए वो सरकार ने नहीं बनाया है, उसकी जगह सरकार ने सर्च कम सिलेक्शन कमेटी बनाई है. Search cum selection committee under the Tribunal Reforms Act, Tribunal Reforms Bill, is what is basically responsible for creating Search cum selection committee for the Tribunal Reforms Act and Tribunal Reforms Bill is the body which is supposed to be in the principal association of creating the appointment of the members of tribunal. ठीक है? Do we understand the point? You want to take a snapshot of this part along with the composition. ठीक है? So the committee will consist of the Chief Justice of India or a judge of a Supreme Court nominated by the Chief Justice of India as the chairperson. ये चीजें आपको थोड़ी याद करनी पड़ेंगी, प्रीलिम्स के लिए इंपॉर्टेंट हाईलाइट कर रहा हूं, करंट अफेयर में है और स्टैटिक पोर्शन में भी है, दोनों में है. It is an ideal recipe for a prelims question. The name of the search cum selection committee is a principal body which shall be responsible for the appointment of the tribunal members on all tribunals in India. And second, the composition of the what you can call search cum selection committee is the Chief Justice of India or a Supreme Court judge nominated by him shall be the chairperson. 2 secretaries nominated by the central government. The sitting or outgoing chairperson or a retired Supreme Court judge or a retired Chief Justice of a High Court सेक्रेटरी ऑफ मिनिस्ट्री अंडर विच द ट्राइब्यूनल इज कॉन्स्टिट्यूटेड विद नो वोटिंग राइट। इसको आपको पूरा अच्छे से मेमोराइज करना है, ठीक है। ये सरकार का प्रस्ताव है कि ट्राइब्यूनल रिफॉर्म्स करने के लिए, मतलब ट्राइब्यूनल रिफॉर्म्स का मतलब है कि ट्राइब्यूनल को और ज्यादा इंडिपेंडेंट बनाने के लिए और एग्जीक्यूटिव इन्फ्लुएंस से मुक्त कराने के लिए आप किस प्रकार से ट्राइब्यूनल के मेंबर्स की जो भर्ती है उसको आप निष्पक्ष करा सकते हो। और सरकार का प्रस्ताव नेशनल कमीशन फॉर ट्राइब्यूनल्स नहीं है। NTC is not the proposition given by the government of India. Instead, the government of India has created a search cum selection committee. And the argument that the government of India has given is that search cum selection committee will be an independent body free from executive influence that will be able to select the members of tribunals only on the basis of merit. ठीक है, this is basically what is the whole idea about a search cum selection committee. इसको आप पूरा चाहे तो इसका स्क्रीनशॉट ले लीजिए, चाहे नहीं तो मैं आपको इसका एक हाइपरलिंक फॉरवर्ड कर दूंगा बाद में, उसमें देख लीजिएगा। The whole idea of a search cum selection committee is given over here. ठीक है, राइट। और इसके बाद आप ये देखेंगे कि जो ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस था जो बाद में बिल बन के आया था, उसने बहुत सारे ट्राइब्यूनल्स को बंद कर दिया। तो फॉर एग्जांपल द बिल रिमूव्स एयरपोर्ट एपेलेट ट्राइब्यूनल, एपेलेट बोर्ड एस्टैब्लिश्ड अंडर ट्रेडमार्क्स एक्ट, द अथॉरिटी ऑफ एडवांस्ड रूलिंग एस्टैब्लिश्ड अंडर इनकम टैक्स एक्ट, द फिल्म सर्टिफिकेशन एपेलेट ट्राइब्यूनल एंड ऑल ऑफ दीज। मतलब इसके अलावा ये जो मेजर इंपॉर्टेंट ट्राइब्यूनल्स थे जो सरकार ने बंद कर दिए। तो अगर क्वेश्चन ऐसा आता है, इफ अ क्वेश्चन इज आस्क्ड व्हिच ऑफ द फॉलोइंग आर द ट्राइब्यूनल्स व्हिच हैव बीन abolished or shut down by the government of India, these are the ones which have been shut down, right? तो जो ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस था जो बाद में बिल बन गया, उसके दो वो थे, दो लक्ष्य थे। पहला था to regulate the way in which appointment to the tribunals in India is going to be conducted, and they created a search cum selection committee which is not the same thing as a NTC. और दूसरा, ये जो आप देख रहे हैं बोर्ड पे, इनको एक बार स्नैपशॉट में डाल लीजिए अपने साथ। These are the tribunals which the government of India abolished under the Tribunal Reforms Act. ठीक, अब समझे। अब जो ये ट्राइब्यूनल रिफॉर्म्स ऑर्डिनेंस था, दिस ऑर्डिनेंस गॉट चैलेंज बिफोर द सुप्रीम कोर्ट। इसको सुप्रीम कोर्ट के सामने चैलेंज कर दिया गया, सुप्रीम कोर्ट के सामने ले जाया गया इसको ये कह के, दिस लॉ, दिस एक्ट गॉट चैलेंज बिफोर द सुप्रीम कोर्ट। इट वेंट टू द सुप्रीम कोर्ट, went before the Supreme Court stating that कि ये जो आपकी सर्च कम सिलेक्शन कमिटी है, दिस इज नथिंग बट अनदर वे ऑफ सेइंग कि एग्जीक्यूटिव ही करेगा। मतलब इसका जो कॉम्पोजिशन है वो इस तरह से बनाया है कि एग्जीक्यूटिव ही ट्राइब्यूनल के ऊपर अपना कंट्रोल रखेगा इस कमिटी के माध्यम से भी, क्योंकि सरकार के बहुत सारे लोग इस कमिटी में बैठे हुए। यू सी द पॉइंट? सो द आइडिया इज that the Supreme Court was taken the Tribunal Reforms Ordinance in 2021, and the Supreme Court was put the question that this search cum selection committee is nothing but executive influence over the members of tribunals. तो reforms के नाम पे जहां पर NTC आना चाहिए था, वहां सरकार ने SC/SC लगा दिया, और NTC जो करना चाहती थी वो SC/SC नहीं कर पाएगी। That after the SC/SC the reforms will not happen actually, and nothing but executive influence will remain. You will have a clear case of executive influence will still remains on these matters. Okay, and thus the Supreme Court के सामने ये वाला केस गया, और सुप्रीम कोर्ट ने what is known as the Madras Bar Association versus Union of India में इस ऑर्डिनेंस को स्ट्राइक डाउन कर दिया। सुप्रीम कोर्ट स्ट्रक डाउन दिस ऑर्डिनेंस एज अनकॉन्स्टिट्यूशनल। मतलब सुप्रीम कोर्ट ने इस ऑर्डिनेंस को पूरी तरह से स्ट्राइक डाउन नहीं किया, लेकिन सुप्रीम कोर्ट में जो सर्च कम सिलेक्शन कमेटी का क्राइटेरिया था ना, ये वाला, ये स्ट्राइक डाउन कर दिया। उन्होंने कहा कि सर्च कम सिलेक्शन कमेटी इज डूइंग नथिंग बट गिविंग द पावर्स ऑफ द ट्राइब्यूनल्स, पावर्स ओवर द ट्राइब्यूनल्स अगेन टू द एग्जीक्यूटिव, देयरफॉर इट इज नॉट अ रिफॉर्म ऑफ एनी काइंड। This tribunal reforms ordinance is only giving the power of having control over tribunals to the executive again, and therefore it is not a reform. And the Supreme Court again started pressing for the creation of a NTC, a National Tribunals Commission. सुप्रीम कोर्ट ने कहा कि आप NTC बनाइए, NTC के अलावा किसी भी तरह से ट्राइब्यूनल्स को इंडिपेंडेंट फंक्शन में नहीं डाला जा सकता. प्लीज क्रिएट अ नेशनल ट्राइब्यूनल्स कमीशन. दिस इज नॉट गोइंग टू बी सफिशिएंट. ठीक है. पार्लियामेंट ने क्या किया, मतलब गवर्नमेंट ने क्या किया, उस स्ट्रक डाउन ऑर्डिनेंस को, द स्ट्रक डाउन ऑर्डिनेंस, the ordinance which was struck down by the Supreme Court was again introduced as a bill in the parliament. Struck down ordinance was again introduced as a bill in the parliament. Struck down ordinance was again introduced as a bill in the parliament, and this time the name of the bill was Tribunal Reforms Act और Reforms Bill. ठीक है, ये बिल आया, पार्लियामेंट ने बिल पास कर दिया और ये एक्ट बन गया. इसको कहते हैं हम ट्राइब्यूनल रिफॉर्म्स एक्ट 2021. We call this the Tribunal Reforms Act 2021. This Tribunal Reforms Act 2021 again created the concept of a search cum selection committee, even despite the fact that the Supreme Court had refused to let a search cum selection committee function, because according to the Supreme Court, the search cum selection committee is just eyewash. It is not giving any power or any independence to the tribunals. It is putting tribunals again under the control of the executive. So it's like an NJAC for tribunals. Supreme Court ने ये कहा था कि जैसे NJAC बना के आप कह रहे थे कि आप सुप्रीम कोर्ट के जजेस का अपॉइंटमेंट निष्पक्ष कर देंगे, लेकिन NJAC में सबसे ज्यादा पावर एग्जीक्यूटिव को ही दे रखी है, उसी तरह से सर्च कम सिलेक्शन कमेटी में भी आप NJAC वाला काम कर रहे हैं. आप कह रहे हैं कि पावर दी जाएगी, निष्पक्षता से काम किया जाएगा, लेकिन साफ बात है कि जितने लोग इसमें बैठे हैं ऑलमोस्ट सब लोग सरकार के फेवर में ही जाएंगे. द गवर्नमेंट ऑफ इंडिया is going to be finally at the helm of deciding what kind of members are to be appointed on a tribunal, right? So the Tribunal Reforms Act again reintroduced the search cum selection committee, और ये Tribunal Reforms Act फिर से सुप्रीम कोर्ट के सामने चैलेंज हो गया. Again it was subjected to a challenge before the Supreme Court. अब सुप्रीम कोर्ट के सामने ये Tribunal Reforms Act is now pending. The Tribunal Reforms Act before the Supreme Court is currently pending. Supreme Court के सामने pending पड़ा हुआ है Tribunal Reforms Act, और Supreme Court ये कह रहा है कि दो क्वेश्चन है. पहला, सर्च कम सिलेक्शन कमिटी कॉन्स्टिट्यूशनली वैलिड है क्या, जो कि सुप्रीम कोर्ट पहले ही बोल चुका है कि नहीं है. दूसरा जो इंपॉर्टेंट क्वेश्चन सुप्रीम कोर्ट के सामने पेंडिंग पड़ा है वो ये है कि if an ordinance has been struck down, by the parliament, by the Supreme Court, can the provision of such ordinance, can the provisions of such ordinance be reenacted by passing a law? ये दो क्वेश्चन सुप्रीम कोर्ट के सामने आज के टाइम में पेंडिंग पड़े हैं. ठीक है, तो सर्च कम सिलेक्शन कमेटी को तो सुप्रीम कोर्ट इनवैलिड करने पे तुला हुआ है. and Supreme Court is pressing for the creation of a National Tribunals Commission, without which it will not be able to satisfy that there is any kind of a independence which is being given to the members of tribunals. सुप्रीम कोर्ट कह रहा है कि जब तक एनटीसी नहीं बन जाएगा तब तक हमें कोई विश्वास नहीं आएगा कि ट्राइब्यूनल के मेंबर्स इंडिपेंडेंटली हो रहे हैं. सर्च कम सिलेक्शन कमेटी नाक को ये पकड़ने वाली बात है. एग्जीक्यूटिव ऐसे पकड़ सकता है, ऐसे पकड़ सकता है, ऐसे पकड़ता है तो डायरेक्टली कर रहा है, ऐसे पकड़ रहा है तो सर्च कम सिलेक्ट कमेटी के माध्यम से कर रहा है. बट द फैक्ट रिमेन्स दैट द power with regard to appointing members of tribunals still is retained with the executive. It has not been given to anyone else but the executive. Okay, clear? Are we clear, class? And second important question is going to be this one, कि अगर एक बार सरकार ने जो कोई ऑर्डिनेंस निकाला, अगर सुप्रीम कोर्ट ने ऑर्डिनेंस को स्ट्राइक कर दिया डाउन, तो क्या सरकार उस ऑर्डिनेंस की प्रोविजंस को बिल बना के पास कर दे सकती है कि नहीं? मतलब इफ अ provision which has been made by an ordinance has been struck down by the Supreme Court, can the government create a bill and reenact the same provisions which were struck down by the Supreme Court in a particular matter? This has to be decided by a 3 judges bench of the Supreme Court, right? So this is the case that I'm actually taking a look at. शुरू से वाला केस आपके सामने रख रहा हूँ. ये वाला केस आज के समय में पेंडिंग है, इसीलिए इसके आसपास के करंट अपडेट्स आपके सामने देखते रहेंगे. हो सकता है 1-2 महीने में कभी ना कभी इसका जजमेंट आ जाए. इलेक्शन से पहले आना मुश्किल है, बट इट इज पॉसिबल दैट यू कैन हैव अ जजमेंट ऑन दिस. बट nonetheless, because this case was in news a lot, this becomes a part of the current updates. The name of the case is Madras Bar Association versus Union of India, right? Take a look at this. The court will decide whether the Tribunal Reforms Act is unconstitutional for reenacting provisions that were struck down in Madras Bar Association for violating independence of the judiciary. You see, search cum selection committee is violating independence of the judiciary. You have 3 judges bench which are governing the Supreme Court. Okay. Okay, so this is the entire part of tribunals which I am trying to cover with you. इससे एक क्वेश्चन मेरे ख्याल से 1 से 2 क्वेश्चन इसमें आने की बहुत पूरी संभावना है, जितना भी हमने इसमें किया है. ठीक है, तो एक बार आप समरी ले लीजिए इसका दोबारा से. I feel that this is an important current update with the reading of the frequency of the newspaper, the kind of times it has appeared, and so many editorials have been written on the National Tribunals Commission, etc., etc. I personally feel this could be a big point in the prelims examination this time. So I would pay a little bit of an attention upon that. Static portion is 42nd Constitution Amendment Act 1976, Swaran Singh Committee, Article 323A and B, quasi-judicial body. What is the nature of a quasi-judicial body? Conceptual understanding of a quasi-judicial body, and constitutional issues and landmark judgments, in which we have discussed SP Sampath Kumar and the L. Chandra Kumar case, both of them landmark judgments given by 5 judges bench each. And in current affairs, we have taken a look at Tribunal Reforms Act 2024 and the way in which this particular act is currently pending before the Supreme Court for review, right? And this is what basically we have taken a look at the entire information around the tribunals, how it works. ठीक है, चलिए अब इसके साथ ही मैं आपको ना बस एक मिसलेनियस सा कुछ एक पॉइंट बता देता हूँ. Let's say, because we are looking at what you call that matters of what basically we are saying is that orders of tribunals can only be tried by यहाँ पर ये शब्द लिखा उसे कहते हैं डिवीजन बेंच ऑफ अ हाई कोर्ट, है ना. तो इस तरह का अगर कोई एक मल्टीपल चॉइस क्वेश्चन में टर्म आ जाता है दैट अ डिवीजन बेंच ऑफ अ हाई कोर्ट is supposed to be the one which is in a way taking a look at this particular part. ठीक है, तो we'll take a look at what the benches of the high court are. मतलब हाई कोर्ट और इवन सुप्रीम कोर्ट में क्या क्या बेंचेस किस प्रकार से होती है, राइट. सो आई एम गोइंग टू इन अ वे look at what is known as article 145 clause 3 of the constitution, which talks about benches of the supreme court. Let's say जब भी हम देखते हैं कि 2 जज बेंच है, 3 जज बेंच है, 4 जज बेंच है, 5 जज बेंच है, एटसेट्रा एटसेट्रा, उसको हम क्या क्या नाम देते हैं, हम सुप्रीम कोर्ट के लेवल का ही पढ़ेंगे इसमें. ठीक है. सो लेट्स से फॉर एग्जांपल इफ आई कॉल इट, if you have one judge bench, if you have one judge, it is called a single judge bench. Class, please take note of this clearly, right? A single judge bench, single bench you can call it, sorry, single judge bench. If there is only one judge, you can call it a single judge bench. If there are two judges, or if there are three judges, अगर किसी बेंच पे 2 जज बैठे हैं या 3 जज बैठे हैं, तो उस बेंच को कहा जाता है डिवीजन बेंच. ठीक है, समझ पा रहे हैं इस बात को. अगर किसी एक बेंच पे 2 जज बैठे हैं या 3 जज बैठे हैं, तो उस बेंच को बोला जाता है डिवीजन बेंच. सो either 2 judges are sitting on a bench or 3 judges are sitting on a bench, that bench is understood to be a division bench. Are we clear? Okay, ठीक है. If it is a 5 judge bench, then you know that everything which is 5 or 7 or 9 or 11 or 13, maximum is 13. We have maximum bench that we have seen is 13. If it is a 5, 7, 9, 11 judge bench, then it is what is known as a constitution bench. ठीक है, this is what is known as a constitution bench. So as we have seen, for example, in the cases of SP Sampath Kumar and in the cases of L Chandra Kumar, and even in the recent case of electoral bonds, you had 5 judges sitting at a bench, and that was a constitution bench. A superior bench than a 5 judge bench is a 7 judge bench. A superior bench than a 7 judge bench is a 9 judge bench. A superior bench than a 9 judge bench is an 11 judge bench, and a superior bench than a 11 judge bench is a 13 judge bench. Okay, so this is how the bench is divided between what you call the this is how the bench is divided with regard to the Supreme Court, right? So for example, if you take what is the definition of a constitution bench, अगर मान लीजिए composition तो पता चल गया आपको कि the composition of constitution bench is that it should have minimum 5 judges, right? So if a question is asked on what is a composition of a constitution bench, you know the answer that it must have minimum of the 5 judges. That is the definition of a composition of the constitution bench. But if I have to take a question as to what is the function of the constitution bench, मतलब constitution bench किस किस प्रकार की चीजों के लिए बनाई जाती है, we'll just take a look at article 145 clause 3. ठीक है, मैं आपको थोड़ा सा बताऊंगा इस बारे में प्रॉपरली. कुछ कुछ टर्म्स हैं जो कि प्रीलिम्स के लिए इंपॉर्टेंट है, इन चीजों से क्वेश्चन पूछे जाते हैं, कभी कभी हिडन फैक्ट्स होते हैं. देखिए, पहले हम आर्टिकल Okay, if you take a look at Article 132 of the Constitution, Article 132 says the appellate jurisdiction of Supreme Court in appeals from High Court in certain cases. An appeal shall lie to the Supreme Court from any judgment, decree, or final order of a High Court in the territory of India, whether in a civil, criminal, or other proceedings, in a case that involves a substantial question of law as to the interpretation of this Constitution. ठीक है, अब इसको देखिएगा जरा सा बात को. अगर कोई केस इस तरह से है which is involving this particular fact, substantial question of law as to the interpretation of the Constitution. If you see this particular phrase, please take a look at this particular phrase. This particular phrase can be repeated as it is in the prelims examination. अगर कोई केस वो है which involves a substantial question of law as to the interpretation of the Constitution, तब वो केस हाई कोर्ट से सुप्रीम कोर्ट में अपील किया जा सकता है ना. जैसे कि मान के चलिए कि संविधान में क्या लिखा है, अगर आपको ये पता करना है, जैसे फॉर एग्जांपल लेट्स से इन द शबरीमाला केस, द क्वेश्चन इज what is written under article 25 clause 1 and 25 clause 2 of the constitution. आर्टिकल 25 क्लॉज 1 में और आर्टिकल 25 क्लॉज 2 में संविधान में क्या लिखा हुआ है. द क्वेश्चन दैट वी आर आस्किंग इज व्हाट इज रिटन इन 25 clause 1 and 25 clause 2 of the constitution. You see, so in this way what you're doing is interpreting the constitution. So whenever we have a substantial question of law as to the interpretation of this constitution, that is when the Supreme Court's highest functions are given. Okay, so for example, if you take a look at article 145 clause 3, now take a look at this. This talks about a constitution bench. This is what talks about a constitution bench. Please take a look at this. If the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution, or for the purposes of hearing any reference under article 143, shall be 5. You see the point? So you have a constitution bench. अभी reference article 143 को छोड़ते हैं. A constitution bench can be created if it is supposed to hear a substantial question of law as to the interpretation of this constitution. मतलब अगर कोई इतना बुनियादी प्रश्न पूछा गया है कि हमको ये प्रश्न पूछना पड़ रहा है कि संविधान में आखिरकार लिखा क्या है. If some question has been asked in such a way that we have to ask that fundamental question as to what is written in the constitution, then that is a substantial question of law with regard to the interpretation of this constitution. अब ये जो phrase है ना, इसके साथ आप देखिए क्या लिखा है कि the minimum judges who are to sit in any of these cases shall be 5. मतलब आपकी जो कॉन्स्टिट्यूशन बेंच होती है वो यहाँ बनती है और कम से कम इस कॉन्स्टिट्यूशन बेंच पे 5 जजेस विराजमान होंगे. तो मतलब अगर प्रश्न पूछा जाए that if a question is raised to the Supreme Court which involves a substantial question of law as to the interpretation of this constitution, then that question is to be referred to a bench of 5 judges minimum, and that bench of 5 judges minimum which is referring to a substantial question of law as to the interpretation of this constitution shall call itself a constitution bench. Right? So whenever we are writing the term constitution bench, this is what we are referring. Class, do we understand the meaning of a term constitution bench? If a question comes, which of the following are the functions which have to be performed by a constitution bench? One of the functions is that a substantial question of law involving the interpretation of the constitution. Okay? मतलब संविधान में लिखा क्या है ये आपको एक बार दोबारा मुआयना करना है कि यहाँ पर अमेंडमेंट ऑफ द कॉन्स्टिट्यूशन लिखा है तो ऑफ का मतलब क्या हुआ. आर्टिकल 124 में विद कंसल्टेशन ऑफ द चीफ जस्टिस ऑफ इंडिया लिखा है तो कंसल्टेशन का मतलब क्या हुआ. When you're going to play with the words inside the constitution to apply an interpretation, that is what is known as this particular part, a substantial question of law as to the interpretation of this constitution. Do we understand this, class? And when you have to have a substantial question of law as to the interpretation of this constitution, the bench that you create to decide this answer is called a constitution bench. A constitution bench may be minimum of 5 but can be 7, 9, 11 and go up to 13. Are we clear, class? Do we have a good sense of this, class? A constitution bench, right? So one of the things that constitution bench can be established is, of course, what we see as a deciding the matters of a substantial question which are associated with the constitution. The other thing for which a constitution bench can be instituted is article 143, which is known as advisory jurisdiction. Okay? Now later on, maybe in the classes, you will take a look at what is known as advisory jurisdiction of the Supreme Court. या फिर थोड़ा सा मैं अभी डिस्कस कर सकता हूँ इसको advisory jurisdiction को हल्का सा. One nation, one election करूँगा, so I'll take a look at the advisory jurisdiction of the Supreme Court. Okay, so very simply, again, let me put it out briefly. If a question comes to you in the prelims examination with regard to this idea, अगर कोई अपील आ रही है हाई कोर्ट से और मतलब अगर कोई अपील आ रही है हाई कोर्ट से which does not involve a substantial question of law interpreting the Constitution of India, that appeal can be challenged before a one judge bench, a two judge bench or a three judge bench. अगर कोई रिट आ रही है तो वन जज के सामने जा सकती है, टू जज के सामने जा सकती है, थ्री जज के सामने जा सकती है. लेकिन अगर कोई ऐसा मैटर आ रहा है which is involving a substantial question of law regarding the interpretation of the Constitution, if such a question is coming which regards the substantial question of law with regard to interpretation of the Constitution, that can be taken minimum by a 5 judge bench, then 7, then 9, then 11, then 13. Clear? And this is what is known as a constitution bench, right? So for example, a question can be, on what purposes can a constitution bench or which of the following is correct about what is known as a constitution bench? अगर ये प्रश्न पूछा जाता है आपसे कि which of the following is correct about a constitution bench? A, it is minimum of 5 judges, then it is correct. Okay, 5 judge होने चाहिए कम से कम to compose a constitution bench. The maximum we have seen till now is 13, and 13 it was in the Keshwananda Bharati case, right? Keshwananda Bharati was the state of Kerala, which is the case in which the basic structure doctrine was created. This was the case which led to the creation of a 13 judge bench with regard to the constitution bench maximum strength. Okay, point number B about a constitution bench, as we can see it, if I take a look at point number B as a constitution bench, as we can see it, is going to be of the fact that it can be created for a substantial question involving the interpretation of the Constitution. Substantial question involving the interpretation of the Constitution. Okay. Point number C, after point number B, we can take a look at is that even for an advisory jurisdiction, under Article 143, for an advisory jurisdiction under Article 143, a constitution bench can be established. Okay, so for example of advisory jurisdiction is, let's say, in reference Berubari Union case. Berubari Union is an example of advisory jurisdiction of the Supreme Court, and also in reference you have, let's say, for example, the Advocates on Record Association, which was a 9 judge bench. In fact, in reference appointment of judges to the Supreme Court and High Court, ये लिख देता हूँ. (1993), in which the collegium system was created. In this, the collegium system was created. Class, do we understand? This is the kind of question that we are taking a look at in terms of in the UPSC prelims this time. Why am I saying this? Because as I showed you yesterday, 7 matters with 7 judge bench are coming out for listing, as the Supreme Court has said. One of them is AMU, which has already been heard by the Supreme Court, but the judgment has not been pronounced. The other is Nabam Rabia judgment. We have seen how a 7 judge bench is coming. So the concept of a constitution bench is becoming very important this time, because the Supreme Court has announced the creation of what you can call 7 matters which are going to be referred to the Supreme Court. This is the case that I took out yesterday, right? Passage of laws as money bills, सब categorization of scheduled caste and scheduled tribes, ये वाला क्वेश्चन भी आपने पूछा था मेरे से. ये सारे जो मैटर्स हैं ये 7 जज बेंच के सामने आ रहे हैं. ठीक है. पैसेज ऑफ लॉज ऑफ मनी बिल ये आएगा. ये आधार जो 5 जज का बेंच है उसका रिव्यू करने वाला मैटर है. सब क्लासिफिकेशन ऑफ शेड्यूल्ड कास्ट और शेड्यूल्ड ट्राइब्स, जो मतलब इसमें क्रीमी लेयर होनी चाहिए कि नहीं होनी चाहिए, ये आएगा मैटर इसमें. Interplay between breach of privileges of legislatures and citizens' fundamental rights. This is a very important matter in context of the Mahua Mitra case. Speaker's pen here disqualification petitions. ये वाला Nabam Rabia judgment है, right? And of course, there is a criteria for an educational institution to be tagged as a minority run. This is the AMU judgment. And the validity of the state laws to impose surcharge on sale tax. Right, these 7 judgments have been listed. What you can say, these have been listed as matters which have a substantial question of law regarding interpretation of the Constitution. राइट ठीक है. तो ये इसीलिए क्योंकि दिस इज अ काइंड ऑफ अ बिफोर द करंट चीफ जस्टिस ऑफ इंडिया इज retiring, he will possibly be able to, but he wants to dispose these matters before he retires. He retires in November 2024. तो नवंबर 2024 से पहले आपको धड़ल्ले से ये सारे जजमेंट्स आते हुए दिखेंगे. और क्योंकि ये हिस्टोरिकल नंबर ऑफ कॉन्स्टिट्यूशन बेंच बनाई है, तो इसीलिए it is possible for us to ensure that this is a question in the prelims examination this time as to what is a constitution bench. Class, do we understand this, the whole idea of a constitution bench and the points around it in concern of that? Okay, just a kind of a miscellaneous topic I wanted to take up in this particular matter. The government, the question that you ask about NTC, okay, maybe I can circulate a note upon this also. Okay. A case by the Supreme Court in Madras Bar Association. सुप्रीम कोर्ट के अपने खुद के शब्दों में यहाँ दे रखा है नेशनल ट्राइब्यूनल्स कमीशन के बारे में, एनटीसी के बारे में। ठीक है, इसको देख रहे हैं आप? We've discussed the L. Chandra Kumar case. Again, the Supreme Court had said something like this. ठीक है, तो यहाँ पे सुप्रीम कोर्ट ने पूरा चैप्टर लिखा है अपने जजमेंट में। अभी एक रिसेंटली एक केस आया था जिसमें ऑर्डिनेंस को स्ट्राइक डाउन किया था, उसमें साफ साफ सुप्रीम कोर्ट ने लिखा था दैट यू हैव अ नेशनल ट्राइब्यूनल्स कमीशन, improving the effective functioning of the tribunals and enhancing the public image of the tribunals. The mounting arrears in the tribunals is mainly due to the delay in filling up the vacancies of the presiding officers and members of the tribunals. The learned amicus curiae suggested that there should be a national tribunals commission manned by retired judges of the Supreme Court, Chief Justice of High Court, and members of the executive, which will have a full-time secretary performing the following functions. Right? तो ये functions है। तो आप जो question पूछ रहे हैं ना, उसका आंसर ये है कि this is supposed to be the set of functions of a proposed NTC. What the Supreme Court says, this is basically a NTC should look like: selection of candidate, reappointment of candidates, conductive of inquiry against members, sanction leave of members wherever necessary, monitor the functioning of the tribunals, in particular the arrears and disposal of cases and filling up of vacancies, ensure adequate infrastructure and IT support. You see? So, and if you look at a composition, this is what basically it is given. So, Supreme Court has already given a set of guidelines to the government of India as to how an NTC must be. And again, NTC is going to be very relevant coming up in the prelims examination this time, because every time we are mentioning the term tribunals and tribunal reforms, the question which is coming up is NTC. ठीक है? How is special? Achha, you will have a class on judiciary at the end of this. Raza sir will take the portion on judiciary. So you will have the doubts of judiciary addressed at the time towards the end. Okay. थोड़ा सा अभी इसमें जो बीच में एक मिसलेनियस पार्ट मुझे लगा था इंपॉर्टेंट है, मैंने बता दिया। बाकी सारे जो आपके हाई कोर्ट, सुप्रीम कोर्ट वगैरह के डाउट है, ये आप यू विल हैव टू पिन देम फॉर अ लिटिल लेटर ऑन। ओके, राइट। सो दिस, तो ये ट्राइब्यूनल्स का वाला पूरा खत्म हो गया। प्लीज इसको ढंग से कर लीजिएगा, प्रीलिम्स के क्वेश्चन आएंगे इस वाले में से शर्तिया तौर पे। ठीक है, अब if we take a look at a few things forward, okay, the one topic which I can finish in time, which is again relevant from the perspective of the prelims examination, because it is mixing both the criterias. It has a current update upon it and it has a very rich static portion upon it, is the cooperative societies. आप में से किसी ने बोला था मल्टी कोऑपरेटिव सोसाइटीज का जो पार्ट है उसको एक बार कवर कर लेते हैं। तो वी आर गोइंग टू टेक अ लुक एट व्हाट इज नोन एज द कोऑपरेटिव सोसाइटीज, राइट। सो वी आर लुकिंग एट पार्ट 9B ऑफ द कॉन्स्टिट्यूशन। इसका साइनॉप्सिस मैं आपको जल्दी से बनाता हूँ। लेट मी टेक अ लुक एट पार्ट 9B ऑफ द कॉन्स्टिट्यूशन। पंचायत के बाद कोऑपरेटिव लगाया गया है। ठीक है, कोऑपरेटिव्स भी थोड़ा सा न्यूज़ में ज़्यादा हैं इस बार, क्योंकि एक तो मल्टी स्टेट कोऑपरेटिव सोसाइटीज़ बिल पास किया है पार्लियामेंट ने इस बार मॉनसून सेशन में, और उसके अलावा जो सबसे नई मिनिस्ट्री है भारत सरकार के अंदर, द न्यूएस्ट मिनिस्ट्री विच इज़ अंडर द गवर्नमेंट ऑफ इंडिया is the Ministry of Cooperation. Okay, so we are going to take a look at that part also. Part 9b. Now I'm going to again detail out the, what you can say, synopsis of what you have to understand from the perspective of the cooperative societies. Okay, going to put out a little bit of a synopsis of what you can understand from the perspective of cooperative societies. The first thing that we can understand from this perspective is again the static portion. Okay, in static portion we take a look at what is known as the 97th Constitution Amendment Act. (2011). 97th Constitution Amendment Act 2011, which for the first time introduced the concept of cooperatives. पहली बार जो cooperatives की बात की थी वो 97th Constitution Amendment Act ने की थी. Right? There was no concept of a cooperative in the Indian Constitution in original draft. Even in the 73rd and 74th Constitution Amendment Acts, which created the panchayats and the municipalities at the local level, which added Part 9 and Part 9b of the Constitution, even they did not talk about a system called the cooperatives. जो सहकारी, जो मतलब the whole idea of creating a cooperative society, सहकारी व्यवस्था बनाने का जो पूरा point है, that was not done by the original Constitution of India. It was done merely by the 97th Constitution Amendment Act, which added the term cooperative by including it in Part 9b of the Constitution. ठीक है, तो Part 9b Constitution का यहाँ पर create किया गया था. So you can see Part 9b of the Constitution inserted in the Constitution by 97th Amendment Act 2011. जाहिर सी बात है कि जो ये वाला पॉइंट है ये हम एक करेंगे. ठीक है, the first thing is going to be taking a little bit of a look at this Amendment Act and the logic behind it, and second we'll take a look at what is known as the judgment of the Gujarat High Court and the Supreme Court on this matter. The very important judgment of Rajendra N. Shah versus Union of India. First, it is a matter of the Gujarat High Court in 2011, but then the Supreme Court of India in 2021 has revisited this judgment, right? And this basically is a judgment which is a landmark judgment again by the Supreme Court, which talks about the constitutionality, or what you can say, the constitutional validity of Part 9b. तो ये जो हमारा Part 9b है ना, इसको उसकी संवैधानिकता के लिए प्रश्न चिन्ह लगाया गया है इसके ऊपर इन द राजेंद्र एन शाह वर्सेस यूनियन ऑफ इंडिया जजमेंट 2011 एंड 2021. ठीक है, तो ये वाली एक चीज आपको याद रखनी पड़ेगी थोड़ी सी. और उसके बाद जो हमारा करंट पोर्शन है, in our current portion in this particular matter, we are going to take a look at, for example, point number 1 on what is understood as the Ministry of Cooperation. जो भारत सरकार ने एक मिनिस्ट्री बनाई है, मिनिस्ट्री ऑफ कोऑपरेशन, इसके ऊपर हम थोड़ी सी डिटेल लेंगे क्योंकि ये मिनिस्ट्री काफी हद तक न्यूज में रही है. एंड सेकेंड थिंग दैट वी आर गोइंग टू टेक अ लुक एट इज मल्टी स्टेट कोऑपरेटिव सोसाइटीज एक्ट. This is an act which has been passed by the parliament recently, and therefore this act which is passed by the parliament can be a very clear update in the current affairs. Okay, so in that sense, हाँ, लोकसभा एथिक्स कमेटी हम करेंगे, वो पार्लियामेंट्री प्रिविलेजेस और महुआ मित्रा वाला पूरा केस करेंगे हम, डिस्क्वालिफिकेशन एक्सपल्जन वाला. We'll take it up, don't worry, it's on my list. Okay, draw this synopsis a little bit so I can move forward. Now I hope that you're coming to terms with the logic that I'm applying in dealing with a lot of these subjects in the paper of the constitution. My idea is, rather than covering the static portion and current portions as a list separately, I'm trying to create items which have a very clear relevance from both the current and the static portion, so that we have material that we study in the classroom which you are able to answer the questions from directly in the prelims examination. It's trying to read the intuition of the UPSC. आप UPSC का मन पढ़ने की कोशिश करते हैं यहाँ पर, और आप ये देखने की कोशिश करते हैं कि UPSC ने पिछले वर्षों में जो प्रश्न पूछे हैं उनसे हमें क्या आकलन लगता है कि UPSC इस वर्ष हमसे किस किस प्रकार के प्रश्न पूछ सकती है. We are trying to determine by this kind of a exercise, we're using the patterns that have appeared in the UPSC examination in the previous years and trying to understand what is the mindset with the UPSC asks the questions, and that is what I'm trying to replicate in this. And that's what exactly the formula is, that it has to be a current topic, but it must have a rich background, it must have a rich static portion. तो यूपीएससी फिर इस करंट टॉपिक से डायरेक्टली क्वेश्चन पूछ लेती है, या इस करंट टॉपिक को पढ़ के उसके बैकग्राउंड से डायरेक्टली क्वेश्चन पूछ लेती है. You see the point? That's basically what you can see is, in one sense, the formula to understand the mind of the UPSC, and that is exactly the formula I'm applying in terms of laying out the details before you. तो जो चीजें मैं आपके सामने रख रहा हूँ वो उसी फॉर्मूले के माध्यम से रख रहा हूँ. ठीक है, चलिए, let's start. Now you keep your pen and paper ready and we'll take a look at this part. If you take a look at the statement of objects and reasons, this is what you can say, the amendment which was made to the constitution was made under this by the government of India. Just read this paragraph, please. The cooperative sector over the years has made significant contribution to various sectors of national economy and has achieved voluminous growth. However, it has shown weakness in safeguarding the interests of the members in fulfillment of objects for which these institutions were organized. There have been instances where elections have been postponed indefinitely and nominated office bearers or administrators remaining in charge of these institutions for a long time. This reduces the accountability of the management of cooperative societies to their members. Inadequate professionalism in management in many of the cooperative institutions had led to poor services and low productivity. Cooperatives need to run on well-established democratic principles and elections held on time and in a free and fair manner. Therefore, there is a need to initiate fundamental reforms to revitalize these institutions in order to ensure their contribution in the economic development of the country and to serve the interests of members and public at large, and also to ensure their autonomy, democratic functioning, and professional management. Right? Now, this is basically the kind of a statement of objectives. And what we basically take a look at it is that by the amendment made to the Constitution, you have three things which get added with the 97th Amendment Act. नाइन्टी सेवेंथ कॉन्स्टिट्यूशन अमेंडमेंट एक्ट जो आपके सामने है उसमें तीन चीजें ऐड होती हैं. ठीक है, तो पहला मैं लिखना शुरू करता हूं यहां पर. Three things are added to the Constitution. Under Article 19(1)(c), जहां लिखा है right to association, okay, under Article 19(1)(c), where you have right to association and form unions, मतलब associations और union बनाने के जो rights हैं, उसके साथ साथ एक जो नया टर्म लगा दिया गया था उसका नाम था cooperatives. मतलब making or forming cooperatives was secured as a fundamental right by including the formation of cooperatives under 19(1)(c). Okay, please take a look at this very clearly. 19(1)(c) states that establishing cooperatives is a fundamental right under Article 19(1)(c). ठीक है, ये बिल्कुल आपका प्रीलिम्स का रखा रखाया क्वेश्चन है, साफ साफ. 19(1)(c) आपने कभी चलते फिरते पढ़ा होगा. If you have seen, for example, the question of when you have seen 19(1)(c) somewhere or the other, you always say that right to association and unions, उसके साथ साथ cooperatives लिखा है. cooperatives के ऊपर एक footnote लिखा हुआ है. footnote का मतलब है कि this is added in the constitution, or under 19(1)(c) this part has been added by the 97th Constitution Amendment Act 2011. Okay, this is what we basically mean to understand. तो ये आपके सामने बिल्कुल रखा रखा है प्रश्न है, बिल्कुल प्रीलिम्स के क्वेश्चन इसी तरह से बन के आते हैं. That by which amendment of the constitution was the term cooperative added to right to association and form unions, right? So the answer is 97th Constitution Amendment Act. उसके बाद जो अगली चीज cooperatives ने ऐड करी थी, that was Article 43B. ये डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी में ऐड किया था. This was added in Part 4 of the Constitution. Part 4 of the Constitution, which goes by the title of Directive Principle of State Policies. Okay, so the 97th Constitution Amendment Act 2011 added Article 43B to the Constitution, which talks about what is known as the Directive Principles of State Policy. Clear? If you want to take a look at Article 43B, it talks about promotion of cooperative societies. The state shall endeavor to promote voluntary formation, autonomous functions, and democratic control and professional management of cooperative societies. You see? So, cooperatives have a distinction. Now, take a look at the statement. Cooperatives have a distinction ये वाला स्टेटमेंट आपके प्रीलिम्स में आता है इस तरह से. cooperatives have a distinction of both being a fundamental right and a directive principle of state policy. एक और दो चीजें ही हैं इसके अलावा, जैसे कि एजुकेशन है जो कि फंडामेंटल राइट और डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी दोनों में है. Under Article 21A, you have the right to education, and the directive principles also you have the education of children, nutrition of children. But it is the cooperatives which has a very clear distinction of both being both a fundamental right and a directive principle of state policy at the same time. ठीक है, तो इसको थोड़ा सा इसीलिए हम इम्पोर्टेंट समझते हैं कि इसका जो पूरा एक्टिविटी यहाँ पे क्रिएट हुआ था उसमें हम why do we pay attention to this. Okay, so Article 43B was added, and then of course the main addition to this part was Part 9B, जहाँ पर कि cooperative societies को institutionalize किया गया था. Right, the entire part of the constitution on cooperative societies was added. ठीक है, ये वाली बात आपको थोड़ी सी प्रीलिम्स के माध्यम से याद करनी पड़ेगी. क्लास अभी हेयर, मैंने आपसे सुबह से आज से बात नहीं करी, आप लोग हैं यहाँ पर कि नहीं है? क्लास अभी हेयर टुडे और नॉट? आर यू ऑल डिसअपीयर्ड? अभी हेयर? डू वी अंडरस्टैंड व्हाट आई एम ट्राइंग टू से ओवर हियर क्लास? स्टैटिक पोर्शन फॉर द कोऑपरेटिव सोसाइटीज. डू वी मेक सेंस हियर क्लास? टेल मी, यस और नो? Okay, so you have the 97th Constitution Amendment Act 2011, which talks about 3 amendments which were made into the Constitution. 19(1)(c) में right to association and union के संग cooperatives लगा दिया गया था. उसके बाद establishing cooperatives is a fundamental right under Article 19(1)(c). Okay, and then you have Article 43B, which makes formation of cooperatives a directive principle of state policy, and Part 9B was dedicated for the creation of what are known as cooperative societies. तो Part 9B में directly cooperative societies की creation को एक तरह से इंस्ट्राइन कर दिया गया था. Do we understand? Okay, now if you take a look at this very simply, we are going to focus upon Part 9B. अब Part 9B जब लगाया गया था तो पंगा ये था कि Part 9B में the, let's say, some of the provisions of Part 9B which had cooperative societies. By the way, just to be make sure about this particular part, कि जब 97th Constitution Amendment Act enact किया गया था, कांग्रेस की सरकार थी 2011 में, when 97th Constitution Amendment Act 2011 was enacted, at that time the procedure of Article 368 was followed, but the 50% ratification of state assemblies was not taken. ठीक है, ये वाली बात थोड़ी सी ध्यान में रखिएगा आप, जो भी हमको आगे इसमें कवर करना है. जो 50% रैटिफिकेशन स्टेट असेंबली का होता है वो नहीं लिया गया था इसके अंदर. ठीक है, तो ओनली बाय द स्पेशल मेजॉरिटी मेंशन अंडर आर्टिकल 368 क्लॉज 2 वाज दिस पर्टिकुलर पार्ट अमेंडेड. सिर्फ एक जो स्पेशल मेजॉरिटी होती है आर्टिकल 368 क्लॉज 2 के अंदर, पार्लियामेंट से ही पार्ट 9B को इंट्रोड्यूस करा लिया गया था, लेकिन जो 50% स्टेट लेजिस्लेचर्स का जो लगता है हिस्सा, उसको नहीं लगाया गया था. द part which is played by the state legislatures, that was not created in this particular regard at all. Okay, do we understand this class? अब Part 9B के संग पंगा ये है मतलब प्रॉब्लम इसके साथ ये है कि इन पार्ट 9B इन सम पार्ट्स, देखिए जनरली व्हाट बेसिकली द आइडिया इज दैट एज यू कैन सी दिस डॉक्यूमेंट ओवर हियर गिवन बाय द गवर्नमेंट ऑफ इंडिया, cooperative societies is a subject mentioned under entry 32 of the state list. जो cooperative societies हैं वो entry 32 state list में mentioned है, साफ साफ है ना. तो for example if I go to the state list, I'm sure you understand what we mean by the state list, right? It is the 7th schedule that we are talking about. देखिए ये सेकंड लिस्ट है, मतलब स्टेट लिस्ट है. और एंट्री 32 ये भी अलग से आपको याद करना पड़ेगा. एंट्री 32 जो है स्टेट लिस्ट की वो बात करती है कोऑपरेटिव सोसाइटीज की. So the concept of cooperative societies is discussed by entry 32 of the state list. You see, so what does it mean? That cooperative is a state subject. Are you getting my point? I'm just trying to be kind of clear with you on this particular aspect. क्योंकि क्वेश्चन इसी तरह के आते हैं. पिछली बार ऐसी प्रिजन्स के ऊपर क्वेश्चन आया था 2023 में कि प्रिजन्स कौन सा सब्जेक्ट है और पहले कौन सा सब्जेक्ट हुआ करता था, इत्यादि इत्यादि, है ना. तो यू टेक अ लुक एट पार्ट 9B of the constitution. The problem is that the cooperative societies are a state subject. मतलब cooperative societies के ऊपर लॉ बनाने का या उनको गवर्न करने का जो एक्सक्लूसिव जुरिस्डिक्शन है वो स्टेट्स को दे रखा है, राइट. स्टेट्स हैव द एक्सक्लूसिव जुरिस्डिक्शन. आपको पता है आर्टिकल 245 इत्यादि के साथ जो हम पढ़ते हैं कि जो चीजें यूनियन लिस्ट में है उनका जो लॉ बनाने की पावर है एक्सक्लूसिवली यूनियन के पास होगी, और जो चीजें स्टेट लिस्ट में है उनके ऊपर लॉ बनाने की पावर एक्सक्लूसिवली स्टेट के पास होगी. ये बात सही है कि नहीं है, राइट. तो कोऑपरेटिव्स जैसे हमने देखा is under entry 32 of the state list. जो cooperatives हैं ये सारी 32 में state list के साथ एंट्री करी हुई है. The entry which is given over here is on the state list. Clear? तो अब पॉइंट ये है हमारा, मतलब क्वेश्चन ये है कि अब जब स्टेट लिस्ट का मैटर है तो पार्ट 9B में क्या लिखा हुआ है. पार्ट 9B में यूनियन गवर्नमेंट ने ये कहा कि जैसे मान के चलिए ऐसे एक कोई कोऑपरेटिव है महाराष्ट्र के अंदर. लेट्स से फॉर एग्जांपल इफ देयर इज अ कोऑपरेटिव विद इन द स्टेट ऑफ महाराष्ट्र, बहुत बहुत बड़ा कैपिटल जनरेशन स्कॉट्स होते हैं. कोऑपरेटिव्स हैव इमेंस अमाउंट ऑफ कैपिटल विद देमसेल्व्स. लेट्स से फॉर एग्जांपल इन महाराष्ट्र देयर इज अ डेयरी कोऑपरेटिव, है ना. अब देखिए बात यह है कि आप कॉर्पोरेटिव और कॉर्पोरेशन में अंतर समझिए. ट्राई टू अंडरस्टैंड द डिस्टिंक्शन बिटवीन कोऑपरेटिव एंड कोऑपरेशन. सॉरी, cooperative and a corporation, cooperative and a corporation, right? A corporation is a private limited company which works for profit, and all companies and corporation are under the first schedule, under the first stage of the 7th schedule. तो जैसे मान के चलिए कि कोई अगर एक कंपनी है और कंपनी अगर पैसा कमाती है तो वो अपना इनकम टैक्स और कॉर्पोरेट टैक्स केंद्र सरकार को देती है, क्योंकि ये सारी जो सब्जेक्ट्स हैं ये केंद्र सरकार के पास है शेड्यूल 1 में, ठीक है, शेड्यूल 7 के लिस्ट 1 में. बट इफ अ कोऑपरेटिव अर्न्स मनी and if the cooperative's earning of money is taxable, right? If a cooperative earns money and if the cooperative's earning of money is taxable, then since cooperative is a state subject, all the money taxed from a cooperative is given to the state government. Are we clear? So therefore what we basically see is that cooperatives are one of the great business activities which happen. And because of a lot of, for example, if you take a look at a dairy cooperative in Maharashtra, it has such a huge capital. They have controlled the entire dairy supply in the state of Maharashtra. Milk, curd, buttermilk, all of these things in Maharashtra are supplied by dairy cooperatives. You will hardly find multinationals, etc., etc. And even if you find, for example, some multinationals in these atmospheres, they are very limited. Most of the multinationals may exist in a metropolitan area, but the general supply of milk, curd, buttermilk in Maharashtra is done by dairy cooperatives. And imagine the kind of money that they make as income. But also, good fortune for the state of Maharashtra is that when cooperatives earn revenue, they have to pay taxes in the state of Maharashtra to the state of Maharashtra, because cooperatives are a state subject. On the other hand, if you are a corporation and if you're earning revenue in the state of Maharashtra, you're not paying your income tax to the state of Maharashtra, you're paying it to the government of India, central government, right? So cooperatives, meaning in a very simple way, if I want to tell it to you, cooperatives are huge economic machines which work on a different logic than a corporations. And the good fortune for the states having the cooperatives as a state list exclusively is that all the taxes which are to be paid by a cooperative are paid by the cooperative to the state government. It goes to the consolidated fund of the state, right? Now what part 9b basically says is that if there is a cooperative in the state of Maharashtra, and as you would know from your static portion reading of a cooperative, if there are cooperatives in the state of Maharashtra, those cooperatives are run by elections. Okay, and since it is a state subject, it is the State Legislative Assembly of Maharashtra okay, please pay attention to this. If it is a cooperative in the state of Maharashtra, the elections of the cooperative are to be managed by the State Assembly of Maharashtra. So आपने पता है कि पंचायत और म्यूनिसिपैलिटी में कि पंचायत के जितने भी चुनाव होते हैं वो उनका जो पूरा मतलब लॉज बनते हैं चुनाव को कंट्रोल करने के लिए पंचायत के, वो राज्य सरकार बनाती है, आपका विधानसभा बनाता है. अगर उत्तर प्रदेश की पंचायत में चुनाव हो रहे हैं तो पंचायत में चुनाव किन कानूनों के अधिकार पे होंगे वो उत्तर प्रदेश की विधानसभा बनाएगी. आर वी क्लियर? Similarly, since cooperative is a state subject, so elections to cooperatives and the management of cooperatives generally is supervised by laws made by the state legislature. ठीक है. अब क्योंकि यूनियन गवर्नमेंट को ये लग रहा था कि यहाँ कॉपरेटिव्स का सारा पैसा स्टेट्स के पास जा रहा है और यूनियन के पास कॉपरेटिव्स का कोई भी पैसा नहीं आ पा रहा है टैक्स वाला, right? Which means cooperatives are giving states a lot of weightage in terms of getting their own revenues, and union government is missing out in action of collecting revenues, especially from the southern Indian states, right? Maharashtra, Gujarat, Tamil Nadu, Karnataka, these are all hubs of cooperatives in India. An immense amount of wealth is in the hands of politicians and cooperative owners. Some of the politicians are cooperative owners because of the amount of money that is directly coming in the pocket of the state government. Okay, so the question therefore is, how do you create a cooperative to be able to direct the funds of the cooperative to the union government? Consolidated Fund of India में किस तरह से cooperative के taxes को और पैसे को लगाया जाए. ठीक है, तो अब इस चीज में पार्ट 9 भी बनाया गया. पार्लियामेंट ने पार्ट इसको करने के लिए पार्ट 9 भी बनाया और पार्लियामेंट ने पार्ट 9 भी में कहा कि जो कोऑपरेटिव के अंदर जो चुनाव होते हैं, the elections that happen in the cooperative societies are now going to be governed by laws made by the parliament. ये वाला प्रोविजन उन्होंने डाल दिया. As you can see, for example, even in the statement of objectives, what these people want to do basically is that the elections which are happening in cooperatives, okay, you can see over here, there have been instances where elections have been postponed indefinitely and nominated office bearers or administrators remaining in charge of these institutions for a long time. देखो इसको पढ़ो. तो the government says कि elections अच्छे से नहीं हो रहे हैं, corruption हो रहा है, गलत लोगों को power दी जा रही है, cooperative के resources को एक तरह से waste किया जा रहा है. तो इसके लिए हमको reforms लाने की जरूरत है. We need to bring in reforms to, in a way, make the cooperative management better. It has to be subjected to a variety of reforms. And in the name of reforms, what the government does under Part 9B is, it says that the overlooking of elections and the procedure by which elections are going to be conducted at the cooperatives are going to come under the, what you can call, domain of the parliament. So the power which was given previously to cooperatives, right, was with the state government. जो पावर दे रखी थी कोऑपरेटिव को या कोऑपरेटिव्स को, वो स्टेट गवर्नमेंट को दे रखी थी पावर, है ना. अब वही पावर स्टेट से लेकर सेंटर को दे रखी है. तो जैसे मतलब पावर टू कंडक्ट इलेक्शंस ऑन कोऑपरेटिव्स वाज गिवन टू द स्टेट गवर्नमेंट, दिस पावर हैज बीन ट्रांसफर्ड टू द यूनियन ऑफ इंडिया, राइट. एंड दिस इज व्हाट द स्टेट्स स्टार्टेड कॉलिंग अ यूसरपेशन, कि द यूनियन by Part 9B, the parliament has usurped a state subject. By Part 9B, the parliament has usurped a state subject and is unconstitutionally making laws to govern elections on a subject which is exclusively given to states under entry 32 of the state list. Please take a look at this argument that was made by the state government, and the site at which this argument was made was the judgment of Rajendra N. Shah. So it was Rajendra N. Shah versus Union of India. This judgment or this question was asked before the Gujarat High Court. ठीक है, ये बहुत बड़ा जजमेंट था गुजरात हाई कोर्ट का 2011 में, इसके सामने ये बात रखी गई थी. ये कहा था कि this amendment to the constitution is a violation of the basic feature of federalism, right. Now you know, for example, the basic structure doctrine applies to the amendment of the constitution, and they said that the 97th Constitution Amendment Act 2011 is a violation of the basic structure doctrine. As it violates what is known as the basic feature of federalism. The basic feature of federalism is violated by this particular law, right. And therefore this 97th Constitution Amendment Act, by judicial review under the basic structure doctrine, must now be struck down. The court was, the argument that was made before the court was that the Constitution Amendment Act 97th in 2011, which is violating the basic feature of federalism by usurping a part which is given to the state for making laws and giving it a kind of a, giving the union the ability to control the elections within cooperatives, it needs to be struck down. And it is indeed the case that the Gujarat High Court struck down and declared the entire 97th Constitution Amendment Act 2011 as unconstitutional. An entire part of the constitution which was amended by the government was declared unconstitutional by the Gujarat High Court, in the case of Rajendra Ehn Shah versus Union of India. And Gujarat High Court agreed with the arguments made by the petitioners, saying that it is very specifically and clearly mentioned that cooperatives are a state subject. Okay, it is very specifically and clearly mentioned that cooperatives are a state subject, and under the guise of amending the constitution, the Gujarat High Court stated the parliament, what it has done, it has what you can call given the power to the union parliament to make laws upon a state subject, and this is a violation of federalism. You see, so the right procedure for it should have been that first the Cooperative Societies Act or cooperative societies as an entry should be taken from the state list and put in the union list by an amendment to the constitution, and then you could have made something like this. But since it is explicitly mentioned, there is a very clear what you can call point in which it is mentioned that the cooperative societies are a state subject, and when you are making that part which is a state subject under the laws are being made by the parliament, it is ultra vires the constitution, it violates the basic structure of federalism, and therefore it is going to be declared as unconstitutional, and the Gujarat High Court strikes the entire law down in 2011. After the law has been struck down by the Gujarat High Court, the government of India appeals against the decision of the Gujarat High Court before the Supreme Court of India, right? And the judgment of the Supreme Court of India is given in the year 2021. Again, this is one of the most important landmark judgments to be coming out of the Supreme Court in the what you can say in the recent times. Judgment of Rajendra N. Shah versus the Union of India versus Rajendra N. Shah, in which Union of India takes a what you can say judgment of the Gujarat High Court and presents it before the Supreme Court of India. You have Justice Rohinton Nariman sitting upon the matter, and the matter is now under the consideration of the Supreme Court of India, and the Supreme Court of India is going to give a judgment, but I can't take a look at that judgment today. I'll take a look at that judgment tomorrow. From giving this judgment, later on we also have what is known as the Ministry of Cooperation. Now all of you know for a fact that it is the Ministry of Cooperation is the most recent addition to the portfolio at the union. Okay, Ministry of Cooperation was also formed in 2021. Incidentally, no question has come in the UPSC since 2021 on cooperatives, and also the this year you have seen what you can call a Multi-State Cooperative Societies Act, which has been passed. So all of this becomes a very nice what you can say amalgamation which makes it very relevant for us to understand that the cooperatives can be a very good what you can say sample size on which a question can come, right? I'm taking three things which have appeared in the current updates, and I hope that you're able to understand the formula that I'm using to select the material which I want to transfer for the prelims examination. It has a rich background, meaning it has a lot of provisions in the constitution, some controversy in the Supreme Court, and it is constantly a part of the current updates. 2021 Supreme Court judgments come with regard to the Gujarat High Court appeal. In 2021 also you have the formation of the Ministry of Cooperation, right? This is the again youngest ministry within the union portfolio, and also what you see is that in 2023 the parliament in the monsoon session has passed the what you can call the Multi-State Cooperative Societies Act. Okay, so 2021 and 2023, all these three current events have been boiling in the region of what is known as constitution polity, and therefore this becomes a good recipe for a question. Okay, so I will pause it over here, resume it again tomorrow, and also tomorrow, by the way, once we finish the Multi-State Cooperative Societies Act and everything, we are going to take an entire segment to understand the electoral bonds case. Tomorrow I want to have a clear field to be able to decipher the judgment of the Supreme Court in the electoral bonds case. Again, this is a judgment which has been given by a 5-judge constitution bench, and it has been considered one of the most landmark judgments of the Supreme Court in the recent times in terms of its efficiency and reach that it wants to arrive at. Okay, so we are going to be dealing with that. We need an open field about 2.5 hours entirely to discuss with the nitty gritties of electoral bonds and ask the question, if today contributions can be made to political parties, how can these contributions be made, right? Okay. In that sense, also if you have other suggestions, I'm going to take a look at the chat properly so we can also incorporate whatever your suggestions are in dealing with this particular thing. Okay, all right, thank you for your time and patience for the joining today, and we are going to deal with the remaining parts of cooperatives tomorrow, and also a open and clear field discussion upon the constitutional invalidity of the electoral bonds, and how is it that today, if you want to make contributions to the political parties after the electoral bonds have been struck down, what are the provisions around which you can do it? You are possibly looking at a question on that part also in this prelims examination. Okay, take it. So we are going to just resume from where we were, what we were discussing yesterday. We were taking a look at what are known as the cooperative societies, right? तो मैंने कल आपको थोड़ा सा cooperative societies के बारे में बता दिया था. We've taken an understanding of what are the cooperative societies, right? And while we were taking a look at the understanding of the cooperative societies, we have seen, for example, how we take an understanding in both the static portion. तो कल जो static portion बताया था मैंने आपको cooperative societies का वो भी था, और यहाँ पर इसका dynamic portion, which is the current updates part, right? Now in the static portion I had covered till I feel that the Gujarat High Court had passed a judgment. Gujarat High Court had passed a judgment stating that Part 9B inserted into the Constitution Part 9B inserted into the Constitution was a violation of the basic features of the Constitution. Basic feature of the Constitution, which is known as federalism. And it is a violation of the basic feature of the Constitution known as federalism. Right? And therefore, I think the background of this you understand very clearly, that the idea specifically was that Part 9B, which was introduced into the Constitution by the 97th Constitution Amendment Act 2011, Part 9B, which was introduced by the 97th Constitution Amendment Act 2011, was specifically made by the Parliament to usurp upon the cooperatives, which is a state subject, right? This was the argument that was made before the Gujarat High Court, and the Gujarat High Court agreed with this argument. Gujarat High Court took a clear agreement with this argument, and it struck down the entire Part 9B. However, it is to be noted that Article 19(1)(c) में जो cooperatives का जो part दे रखा था, that was upheld, और Article 43B को भी upheld कर दिया है. ठीक है, तो ये मैंने आपको दो चीजें बताई थी कल कि in the 97th Constitution Amendment Act 2011, when we take a look at 97th Constitution Amendment Act 2011, we see that Part 9B of the Constitution was added, and along with Part 9B you had Article 19(1)(c) and Article 43B. इन दोनों parts को भी add किया गया था, इसके अलावा Part 9B के अलावा. है ना। और पार्ट 9B को ऐड करने के लिए parliamentary the Constitution Amendment Act Article 368 was taken, but no ratification of the states was taken. मतलब तो स्टेट का रैटिफिकेशन नहीं लिया गया था इसमें। तो इसमें जो आर्गुमेंट था वो ये था कि क्योंकि जो कॉन्स्टिट्यूशन अमेंडमेंट एक्ट है ये पार्लियामेंट को पावर दे रहा है लॉ बनाने की उस सब्जेक्ट पे जो कि स्टेट लिस्ट में दे रखा है। प्लीज लिसन टू व्हाट आई एम सेइंग वेरी क्लियरली। द कॉन्स्टिट्यूशन अमेंडमेंट एक्ट इज गिविंग द पावर टू द पार्लियामेंट to make a law upon a subject which is given in the state list. The Constitution Amendment Act is giving the power to the Parliament to make a law upon a subject which is given in the state list, right? And therefore, this activity, which is basically meaning this activity which is basically coming over here, is basically unconstitutional because this violates the basic feature of federalism. तो गुजरात हाई कोर्ट ने 2011 में इस कॉन्स्टिट्यूशन पार्ट 9B को पूरा स्ट्राइक डाउन कर दिया। ठीक है, तो बहुत बड़ा जजमेंट था क्योंकि एक संविधान के द्वारा जो लाया गया था पार्ट, उस पूरे पार्ट को ही स्ट्राइक डाउन कर दिया था एक हाई कोर्ट ने। तो बहुत बड़ा जजमेंट था। एंड द फैक्ट दैट इट वाज needed as an activity which was made under the Constitution Amendment Act of Article 368 of the Constitution, that made most of the amount of importance. So the powers of the High Court were most properly recognized in this thing. ठीक है, अब क्या हुआ कि उसके बाद the Union of India, which had made the law after the government had changed in 2014, Union of India appealed against the judgment of the Gujarat High Court before the Supreme Court. Union of India versus Rajendra N. Shah. This is a judgment which is a landmark judgment given by the Supreme Court recently. This was the year 2021. ठीक है, इसमें क्या था कि गुजरात हाई कोर्ट का जो जजमेंट था, the judgment given by the Gujarat High Court which stated that part 9B of the Constitution is going to be declared as unconstitutional. ठीक है, पार्ट 9B को जो अनकॉन्स्टिट्यूशनल डिक्लेयर करने का जो जजमेंट था उसको चैलेंज किया गया था। मतलब सुप्रीम कोर्ट का जो बेंच बैठा था, दैट जजमेंट, द बेंच ऑफ द सुप्रीम कोर्ट वाज सपोज्ड टू टेक अ चैलेंज ऑफ व्हाट यू कैन से द judgment given by the Gujarat High Court. Okay, why Article 19(1)(c) is still valid? Because see, Article 19(1)(c) only talks about a right to create corporations. मतलब it's basically talks about a fundamental right to create corporation as association. That's it. अब वो ये नहीं कह रहा कि स्टेट बनाएगा या सेंटर बनाएगा। तो अगर आप किसी एक राज्य को, if you're giving a state a power to create corporations, then it is possible to understand it in a very simple manner. Okay, that a fundamental right which has been given to a state to create a corporation is given under Article 19(1)(c). Okay, now if the state has if a state has got the power to create corporations, then it is not a violation of the right of the state or the encroachment of the union on the what you can call turf of a center. तो इसीलिए आर्टिकल 19(1)(c) सिर्फ एक फंडामेंटल राइट ऐड कर रहा था, उसमें कोई फेडरलिज्म का वायलेशन नहीं हो रहा था। आर्टिकल 19(1)(c) was only adding a fundamental right. It was not subjecting that activity to any kind of a violation of the principle of federalism, right? And for that reason, we see that the 19(1)(c) and 43(b) were retained, but article part 9B of the Constitution, which was talking about unions power to make laws upon a state subject, that was challenged. Okay, so that was a difference between what you can say part 9B, 19(1)(c) and 43(b). ठीक है, अब जब सुप्रीम कोर्ट के पास ये वाली बात चैलेंज में आई, when the Supreme Court heard the challenge upon part 9B of the Constitution, then the Supreme Court in a way revised the judgment of the Gujarat High Court. और सुप्रीम कोर्ट ने गुजरात हाई कोर्ट के जजमेंट को थोड़ा सा रिवाइज किया। Now, this is a judgment that came out of the Supreme Court in the year 2021. Again, an important part for the polity current updates. And this followed later on by the creation of the Ministry of Cooperative Societies, which is the Cooperation Ministry at the Union Cabinet. अब Supreme Court ने क्या कहा देखिए इसमें, थोड़ा सा ध्यान दीजिएगा इस चीज को, ये कंसेप्चुअल पॉइंट है, अगर ये समझ में आ गया तो जो प्रीलिम्स के क्वेश्चंस हैं वो आप कर सकते हैं आराम से. दिस इज अ कंसेप्चुअल सेगमेंट. इफ यू अंडरस्टैंड दिस यू विल बी एबल टू अंडरस्टैंड द क्वेश्चंस ऑफ prelims also very easily. Not a problem, not too much problem will come out of that in terms of understanding these questions. Okay, so if I take a look at this, for example, let's say the revision of the Gujarat High Court judgment was made into two parts. ठीक है, the center, the Supreme Court made a distinction between what are known as single state cooperative societies the Supreme Court made a distinction between what are known as single state cooperative societies and what is known as multi-state cooperative societies. Okay, and then Supreme Court said that all the parts of Part 9b sections of Part 9b that deal with sections of Part 9b that deal with single state cooperative societies are struck down. But on the other hand, sections of Part 9b that deal with multi-state cooperative societies are upheld. ठीक है, अब इस चीज पे आपको थोड़ा सा ध्यान देना है. इस मतलब इस पूरे कॉन्टेक्स्ट को समझने के लिए यू कैन हैव अ very categorical and clear question in the prelims examination from a literature like this, that part 9b of the constitution currently is not entirely struck off. ठीक है, जैसे हमने पहले बात करी थी आपसे कि जो पार्ट 9b है कॉन्स्टिट्यूशन का, the part 9b of the constitution is not entirely struck off. It is not entirely taken out of the context completely, but the section of part 9b which deal with a single state cooperative societies, those sections are struck off, but sections of part 9b that deal with multi-state cooperative societies, those sections are upheld. So the inclusion, basically the idea was very simple, that the principal challenge which was made before the Supreme Court, the principal challenge which was made before the Supreme Court on the validity of the Cooperative Societies Act, or the validity of the 97th Constitution Amendment Act 2011, was that it is encroaching upon the turf of the state governments. The parliament is encroaching on the turf of the state government. It is reaching out to make laws upon a subject which has been given to state. So the constitution, the Supreme Court said that it is correct that if a cooperative is existing within one single state, let's say for example if there's a cooperative within Maharashtra only, okay, then insofar as that cooperative is concerned, as far as we are talking about that cooperative society, जब तक हम उस cooperative society की बात कर रहे हैं, तब आपको परेशान होने वाली बात नहीं है. मतलब this is correct. यहाँ पर this is the reasoning is right that the Supreme Court, the Parliament cannot interfere into the cooperative societies which are created within a single state. अगर एक ही स्टेट में कोई कोऑपरेटिव सोसाइटी बनी हुई है तो पार्लियामेंट उसको कंट्रोल कर सकता है. Parliament can create a the parliament cannot create a regulation upon that. I'm sorry. So if a cooperative society is existing within one particular state only, the parliament cannot create a regulation upon that cooperative society. Clear? That's the first point. But if a cooperative society is existing in multiple states, let's say अगर कोई जैसे मान के चलिए कोई cooperative society है जो कि राजस्थान में है, पंजाब में है, हरियाणा में है, उत्तर प्रदेश में है, सब जगह इसके ऑपरेशंस हैं. तो प्रश्न ये उठता है कि कौन से स्टेट में आएगी, विच स्टेट इज गोइंग टू गवर्न दिस. If it is a cooperative societies which has a multi-state kind of a format of operation, the question is going to be under which state is this going to fall now. And then the answer is that a multi-state cooperative society will be a part of the union governance, and therefore again, as an inference of this judgment of the Supreme Court known as Union of India versus Rajendra and Shah, which deals with the constitutional validity of, what you can say, which deals with the constitutional validity of the cooperative part 9b. In this particular case, the Supreme Court states that part 9b is struck down in provisions that deal with single state cooperative societies. Okay. Part 9b is struck down in provisions that deal with single state cooperative societies. And the second point was part 9b. अब ये आपका बिल्कुल, this is a very simple prelims question, इसी तरह से बन के आएगा statement. So I hope that you're noting it all as I'm speaking over here with a pen and a paper. Part 9b is active in the provisions that deal with multi-state cooperative societies. The provisions which deal with multi-state cooperative societies. So I'm going to give it an abbreviation like MSCS. Parts of the Constitution that deal with multi-state cooperative societies. These parts are going to be relevantly placed as they are. Do you understand this class clearly? If you've taken a note of this, please. Now, once, for example, the government of India, the part 9b, once part 9b became operational for multi-state cooperative societies. Again, the intention, of course, at the center or at the union level is to control the taxes which are given by the cooperatives. Cooperatives, as I mentioned out yesterday, are very heavily, very intensively active in terms of paying a lot of taxes to the governments. And if they are coming under the state subjects, they become subjects of a tax which is going directly to states. And that is one of the incentives for the union government to take control of those tax monies which are going to the states, especially the southern Indian states, which have stalwart politicians who do a lot of welfare activities, prominently from the states which are prominently from the taxes which are coming from the cooperatives, right? And is creating very strong regional politics in South Indian states in India. Okay, now at this point of time in 2021, when the multi-state cooperative societies were under the control of the union, were declared to be under the control of the union. Okay, please take special attention of all of these parts. Okay, you can have any of these terminologies as a prelims question. Part 9B became operational for multi-state cooperative societies under the control of the union. And in 2021, it was the addition of what is known as the Ministry of Cooperation. Ministry of Cooperation, or the Cooperation Ministry, as the, what you can say, the newest portfolio created in the union cabinet, right? So if a question, let's say for example, is standardized against this, that which is the newest ministry created, which is the youngest ministry created, the newest portfolio created within the union cabinet, newest portfolio created within the union cabinet is the Ministry of Cooperation, right? And the Ministry of Cooperation specifically has jurisdiction over what are known as multi-state cooperative societies. Okay, so this can again be a question. So you can draw a very clear link directly from what we have studied in Union of India versus Rajendra and Shah, ठीक है, जो हम यहाँ पर पढ़ रहे हैं, directly आप इसका link बना सकते हैं कि because so you know a big question in the prelims examination come from the heading of cooperative societies having multiple statements, okay, which may ask you the amendment to the constitution, the nature of part 9B, how much of it is operational, how much of it is inactive, then the Ministry of Cooperation and the jurisdiction of the Ministry of Cooperation. Of course, a union ministry cannot have a jurisdiction over a state subject. Single state cooperative societies are a state subject. So the Ministry of Cooperation has jurisdiction only over multi-state cooperative societies, not upon single state cooperative societies. Do we understand? Ministry of Cooperation has jurisdiction only over multi-state cooperative societies, not over single state cooperative societies. Okay, so I'm just going to visit the website of Ministry of Cooperation to get you a sense of the initial ideas that you have to understand in this regard. Okay, so some amount of prelims centric questions can come about the Ministry of Cooperation. Again, for the reason that it is the youngest ministry created, and also that multi-state cooperative societies bill has recently been passed by the parliament. Okay, so take a look at this. Try to get a sense of this. Ministry of Cooperation. Here, Ministry of Cooperation was created by transferring the existing entries related to cooperation and cooperative in the business of the erstwhile Ministry of Agriculture, Cooperation and Farmers Welfare Wide Cabinet Secretary's Gazette notification in July 2021. Again, this is the most recent ministry. Mr. Amit Shah, who is also the Home Minister, is also appointed as the Minister of Cooperation. Amit Shah has had an experience of heading a cooperative bank in Gujarat in his formative years. Okay, the ministry is responsible to provide separate administrative, legal. Ministry is responsible to provide a separate administrative, legal and policy framework for strengthening the cooperative movement in country. It aims to deepen cooperatives as a true people-based movement reaching up to the grassroots and develop a cooperative based economic model where each member works with a spirit of responsibility. The principal activities of the ministry include streamlining process of ease of doing business for cooperatives and enabling development of multi-state cooperative societies. Okay, so you see the point over here. The jurisdiction of the Ministry of Cooperatives shall be only upon what are known as multi-state cooperative societies. I am highlighting this important for the prelims examination, right? Not upon single state cooperative societies. In pursuant to the judgment of the Supreme Court in Union of India versus Rajendra and Shah, it is only with regard to the multi-state cooperative societies that the jurisdiction of the Ministry of Cooperation shall lie. It lays emphasis on strengthening, bringing transparency, modernization, computerization, creating competitive cooperatives, working constantly to meet the challenge for accessibility to development for every underprivileged in rural areas, and on connecting every village with cooperatives, making every village prosperous with the mantra of Sahakar se Samriddhi, right? So this is another little bit of a anecdote which may be asked in the prelims examination, which talks about what is known as the mantra for a cooperative societies, which is called Sahakar se Samriddhi. This is what is given in this particular activity, which is known as the multi-state cooperative societies are under the jurisdiction of what is known as a cooperative ministry. Right? Are we clear, class? So this is one part that you have to take a look at. Just another thing that you can study from the perspective of Ministry of Cooperative is also what you can say these 7 universally accepted cooperative principles. Okay, so again, this is a prelims kind of a fodder. 7 universally accepted cooperative principles. 7 universally accepted cooperative principles. Just take a snapshot of these things. 1, 2, 3, 4, 5, 6, 7. These are given in the headline of what is known as Ministry of Cooperative. ठीक है, तो ये आपकी Ministry of Cooperatives की headline में दे रखा है. And therefore this may again come as a question. Open and voluntary membership, democratic member control, members economic participation, autonomy and independence, education, training and information, cooperation among cooperatives, and concern for community. ये थोड़ा सा आपको याद करना पड़ेगा. The 7 principles accepted for cooperative societies. Do we understand this? ठीक है? Class, are we clear? Right? So this is basically what we are in a way putting out as the information that is important for the prelims examination from what is known as the cooperative societies. I hope that this part is clear to you. Okay. Now we'll come to the last bit of the current update upon the cooperative societies. The last bit of the current update is what is known as multi-state cooperative societies. What is the nature of multi-state cooperative societies? And the Multi-State Cooperative Societies Act, which has been amended in 2023. Okay, so this amendment act for the Multi-State Cooperative Society has been put out by the Parliament of India in 2023. It is in fact one of the most recent legislations to be passed by the Parliament, which has a lot of import. For example, this legislation was passed in the monsoon session of 2023 by the Parliament, and again deals with the multi-state cooperative societies as a feature. Okay, so let's take a look at a little bit of a detail upon this part. Okay, and I am expecting very clearly certain questions to come from this section. This is a report that I'm referring as a, what you can say, database from which questions are going to be asked upon this matter. Lok Sabha report of the Joint Committee on the Multi-State Cooperative Societies Amendment Bill 2022. Okay, a few things that I would want you to take a highlight of from this particular part, very simply, to be sure that you understand what is happening in the elementary understanding of this particular activity. Okay, now see, this is a chapter that I want you to read. If you take a look at, for example, one of the questions of the UPSC Prelims 2023 in the polity paper, there was a question from what are known as the prisons and prisons as a state subject. Take a look at this question, question number 32 in the prelims examination 2023. Okay, just take a look at this question, and on this question only basically I'm trying to model the idea that this time you may have a question on cooperative societies exactly upon the same idea. Consider the following statements. In India, prisons are managed by state government. So you have to be prepared for questions like these. These are extremely difficult questions, and one of the objectives of a classroom like this is to ensure that these questions also you can take a look at, right? It is very difficult to attempt a question like this without having a thorough understanding of the nature of the question. You can't take a lot of guesswork, and anyway in this prelims examination you are very clearly seeing that the guesswork element is being eliminated, right? So you have to be very, very clear in knowing the answer in right or wrong terms to be able to attempt it. Okay, if you take a look at this question, question number 32, which is coming from the prelims examination 2023, my sense is that in the, what you can say, main examine in the prelims examination 2024, you can have a very clear question like this from the cooperative societies. Exactly similar question can be asked in the main examination 2024 from what is known as the cooperative societies. ठीक है, तो अब इस तरह से just let me show you a little bit of a reading on the material which I am in a way targeting over here. Okay, this part, for example, let's say if you take a look at this first paragraph, the cooperative movement in India traces its origin to the agriculture and allied sector and was originally evolved as a mechanism for pooling the people's meager resources with a view to providing to them advantage of the economies of scale. The first attempt to institutionalize cooperatives began with the enactment of the Cooperative Credit Societies Act 1904, the scope of which was subsequently enlarged by the more comprehensive Cooperative Societies Act of 1912. Under the Government of India Act, the subject of cooperation was transferred to the then provinces, which were allowed to enact their own cooperative laws. Now, here, are you noticing what I'm trying to say over here? Exactly on the same basis of the question that you saw over here. You see, the question that you see is that when does prisons become a state subject or a provincial subject? On the same basis, a question can come upon the cooperative societies, because the cooperative societies, multi-state cooperative societies bill is currently passed by the parliament as an important legislation. Okay, so just take a look at this. it says under the Government of India Act, and I hope that you are taking a note of this, the subject of cooperation was transferred to the then provinces which were allowed to enact their own cooperative laws. Please be sure about what I'm trying to write over here. Okay, so the subject of cooperatives was transferred from being a union subject to the provinces in the Government of India Act 1919. The Government of India Act 1935, cooperatives remained a provincial subject. So as we have seen that entry 32 of the state list today determines what are cooperatives, right? Have you seen this part or not? Yes. Entry 32 of the state list today determines what are cooperatives, which is the power to make laws upon cooperatives today is a state subject. A historical question upon this can be asked on the basis of the historical question which is asked with regard to the prison reforms or the prison as a such subject. So the Government of India Act 1999 established corporates as a provincial subject, which means a state subject. And then again, the Government of India Act 1935, cooperatives remained a provincial subject. Presently, the item cooperative societies is a state subject under entry 32 of the state list of the Constitution of India. Okay, now very clearly and very quickly, I want you to take a note of this particular thing on your pieces of paper. Again, I'm highlighting this to be important for the prelims examination this time. You are seeing a question like this. Again, if I can repeat the question before you, this is a 2023 question. Exactly standing over here, I was making these assessments about the prelims examination because of the fact that the prisons reform was one of the most important what you can say concepts which were taken by the Home Ministry last year, and that is how it came in the questions, right? So for example, if you want to read the mind of the UPSC, the one of the important news to come last year was related to what are known as the prison reforms. You see, this is one of the important news that had come at the time. Union Home Ministry planning to revamp prisons by 247, says Ajay Kumar Mishra. Now, this is basically what it talks about, the prison reforms which were supposed to be done and was added. And the UPSC took this, what you can say, item from the current updates about prison reforms and created this question, which is with regard to the ways in which prisons are subjected to a state list or a central list, right? Plus, we are trying here to read the mindset of the UPSC. How does the UPSC asks questions? So you have questions in which prisons were basically taken up, and on the basis of those questions from prisons, you had a direct, the current update of prisons was taken up over here, and on the basis of that direct update upon prisons, the UPSC had asked a question number 32 with regard to the prisons. Exactly like this, 2023. My submission to you is that today you have enormously the concept of a Multi-State Cooperative Societies Act. And again, the heart of the matter is whether it is a state subject or a central subject. And what you are basically seeing at this point of time is very clearly the passing of the Multi-State Cooperative Societies Act in the parliament. Just take a look at this. Rajya Sabha passes multi-state cooperative bill. The bill provides norms for appointing employees, ensuring no nepotism or the practices exist. The Rajya Sabha has gathered in the full volume to pass the Multi-State Cooperative Societies Act as India members from the opposition parties walked away. You see, this was all happening while the Manipur issue was happening in the background, and thus on the basis of this, again, because in the cooperative societies, one of the most integral features is whether the power is given to the center or the state, and what is the part 9b of the constitution allowing and what it is disallowing, and what is the Ministry of Cooperation, and also, as I'm referring to you, this particular historical aspect of it. Okay, so again, please very nicely and gently take a look at this part, and you may see this as a question in the UPSC prelims examination, this part very clearly. Okay, again, so अंडर द गवर्नमेंट ऑफ इंडिया एक्ट से लेकर यहां तक, इसको आप थोड़ा सा नोट कर लीजिए अपने सामने. प्लीज टेक a kind of a good notation of this part very clearly for yourself from here to here. I am anticipating that a prelims question on the cooperative societies, including its historical background, etc., etc., can be asked by the UPSC this time, right? So please take a look at this clearly. इसको लिख लीजिए एक बार. In addition to this, you can also take a look at this part, that under entry 44 of the union list, you have multi-state cooperative societies. Under entry 44 of the union list, you have the concept of multi-state cooperative societies, right? And the law which governs multi-state cooperative societies currently is known as the Multi-State Cooperative Societies Act 1984. ये सारे पॉइंट्स आपको अपने पास याद करने पड़ेंगे, मेमोराइज करने पड़ेंगे आंसर देने के लिए प्रीलिम्स का. The law which currently governs multi-state cooperative societies is known as the Multi-State Cooperative Societies Act 1984, and multi-state cooperative societies are a part of the union list under entry 44. I am 90% betting upon this question, this information to come as the prelims question this time, because it checks all the boxes by which the UPSC examination or examiner thinks about it. This may not be a very romantic or a spectacular part of the examination, but it is certainly these kind of questions which are mundane, which are dry, they end up becoming a very populated part of the UPSC examination. So it may not be as fascinating as a Maharashtra Legislative Assembly and electoral bonds and all of that, but these simple background facts which keep happening in the country, these become a very important fodder of the UPSC prelims examination. Again, the Multi-State Cooperative Societies Act 1984 is the one which governs multi-state cooperative societies, and it is under entry 44 of the union list that multi-state cooperative societies are a union subject. So cooperative societies are a state subject under Article 32, but multi-state cooperative societies are a union subject under entry 44 of the union list. I hope that you have been taken a point upon this, right? Now, we have taken a look at, for example, what is the Multi-State Cooperative Societies Act, which was passed in 1984. This Multi-State Cooperative Societies Act was further renewed in 2002. Okay? So the current law governing multi-state cooperative societies is the Multi-State Cooperative Societies Act 2002. ठीक है, इसका नाम लिख लीजिए. और इसी लॉ में इस बार अमेंडमेंट किए गए. Only in this law there have been amendments made. Multi-State Cooperative Societies Act 2002 has been amended in 2023. This is the basic point that we are trying to, in a way, understand. Okay, I hope you get a point of it. So, if I can very simply summarize it for you, if you take a look at cooperative societies as a state subject, cooperative societies as a subject, okay, by the 1919 Act and by the 1935 Act, which were made by the thing, cooperative societies was a state subject, or what is known as, in the terminology at the time, provincial subject, right? Both in 1919 and 1935, cooperative societies were a state or a provincial subject. Again, in 1950 Constitution, entry 32 talks about cooperative as a state subject. But when we talk about, let's say for example, multi-state cooperative societies, MSCS, when we talk about multi-state cooperative societies, under entry 44, they are a part of the union list. First, there was a Multi-State Cooperative Societies Act made in 1984. Then the current act is made in 2002, and the current act is amended in 2023. Amendments to the Multi-State Cooperative Societies Act have been passed by the Lok Sabha and the Rajya Sabha in the monsoon session of the 2023 parliamentary year. This is what basically we are taking a look at with regard to the Multi-State Cooperative Societies Act. Along with this, you also understand that in 2021, you had a Ministry of Cooperation. In 2021, you had a Ministry of Cooperation, which was instituted, as we have taken a look at it, and it is the youngest ministry within the portfolio of the Government of India currently. Okay? Do we understand this part? Okay. Okay. That's basically it. Now, just one last thing that I can tell you at this point of time is that what are the major features of multi-state cooperative societies Amendment Act 2023. Multi-state cooperative societies Amendment Act 2023 के basic features क्या है, ठीक है? Again, just a little bit of a understanding of how this kind of an activity works. Take a look at this. The basic features of multi-state cooperative societies, the key provisions of the bill, मतलब ये bill जो अब act बन चुका है. Election of board members. Under the act, elections of the board members of multi-state cooperative society are to be conducted by its existing board. The bill amends that the central government will establish cooperative election authority. ठीक है, इसको थोड़ा ध्यान से नोटिस करिएगा. The bill establish cooperative election authority. Okay, so you know for a fact, let's say for example, it is like the Election Commission of India, Election Commission for cooperative societies. All the election which is organized within a cooperative society is to be organized by a body which is established by the amendment made to the Multi-State Cooperative Societies, known as the Cooperative Election Authority Act, known as the Cooperative Election Authority, which is supposed to be an election commission like body for the purposes of cooperative election. ठीक है. सो अगर प्रश्न ये पूछा जाता है कि कोऑपरेटिव इलेक्शन कराने के लिए कौन सी बॉडी संगठित की गई है, the question if it asks is what is the body which has been instituted for conducting cooperative elections, then the answer is cooperative election authority, right? This is the most important, what you can say, activity which has been taken out in the Multi-State Cooperative Societies Act. Okay, so for example, let me, if you want, I can put it in perspective. If we think about elections in India, if we think about all the elections which are conducted in India, right, you can divide them into these categories along with these bodies. The elections to Lok Sabha, Rajya Sabha, Vidhan Sabha, Vidhan Parishad, President and Vice President. ये जो चुनाव होते हैं भारत के अंदर, all these elections which happen in India, they are organized please take a look at this clearly. Elections to Lok Sabha, Rajya Sabha, Vidhan Sabha, Vidhan Parishad, President and Vice President. To these 6 items, the elections are organized by the Election Commission of India. Right? The election to these positions are organized by the Election Commission of India. If you take about elections to Panchayat and municipalities, which are also what are known as local bodies or local governance bodies, the elections are organized by state election commissions. So for example, if there's a panchayat election in the state of West Bengal, the election is to be organized by a state election commission. Clear? And now when we talk about, for example, with regard to multi-state cooperative societies, this is a question that you can very simply understand. कोऑपरेटिव सोसाइटीज में जो मल्टी स्टेट कोऑपरेटिव सोसाइटीज हैं, उनका इलेक्शन ऑर्गेनाइज करने के लिए अब एक बॉडी क्रिएट की गई है. यू कैन सी द नेम ऑफ द बॉडी ओवर हियर, द कोऑपरेटिव इलेक्शन अथॉरिटी फॉर मल्टी स्टेट कोऑपरेटिव सोसाइटीज. दिस इज गोइंग टू बी अ प्रीलिम्स क्वेश्चन दिस टाइम. दिस इज एग्जैक्टली गोइंग टू बी अ प्रीलिम्स क्वेश्चन. बहुत ड्राई और बेसिक और फैक्चुअल क्वेश्चन है, लेकिन इस तरह के प्रश्न आएंगे आपके प्रीलिम्स के पेपर में. Okay, multi-state cooperative societies, as you can see in the amendment which is made, has established a cooperative election authority. Which is a body which has been established by the Multi-State Cooperative Societies Act, or in fact what we can say, Multi-State Cooperative Societies Amendment Act 2023. This has been established. Okay, this is the part that I want you to take a look at very clearly and distinctly to be able to answer a question like this in regard to the cooperatives. With whatever we have covered in the class with regard to cooperatives, if there is any question from cooperatives, you would be able to answer that question from the information which is given in front of you. And I am very, very certain, because of the developments which have been happening on the subject of cooperatives since 2021, the judgment of the Supreme Court, the establishment of the Ministry of Cooperative, and the passing of the Multi-State Cooperatives Act 2023. Since 2021, this matter has been very much relevant in the current affairs, and because since 2021 no question has appeared upon the subject of multi-state cooperative societies or cooperation as general, and because in 2023 you have a Rajya Sabha and the Lok Sabha passing the multi-state cooperative societies bill to create the cooperative election authority, you are very clearly looking at a question which is going to come in the cooperatives section this time. ठीक है, आपको बिल्कुल साफ साफ दिख रहा है कि कोऑपरेशन या कोऑपरेटिव सेक्टर से कोई ना कोई प्रश्न आएगा, और अगर कोऑपरेटिव सेक्टर से कोई प्रश्न आएगा तो आपका जो कंटेंट क्लास में दिया है इसके बाहर से नहीं आएगा. Whatever we have understood about a cooperative society, etc., in the class, no content would be placed outside of it, right? So I want you to take a very clear and distinct notice about this part. Okay, so for example, if you take a look at elections in India, this is a good chart for you to understand. Elections to the Lok Sabha, Rajya Sabha, Vidhan Sabha, President and Vice President are organized by the ECI, right? and elections at the panchayat and municipality levels are organized by the state election commissions. Every state has its own election commission, and the role of the state election commission is to organize elections at the local level, which means to the panchayats and the municipalities. Okay, but when it comes to organizing elections at the cooperative level, which is specifically for multi-state cooperative societies, an authority which is known as a cooperative election authority has been created in 2023, which will have the organizational power over cooperative elections in multi-state cooperatives. Yes, आर्टिकल पार्ट 9B के जो आपके आर्टिकल्स है मल्टी स्टेट कोऑपरेटिव सोसाइटीज पर एप्लीकेबल है. When a high court struck down some law and the concerned party appeals to Supreme Court, so until then does the law be in existence or it ceases to exist until the SC decision? It ceases to exist. You are correct about what your observations are. The judgment given by the High Court was in the year 2011 and the judgment was reversed by the Supreme Court in 2021. But during this period, Part 9 was Part 9B was switched off. Part 9B was inapplicable. तो पार्ट 9B में कोई भी गतिविधि इस पीरियड के दौरान नहीं की जा सकती जब तक कि हाई कोर्ट का जजमेंट सुप्रीम कोर्ट का जजमेंट रिवर्स नहीं कर सकता है. Until the time the Supreme Court has reversed the judgment of the High Court, activity under Part 9B cannot be taken up. Right? There are certain technicalities to it also. For example, interim injunction and all of these things can be filed, but that is not what happened in this particular case. Yes, cooperatives can be formed by purely private members. In fact, it is usually formed by purely private members. It is hardly ever that the government, is one of the foundational or founding, actors in a cooperative society thing. Okay, so class, do you understand this? This kind of a slightly dry but very underground kind of a information base is very relevant in the prelims examination every time. And that is why I'm trying to focus specifically upon two of these topics. One is the tribunals, the other is the cooperatives, which have a very rich current update material and which also has a very rich, what you can say, antecedent into the constitution, which is the kind of a culmination and the balancing of the static portion and the dynamic portion. And you see, year after year, UPSC asks questions on events like these very often. So we are basically focusing upon these materials for that particular instance in specific. Right? Class, are we clear about this? Do we have the entire understanding of what the cooperatives are about? Right? Static portion and dynamic portion we've covered. 97th Constitution Amendment Act 2011. You have to remember the number through which the Constitution was amended. Gujarat High Court striking down Part 9B. 19(1)(c) and 43(b) are still a part of the Constitution. The reasoning given by the Gujarat High Court that the federal structure of the Constitution was violated by the 97th Constitution Amendment Act 2011. That is also what you understand. Then you know that Union of India versus Rajendra Shah 2021 gave the judgment, and it made a distinction between single state cooperative societies and multi-state cooperative societies. And this was the context of the judgment. Part 9B struck down in provisions that deal with single state cooperative societies, but not for provisions which deal with multi-state cooperative societies. This can be a prelims question directly as it is phrased over here. Part 9B became operational for multi-state cooperative societies under the control of the union. Right? 2021 Ministry of Cooperation was made. It is the newest portfolio created within the union government, and I have given you a little bit of a sense of the Ministry of Cooperation. Specifically, that it is only for the relationship of multi-state cooperative societies. The union government does not have any authority upon single state cooperative societies. Since the Ministry of Cooperation is created by the union government and the Ministry of Cooperation can have authority only on a multi-state cooperative society. Clear? Okay. And then you have the Multi-State Cooperative Societies Act amended 2023. The act which is currently working is in 2002, and the Amendment Act came in 2023. Clear? Then you take a look at this bit of a historical understanding, how cooperatives were placed differently in different timelines, and multi-state cooperatives are placed under entry 4 of the union list. Single state cooperatives are placed under entry 32 of the state list. And then you have the Multi-State Cooperative Societies Amendment which is basically the most important part of the multi-state cooperative societies amendment, is that it has set up what is known as a cooperative election authority, which is again specifically related only to multi-state cooperative societies. हाँ, देखिए अगर जो हमने यहाँ पर पढ़ा है ना कोऑपरेटिव के अलावा, इसमें आपको पढ़ने की इसके अलावा कुछ जरूरत नहीं है. Whatever we have taken a prelims के लिए, कम से कम मेंस के लिए अलग बात है, but for the prelims examination it is not necessary to read anything in addition to what we have read over here with regard to cooperative societies. जो हमने अभी cooperative societies के बारे में पढ़ा है, इसके अतिरिक्त आपको और कुछ पढ़ने की prelims के लिए जरूरत नहीं है. मेंस के लिए you can read article 243 etc, but for the prelims examination nothing more is supposed to be needed about this. नहीं members, अच्छा composition वैसे question मुश्किल है, composition में नहीं आएगा, but if you want to take a look at the composition you can take a look at this. Okay. For the, if you want to understand the context of the composition of the cooperative election authority, composition of the cooperative election authority, the authority will consist of a chairperson, vice chairperson and up to 3 members appointed by the central government on the recommendation of a selection committee. इसको अगर आप चाहें तो नोट कर सकते हैं. This is going to be the composition. It is a 5-membered body which is going to have 1 chairperson, 1 vice chairperson and 3 members appointed by the central government on the recommendation of a selection committee. ठीक है, इतना काफी रहेगा prelims examination के लिए. Clear? नहीं, आस्था, for single state cooperative societies they cannot have the jurisdiction ना, क्योंकि multi state cooperative societies act only deals with multi state cooperative societies, not with single state cooperative societies. For single state cooperative societies, elections are managed by each of the states. Every state has a different kind of a way to manage those elections. That is not going to be relevant for a union public service examination. ठीक है, स्टेट के लेवल पे आप अपने स्टेट का कोऑपरेटिव सोसाइटी का स्ट्रक्चर याद कर सकते हैं, लेकिन यूपीएससी के लिए यूनियन का पर्याप्त रहेगा. द स्ट्रक्चर which has been given for the union is going to be enough for the UPSC. Difference is with the 1984 Act के काफी सारे provisions they were not suiting the current time, so they were in a way changed. So, for example, you have a 1956 Companies Act which was changed in 2013 according to the changes in technology, etc. So especially after liberalization of the economy, the 1984 Act was not able to deal with the cooperative societies apparatus which had to be created. So in 2002 a new cooperative act was brought about. Okay, how do cooperative elections are organized by single state cooperatives are under that state. If I am a single state cooperative in the state of Uttar Pradesh, then it is the Uttar Pradesh Legislative Assembly which shall decide how my activities are organized. Okay, are we clear about this class? Cooperative societies, समझ में आ गया आपको ये? Composition अगर आपको पता करना था, I have given you the understanding of it. Class, is everything clear? Class, are we here all of us? ये सारी चीजें बहुत ड्राई और डिस्कर्सिव लग सकती हैं, लेकिन प्रश्न इनसे आते हैं. Right? On one hand, you have the bombastic and spectacular items like the electoral bonds, like the Maharashtra Legislative Assembly, reservations, etc. But ये ना जो background की चीजें हैं ना, which are slowly moving and the media doesn't pay too much attention on them, these are also a very fundamental part of the UPSC examination. ये पीछे पीछे से आती रहती है, किसी को पता नहीं चलता कि questions क्यों आए. Right? But all of these are coming out of the current updates. Current updates में जो चीजें चल रही हैं उन्हीं से प्रश्न पूछे जाते हैं. मैंने आपको प्रेजेंस वाला क्वेश्चन दिखाया था, पिछली बार सब लोग परेशान हो गए थे इस क्वेश्चन को देख के, लेकिन किसी को ये नहीं पता था कि यूपीएससी ने क्वेश्चन हवा में से नहीं निकाला है. The UPSC has not taken out this question out of thin air. It is the fact that it appeared as a current update. Prison reforms was a very important notification released by the Home Ministry just 3 months before the exam came out, and on the basis of that they asked a question which is historically connected to that part. Okay, so in the same sense I am in a way flagging the concept of cooperatives for you. ठीक है, चलिए अब आगे बढ़ते हैं. Let's move forward. Okay, today the most important part that I'm going to discuss, as I have been telling for some time, is the case of electoral bonds. ठीक है, इससे आपका प्रश्न आएगा ही आएगा इस बार, लेकिन प्रश्न आसान नहीं आएगा, मुश्किल आएगा, क्योंकि आसान चीजें सबको पता होंगी, क्योंकि थोड़ा बहुत तो सब लोगों ने पढ़ ही लिया होगा, right? The question that is going to come out of this particular part is going to be slightly different and difficult, and therefore we have to be able to understand that we study the what is known as the electoral bond scheme, which came up in 2018. Electoral bond scheme which came out in 2018, which is basically what we want to study very clearly and categorically over here. Okay, so class, are we ready? Guys, are you here or not? Starting with the electoral bond scheme. अब ये हमारा जो आज का पूरा क्लासरूम है, अधिकतर इलेक्टोरल बॉन्ड्स के आसपास ही घूमेगा. Whatever is happening within the electoral bonds is what I'm going to now start in a very categorical manner. ठीक है, चलिए, let's begin. We are going to, this is going to be one of those chapters again as lengthy and as rich as reservations and Maharashtra Legislative Assembly. ठीक, और question इस पे से आएंगे. You will expect a question from the UPSC in this prelims examination, certainly upon something which is going over here. It's a judgment given by the Supreme Court on the 15th of February 2024. It is a recipe for a current update. The name of the judgment is Association for Democratic Reforms, also known as ADR versus the Union of India. Okay, this is what basically we are taking a look at. The writ petition, the judgment has been given on 15th of February 2024 by the Supreme Court. 5-judge bench, unanimously they have given this judgment. Yesterday I had taken a look at what is known as the 5-judge bench of the Supreme Court, etc., etc. Okay, so now we're going to take a little bit of a context of this judgment. The main point, let's say for example, अब देखिए इन तरह के प्रश्नों के साथ ना बात क्या होती है, the whole idea about questions like these is that they have to be understood slightly better than everyone else understands them. सबको पता है थोड़ा बहुत इलेक्टोरल बॉन्ड में क्या होता है, everyone would know it. आपको थोड़ा कुछ अलग जानना है जिससे कि यूपीएससी का एग्जाम निकल जाए. Your knowledge about these things is supposed to be slightly different and slightly advanced than what is known as what is the UPSC basically trying to do over here. Okay. Just let me adjust the relevant pages on this particular part properly for you to understand it. अब ढंग से आप अपने कॉपी किताब लेके बैठ जाइए, ढंग से, बहुत सारी चीजें समझने की है. We are going to focus upon understanding it properly, but also make sure that we understand it and we are able to memorize the provisions which are going to be there. Okay. The legislation which is at the center of this entire thing is what is known as the Finance Act 2017. Okay, Finance Act 2017 is at the center of this entire litigation. What is happening basically with regard to the electoral bond scheme, etc., etc. If you go down in the technical details of these parts, These are what are known as the concepts of the electoral bond schemes under the Finance Act. Okay, now there are provisions within the Finance Act which have been amended, and I need to in a way explain to you how this particular part works. पहले सबसे पहले हमको ये समझना पड़ेगा कि फाइनेंस एक्ट के आसपास की जो चीजें हैं वो क्या होती हैं. Class, are we ready? You'll have to pay a little bit of an attention to what we are writing over here. It is in the Finance Act the term electoral bonds appear. Finance Act 2017. ठीक है. Class, are we ready? Are you all here? ठीक है, आप बिल्कुल तैयार हैं आप इलेक्टोरल बॉन्ड्स का पूरा ऊपर नीचे समझने के लिए. This is going to be a little bit of a long drawn understanding of this particular matter. तो आपको ध्यान से सुनना पड़ेगा इन चीजों के बारे में. Okay, let's start. The Parliament of India passed the Finance Act 2017. The Parliament of India passed the Finance Act 2017. Okay, ठीक है. And in the Finance Act 2017, there was mention of what are known as electoral bonds. Just take a look at this descriptively. We'll go to the details of it in a bit, but just take a look at it descriptively. Very simply, analytically, I'm trying to put a little bit of a historical understanding to this part. Parliament of India passed the Finance Act in 2017, and in the Finance Act 2017, you had the electoral bonds. But the scheme of electoral bonds basically emerged from the Finance Act 2017. Okay, first of all, the question is, what is a Finance Act? ठीक है, बिल्कुल सिंपल एक हमारा बुनियादी प्रश्न आएगा यूपीएससी में, वो ये है कि फाइनेंस एक्ट क्या होता है. इनफैक्ट दिस क्वेश्चन हैज बीन आस्क्ड बाय द यूपीएससी even in 2023. Okay, what is a Finance Act? So just take a look at this question, for example, over here. You take a look at this question. Question number 37. A question on finance bill has been asked by the UPSC, even here. ठीक है, तो सबसे पहले हमको ये समझना है कि what is a Finance Act, what is a Financial Act, what are the money bills, etc. etc. थोड़ा सा इस पे हल्का सा let me do a little bit of a juggling to understand this part. Okay, now please pay attention to this. The question that we're first asking is, what is a Finance Act? Right, now the answer to that question is very simply, Finance Act is the bill passed by the Parliament in the budget session. Finance Act is the bill passed by the Parliament in the budget session, comma, which is a part of the procedure of what is known as annual financial statement. Take a look at this. Finance Act is a bill passed by the Parliament in the budget session, which is a part of what is known as annual financial statement. कहने का मतलब ये है that a Finance Act is an act which is made by the Parliament during the budget session. ठीक है, और Finance Act is the act by which taxes are imposed upon the people of India. Okay, so for example, if you go a little bit deeper into this part, class, I'm trying to develop concept after concept after concept after concept to understand the entire electoral bond schemes and the logic which has been used by the Supreme Court to declare it as unconstitutional. Please pay very good attention upon this. This is the hottest topic in the polity paper this time. Okay, I'm inviting your attention a little more heavily than usual upon a matter like this. If you take a look at, for example, the process of what is known as an annual financial statement, also known as the budget. If you take a look at the process of what is called an annual financial statement, also known as a budget, the annual financial statement also known as a budget, then what happens basically within the annual financial statement is that you have, let's say for example, the Consolidated Fund of India, right? Now you know for a fact that there is a Consolidated Fund of India which is at the center of where the money is kept with the government of India. So all the money which is earned by the government of India as revenues and spent by the government of India is taken from the Consolidated Fund of India. So if tax is being charged upon the people of India, the money is being taken into the Consolidated Fund of India. And if government is making expenditure from the money of the people of India, the money is being taken out from the Consolidated Fund of India, right? And the estimate of receipts and expenditure, again I will repeat, the estimate of receipts and expenditure which happens with regard to one financial year is known as the annual financial statement, also known as the budget. Okay, so for example, let's take a look at this. The government of India, if I place for example the government of India on both these ends, okay, the government of India presents before the parliament, this is the parliament, okay, the government of India presents before the parliament what you can say an estimate of receipts and an estimate of expenditure. Right? The government of India places before the parliament an estimate of receipts and an estimate of expenditure for one financial year. Right? And this statement, which calls itself the estimate of receipts and expenditures, is known as the annual financial statement, as it is provided under Article 112 of the Constitution. Class, are we focusing upon this? What is known as the annual financial statement is also in very simple colloquial terms known as the budget or the union budget, if you will. Okay, Government of India presents before the Parliament estimates of receipts and estimates of expenditure. Estimates of receipts imply that the Government of India wants to collect taxes from the people of India. Okay, Government of India wants to collect taxes from the people of India, and then those taxes need to be stored in the Consolidated Fund of India. So the estimate of receipts means the taxes which are to be collected from the people of India so that the money can be put inside the Consolidated Fund of India is what is known as an estimate of receipts. Am I clear about this, class? The Government of India has to fill the Consolidated Fund of India so that it can spend the money in its activities. Okay, so the way to fill the Consolidated Fund of India for the Government of India is to collect taxes from the people of India and, with the permission of the Parliament, impose those taxes before the people of India, and the money which is earned by those taxes is supposed to be made a part of the consolidated fund of India. Am I clear, class? Class, does it make sense? If I am the government of India, I am taking money from the people of India with the permission of the parliament. Article 265 of the constitution says that no tax can be levied upon the people except by the authority of law. Okay, so the government of India, if it has to apply a tax upon the people of India, it has to have a bill passed by the parliament. I will repeat again. Article 265 of the constitution says that no tax can be applied upon the people of India except by the authority of law, which means to say that if the government of India wants to pick a 20% GST upon the people of India, it can only be done by passing a law before the parliament. Right? Now, if you take a look at the annual financial statement, which is called the budget, in the annual financial statement, the government of India proposes before the parliament a set of taxation values. Okay, so for example, if you see, for instance, when our finance minister stands before the parliament and says, we want to increase income tax slabs, or we want to make adjustments to income tax slabs. For example, 15% income tax has to be charged for people who are earning between 5 lakh to 10 lakh rupees. Okay, in this way, what the finance minister is saying to the parliament is that we want to increase the taxes on the people who are earning money from 5 to 10 lakh rupees, and by these increase of taxes we are going to earn our revenue. That revenue is going to be stored in the consolidated fund of India, and that revenue is going to be spent by the government of India upon its policies and schemes. So this part which I am indicating is known as the expenditure, and this part is what I am indicating known as receipts. Are we clear, class? Class, are we clear about this? Yes or no? So you have an estimate of receipts and estimate of expenditure which is made by the government of India before the parliament, which is done for one financial year, known as the annual financial statement under article 112 of the constitution, also known very simply as the budget. Do we get this point, class? Okay. So for example, very simply, if I make a point like this, that if I am the government of India and I am presenting before the parliament an estimate of receipts, what is that estimate of receipts supposed to contain within itself? It is supposed to contain within itself how taxes are supposed to be adjusted or readjusted. You see, so for example, I am increasing income tax upon people who are earning more than 30 lakh rupees. I am increasing GST upon this item. I am increasing CGST upon this item, IGST upon this item. All of these taxation rates are to be produced by the government of India before the Parliament of India for the Parliament of India's approval. And once the Parliament of India has approved it under the procedure which is given in the Constitution, then these taxation rates apply upon the people of India. So every time, for example, after the budget session, you most importantly look in the news to understand whether certain items have become costlier or cheaper, and that basically is identified not because the rate of the item is changing according to the demand supply logic, but because the government taxes upon those items have been varied. How do the taxes vary? When the government presents before the parliament a statement of receipts which tells the parliament this item is going to be taxed like this, this item is going to be taxed like this, this item is going to be taxed like this. And the objective of the government to present the statement of receipts before the parliament is to earn revenue. The earned revenue, with the permission of the parliament, is stored in what is known as the consolidated fund of India, right? But to earn revenue by imposing taxes upon the people of India, the government must take permission of the parliament, because under article 265, and it is a simple principle of law in India, the taxes in India cannot be imposed except by the authority of law. So you need a bill to be passed by the parliament before taxes can become a real application upon the people of India. Am I clear about this part? Yes or no? Now, if I very simply take a look at this particular perspective, when a bill is introduced before the parliament, or let's say, when a bill is introduced before the parliament, asking the parliament's permission to put a certain taxation upon the people of India, this bill is known as a financial bill. Sorry, this bill is known as a finance bill. Okay. Again, let me very simply take a look at it. A bill which is introduced by the government of India before the parliament detailing the tax it wants to levy for one financial year in pursuit of the estimate of receipts. That bill is known as a financial, sorry, that bill is known as a finance bill. Okay, this is what basically is the definition of a finance bill. Am I making my point clear to you, class? The bill which is introduced by the government of India before the Parliament of India, saying that these are the tax rates that we are going to apply upon the people of India for the coming financial year, so that we have money in the consolidated fund of India to spend in the next financial year. Okay, these are the taxes that we are going to apply on the people of India for the coming financial year, so that we have enough money to spend from the consolidated fund of India. Do you get the point? This proposition, this application made before the parliament, again I'll repeat, this application made before the parliament by the government of India to impose such and 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 such tax rates is what is known as a finance bill. Once the parliament has passed the finance bill, it is known as a finance act. With the passage of the finance act, the tax rates which are approved by the parliament become applicable upon the people of India, and the people of India start paying those taxes, and then the tax which is paid by the people of India is stored into the consolidated fund of India, and this money now becomes usable by the government of India for its expenditure. Do I make myself clear? What is a definition and the context of what is a finance bill? And again, just a very simple understanding that the government of India also makes what you can call a bill which is giving estimates of expenditure. Okay? So once, for example, you have money in the consolidated fund of India, if you want to draw the money out of the consolidated fund of India, that also cannot happen without the will of the parliament. Okay, if you want to draw the money out of the consolidated fund of India for your expenditure, so where you have estimate of expenditure, if you want to draw the bill out of the consolidated fund of India for your expenditure, then the bill over here is what is known as an appropriation bill. Okay, appropriation bill is a bill which is introduced by the government of India before the parliament to appropriate monies out of the consolidated fund of India. Okay, so appropriation bill and finance bill are opposite to each other. By a finance bill, you present before the parliament the proposal. By finance bill, you present before the parliament the proposal that this money has to be introduced into the consolidated fund of India by taxing people. So basically, it talks about tax rates which are to be applicable upon the people of India for the purposes of government earning revenues, and the revenues are stored in the consolidated fund of India. Clear? This estimate of receipts is what is known as a finance bill. Finance bill is proposed by the government of India, which means that the government of India is proposing a taxation rate. Okay, and the finance bill is supposed to be cleared by the Parliament of India, approved by the Parliament of India. Once the Parliament approves it, or it can disapprove it, of course, it is not necessary for it to approve it, it can disapprove it, it can vote it down. But once it has been cleared by the Parliament, then money into the consolidated fund of India can start running, and the tax code starts getting applied upon the citizens of India. This is what is known as a finance bill. So a finance bill is a bill made by the government of India before the Parliament of India as a part of the annual financial statement made in the budget session, which talks about a tax rate which has to be applied upon the people of India, by which revenues are going to be earned and stored in the consolidated fund of India. And once these revenues have been earned and stored into the consolidated fund of India, these revenues need to be withdrawn for expenditure. Government of India wants to buy 5 S-400s from Russian government. It has to take the money out of the consolidated fund of India, give it to the Ministry of Defense to make that kind of a purchase. Right? So this kind of a bill, which is presented before the Parliament to appropriate money out of the consolidated fund of India, which is indicated in the estimate of expenditures for one financial year, is known as appropriation bill. Yes, finance bill only includes the receipts of the government, meaning the taxes. Yes, ideally it is only supposed to include that, nothing else. Mostly it is inclusive of that only. Class, are we understanding the difference between a finance bill and an appropriation bill? Class, are we here? Do we understand the difference between a finance bill and an appropriation bill? So what you're saying is not finance bill but financial bill type 1 and type 2. That's a different terminology. It's not the same thing, and I'll come to it later on. What you're talking about it, Article 117, 117 clause 1 and clause 3, I'll come to it later on. ठीक है, अभी थोड़ा सा मैं बस एक फाइनेंस बिल पे थोड़ा फोकस करूंगा इस लेवल पे. आप जिसकी बात कर रहे हैं उसको फाइनेंशियल बिल कहते हैं, फाइनेंस बिल नहीं कहते. ठीक है, आप देखिए एक बार आर्टिकल 117 में जो लिखा हुआ है, इफ यू टेक अ लुक एट व्हाट इज रिटन अंडर आर्टिकल 117, इट इज नॉट फाइनेंस बिल बट फाइनेंशियल बिल्स. Finance bill is not mentioned in the constitution as such. Appropriation bill and finance bill both are a part of the budget. Budget की proceedings को अगर आप डिटेल करेंगे तो उसमें से निकल के आएगा appropriation bill और finance bill. ठीक है? If the government runs out of money in this middle of the financial year, the government can make exceptional grants under Article 115 of the Constitution. I request you to read Article 115 of the Constitution, please. You will get the answer over there. Exceptional demands or supplementary or additional demands are given under Article 117 of the Constitution. Okay? Right. Now, am I clear about this part, please, class? So, when I take a look at, for example, again, in a little bit of an understanding, by a finance bill which is passed in the budget session of the Parliament, taxes are implemented or enforced upon the citizens of India by a finance bill which is placed before the Parliament by the government. Taxes are enforced upon the people of India, and the collection of these taxes is sent to the consolidated fund of India. Am I clear about this? A finance bill is presented during the budget by which the Parliament approves the taxes which are supposed to be subjected upon the people of India for earning the revenues for the government of India, which are stored under the consolidated fund of India. So money comes in the form of taxes which are imposed upon the people of India. This is done through what is known as a finance bill. The finance bill is introduced inside the Lok Sabha and the Rajya Sabha by the government, and the finance bill is a form of money bill. Let me be very clear about this. finance bill is certified as a money bill. If you want, I can write it out more elaborately. All of these are going to be very important questions this time. Finance bill is certified as a money bill. Okay, class? Finance bill is certified as a money bill. And therefore, the procedure of money bill under Article 109 is followed. Okay? The Speaker of the House under Article 110, Clause 3 of the Constitution has the power to classify a particular bill as a money bill or another bill. And the tradition with the finance bill is that it is certified as a money bill. And therefore, the finance bill is passed by the parliament in the same way that the parliament passes a money bill. But whatever procedure it takes to pass a finance bill, to pass a money bill, is exactly the same procedure it takes to pass a finance bill. This is what distinguishes a finance bill from a financial bill. Okay, financial bill is distinct from a money bill. Finance bill is a money bill, and therefore these are two distinct concepts altogether. They're not similar to each other. Okay, the money which is being taken from the Consolidated Fund of India and given to the Government of India for expenditure is approved by the Parliament by the passing of what is known as a appropriation bill. Do we understand this? By passing of what is known as an appropriation bill. An appropriation bill is also certified as a money bill. Appropriation bill is also certified as a money bill. Am I clear about this, class? So you have a finance bill which is certified as a money bill. You have an appropriation bill which is certified as a money bill. A finance bill which is certified as a money bill, an appropriation bill which is certified as a money bill. A finance bill makes money come inside the Consolidated Fund of India by the imposition of taxes. An appropriation bill makes money get out of the Consolidated Fund of India by the receipt of expenditures. And this is how the budgetary cycle moves. You put money inside the Consolidated Fund of India by passing a finance bill. You put money outside the Consolidated Fund of India by passing the appropriation bill. And the procedure for passing both the financial bill and the appropriation bill is exactly the same which is given in the Constitution for a money bill. You see, the procedure for passing a money bill is given under Article 109 of the Constitution. And procedure of passing the money bill requires that money bill can only be introduced in the Lok Sabha. Money bill can transmit from the Lok Sabha to the Rajya Sabha. Rajya Sabha will have powers only to make recommendations on a money bill, but these recommendations are not going to be binding upon the Lok Sabha. Rajya Sabha has to return the money bill with its recommendations to the Lok Sabha within 14 days of its receipt. If it does not return the money bill within 14 days, the power of the Rajya Sabha shall be considered to be void, and the money bill shall be passed as it was passed by the Lok Sabha. So within 14 days, the Rajya Sabha has to return the money bill to the Lok Sabha. And when it comes to the presidential assent, when it comes to the assent of the president, the money bill shall not be, what you can say, returned by the president to the parliament. It has either to be given assent to, or it can be withheld, but it cannot be returned. All of these provisions are given under Article 109 of the Constitution. So please, I request you to, after the classes are done, take a look at Article 109 of the Constitution to read about the procedure of passing a money bill. And the procedure of passing a money bill specifically deals with the bypassing of the powers of the Rajya Sabha. So again, to derive from it a very simple idea, that when taxes are imposed upon the people of India and money is placed inside the consolidated fund of India, then a finance bill is passed, and finance bill is a money bill. The certification of finance bill is done as a money bill, and thus a finance bill does not go through the Rajya Sabha, right? The Rajya Sabha does not have any voting power upon a finance bill because it is a money bill. Similarly, when money is taken out of the consolidated fund of India and given to the government of India for expenditure, when money is taken out of the consolidated fund of India and given to the government of India for expenditure, at that time also a finance appropriation bill is passed, and appropriation bill is also tagged as a money bill, and therefore the appropriation bill also does not need to be voted by the Rajya Sabha, and thus the Rajya Sabha can be bypassed in both the finance bill and the appropriation bill. Am I making my point clear to you, class? Yes or no? This has been a question in the 2023 prelims paper. Class, do we understand it? Yes or no? Are we getting the point I'm trying to make over here? A finance bill is certified as a money bill, an appropriation bill is certified as a money bill. Both of them follow a procedure of passing a money bill under Article 109 of the Constitution. The procedure of passing a money bill is the same as what is given under Article 109, and the key feature of the procedure of passing a money bill that it need not be passed through a Rajya Sabha. The key feature of passing a money bill is that it need not be passed through a Rajya Sabha. Okay, and therefore by finance bill and by appropriation bill, you can take the money inside the consolidated fund of India but bypass the Rajya Sabha, and you can take money outside the consolidated fund of India and bypass the, what you can say, Rajya Sabha. Now, you know for a fact, if you take a look at the simple parliamentary form of government, which I'm assuming that you understand by now, the largest party in the Lok Sabha forms the government, right? The government introduces the bill before the Lok Sabha. The government, which is the political party in the government, has the majority in the Lok Sabha. Therefore, the government and the majority in the Lok Sabha can easily pass a finance bill and an appropriation bill. And a check and balance which is to be provided by the Rajya Sabha is not needed. So more or less, it can be simply stated that the government, which has the political majority within the Lok Sabha, can easily pass a finance bill and an appropriation bill, which means the government, which has a majority in the Lok Sabha, can easily take taxes, place taxes upon the people of India and put money inside the consolidated fund of India, and take money out of the consolidated fund of India and spend it upon the people of India. Do you get the point? Do you understand the point? Class, are we clear till now? So if the government, which has a political majority in the Lok Sabha, as a political party has to decide to pass a finance bill, it can do it by bypassing the Rajya Sabha. And if the government, which has a political majority in the Rajya Sabha, a political majority in the Lok Sabha, tries to take money out of the consolidated fund of India by bypassing the Rajya Sabha, it can do it. Right? Now think about it like this. A political party which has the majority in Lok Sabha forms the government of India. A political party can place any kind of a tax upon the people of India through a finance bill and get the Lok Sabha to pass it, and the Rajya Sabha is not needed to pass it. So this money can be kept inside the consolidated fund of India by that political party. Right? And the same political party, if it has power in the Lok Sabha, can take the money out of the consolidated fund of India and bypass the Rajya Sabha and spend the money of the people of India on the people of India. Do I make my point clear? A finance bill is a money bill which gives power to the political party which has control over the Lok Sabha to put any taxes upon the people of India and put those taxes in the consolidated fund of India. And at the same time, the political party which is in power in the Lok Sabha has very simple, authority to take money from the consolidated fund of India and take that money and spend it on the people of India. So the higher power within the budget, within the annual financial statement, is given to the political party which has a majority in the Lok Sabha, because a political party in the majority in the Lok Sabha controls the Lok Sabha and it also forms the government, both in the cases of finance bill and appropriation bill, and both the finance bill and appropriation bill are certified as money bills. क्लास कुछ समझ में आया? थोड़ा थोड़ा मैं डिटेल में और अच्छे से बता दूंगा, पर आप समझ पा रहे हैं ना इसमें हम क्या कहना चाह रहे हैं? अगर कोई पॉलिटिकल पार्टी लोकसभा में मेजॉरिटी में है तो वो लोकसभा भी कंट्रोल करेगी और गवर्नमेंट भी बनाएगी, और अगर उसको कोई टैक्स लगा के लोगों से पैसे लेने हैं तो वो ले सकती है, क्योंकि राज्यसभा बाईपास की जा सकती है, क्योंकि फाइनेंस बिल इज सर्टिफाइड एज अ मनी बिल. सिमिलरली अगर वही पॉलिटिकल पार्टी लोकसभा में मेजॉरिटी में है और अगर वो कंसोलिडेटेड फंड ऑफ इंडिया से पैसा निकालना चाह रही है तो वो, क्योंकि गवर्नमेंट भी है और लोकसभा में भी मेजॉरिटी में है, तो वो पॉलिटिकल पार्टी आराम से कंसोलिडेटेड फंड ऑफ इंडिया से पैसा निकाल के कहीं पर भी लगा सकती है विदाउट टेकिंग कंसल्टेशन ऑफ द राज्यसभा, बिकॉज द राज्यसभा is bypassed in a money bill, and a finance bill which takes the money inside the consolidated fund of India and which takes the money outside the consolidated fund of India is a money bill, is certified as a money bill, and the money bill can be bypassed by the Lok Sabha. Bypassed money bill can bypass the Rajya Sabha and focus only upon Lok Sabha. तो आपको सिर्फ एक ही चीज पे फोकस करना है कि आप लोक सभा का कंट्रोल कैसे करोगे. मतलब how do you win the Lok Sabha elections? If you can win the Lok Sabha elections, any tax you can impose upon the people of India and any money you can spend out of the consolidated fund of India for the people of India. Class, do we have a sense of it? Yes or no? Okay, so let's say for example if I identify for you, now forget about financial bill type A type B, भूल जाइए उसको, बाद में बताएंगे उसके बारे में. financial bill type A type B को भूल जाइए, बाद में बताएंगे, कंफ्यूज मत होइएगा. If I take a look at what is known as the, let's say a document given by the Rajya Sabha Secretariat itself, and understand what is the nature of a finance bill and an appropriation bill. Let's see what this document says for us. Take a look at this. We talk about a finance bill, as I'm telling you that the finance bill is certified as what you can call a money bill. Okay, please take a look at this part very simply, very clearly. यहां से लेकर यहां तक इसको पढ़िए. Finance bill which is introduced in the Lok Sabha immediately after the presentation of the budget by the Minister of Finance is passed by the Lok Sabha and transmitted to the Rajya Sabha after the passing of the appropriation bill. It is also certified as a money bill. So what am I getting over here? A finance bill which is taking money out of the money from the taxpayers and putting it in the consolidated fund of India is going to follow the procedure of the money bill, which means the Rajya Sabha will not have any power with regard to the taxes which are going to be imposed upon the people of India and those taxes coming to the consolidated fund of India. A finance bill is certified as a money bill. इसी पे पिछली बार क्वेश्चन पूछा गया था 2023 में. The question that was asked was exactly upon this particular part, which was finance bill and money bill. ये वाला question था इस पे. Exactly this part was a form of the question last year. Right? Do we understand this? ठीक है. अब देखिए, अब एक बार आप फाइनेंस बिल समझ गए तो अब थोड़ा ध्यान से देखिएगा इस चीज को. ठीक है, जस्ट गिव मी स्पेस ओवर हियर टू मेक यू अंडरस्टैंड व्हाट आई एम ट्राइंग टू से. बात हो रही है यहाँ पे फाइनेंस एक्ट 2017 की. वी आर टॉकिंग विद रिगार्ड टू द इलेक्टोरल बॉन्ड स्कीम. वी आर टॉकिंग अबाउट फाइनेंस एक्ट 2017. नाउ यू नो फॉर अ फैक्ट दैट फाइनेंस एक्ट 2017 must have been passed during the budget session. Yes. Okay. Second, it must be a part of the annual financial statement. Yes. It must talk about tax rates which are increased or decreased for the financial year 2018-19, है ना? Tax rates which are increased or decreased for the financial year 2018 and 19. यही बात है, ठीक है? You understand? It is certified as a money bill, which means that the Rajya Sabha does not have any powers over it. Do we understand this? हम बात कर रहे हैं फाइनेंस एक्ट 2017 की, ठीक है? तो फाइनेंस एक्ट 2017 is where basically the first time the concept of electoral bonds comes into picture. I hope that now I am able to in a way set the background straight for what we are trying to understand over here, class. When we talk about the Finance Act 2017, in the Finance Act 2017 you have the budget session, which is the part of the annual financial statement. Tax rates ऊपर नीचे करते हैं 2018-19 के financial year के लिए, right? In fact 2017-18 के लिए, not for 18-19, 2017 and 18 financial year. ठीक है? It is a part. It is known as a money bill, which means it can bypass the Rajya Sabha, and it is a part of the money bill, which means it can bypass the Rajya Sabha, and it is the point in which electoral bond scheme was initiated. ठीक है? तो यही मैं आपको दिखाना चाह रहा था. For example, if you take a look at this part over here, under section 137 of the Finance Act, you have, for example, concept of what is known as an electoral bond. So if a question comes, very simply, now we're going to deal categorically step by step of the data from which electoral bonds पे questions आ सकते. देखिए, simple सवाल नहीं पूछा जाएगा electoral bond पे, थोड़ा सा technical सवाल पूछा जाएगा. Okay? The question, for example, if it comes to you, is under which of the following laws was the electoral bonds first instituted? The answer is Finance Act 2017. You know what a Finance Act is. Finance Act or a finance bill, a bill before it is passed is known as a bill, after it is passed it is known as an act. A finance bill or finance act is certified as a money bill. It is a bill which is brought before the government, brought by the government before the Lok Sabha, specifically because it is a money bill. It cannot be introduced in the Rajya Sabha. So it is a bill which is brought by the government before the Lok Sabha for putting money from the taxpayer's pocket into the consolidated fund of India during the budget session as a part of the annual financial statement. ये सारे आपके terms बन के आएंगे multiple choice questions की तरह एग्जाम में, क्योंकि ये सारा इलेक्टोरल बॉन्ड के आसपास ही घेरा घूम रहा है. पिछली बार भी प्रश्न ये एक आ चुका है फाइनेंस बिल पे, उसके पिछली बार भी आ चुका है. इस बार किसी नए परम्यूटेशन कॉम्बिनेशन में प्रश्न दोबारा पूछा जा सकता है. क्लास, am I making this point clear to you? So the first time the concept of electoral bonds as a concept was inserted was in Finance Act 2017, 2017. Am I clear? Right? Now, if you take for example an understanding of this part slightly more properly, how does the Finance Act, now very simply I'm just putting over here a little bit of a thing. Okay? Just if I take about, let's say for example, the electoral bond scheme. If I take a look at the electoral bond scheme, I know that it emerged from the Finance Act 2017. Okay, I am preparing for you all your possible prelims possibility questions. This is one of the most landmark judgments of the Supreme Court. A lot of people have hailed this judgment of the Supreme Court as a historical judgment, right? For example, the previous Election Commissioner of India, he has said that this is the most important judgment given by the Supreme Court in the last 10 years. पिछले 10 वर्षों में जो सबसे इंपॉर्टेंट जजमेंट आया सुप्रीम कोर्ट का वो इलेक्टोरल बॉन्ड्स का, इसीलिए मैं आपको हर तालिका पे, हर कैटेगराइजेशन पे इसके बारे में प्रॉपरली क्लैरिटी देना चाहता हूँ. Okay, now if you take a look at, for example, the electoral bond which comes of a finance act. फाइनेंस एक्ट में सरकार क्या करती है? फाइनेंस एक्ट में सरकार ये चीजें करती है, देखिएगा. प्लीज टेक अ लुक एट दिस. फाइनेंस एक्ट में सरकार आरबीआई एक्ट की कुछ प्रोविजंस लेती है और उनको अमेंड कर देती है. You see, certain provisions of the RBI Act are taken by the government and amended. Okay, so for example, if you go to the judgment over here, government takes the, what you can say, let's say the government takes the section 29C of the Representation of People's Act and amends it by section 137 of the Finance Act 2017. थोड़ा देखिएगा, इसको आ जाएगा समझ में धीरे धीरे, परेशानी वाली बात नहीं है. Okay, it takes section 29C1 of the Representation of People's Act and amends it by section 137 of the Finance Act. It takes section 182 of the Companies Act and amends it by section 154 of the Finance Act. It takes section 13A of the Finance Act of the Income Tax Act and amends it by the Finance Act. Okay, थोड़ा इसको एक बार पढ़िए. I'm going to be very clear about explaining this properly. Okay, now think about it very simply. Let's say if this is the RBI Act. Okay, ये RBI Act है. थोड़ा समझते हैं इस चीज को, बहुत आसानी समझ में आ जाएगा, कोई मुश्किल वाली बात नहीं है, समझना जरूरी है इस चीज को. Let's say if this is the RBI Act. RBI Act has section 1, 2, 3, 4, 5, etc., etc. Okay, and let's say for example if this is the Representation of People's Act. Okay, so you have the RBI Act, Representation of People Act 1951, RBI Act 1934. Okay, and let's say for example you have the Companies Act. (2013), and let's say for example you have what is known as the Income Tax Act. ठीक है, देखिए जरा टेक्निकलिटी देखिए. ये सारे एक्ट आपके बने हैं, इन एक्ट्स के अंदर काफी सारे सेक्शन लगे हुए हैं. ठीक है, सेक्शन लगे हुए हैं, यहाँ पर भी सेक्शन. ठीक, अब सरकार ने क्या किया? 2017, in the 2017 budget session, okay, please be careful about this. Okay, in the 2017 budget session, the government of India prepared what is known as a finance bill. In 2017 budget session, the government of India produced a finance bill, and then what the government of India did was, in the finance bill, it took, let's say for example, this part of the RBI and introduced this has to be amended. जैसे मान के चलिए यहाँ पर लिखा था 411,789. Okay, what the government of India did over here was, it took 4 and it said to 11789, we are going to add plus 2. Just think about it technically. Okay. Similarly, for example, it took 5 from the RPA Act and placed it over here. And let's say the 5 read 3384. Then the government of India said 5 we are going to make it like this, 3384 plus 3. ठीक है, इसको ऐसे समझिए बिल्कुल सिंपली. यहां पर 11789 लिखा है. अगर यहां से सरकार ने सेक्शन 4 उठा के यहां डाला और यहां लिख दिया 11789 plus 2, this is the amendment. What is written in white is the amendment. 3384 plus 3, this is the amendment. Okay. And similarly, it takes, for example, this part from here and makes an amendment to this also. And it takes this part from here and makes an amendment to this also. ठीक है, अभी इन दोनों को छोड़ देते हैं. Let's focus upon only this one. Okay. Now, the Finance Bill 2017 was placed before the Parliament. Finance Bill 2017 was placed before the Parliament. Clear? The Finance Bill 2017, once it is placed before the Parliament, of course it is going to be a money bill. Which means that within the Parliament, only the Lok Sabha shall have the power upon the Finance Bill. Okay. Now, once Finance Bill has been passed by the Lok Sabha and it becomes a Finance Act. Once Finance Bill has been passed by the Lok Sabha, it becomes a Finance Act. ठीक है, take a look at this. 4 और 5 इस तरह से लिखे जाएंगे, 11789 plus 2, 3384 plus 3. एक बार ये प्रोविजंस लोकसभा ने पास कर दिए तो इन प्रोविजंस को अप्रूवल मिलने के बाद यहां पर भी यही लिखा जाएगा, 11789 plus 2 and 3384 plus 3. Now, take a look at the statement. Try to understand this equation, class. It is important that you understand it very clearly because it is absolutely essential that you understand how a Finance Act works, because it is a question in the prelims examination last year. It may be a little technically challenging, but trust me, if you endure with this, you will feel rewarded. In 2017 budget session, a finance bill was introduced before the Parliament as a money bill, and the finance bill said that this finance bill is amending these provisions of the RPA, these provisions of the RBI Act, these provisions of the RPA, these provisions of the Companies Act, and these provisions of the Income Tax Act. So it is taking provisions from all these laws, putting it as a finance bill provision, putting it as a bill in the finance bill, provision in the finance bill, passing it through the Lok Sabha as a money bill, and once it has been passed in the Lok Sabha, then the provisions in the respective law stand amended. Okay, so for example, take a look at this. If I take a look at the RBI Act, there is one way in which I can amend the RBI Act. I can take a look at the RBI Act, present it before the Parliament, and say I want to amend section 35 of the RBI Act to increase the number of people in the Monetary Policy Committee. I can do that if the Parliament passes the law. I can amend the RBI Act. But what also I can do it, I can take section 35 of the RBI Act, place it in a finance bill, present it before the Parliament as a part of the finance bill, and then once I am presenting the finance bill before the Parliament, it is presented as a money bill. And then only the Lok Sabha, if it passes the finance bill, along with the finance bill is also passed an amendment to section 35 of the RBI Act, and now once the Lok Sabha has passed it as a finance bill amendment, this amendment shall reflect in the RBI Act as amended. That is what you say, for example, very simply, that the RBI Act, the RPA, the Income Tax Act and the Companies Act were amended by the Finance Act 2017 to introduce the concept of electoral bonds. This is basically the meaning of the statement that I am making in front of you. Do we understand this logic or not, class? Please confirm to me yes or no. Otherwise, I'll have to go at it again. When I make the statement that the RBI Act, the RPA, Companies Act and the Income Tax Act were amended by the way of Finance Act 2017 to introduce electoral bonds in each of these. So the point, for example, there was no mention of electoral bonds in the RBI Act, there was no mention of electoral bonds in the RPA, no in Companies Act and no in IT Act. But after the provisions of these acts were amended by the 2017 budget session as a finance bill bypassing the Lok Sabha, these amendments eventually let the RBI Act, the Representation of People's Act, the Companies Act and the Income Tax Act all have the concept of electoral bonds. So just before the striking off, for example, all these acts would have the term electoral bonds written into them, but these acts have not singularly been subjected to amendment. Instead, certain provisions of these acts have been taken in the finance bill. The finance bill has made the addition of electoral bonds to these provisions, and then these provisions are presented before the parliament as a money bill, because a finance bill is a money bill, and then the money bill, which is passed by the Lok Sabha, passes the finance bill, becomes the Finance Act 2017, and with the passage of the Finance Act, these provisions now reflect as reality for these individual laws. Do I make sense, class? I can admit if it is slightly technically intimidating, but एक बार समझ में आ गया ना तो पूरा केस आपके सामने खुल जाएगा, क्योंकि जाहिर है इसमें साफ साफ दिख रहा है कि आरबीआई एक्ट को, आरपीए को, कंपनीज एक्ट को और इनकम टैक्स एक्ट को अमेंड करने के लिए आपको लोकसभा और राज्यसभा दोनों चाहिए. लेकिन अगर आप इनकी प्रोविजंस उठा के फाइनेंस बिल में डाल देते हैं तो फाइनेंस बिल मनी बिल की तरह होता है, तो आप राज्यसभा को बाईपास कर सकते हैं. यू सी द पॉइंट? Do you not see the constitutional question over here, right? Exactly. That the putting of the provisions of these bills, of these acts into what is known as the finance bill and passing the finance bill as a money bill is bypassing the Rajya Sabha in one way or the other. Do you get the point? So the question, of course, over here is that the constitutional question is, can provisions of Companies Act, Information Technology Act, Income Tax Act, RPA, etc., etc., can these be passed as a money bill? But if the government takes all of these provisions and puts them in a financial bill, a finance bill, and passes of them as a money bill, it doesn't have to go through the Rajya Sabha. Now, it is a matter of fact, all of you understand that in 2017, the government did not have a majority in the Rajya Sabha. The majority existed only in the Lok Sabha. And in 2019, there were general elections, right? And the Rajya Sabha was building up a kind of a striking down of the electoral bond scheme. So what the government of India did was, the government of India put these acts, exactly the whole problem, Aadhaar passed as finance bill is a problem exactly for that reason. And there is a 7-judge bench made by the Supreme Court, as we were referring it yesterday, that one of the 7 judges bench which is going to take a look at a very serious constitutional matter today is the bench which is going to review the Aadhaar 5-judge bench of asking the question, can an Aadhaar Act be passed as a money bill or a finance bill? And similarly, a bunch of petitions have been made before the Supreme Court, which is going to be reviewed by that 7-judge bench, that can 1, 2, 3, 4 be put into the finance bill and be passed as a money bill by passing the Rajya Sabha. 2017, the government did not have majority in the Rajya Sabha, but they wanted to bring the electoral bond scheme. And thus, to bypass the Rajya Sabha, they introduced the select provisions of the RBI Act. So, for example, RBI Act section 31 was added with section 31 subsection 3, which stated that the government of India, the Reserve Bank of India, can issue electoral bonds or can allow the State Bank of India and other scheduled banks to issue electoral bonds. So, all of these acts had to contain certain provisions about electoral bonds. To make those provisions come into these acts about electoral bonds, you had to make amendments into these acts. But if you made amendment to these acts as ordinary laws, they would be blocked by the Rajya Sabha. So what you did during the budget session, you took the provisions of these acts, put them in a finance bill, and then passed the finance bill as a money bill bypassing the Rajya Sabha. And once the money bill was passed, the provisions of these act also stood as passed. This is what you can say, the background of the statement. That again, I'll repeat this statement, and you read this statement everywhere. You read the introduction about the electoral bonds. The statement says this, that the government of India, the Parliament of India, amended the provisions of RBI Act, the Companies Act, the Income Tax Act, and the Representation of Peoples Act via the Finance Act 2017, by the way of amending, by the way of Finance Act 2017, to create the position of electoral bonds in all of these laws. Do you see the point? Do you see the point? How structurally and institutionally it has been done, and how structurally and institutionally it is a question with regard to its constitutionality. Do you get the point, class? Okay, so if you take a look at the statement, the electoral bond scheme, the provision of section 29C of the Representation of People Act as amended by section 137 of the Finance Act, section 182 of the Companies Act as amended by section 154 of the Finance Act, and section 13A as amended by section 11 of the Finance Act are violative of article 19(1)(a) and unconstitutional. This is a judgment given by the Supreme Court, but I will come to the part of the judgment later on. First, the question is, do you understand what is given in this kind of an assertion? यहाँ पर क्या लिखा है, इसको आप समझ पा रहे हैं कि नहीं समझ पा रहे? That is the basic question. You get the point? Section 229C of the Representation of Peoples Act as amended by section 136(7) of the Finance Act. So instead of amending section 29C as an ordinary law, by putting it as a finance act, as a finance bill, which is a money bill, you can bypass the Rajya Sabha. Section 182 of the Companies Act is amended by section 154 of the Finance Act. So by putting it in the Finance Act, you can bypass the Rajya Sabha. And similarly, section 13A as amended by section 11 of the Finance Act, this would have required a ordinary law, but since it is now made a part of Finance Act, which is a money bill, you can violate the, or you can bypass the fact that you have to make this kind of a law be passed by the Rajya Sabha. Right? Do we understand this, class? Yes or no? Give me a yes or no, and we'll take a break. Do we understand this? What is basically happening here in the political scenario, and what is the nature of a Finance Act, and why do we say that the judgment of the Supreme Court, if for example, if you take a look at very simply the initial terms of the Supreme Court, what it is writing over here. Take a look at this statement. I want you to be very clearly understanding of this statement. See, this is very elementary understanding. You will not develop unless you pay focus on what we are studying over here. And your questions are not going to be out of very superfluous things. Questions आपके इससे पूछे जाएंगे. अब आप मुझे बताइए कि ये statement आप पढ़ पा रहे हैं कि नहीं पढ़ पा रहे हैं? इसे comprehend कर पा रहे हैं कि नहीं कर पा रहे हैं? Tell me, can you read this statement and understand the meaning of this statement? Judgment of the Supreme Court. The petitioners have also challenged the provisions of the Finance Act 2017, which among other things amended the provisions of the Reserve Bank of India Act 1934, the Representation of Peoples Act India 1951, the Income Tax Act 1978, and the Companies Act 2013. Are you able to understand what is the conceptual background of this provision? समझ में आ गया ना? तो बस आधा काम खत्म हो गया यहाँ पर, क्योंकि आधे प्रश्न इसी से आएंगे. If you understand this, it's very clearly, at the point of superiority, you have understood it better than anyone else. What is basically happening over here? If I decode this slightly, what I get out of that decodification is the fact that the government of India has used the method of finance bill to bypass the Rajya Sabha, because a finance bill, as we have seen in this document, right? A finance bill is what you can say certified as a money bill. Do we get the point? The finance bill is certified as a money bill. And for a money bill, you can bypass the Rajya Sabha. And therefore, again, if I come back to this provision right here, The petitioners have also challenged the provisions of the Finance Act 2017, which among other things amended the provisions of the Reserve Bank of India Act 1934, the RPA 1951, the IT 1961 and the Companies Act 2013. These all laws were inserted with the term electoral bonds, but without going to the Rajya Sabha, because the Rajya Sabha did not have a majority of the political party then in government, and there were 2019 elections coming up. Do you get the point? This is the first constitutional challenge that we take a look at. And then the second constitutional challenge is with regard to fundamental rights, Article 19 and Article 14. Once we are done with the next session, I assure you that if you're catching it up properly, you would have a very succinct and a clear understanding of what is the electoral bonds case and all the peripheral information which flows for it, which is going to be a part of your prelims examination. All right, so here, this is the point that I'm trying to make. If we have a statement like this, first of all, very clearly, that if I take a look at this part very simply, if I take a look at the concept of what is known as the electoral bond scheme, take a look at an understanding of what is known as an electoral bond scheme, then what I can say about it as a proposition is that it is introduced as amendments, whether these have been electoral bond as concepts, amendments to the Reserve Bank of India Act, comma, the Income Tax Act, comma, the RPA, Representation of Peoples of India Act, right, and the Companies Act. By the amendments made by the Finance Act 2017. It didn't take 7 years. The mistake was always open. It was, for example, at the time when our Chief Justice was Mr. Ranjan Gogoi, who later became a member of Parliament from the Rajya Sabha from the Bharatiya Janata Party, he was presiding over the matter and he said it's something that I can't interfere in because the decision of the Speaker. You see, that's the point. If you have, for example, and even today, by the way, this issue is not solved yet. If you take a look at Article 110, Clause 3, if you take a look at Article 110, Clause 3, which talks about the money bill, it says the decision of the Speaker upon a money bill shall be final. Whether a bill is to be certified as a money bill or not, the decision of the Speaker shall be final. Do you get the point I'm trying to make over here, class? Whether a bill passes off as a money bill or not, or is certifies upon itself as a money bill or not, the decision of the Speaker shall be final. Now, it is again the same thing as the Speaker of the Lok Sabha and the Legislative Assembly in matters of the anti-defection law and the disqualification on the ground of defection. Okay, so in that sense, the question basically becomes this: number one, can there be a judicial review of the Speaker's decision on a money bill? That is the first question. And the answer that was given by the Supreme Court in what is known as the Aadhaar 5-judge bench case was yes. ठीक है, सुप्रीम कोर्ट ने आधार वाले केस में कहा था कि जो स्पीकर का डिसीजन है आर्टिकल 110 क्लॉज 2 में किसी भी चीज को मनी बिल कह देना, तो आप आरबीआई एक्ट को भी मनी बिल कह सकते हो, आप इलेक्टोरल बॉन्ड्स को भी उसको कंपनीज एक्ट को भी मनी बिल कह सकते हो, किसी को भी कह सकते हो, है ना. So the question is that when a speaker is identifying a particular act as a finance bill and finance bill then being passed as a money bill, is it subject to judicial review? So this was a landmark judgment of the Supreme Court in the Aadhaar case. Yes, it is subject to judicial review. लेकिन इसी आधार केस में क्वेश्चन जैसे आपने पीछे पहले पूछा था, क्वेश्चन वही था कि आधार एक्ट was also passed as a money bill. Okay, Aadhaar Act was also passed as a money bill. और क्वेश्चन ये पूछा गया कि is it true that Aadhaar can be classified as a money bill? This was also a question that was before the Supreme Court 5-judge bench. But in this case, the Supreme Court gave a majority opinion, 4:1. 4 judges of the Supreme Court says yes, classifying Aadhaar as a money bill is correct. मतलब जो स्पीकर है उसका डिसीजन सही है. 4 जजेस ने ये कहा था. But there was a dissenting opinion at the time given by Justice D.Y. Chandrachud, who is the current Chief Justice of India. The dissenting judgment given by Justice D.Y. Chandrachud was that classifying Aadhaar as a money bill is a fraud upon the Constitution of India. As the powers of the Rajya Sabha are bypassed. तो D.Y. Chandrachud ने उस समय ये डिसीजन दिया था. In a way, what you can say, classifying Aadhaar as a money bill is a fraud upon the Constitution of India. This is the judgment that was given by D.Y. Chandrachud. And now this 5-judge bench judgment is now pending with a 7-judge bench. जैसे हमने आपको कल दिखाया था ना कि there are judgments which are pending before the 7 judges bench, and one of those pending judgments, ये आगे जाके आपको डेवलप होता दिखेगा अच्छे खासा. One of those 7 judge benches judgment is going to take a look at the, what you can say, classification of Aadhaar Act as a money bill. And also, by the way, only in this case also we'll take a look at the classification of Finance Act 2017 as a money bill. तो देखिए ये वाला जो क्वेश्चन है ना, स्पीकर की पावर मनी बिल को डिसाइड करने की फाइनल होती है या नहीं होती है, और क्या क्या मापदंड होते हैं जिससे कि आप मनी बिल को डिसाइड कर सकते हो, ये सुप्रीम कोर्ट की 7 जज की बेंच डिसाइड करेगी. तो दो द सुप्रीम कोर्ट हैज मेड अ ऑब्जेक्शन टू द fact that the Aadhaar bill, the RBI Act, the Companies Act, the Income Tax Act, and the, let's say, the Representation of People's Act have been amended via what you can say, money bill route. The Supreme Court has not declared a decision upon that matter because that decision and that whole conceptual question is pending before a 7-judge bench of the Supreme Court. ये वाला मैटर आपका इस समय पेंडिंग चल रहा है. तो मैंने आपको बताया था ना कि कितने सारे मैटर्स हैं सुप्रीम कोर्ट के जो 7 जजेस के बेंच इस बार सॉल्व करेंगे. वन इज द अलीगढ़ मुस्लिम यूनिवर्सिटी माइनॉरिटी स्टेटस, द अदर इज द सब कैटेगराइजेशन ऑफ SC and ST, The other is the Nabam Rabia judgment that we have discussed previously. One of those judgment which is going to be decided by a 7-judge bench of the Supreme Court in the year 2024 itself is going to be a review of this entire thing. तो ये जो question है ना कि can speaker and the government declare anything as a money bill and bypass the Rajya Sabha? What are the checks and balances which can be introduced upon this kind of an activity by the Supreme Court of India? Right, that is going to be one of the most fundamental, what you can say, question that is going to become relevant before the 7-judge bench. ठीक है, अब क्योंकि इलेक्टोरल बॉन्ड्स वाले केसेस में 5-judge bench थी, the 5-judge bench has only given it to the 7-judge bench. तो ये वाला मैटर तो 7-judge bench के सामने चला गया. A larger bench has been created upon this matter. Okay, तो ये वाला जब आपके पास मैटर आएगा तब आप इसके बारे में पढ़ेंगे. We are very clear that this year itself you will have a solution to this problem. ठीक है, again take a look at this. 7-judge constitution bench to revisit the issue. Okay, what is a money bill? Why is a larger bench reference made? And then you will have laws like the Prevention of Money Laundering Act also, जिसमें ईडी को पावर दी गई, इन्फोर्समेंट डायरेक्टरेट को पावर दी गई है ये सारी चीजें करने के लिए जो वो आज कर रही है. What are the powers given to these bodies by which we can take a look at the question of money bill? ठीक है, अब देखिए इसको, take a look at this first paragraph over here. This is October in 2023, again a part of your current updates. The Chief Justice of India on Friday said that he will constitute a 7-judge constitution bench to hear a batch of petitions on October challenging the centre's use of money bill route to pass key legislations after senior advocate Manika Goswami mentioned the matter for urgent listing. A bench comprising of Chief Justice and Justice Pardiwala and Manoj Mishra intimated that all pending 7-judge matters will be listed on October 12 for pursuing procedural directions like the appointment of nodal counsel and for final hearing. ठीक है, तो ये सारी चीजें आने वाली हैं आपकी मनी बिल वाली. तो ये वाला पूरा जो पार्ट है कि व्हाट इज अ मनी बिल एटसेट्रा एटसेट्रा, ये वाली चीज अब 7 जज के सामने पहुंच चुकी है. इसमें वी विल, I'll just take a look at the Prevention of Money Laundering Act also, because even the PMLA amendments which were made into the PMLA, which gave powers to Enforcement Directorate, a lot of powers were given to the ED by amending the PMLA, Enforcement Directorate. That also was passed as a money bill. You see, तो ये वाला जो question है आपका, ये वाला तो इस matter में this is what basically is going to be the question on what it is going to be the case. Okay, and in the same judgment you will take a look at how, for example, the electoral bond scheme also was presented as a money bill. तो ये वाला जो हमारा अभी मतलब the judgment which has come, it has actually not given a clarification because that matter is pending before the, what you can say, 7-judge bench of the Supreme Court. ठीक है, तो just what I'm trying to indicate for you, what is the way that it is working. Just let me show you this part. Okay, I can't access it. 1 second. if you can just take a look at this part over here. Although the Supreme Court struck down the electoral bond scheme as unconstitutional earlier this month, it did not clarify one aspect of the challenge, that is the use of money bill route by government to pass key legislation. As you can see, the issue is pending consideration before a 7-judge constitution bench of the court that is yet to be formed. Okay, so this is what I'm trying to in a way understand with you, that the first thing that we understand, that the constitutional question with something like a electoral bond which is not yet decided, because वो 5 जज की बेंच ने डिसाइड नहीं करना था, 7 जज की बेंच ने करना था, तो इस 5 जज की बेंच ने ये नोट तो कर लिया है कि द मनी बिल राउट which bypasses the Rajya Sabha is seen in many cases. For example, the Aadhaar Act, the Prevention of Money Laundering Act, and of course the whole idea of electoral bond scheme. तो अब इलेक्टोरल बॉन्ड स्कीम को तो यहाँ पे अलग ग्राउंड्स की वजह से अनकॉन्स्टिट्यूशनल डिक्लेयर कर दिया, लेकिन सरकार ने, सुप्रीम कोर्ट ने कह दिया कि दिस एंटायर कॉन्सेप्ट ऑफ अ व्हाट यू कैन से, कैन मनी बिल राउट बी यूज्ड टू पास की लेजिस्लेशंस लाइक दीज by putting them in money bill category and putting the electoral bonds in a finance bill category. इसका जो एक पूरा बड़ा जजमेंट आएगा ना, हमेशा के लिए बाइंडिंग होने वाला, वो इसी साल आएगा 7 जज की बेंच के द्वारा. ये वाला आपका मैटर पेंडिंग है. तो whatever your questions are with regard to the nature in which this particular route is being used to bypass the will of the Rajya Sabha by the Lok Sabha and the government of India, that is going to be a constitutional question on a bench which is going to be headed by the Chief Justice of India. Okay, so that is one thing that we will take a look at later on as it happens. It is not going to be a part of our scheme of things currently. Okay, but in addition to this, if you take a look at now the grounds upon which, let's say for example, very simply, if I take a look at this now, अब ये वाला पहला पार्ट हमारा खत्म हो गया, क्योंकि इससे जो क्वेश्चन आएंगे फाइनेंस बिल पे और फाइनेंस बिल के जो आसपास की एक्टिविटीज है, अगर आप उसको समझ गए हैं कि किस तरह से पास हुआ है बिल, की संख्या, परेशानी है, एंड ऑल ऑफ दैट, तो अब वी कैन कम टू द नेक्स्ट पार्ट ऑफ द एंटायर ऑब्जेक्ट. इफ यू टेक अ लुक एट इलेक्टोरल बॉन्ड्स एज वी हैव सीन इट, इलेक्टोरल बॉन्ड्स talk about amendments which are made to the Reserve Bank of India Act. ठीक है. Second, Representation of People's Act. Third, Companies Act. And fourth, the Income Tax Act. अब इनको ना एक एक करके हम समझने की कोशिश करेंगे इंडिविजुअली कि इन इंडिविजुअल एक्ट्स में क्या क्या किया गया था और व्हाट इज बेसिकली द प्रोविजन व्हिच इज हैपनिंग अंडर ऑल ऑफ दीज एक्ट्स. ठीक है, और फिर उसके बाद एक एक चीज में देखेंगे. सो यू सी फॉर एग्जांपल, इफ आई मार्क एक्स एज इलेक्टोरल बॉन्ड्स, electoral bonds as a concept were introduced in RBI Act, in RPA Act, in Companies Act, and in the IT Act, right? And exactly these provisions has been declared as unconstitutional by the Supreme Court to strike down the electoral bond scheme. तो आपने जैसे for example, if I mark it like this, if I mark it like X1, X2, X3 and X4. So when X1, X2, X3, X4 is marked down, by that virtue, the entire electoral scheme is also marked down. So basically, if I put it very simply in simple categorical terms, the electoral bond scheme emerges out of amendments made to the RBI Act, to the RPA 1951, to the Companies Act and to the IT Act. The concept of electoral bonds has been inserted inside the, what you can say, legislations which are 1, 2, 3, 4 in number. And the Supreme Court has taken a look at each of these legislations, for example, RBI Act, and it has declared the provisions of electoral bonds mentioned in the RBI Act as unconstitutional. Provision of electoral bonds mentioned in the RPA as unconstitutional, provisions of electoral bonds mentioned in the Companies Act as unconstitutional, and provisions of electoral bonds mentioned in the Income Tax Act as unconstitutional. So by striking down X1, X2, X3, X4, the entire electoral bond scheme has been struck down. Okay, so we are going to take a look at the point about this particular thing, which is basically what we are looking at in understanding. ठीक है, आपका क्वेश्चन यहाँ पर है, what is SC reviewing if it's mentioned in the constitution itself that speaker's decision is final? Is it not some undue advantage that the courts use under the impression of interpreting the constitution like the court is becoming the final authority? Well, that's a good question, but then another related question to this is that if you take a look at the constitution itself, see, I'm not saying it is correct or incorrect, but if you take a look at the view that the Supreme Court says about this, अगर आप Supreme Court का पक्ष जानने की कोशिश करें तो मैं बता रहा हूँ कि वो क्या कहेगा. Supreme Court will say that if the speaker's decision had to be final and completely uninhibitedly final, then why did the constitution go in such a detail to describe what is a money bill under Article 110 and what is not a money bill under Article 110? अगर डिसीजन स्पीकर का फाइनल था तो स्पीकर को ही पता होना चाहिए मनी बिल क्या है, मनी बिल क्या नहीं. तो संविधान ने आर्टिकल 110 में इतने डिटेल्ड में बताया क्यों है कि मनी बिल क्या है और क्या नहीं है. नाउ दैट इज ट्रू. If you take a look at Article 110 of the Constitution, 110 Clause 1 A to F, it goes in very, very pointed detail to describe what is a money bill. And also later on it says what is not a money bill. So why are you going to give a definition about something when there is no one to interpret the definition, because the speaker can do whatever he pleases? You see? So this is what the counter, that the fact that the Constituent Assembly has given a detail description of what a money bill is itself implies that the Constituent Assembly wanted the power of the speaker to be supreme, but nonetheless the power of the speaker cannot be completely absolute and there has to be some authority. So if the speaker is not reading the Constitution correctly, the fact that the definition of the money bill has been given, it will deal only related to matters which are given under Article 110 Clause 1 A to F. If only these matters are supposed to be called money bill, if the speaker is misreading these provisions are useless. So there has to be someone who will read these provisions correctly and then tell the speaker that what you're reading is incorrect. And who else would be that apart from the Supreme Court? So that is how basically it assumes the power of what you can call judicial review, that a detailed definition of money bill has been given. Someone has to read it, right? And speaker is not reading it, then he is himself letting us interfere in the matter, because what is written in the Constitution has to be written because it has to be read and applied. If it is not being read and applied, the speaker is himself creating the room for judicial review, right? Okay, so now we'll take a look at each of them independently now. Just take a look at what we are understanding over here. In the RBI Act, what we call, for example, the electoral bonds. In the RBI Act, for example, if you go to the judgment here, take a look at this. Section 31 of the RBI Act stipulates that only RBI or central government authorized by the RBI Act shall draw, accept, make or issue any bill of exchange or promissory note for payment of money to the bearer of the note of bond. The Finance Act 2017 amended the RBI Act by including Section 31 subsection 3, which permits the central government to authorize any scheduled bank to issue electoral bonds. Okay, ये वाली बात थी सबसे पहले. तो यहाँ for example RBI Act में Section 31 subsection 3, okay, you see Section 31 subsection 3 was inserted. ठीक है, और अब देखिए इसमें बात थोड़ा समझिएगा. If you take a look at, very simply, if you take a look at, let's say for example, the concept of a what you can call an instrument. what is known as a negotiable instrument. अब आरबीआई आर्टिकल 31 में सेक्शन 31 में लिखा है कि अगर कोई भी किसी भी प्रकार का फाइनेंशियल इंस्ट्रूमेंट है तो आरबीआई इज द सोल अथॉरिटी फॉर इशूइंग अ फाइनेंशियल इंस्ट्रूमेंट, व्हाट इज नोन एज अ बेयरर्स नोट. ठीक है, तो मतलब कहने का अर्थ है जैसे फॉर एग्जांपल what are you taking examples, you say let's say for example if it is a currency is a kind of a bearer's note, then RBI is a sole authority, the Central Bank of India is a sole authority to issue a currency. Similarly, if you take a look at something like government securities, GSECs, then RBI is the sole authority to issue government securities. Okay, so when for example the idea is that to be able to produce an instrument, see very simply if you take a look at what is an electoral bond. ओके थोड़ा सा मैं समझाना शुरू करता हूँ इलेक्टोरल बॉन्ड में क्या बोला था, इसमें थोड़ा ध्यान दीजिएगा इस चीज को. इस स्कीम में ये बोला था कि जो स्टेट बैंक ऑफ इंडिया है, इफ यू हैव अ स्टेट बैंक ऑफ इंडिया, राइट, इफ यू हैव अ स्टेट बैंक ऑफ इंडिया, दैट स्टेट बैंक ऑफ इंडिया हैज समथिंग कॉल्ड इलेक्टोरल बॉन्ड्स. ठीक है, नाउ व्हाट आर इलेक्टोरल बॉन्ड्स? ओके, सो लेट्स से फॉर एग्जांपल इलेक्टोरल बॉन्ड्स को आप ऐसे इमेजिन करिए कि इट इज अ पीस ऑफ पेपर, स्टैम्प पेपर आपने कभी देखा होगा उसकी तरह इमेजिन करिए, ये इलेक्टोरल बॉन्ड है. ठीक है, इफ दिस इज फॉर एग्जांपल इलेक्टोरल बॉन्ड, अब मान के चलिए यहां लिखा है कि ये है 50 लाख रुपए का इलेक्टोरल बॉन्ड, राइट. तो आप देखिए कि यहाँ पे भारत का मतलब पूरा वो कारीगरी बना हुआ है, भारत की लाट, अशोक की लाट और वो सारी चीजें लगी हुई हैं. सी इफ आई कैन शो एन इमेज ऑफ ए इलेक्टोरल बॉन्ड, what does it look like? ठीक है, ये देखिए दिस इज बेसिकली व्हाट इज अ इलेक्टोरल बॉन्ड, राइट. नाउ what does it say? Electoral bond, this is a electoral bond in the form of a promissory note, and you can see date of issue is given over there, valid up to 15 days of the date of issue, value of the instrument is 1000 rupees. So this is what is known as a electoral bond. Okay, you get the point. How does it work? Basically, how does a scheme work is what I'm trying to explain to you. Let's say for example if you go to the State Bank of India, अगर आप State Bank of India के सामने जाते हैं और आप बोलते हैं कि मुझे 20 लाख रुपए का इलेक्टोरल बॉन्ड चाहिए, ठीक है, तो स्टेट बैंक ऑफ इंडिया के को आप 20 लाख रुपए पकड़ाइए, चेक दे दीजिए 20 लाख रुपए का, डिमांड ड्राफ्ट दे दीजिए 20 लाख रुपए का, इलेक्ट्रॉनिक ट्रांसफर कर दीजिए 20 लाख रुपए का, यू मेक अ ट्रांसफर टू द स्टेट बैंक ऑफ इंडिया 20 लाख वर्थ रुपीज, एंड 20 लाख वर्थ रुपीज के वो आपको इलेक्टोरल बॉन्ड दे देगी. सो लेट्स से फॉर एग्जांपल दिस इज नोन एज एन इलेक्टोरल बॉन्ड सर्टिफिकेट, राइट. यहाँ पर लेट्स से फॉर एग्जांपल इफ आई राइट द वैल्यू 20 लाख रुपीज, तो आपको एक डॉक्यूमेंट मिल गया जो बिल्कुल आपका पर्सनलाइज कस्टमाइज डॉक्यूमेंट होगा, उस पे एक रिसीट नंबर पड़ा होगा, उस पे सारी चीजें मतलब बेसिकली ऑल द व्हाट यू कैन से formalities would be done, a particular specific number would be given to it, right. So this is basically how you can get an electoral bond. So मान के चलिए कि आप I go to the Reserve Bank of India, I pay them 20 lakh rupees by a demand draft, by a check, by electronic means, and I purchase what is called a electoral bond. Clear? You see the point? Now what happens is, let's say for example if this is the electoral bond I have purchased, this is the electoral bond I have purchased, okay. Now if I go to a political party and I hand them this electoral bond, मैं उनको दे देता हूँ electoral bond ये वाला, ठीक है. जैसे for example let's say if I have got this electoral bond from the State Bank of India, I go and give this electoral bond to let's say आम आदमी पार्टी, तो आम आदमी पार्टी के पास इलेक्टोरल बॉन्ड आ जाएगा, ठीक है. अब क्या होगा, द पीपल, द अथॉरिटी ऑफ द आम आदमी पार्टी will go to the State Bank of India and furnish this electoral bond. वो स्टेट बैंक ऑफ इंडिया के सामने इलेक्टोरल बॉन्ड रखेंगे और इलेक्टोरल बॉन्ड को देख के स्टेट बैंक ऑफ इंडिया जो 20 लाख रुपए जमा हुआ था इस इलेक्टोरल बॉन्ड के नाम का, उसको पॉलिटिकल पार्टी को दे देगी. Do you get the process of it? Class, are you following what I'm saying over here? If I purchase an electoral bond from the State Bank of India, okay, then I can take this electoral bond in a physical copy. Physical copy में ही दिए जाएंगे, electronic copy में नहीं दिए जाएंगे. आप State Bank of India के पास जाएंगे, they will physically issue you electoral bond. You take that electoral bond, pay 20 lakh rupees to the State Bank of India, and then you give this electoral bond to a political party as a matter of, transaction. Sorry, as a matter of giving them to a political party as a matter of grant. Okay. Now, if that political party goes and takes an electoral bond to the State Bank of India, तो 20 लाख रुपए स्टेट बैंक ऑफ इंडिया उस पॉलिटिकल पार्टी के अकाउंट में डाल देगी और इलेक्टोरल बॉन्ड को रख लेगी. What is happening basically in this transaction? Tell me. What is happening is that the donor, let's say I want to give Aam Aadmi Party 20 lakh rupees. Right? What am I doing? Instead of putting money directly in the account of the Aam Aadmi Party, right? What I am doing is I am purchasing what is known as an electoral bond from the State Bank of India. State Bank of India के अकाउंट मैंने 20 लाख रुपए डाले, इलेक्टोरल बॉन्ड ले लिया. I give this electoral bond to the Aam Aadmi Party. Aam Aadmi Party goes to the State Bank of India, redeems or what you can call encash this electoral bond. तो 20 लाख रुपए स्टेट बैंक ऑफ इंडिया के अकाउंट में जो मैंने दिए थे उसके बदले में इलेक्टोरल बॉन्ड लिया था, उसको उठा के स्टेट बैंक ऑफ इंडिया नाउ पुट्स इट इन द अकाउंट ऑफ आम आदमी पार्टी. दिस इज हाउ बेसिकली द स्कीम वर्क्स in a simple kind of a sensible understanding of the scheme. This is how it actually operates. Okay, so for example, take a look at this. For a value received, the bank hereby promises to pay on demand to the eligible payee which is holding this instrument upon surrender of the original instrument in the designated account of the eligible political party with the bank, the sum representing the value of this instrument 1000 rupees in accordance with the scheme called the Electoral Bond Scheme 2018, notified by the central government, wide notification, etc. etc. You see, तो क्या कहने का अर्थ है इसमें कि जो भी वैल्यू इसमें दे रखी है 1000 rupees, it demand to the what you can call to the eligible payee which is holding this instrument upon surrender of the original instrument in the designated account of the political party with the bank. ठीक है, तो अगर मतलब मान के चलिए कि भारतीय जनता पार्टी हैज अकाउंट विद द स्टेट बैंक ऑफ इंडिया और विद द एक्सिस बैंक ऑफ इंडिया, एनीथिंग, अपॉन पेमेंट ऑफ द इलेक्टोरल बॉन्ड, upon presenting the original copy of the electoral bond, the State Bank of India will transfer that money to the account of the BJP. Do you see the point? This is how the entire instrumentality of the State Bank of Electoral Bond works. And as you can see, for example, this is what basically is an instrument of exchange, right? It is a form of what is known as a promissory note, and even currency is nothing but a promissory note. तो मतलब करेंसी एक बहुत सिंप्लीफाइड promissory note होता है. 10 रुपए का नोट या 50 रुपए का नोट एक तरह का बॉन्ड ही होता है, where the Reserve Bank of India writes that I promise to pay the bearer a sum of this amount. Clear? Right? So that's already given as a matter of what you can say practice. But in addition to that, what we are saying is that the problem which is raised specifically by the Reserve Bank of India is that जो सेक्शन 31 सबसेक्शन 3 में ये कहा गया है रिजर्व बैंक ऑफ इंडिया के, दैट एसबीआई और एनी शेड्यूल्ड बैंक फॉर दैट मैटर can also issue promissory notes in the form of electoral bonds. इस चीज पे रिजर्व बैंक ऑफ इंडिया ने ऑब्जेक्शन लगाया था 2017 में. 2017 में आई थिंक इट वाज अरिजित पटेल or Raghuram Rajan, I think one of those people who was the governor of the country, of the Reserve Bank of India. I think it was Rachit Patel. Rachit Patel had created an objection to this part in which he had said that the the authority within India which has the ability to issue any kind of a promissory note is always the Reserve Bank of India. अगर किसी भी प्रकार का promissory note issue करना है तो वो Reserve Bank of India ही कर सकता है. If you're going to give a central, if you're going to give a kind of a commercial bank or a scheduled bank the authority to issue promissory notes, that is going to be a problem in multiple levels. मतलब अलग अलग प्रकार की प्रॉब्लम्स शुरू हो जाएंगी. यहाँ से काउंटरफेटिंग की प्रॉब्लम शुरू हो जाएगी, ठीक है, ट्रेडिंग की प्रॉब्लम शुरू हो जाएगी. All of these problems are going to start. So the first objection that came to the Reserve Bank of India Act, which was amended under section 31 subsection 3, was made by the Reserve Bank of India itself in a letter written to the Government of India Finance Ministry, that the electoral bond schemes gives the power to a scheduled bank to issue promissory notes, and no such power has ever been exercised by anyone else but the Central Bank of India. Therefore, section 31 subsection 3 is subjected to some kind of a serious inconvenience. It is subjected to some kind of a serious, what you can say, controversy. ठीक है, तो ये सबसे पहली बात यहाँ पर करी गई थी. Section 31 subsection 3 of the Reserve Bank of India, which gave the power to the Government of India to make the State Bank of India be the releaser of what are known as promissory notes, known as electoral bonds. Okay, that was the first part. Okay, ठीक है. Second part, if you take a look at this, if you take a look at what is known as the Companies Act, जो major amendments किए गए थे वो Companies Act में किए गए थे, है ना. उसको थोड़ा सा हम लेके आते हैं आपके सामने. Companies Act 2013. Okay, now let me just put out the point of reference over here. Now this is a sub chapter in itself, and we are going to discuss with a few points in this regard. We are looking at the concept of what is known as corporate contributions. Okay, this is basically at the center of what the electoral bond schemes are. Right now, bit by bit, I hope that you're getting a sense of what the electoral bond scheme is and how we deal with this with regard to the idea of how this is moving up. Right, you know how electoral bonds work. I want to donate money to a political party. I buy bonds from State Bank of India, give money into the account of the State Bank of India. The political party, I go to the political party, hand them the bond. Okay, political party takes the bond to the State Bank of India, withdraws the money, which means I have indirectly made a donation to the political party. This we understand, right? Okay, now let's say the question that you're asking is, what does the person who's purchasing the bonds get? Of course, see, why do you donate to a political party is a question. Now you can do it for two things. Number one, that you like the political idea of the political party. The other could be a kind of a, let's say, if I donate 30 crore rupees worth of electoral bonds to a particular political party, which the political party utilizes to fight elections, campaigning, propaganda, everything, right? If that political party comes into power, then my 30 crore rupees are going to become a quid pro quo, right? Meaning they understand me as an important donor to the political party, and I understand that I have donated because I wanted something in return. So some kind of a license, some kind of a contract, some kind of an agreement, some kind of a law may be made to make me prosperous in my own business. You see, that is what basically is the speculation over here, that wealthy business corporations can fund political parties into power, and when these political parties are into power, they can use the power of the state to give benefits to the wealthy corporations. This is what is known as a quid pro quo, right? The idea that you scratch my back, I scratch your, that you have a very clear sense in which you may have a transactional relationship between the political parties and business corporations. Okay, so the whole idea is about understanding the nature of corporate funding. How do we get a sense of what is known as a corporate funding or corporate contributions? The bank is getting no benefit, no interest can be charged, nothing. It is a purely no benefit proposition for a bank. Bank doesn't get anything out of it. आप इस पे interest नहीं charge कर सकते electoral bonds पे. Why not transfer it through checks and other methods? Why need to issue an electoral bond? वही तो बात है. That's the point I'm coming to you. यही तो समझाना चाह रहा हूँ मैं भी. पूरा आप इसको बनने दीजिए एक बार, क्योंकि चेक में तो आपको पता चल जाएगा ना कि किसने पैसा दिया है. I'm just trying to tell you exactly brick by brick as to what is happening. When we take a look at the Companies Act 2013, it talks about what is known as corporate contributions, right? Now, when we understand the concept of corporate contributions, Companies Act का section 182 है जो कि बात करता है corporate contributions की. Section 182 of the Companies Act talks about corporate contributions, and section 182 says that a company can contribute to political parties. कोई दिक्कत नहीं. जैसे for example अगर मैं let's say I am let's say Tata Enterprises, right? I'm let's say Tata Sons, which is a board of Tata company. I want to give a 300 crore donation to the political party named Indian National Congress. ठीक है, मैं 300 करोड़ रुपए इंडियन नेशनल कांग्रेस को देना चाहता हूँ. Section 182 of the Companies Act governs that kind of a procedure. A company can contribute to a political party. A company can contribute to a political party, but there are certain features to it. ठीक है, पहला फीचर क्या है? Take a look at this. A sum of, let's say the total sum contributed. I'm just trying to write this down for you. Okay, ये सारा आपके prelims के लिए important है. The sum of contribution should not exceed, the sum of contribution should not exceed 75% of the total profit of the last 3 financial years. ये फॉर्मूला है, इसको लिख लीजिए अच्छे से. मतलब ये इलेक्टोरल बॉन्ड्स को लगाने से पहले का स्टेटस है. इलेक्टोरल बॉन्ड तो इसके ऊपर लगाया जाएगा. Section 182 of the Companies Act stated that a company can contribute to a political party. The sum of contribution should not be exceeding 7.5% of the total profit of the last 3 financial years of a company. So let's say for example, अगर मान के चलिए कि कोई कंपनी है, ठीक है, ध्यान दीजिएगा इस बात पे. अगर मान के चलिए you have let's say Jindal Power. Now let's say for example, if Jindal Power wants to give a donation to let's say Aam Aadmi Party, ठीक है, if Jindal Power wants to give a donation to Aam Aadmi Party, then the possibility of it giving a donation is there, कि donation दिया जा सकता है. Jindal Power can give a donation to the Aam Aadmi Party, surely there's no blockage on that. Even today there's no blockage on that. Even after the judgment of the Supreme Court, this position still works. लेकिन इस जो आप पैसा देंगे उस पे एक कैप लगा हुआ है, एक सीलिंग लगी हुई है. Let's say for example, if Jindal Power has made 500 crore rupees of profit in last 3 financial years, अगर जिंदल पावर ने 500 करोड़ प्रॉफिट अगर कमाया है पिछले 3 फाइनेंशियल ईयर्स में, तो वो इसके 7.5% से ऊपर नहीं दे सकता, राइट? मैक्सिमम डोनेशन दैट कैन बी गिवन as donations to political parties is supposed to be 7.5% of the 500 CR. ये पहला इसमें जो था वो लगाया था. You get the point? Clear? Am I clear about it? And then the second thing that was given as a feature was that the donation can only be given after an approval has been made from the board of directors. तो जो कंपनी होती है उसका जो बोर्ड होता है, donation can only be made when an approval has been made from the board of directors. जो कंपनी है, जो उसका बोर्ड होता है, बोर्ड के अप्रूवल के बाद ही डोनेशन दी जा सकती है. ठीक है? Do you understand this? And of course, the last part is that donation can be made directly to the political party in the form of a check, demand draft, और इलेक्ट्रॉनिक ट्रांसफर. कैश में देना मना था. Okay? And D, the company shall maintain all the information about the donation with particulars, comma, which can be inspected. Please take a look at this part. Companies Act 2013. These are the points that were given in section 182. This is unamended. Okay, please pay attention to this part. This is unamended. ये सारी चीजें अभी unamended हैं. इनमें amendments किए जाएंगे, but as they stand, they are before the electoral bond scheme, before the electoral bond schemes. And of course, after the electoral bond scheme has been struck down, these provisions are currently operational. मतलब 15 फरवरी के बाद अगर किसी कंपनी को डोनेशन करना है तो वो इन माध्यम से कर सकती है. ये 4 पॉइंट्स है सेक्शन 182 में लिखे हैं, which are basically covered under the heading of the corporate contribution. Class, I hope you are taking a very specific attention to these parts, because these parts you will find directly in your prelims questions. ठीक है? तो मुझे आशा है कि आप इसको देख पा रहे ढंग से. सेक्शन 182 of the Companies Act. Please take a look at these 4 points clearly. And these 4 points, by the way, after the striking down of the electoral bond scheme, are still applicable today. तो इनसे मतलब अगर किसी कंपनी को इलेक्टोरल बॉन्ड से ये नहीं हो गया है कि कंपनी की डोनेशन पॉलिटिकल पार्टीज में बंद हो जाएगी, it is just going to become more transparent, and this particular aspect will follow under section 182 of the Companies Act. यहाँ पे जो D है उसमें सब कुछ देना पड़ेगा आपको, पर्टिकुलर्स में सब कुछ देना पड़ेगा. You have to give the name of the donor, मतलब कंपनी जिसने डोनेशन दिया है वो तो देना ही पड़ेगा. उसके बाद आपने किसको, कौन सी पॉलिटिकल पार्टी को डोनेशन दिया है, नेम ऑफ द डोनी, द पॉलिटिकल पार्टी. ओके, अमाउंट डोनेटेड, इन सब चीजों का आपको एक ब्यौरा बना के रखना पड़ेगा. और कभी भी सरकार की कोई अथॉरिटी इस ब्यौरे की जांच कर सकती है, कभी भी कोर्ट इस ब्यौरे को मंगा सकता है. Do we get the point, class, over here? Section 182 of the Companies Act, it provided these 4 provisions for corporate fundings of political parties. Okay, but this is what basically is before the electoral bond scheme, right? And because the electoral bond scheme has been struck down, this is how you can today as a corporation give contributions to political parties. Clear? Right? Ab, let's say for example, imagine that within this, let's say framework, I introduce the electoral bond scheme. मैंने amendment क्या क्या किए, ध्यान से देखिएगा इस चीज को प्लीज. ये वाला आपका फ्रेमवर्क है, इसमें मैंने इलेक्टोरल बॉन्ड्स के माध्यम से क्या क्या अमेंडमेंट्स किए हैं, राइट? द फाइनेंस एक्ट ऑफ 2013 2017, it takes the provision of section 218 into itself and amends it. और what are the amendments which have been made? पहला अमेंडमेंट क्या किया फाइनेंस एक्ट ने? पहला अमेंडमेंट था कि इसको हटा दिया, इसको ओमिट कर दिया. You see the point? The first amendment made by the Finance Act is that it omitted, which basically resulted to what? It resulted to the fact that a cap this now means that there is no cap on corporate contribution. एक कॉरपोरेशन कितना कंट्रीब्यूट कर सकती है उसके ऊपर कोई सीमा नहीं है. पहले तो सीमा लगा रखी थी ना, राइट? 7.5% ऑफ द टोटल प्रॉफिट ऑफ द लास्ट 3 फाइनेंशियल ईयर्स, इससे ऊपर आप डोनेशन नहीं कर सकते. लेकिन इस पार्ट को हटा दिया, और इस पार्ट को हटाने के बाद पोजीशन ये हो गई कि देयर इज नो कैप ऑन कॉर्पोरेट कॉन्ट्रीब्यूशंस. दिस इज सेक्शन 182 ऑफ द कंपनीज एक्ट which was amended by the finance act. क्लास आर वी फॉलोइंग? समझ में आ रहा है? ये इलेक्टोरल बॉन्ड स्कीम को लगाने के बाद हुआ है. After the Finance Act of 2017 had amended section 182 of the Companies Act, it omitted the first part. Okay, then the second part was kept as it is. Board of Directors का तो आपको वो चाहिए अप्रूवल, लेकिन थर्ड पार्ट में यहां लिख दिया कि there is another instrument by which funding can happen, and these instruments are known as electoral bonds. ठीक है, ये बोल दिया कि there is another instrument by which funding can happen, and these instruments are known as electoral bonds. Are we clear? तो पहला अमेंडमेंट किया पॉइंट नंबर ए में, दूसरा अमेंडमेंट किया पॉइंट नंबर बी में, सी में, और उसके बाद तीसरा अमेंडमेंट किया पॉइंट नंबर डी में. Point number D में what they wrote in point number D was that, let's say for example, I'm writing it down here. In case of electoral bonds, only total money donated has to be noted, but particulars of donation like 1, 2 and 3 need not be noted. देखिए इस चीज को, ये आपकी इलेक्टोरल बॉन्ड स्कीम लगना शुरू हुई है, सेक्शन 182 ऑफ द कंपनीज एक्ट. जस्ट टेक अ लुक एट दिस. So what is mentioned in green is the original section 182 of the Companies Act. What is mentioned in orange is the amendments made to section 182 of the Companies Act by the Finance Act 2017. क्लास am I making sense? समझ में आ रहा है यहाँ पर क्या हुआ? तो पहला तो इन्होंने क्या किया कि कैप हटा दी कि there is no cap upon corporate contributions. Second, they added the name of electoral bonds as an instrument by which corporate donations can be made. And third, they said, in the case of electoral bonds, only total money donated has to be noted, but particulars of donation, which includes the name of the donor, the company का नाम तो खैर आ ही जाएगा, name of the donee, मतलब कौन सी पॉलिटिकल पार्टी को आपने पैसा दिया है और आपने कौन सी पॉलिटिकल पार्टी को कितना पैसा दिया है वो नोट नहीं करना पड़ेगा. Let's say, for example, imagine, for instance, that if let's say a company run by Ambanis makes a, let's say, 500 CR donation to one political party X, ठीक है, according to electoral bonds. तो इसमें क्या होगा कि अंबानी को अपने रिकॉर्ड में इलेक्टोरल बॉन्ड्स के नाम के नीचे सिर्फ ये लिखना होगा कि टोटल पॉलिटिकल कॉन्ट्रीब्यूशंस और टोटल पॉलिटिकल फंडिंग दैट वी हैव डन इज 500 CR. हमने जो कुल पॉलिटिकल फंडिंग करी है वो 500 करोड़ है बस. लेकिन उसके बाद किसका नाम लिखना है, कौन सी पॉलिटिकल पार्टी को करी है और कैसे किस तरह से करिए, क्या क्या करिए, ये सारी चीजें देने की जरूरत नहीं है. द पर्टिकुलर्स ऑफ टू विच पॉलिटिकल पार्टीज आर टू बी गिवन ऑल ऑफ दीज थिंग्स, दैट इज नॉट रिक्वायर्ड एट ऑल. You see, so what happens basically with the application of this kind of a thing, that if I am a corporation, now think about the logic very simply. If I am a corporation, let's imagine I want to get some kind of a license or an agreement. Let's say, for example, I want to enter into the mining sector and I want the government to give me mining licenses upon certain areas. ठीक है, सरकार के पास लाइसेंस देने का पावर होता है, तो मैं चाहता हूं कि सरकार मुझे लाइसेंस दे दे कुछ काम करने के लिए. ठीक, अब मैं क्या करता हूं, आई गो टू द, लेट्स से आई गो टू टॉक टू अ पॉलिटिकल पार्टी से मैं कहता हूं कि देखो मैं 500 करोड़ रुपए दूंगा आपको, अगर आप पावर में आ जाओगे तो आप मेरे बिजनेस में मदद करोगे लाइसेंस दिला. तो यहाँ पर एक संगठन होगा, अ काइंड ऑफ अ ट्रांजैक्शनल क्विड प्रो क्वो सेटल. नाउ व्हाट डू आई डू, I take the electoral, I go to the State Bank of India, buy electoral bonds worth 500 crore rupees, okay, and then I give those electoral bonds to the political party. Political party in electoral bonds को कैश करा लेगी और पैसे ले लेगी. ठीक है, अब now first of all the amount of money that I have contributed can be endless. There is no limit to what I can contribute, number one. Number two, the record keeping that I have to do as a company will only mention total of 500 CR given to political parties. Which political party has got what amount of money, or the name of the political party which has got an all amount of money, is not needed to be kept if it is transferred by electoral bonds. Do we understand the point, class? This is what was made as a amendment to section 182 of A of the Companies Act. ठीक है, तो देखिए जरा, हमने दो तरह से आपको बताया. पहला अमेंडमेंट किया गया रिजर्व बैंक ऑफ इंडिया एक्ट में. रिजर्व बैंक ऑफ इंडिया एक्ट में ये कहा गया कि अपार्ट फ्रॉम रिजर्व बैंक ऑफ इंडिया द पावर टू इशू प्रोमिसरी इंस्ट्रूमेंट्स कैन ऑल्सो बी गिवन टू अ शेड्यूल्ड बैंक. तो पहली प्रॉब्लम यहां निकल के आई कि अगर आप किसी एक शेड्यूल्ड बैंक को एक प्रोमिसरी इंस्ट्रूमेंट इशू करने की पावर देंगे तो उससे बहुत सारी चीजें परेशानी वाली हो सकती है. इफ यू आर गोइंग टू गिव अ शेड्यूल्ड बैंक द पावर टू इशू नोट्स, इंस्ट्रूमेंट्स लाइक दीज, then it is going to be a problem with regard to shell companies, black money, all of these things. Okay. Second, the Companies Act 182 was amended to introduce electoral bond as a means by which you can give money to a corporation, and the fact that there is no limit to give money to a corporation, and the fact that while you are giving a money to a corporation you don't need to mention the when you are giving money to a political party as a corporation, you don't need to mention the amount which is given to what political party. You can say an overall amount has been given. तो जैसे 500 करोड़ में से मैंने 450 करोड़ एक पॉलिटिकल पार्टी को दिए, 30 करोड़ दूसरी पॉलिटिकल पार्टी को दिए, 20 करोड़ तीसरी पॉलिटिकल पार्टी को दिए. If I have given 450 CR to one political party, 30 to another, 20 to another, then I am going to write overall I have made 500 crores of political contributions. 500 करोड़ का पॉलिटिकल कंट्रीब्यूशन का है, लेकिन इसका जो पर्टिकुलर है, इसका जो डिटेलिंग है, वो मुझे अपने अकाउंट्स में नोट नहीं करना है. मतलब कल को अगर कोई इंस्पेक्ट करता है मेरे अकाउंट्स को, तो उसमें किसी भी पॉलिटिकल पार्टी का नाम नहीं मिलेगा. इफ समवन इज इंस्पेक्टिंग माय अकाउंट्स ऑन दीज एरियाज, no one will find the name of the political party given within these accounts. Class, are we clear? Section 182 of the Companies Act and Section 31 subsection 3 of the RBI Act. दो एक्ट हमने समझ लिया आपके कि क्या हो रहा है यहाँ पर, right? Just to be sure about the background of how this is happening, class. The government of India took RBI Act, RPA Act, Companies Act and IT Act. इसके अलग अलग provisions को लिया and it listed them in the Finance Bill of 2017. So, for example, the provision from the RBI Act was the section 31 subsection 3 was added to the RBI Act to make scheduled bank also available for some kind of a, what you can say, the scheduled banks can also give some kind of a activity out, meaning they can also issue promissory notes. The Companies Act section 182 was amended to say that corporate contributions will have no cap, and in regard to electoral bonds corporate contributions, the details of the political parties need not be recorded by the what you can call by the company, right? That's the second thing. ठीक समझ रहे ना? And then finance bill was passed as a money bill from the Lok Sabha, and then it became the Finance Act, which gave a legislative backing to the electoral bonds as a scheme. As I have mentioned, the finance bill और money bill वाला जो part है वो सुप्रीम कोर्ट में 7 जजेस के पास चला गया, तो वो मैंने आपको मेंशन अलग से करके बता दिया है. ठीक है. What we are taking a look at over here is somewhat different. Class, are we here or not? Do we understand? समझ में आ रही हैं चीजें? Questions आएंगे इन सब चीजों के साथ आपके. नहीं, ऐसा नहीं. फाइनेंस एक्ट 2017 में इनकम टैक्स के रेट्स भी हैं. देखो, फाइनेंस एक्ट में होता तो यही है ना कि इनकम टैक्स के रेट है, लेकिन आपने एक पन्ना और जोड़ दिया कि सबके साथ साथ इसको भी पास करा देते हैं. 2017 Finance Act has rates of income tax, of GST, of IGST, of CGST, but within those sections you have also camouflaged, disguised the sections of RBI, RPA and all of these things. तो आपने जहाँ बजट पास कराया, बजट के साथ साथ आपने ये वाली चीज भी पास करा दी, राइट? तो यू हैव पासिंग अ बजट आपको पास करना, यू हैव टू गिव अ एस्टिमेट ऑफ रिसीट्स एज टू हाउ मच इज द टैक्स दैट यू आर कलेक्टिंग. सो अलोंग विद द बजट यू आर आल्सो पासिंग दिस पर्टिकुलर, मतलब पीछे एक पूछ लगा दी कि बजट के साथ साथ ये भी निकल जाएगा, द अमेंडमेंट्स व्हिच आर मेड टू इट. यू गेट द पॉइंट? क्लास, are we here? Do you get the point? Yes or no? Should I continue? Should I repeat something? Tell me something. I'm sorry, I feel that some of you are having a problem with the Hindi part. Also, by the way, when I'm talking anything about Hindi, I am immediately translating it into English. So, not that I'm saying something exclusively in Hindi. Just got a message from the administration about it. So, I hope that it's fine as a matter of point that everything I'm speaking in Hindi, I'm immediately translating it into English. So you're not really missing out on anything. Just don't get settled out by saying that I'm using Hindi doesn't mean I'm not translating it into English, but it's sometimes just better in terms of establishing connectivity. Okay. All right. So this is one part over here. Now take a look at another part. When we take a, let's say, look at the next part, which is, let's say, the Income Tax Act. ठीक है, ये वाला आपका एक अपना सब चैप्टर है. All of these are going to be sub chapters in and of themselves, right? Income Tax Act. What are the amendments which were made to the Income Tax Act? Right. Now take a position upon this very simply. If I can just open up the Income Tax Act before you. Take a look at this. The question that we're asking over here is this. Please take a look at this. Political parties receive donations / contributions. Okay, we're talking about section 13A of the Income Tax Act. Political parties receive donations / contributions. Question is, are these donations / contributions to be A, recorded by political parties, in detail? This is the first question. Second question, subject to income tax. Now this is another question which is coming out separately, because apparently the CBI has raised a 65 CR claim upon the Congress party, which is an unpaid income tax by the Congress party. So a very important question, and I think one of you asked the question also specifically previously. Okay, if you think about it, for example, if it is important with regard to the question, the question that we're asking basically under this one is this, that let's say if you have a political party, let's say for example if this is Aam Aadmi Party, let's assume. The question that we're asking is that if a donation is coming to the Aam Aadmi Party, ठीक है, let's say मान के चलिए कि इनके पास 100 करोड़ रुपए यहाँ पर आ गए. If a donation is coming to the Aam Aadmi Party, then the question is, first of all, is the Aam Aadmi Party supposed to keep a record of these donations? मतलब प्रॉपर डिटेल में कि किसने कितना पैसा दिया और किस माध्यम से दिया. That record has to be kept. And second is that, is this donation taxable as income? Does income tax apply upon these donations? These are basically two questions for which we are going to take a reference to the Income Tax Act. ठीक, right? और इसके साथ एक लगा हुआ question. Let's say for example if I answer these questions very specifically, reading section 13A of the Income Tax Act. Section 13A of the Income Tax Act says, yes, a detail of particulars is to be maintained by a political party. A detail of particulars is to be maintained by a political party about its income through contributions. तो मतलब उसको पूरा नाम देना होता है, किसने पैसा दिया, कितना पैसा दिया, what are the what are the numbers which are given, who has given the number, etc., etc. All of these have to be maintained by a political party. What is the answer to this question? Is this income which is being received by a political party, is it subject to an income tax? The answer is no. It is not subject to income tax, but upon a few conditions. Okay, matlab the simple answer is, generally speaking, in very simple terms speaking, such contributions are not subject to income tax. मतलब आप इन पे income tax नहीं लगा सकते. But the following conditions apply. What are the following conditions? Point number A, documentation पूरी रखनी चाहिए. That the money which is getting received must be properly documented. And B, cash should not be used. So most of this, contribution must be in the form of electronic transfer, demand drafts, checks, etc. And point number C, documentation must be presented for inspection whenever required. तो अब कहने का अर्थ ये है, for example, the point is very simple, and this is another separate case going all together, right? Take a look at this part very simply, and this is what all of this you'll find again important from the current updates perspective. The question is that, can political parties receive donations and contributions? Of course they can receive donations and contributions. The question is, are these donations and contributions a part of their income tax? Are they subject to income tax? Now the question is, they have to record the donations have to be recorded by the political parties. A detail of particulars is to be maintained by political party, but this income is not subject to what you can call income tax. The tax on income is not going to be subjected upon this kind of a money. So it is mostly tax-free money for the political party, which is come in here, which is section 13A of the Income Tax Act. Okay, section 13A of the Income Tax Act. But to claim the status of tax-free nature of this income, the documentation must be properly kept. Cash should not be used in taking donations, and documentation must be presented for inspection whenever required. So whenever, for example, a person is asking for documentation, let's say if the CBI or a ED or something like that wants to take a look at the money that the political party has received, they must have a proper documentation which is supposed to be there to be able to provide them that kind of an activity, that this is the money that we have received. If the documentation is proper, income tax exemption shall continue. Okay. And apart from this, in fact, in 2003, another amendment was made to this part, which is even better in terms of giving political parties the ability to enjoy their, contributions. The amendment which was made was this, that, let's say, for example, I write it as point number C, that donors shall enjoy tax deduction benefits if they contribute to political parties. So if you are contributing to political parties, then rather than saying that the political parties' income is subjected to income tax, what is said is the reverse, that donors who are contributing to political parties shall enjoy tax deductions, 80G deduction, but the rebates contribute to political parties. Right. So this is basically the whole sense of what we are trying to understand with regard to the political parties and their taxation criteria around it. Do we understand this? Income Tax Act section 31A lays down point A, B, and then a different part of the Income Tax Act which is 80GC lays down the point C. But over here you have a very simple overview as to how the taxation regime applies upon contributions made to political party. Point number A, record has to be kept by all political parties. Point number B, it is not subject to income tax. The income is not subject to tax. Generally speaking, such contributions are not subject to income tax. But the following conditions apply. Documentation must be proper, cash should be avoided, and documentation must be presented for inspection whenever required by any government agency, even the courts. And C, donors shall enjoy tax reduction benefits if they contribute to political parties. So this is basically a very simple understanding of what is given under section 13A of the Income Tax Act. If you want, you can take a look at it very specifically. Okay, I don't think we can go to the technicality of reading this. Let me show you something else. Let's take a look at one of the issues which are developing independently. This is something which is happening simultaneously. You see, this is a 2024 is packed with these kind of news. Take a look at this. Congress alleges IT department withdrew rupees 65 crore from its bank accounts. Right? Congress alleges that income tax department withdrew rupees 65 crore from its bank accounts. Okay, making the claim, party treasurer McCain said that democracy will be forever over if the action of probe agencies goes unchecked. Take a look at this. What this basically says, that the Congress on Wednesday alleged that the income tax department withdrawn rupees 65 crore from its accounts in different banks undemocratically when the case pertaining to their IT returns for previous years is sub judice. Right now, this is a case which is basically asking, or the question that is coming very frequently over here is that the income tax department is making claims to Congress for unpaid income tax upon its political incomes. Income tax rates continue at premises linked to Congress. So this is MP. Okay, sorry, this is a single party one. Take a look at this. Income tax department action against the Congress. This is a question which is basically we're talking about taxation of political parties. In a politically loaded move, the income tax department has raised a demand of 210 crore in penalty and has dues from the Congress, which the party says has effectively stalled the operation of all its bank accounts. On the face of it, the action seems disproportionate to the charges, and an appellate tribunal has subsequently allowed the political party to operate the accounts on the condition that an amount of 115 crore is kept in lien until the case is heard next week. The party says it does not have such amounts in its current accounts. Just weeks before general election, the principal opposition party of the country finds itself restrained by a central agency it is worrying that this falls into the pattern of enforcement agencies targeting those fighting the ruling political party. The income tax department action against the Congress returns tax filed by the party for FY 18, 19, etc., etc. Right. So this is what happened in 2019. This is again happening in 2024, just before elections. That there are income tax rates upon the political party with regard to saying that their income tax is due, that the income which is coming to the political party is due. Now the question is again raised from a constitutional perspective, that are political parties subjected to income tax? The answer is no, they are not subjected to income tax. We have read very clearly, seen the section 13A. Section 13A says that the political parties, when they are receiving contributions and donations, they will not amount to incomes. But the charge which has been made against the Congress party by the ED, by the income tax department, is that they have used a lot of cash in, a lot of what you can call their income is coming in the form of cash, and they are not keeping proper documentation, and they are not letting the authorities inspect. So based upon this, they have created a kind of a bureau which says that the conditions which are given for a kind of a income tax penalty or income tax exemption to be enjoyed by Congress, they have not been fulfilled because they have used a lot of cash in their donations, right? And this matter is currently in front of a tribunal, as we discussed the concept of tribunal yesterday, Income Tax Appellate Tribunal, the ITAT. It is that which is now currently looking at this matter, and there is what basically the Congress is making an appeal, because the bank accounts have been frozen by the income tax department, stating that your income tax is unpaid. And when Congress says that income tax is not payable for political parties, the income tax department has replied, but you have violated the condition that you have taken a lot of cash and your proper paperwork is not in order, therefore we are going to charge income tax upon you, and unless you pay the income tax, we are not going to unfreeze your accounts, thereby blocking the money that the Congress party has in its accounts. Okay, so this is happening separately. So because it is in the news, I'm just trying to highlight the constitutional provisionalities of this in that background, right? Okay. Now if you take a look at this part, what is the changes which have been brought? The Finance Act 2017 has brought what all changes? Okay, let's take a look at this. What all changes has the Finance Act 2017 brought to these provisions? The Finance Act 2017 has added the concept of electoral bonds, right? So it says that the party can receive contribution in the form of electoral bonds, but in addition to demand draft, in addition to electronic payments and checks, it can receive in the form of electoral bonds. This is one thing which has been added. And the next thing which has been added is that when a party is receiving donation in the form of electoral bonds, then this kind of a documentation is not necessary. Again, documentation of particulars to be maintained is not necessary. मतलब अगर इलेक्टोरल बॉन्ड से किसी पॉलिटिकल पार्टी को पैसा मिल रहा है तो उस पॉलिटिकल पार्टी के डॉक्यूमेंटेशन में इलेक्टोरल बॉन्ड्स का जो पैसा आया है उसको मेंशन करने की जरूरत नहीं है. जैसे हमने यहाँ पे देखा ना, डॉक्यूमेंटेशन हैज टू बी क्रिएटेड इफ यू आर रिसीविंग डोनेशंस. व्हाट द फाइनेंस एक्ट 2017 says that when money is coming from electoral bonds, then it is not necessary for that political party to create a documentation of that, what you can say, contribution if it is coming from electoral bond. So if you, for example, apply the activity of electoral bond, let's say money is going from a corporation to a political party through an electoral bond, right? Money is going from a corporation to a political party through an electoral bond. in the documentation of the corporation, if money is going from a corporation to a political party through an electoral bond, in the documentation of the corporation, there is no mention of the money which has been given through electoral bond. Are we clear? There is no mention of money which has been given through electoral bond in the documentation of the corporation. And also, while the money is being received by the political party through electoral bonds, that also does not need to be documented if it is coming from an electoral bond. तो ना तो पॉलिटिकल पार्टी के पास उसका डॉक्यूमेंटेशन रहेगा, ना ही तो कंपनी के पास उसका डॉक्यूमेंटेशन रहेगा, which means that the money which is going from one corporation to another political party will not be disclosed either in the account of the corporation or in the account of the political party. So for example, if Jindal Power gives a donation to Aam Aadmi Party, Jindal Power की बुक्स में आम आदमी पार्टी का नाम मेंशन नहीं होगा और आम आदमी पार्टी की बुक्स में जिंदल पावर का नाम मेंशन नहीं होगा. And even without mentioning the electoral bonds documentation, the income coming from electoral bonds shall be exempt from taxes. Okay, even if it is electoral bonds income which is not supposed to create a proper documentation, then also it shall be exempt from taxes. This is what is given in the amendment made to the Income Tax Act 13A. Right, so class, I'm just trying to put it all to perspective in terms of understanding this entire structure. We've taken a look at the amendments made to the RBI Act 1934. We've taken a look at the amendment made to the Companies Act 2013. Taken a look at the amendment made to the Income Tax Act 1961. And then we take a look at the amendment made to the Representation of People's Act 1951. Okay, so just take a look at this part again. Here, the Finance Act 2017 made the following amendments to Section 13A of the IT Act. I hope you're following it. The political party was not required to maintain a record of contributions if the contribution was received by electoral bonds, and the political party must receive a donation in excess of 2,000 rupees only by a check, bank draft, electronic clearing system, or through an electoral bond. Okay, so basically the implication of this is what? That if a money is coming to a political party through a check, through a demand draft, through any particular other activity, then that money has to be noted, it has to be denoted, it has to be documented. But if it is coming through an electoral bond, it does not need to be form a part of the documentation of the political party. तो दोनों तरफ से गायब पैसा, कॉर्पोरेशन जिसने पैसा भेजा वहां से भी गायब, नहीं पता किसको गया है, और पॉलिटिकल पार्टी के पास जिसके पास पैसा आया वहां से भी गायब, उसको भी नहीं पता है. You see the point, right? So let me just put this entire thing in one particular perspective and order it out for you. If you take a look at, let's say, how does it work? If this is a corporation and if this is a political party, if this is a corporation and if this is a political party, and let's say if the corporation wants to give some money to the political party, what does it have to do now? It has to go to the State Bank of India and purchase electoral bond, let's say for 20 CR. 20 करोड़ के electoral bond खरीद लिए इसने, ठीक है? This they have purchased electoral bonds of 20 CR, and they have, let's say for example, transferred the electoral bonds to the political party. Right? You see the point? Political party can now go to the State Bank of India and get the money from the State Bank of India, which can now come with the political party. Are we clear about this mechanism? A corporation can go to the State Bank of India and say we want electoral bonds of 20 CR rupees, and by which the 20 CR rupees can be given to the State Bank of India. This electoral bond as an instrument can be transferred from the corporation to the political party, and political party taking this electoral bond and giving it back to the State Bank of India can take the money of 20 CR from the State Bank of India. This is how it works, right? And now what it means is that the books of this corporation shall not have details of the political party, and books of the political party shall not have details of the contributor. Does it make sense to us, class, now? So the money has gone from the corporation to the political party, but the details are neither mentioned in the books of the corporation, details are neither mentioned in the books of the political party. So there is where the issue of what is known as transparency arises. And of course, as you can see, the issue that right to information has been considered a fundamental right under Article 19(1)(a), and from that particular perspective, the question of right to information is now arising for this particular activity. Class, am I making sense over here? Now imagine even worse. For example, let's say electoral bonds can be brought physically, and let's say, for example, let's just try to discover what is the whole concept of a shell company over here. So a shell company, for example, let's say if this is, let's say, Tata, which wants to fund a political party, okay, but they don't want to be seen to be funding a political party. They don't want their name associated with a political party, right? Let's say what happens, for example, a shell company is created, right? And let's say the money goes from this shell, from Tata to the shell company. Let's say 30 CR goes from Tata to a shell company, and now this shell company, let's say it is a XYZ Finance Limited, who no one knows who are the shareholders, who are the promoter, who are the board of directors, all fuzzy people. It's a shell company, goes to the State Bank of India and purchases electoral bonds of 30 CR, and then gives these electoral bonds to the political party, and these political parties can go to the State Bank of India and get the money of 30 CR, and the total details of contributions will be listed in the books of the shell company. ठीक है? और मतलब अगर ये तो है ना कि आपको ओवरऑल डिटेल तो देना है कंपनी की तरह कि कितना पैसा आपने दिया डोनेशन में, भले या पर्टिकुलर मत दो. You have to give an overall detail despite the fact that you are not giving particulars. The fact that the name of the Tata can be completely cut out from any kind of a political donation if it is making, because even on the books of Tata, if you go and inspect, 0 rupee in political contribution, no political contributions at all. That's a status stand that Tata takes. But the donations are made via a shell company which has been created specially for channelizing the money from this particular part to another particular part. तो ये लोग यहाँ पैसा डालेंगे, ये लोग इलेक्टोरल बॉन्ड लेंगे और ये इलेक्टोरल बॉन्ड लेके यहाँ पर इधर भेजेंगे. तो यहाँ पर भी, फॉर एग्जांपल, इवन विद इन द स्टेट बैंक ऑफ इंडिया, there is a provision of a KYC. People who are going to buy the electoral bonds, they have to file a KYC form, know your customer. But the fact that you can create a shell company which can manipulate the KYC form, know your customer form, then that is also going to lead to a complete oblivion as to who is funding a political party from which end. Do you get the point? Does the entire scenario become clear to you? And therefore, as you can see this entire case emerging, you see the possibility of why is it that it would be inferred or deduced that a corporation which is funding a political party, and neither the political party is giving the information to the people, money is coming from which corporation, nor the corporation is giving information to the people, money is being sent to which political party. This is a total blackout of what is known as the right to information. Now, it was a Supreme Court in the ADR, the case was ADR versus Union of India 2002, in which the Supreme Court had held that right to information, especially the information about political parties and political candidates and their antecedents and their political, what you can say, their provisions of their resources, contributions, donations, they are a right to be composed under Article 19(1)(a). Right to information is derived in right to freedom of speech and expression, and thus this kind of a blackout, according to the Supreme Court of India, becomes a violation of Article 19(1)(a) of the Constitution. You see the point? This is how basically the unconstitutionality has now been derived at. I hope that in the fact of explaining this only, you can look at the unconstitutionality of this particular part. Right? But again, the UPSC is not going to be so sentimental to ask questions only on freedom and liberty and all of that. UPSC will ask questions on the technical details of the background, because it is easy to have an opinion about freedoms and liberties, but it is difficult to understand the technical details of the background. अब आपको सिर्फ एक sentimental level पे समझ में आ गया क्या हो रहा है, that is not sufficient. You have to take a look at each of these parts from which questions are going to be asked. Okay. Okay. Now let's take a look at the last part, which is the Representation of People's Act. Okay, maybe I can show you the RPA properly. Okay, so if you take a look at this part, Representation of People's Act, section 29C. Since RPA is directly mentioned in your syllabus, just take a look at this, section 29C. Section 29C, Representation of People's Act. Just 1 second. This is the section 29C of the Representation of People's Act, and the way that you see over here, this part was amended by the Finance Act 2017. This part was amended by the Finance Act 2017. Please take a look at this clearly. ठीक है, पूरा पढ़िए ऊपर से. The treasurer of a political party or any other person authorized by the political party in this behalf shall in each financial year prepare a report in respect of the following: A. The contribution in excess of 20,000 rupees received by such political party from any person in that financial year. B. The contribution in excess of 20,000 rupees received by such political party from companies other than government companies in that financial year. ठीक है? Provided that nothing contained in this subsection shall apply to the contributions received by way of electoral bonds. Do you see the point? So, whatever is given under 29 subsection C shall not apply to electoral bonds. What is given in 29C subsection 1, that political party has to prepare a report about contributions more than 20,000 rupees by such political party and contribution more than 20,000 rupees which have been received by corporations, received from corporations. Both these reports have to be prepared necessarily by political parties. But what the 2017 Amendment Act adds in this particular case is that none of these provisions or none of these reports have to be created by a political party in making a kind of an activity over here in the case of an electoral bond, right? And by the way, these reports which are created by the political party have to be submitted to the Election Commission of India. Okay, so these reports which are created by the political party under section 29C A and B, they have to be submitted to the Election Commission of India, which means that under the operation of the Finance Act amendment made to section 29C of the RPA, no report with regard to the contributions which are received by a political party in the form of an electoral bond need to be prepared or be given to the Election Commission of India. Do we understand this, class? Okay, so now once we have this entire structure clear, we can go back to this entire part again, right? The Finance Act 2017 which was passed as a money bill, that is a different question altogether as to how it is going to be dealt as a money bill, etc. Made amendments to section 31 subsection 3 of the RBI Act, made amendment to 29C of the RBI Act, made amendments to section 182 of the Companies Act, and made amendment to section 13A of the Income Tax Act, by which you had the concept of the electoral bond scheme, right? Amendment to section 31 subsection 3, amendment to section 29C, amendment to section 182, and amendment to section 180, right? All of this was what constituted the electoral bond scheme. The Supreme Court, using its powers under Article 13 clause 2, 13 clause 2, what does it say, class? Let's take a quick revision of 13 clause 2, judicial review. Supreme Court, taking a control of its powers under Article 13 clause 2, states, what does 13 clause 2 say? 13 clause 2 says that if any law made by the Parliament after the commencement of this Constitution takes away or abridges any fundamental right, that law to that extent must be declared as void. That is what Article 13 clause 2 of the Constitution of India says with regard to the powers of the Supreme Court. Am I clear about this, class? Take a look at Article 13 and take a look at clause 2. The state shall not make any law, right? Now, of course, the Finance Act 2017 is a law. It says that the state shall not make any law, but the Finance Act 2017 is a law. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. The rights conferred by this part is part 3 of the Constitution. The rights conferred by part 3 of the Constitution, which is in question over here, is Article 19(1)(a), which is right to information, which is derived out of right to freedom of speech and expression, right? So it is the Supreme Court of India who had declared that right to freedom of speech and expression includes the right to information. And in addition, Supreme Court also said it is also a violation of Article 14 of the Constitution. So the Supreme Court states that the state which has made a law which is known as the Finance Act 2017, which make amendments to the RBI Act, to the Income Tax Act, to the Companies Act, and to the Representation of People's Act, violates section 19(1)(a) of citizens, because they don't get to know the antecedents of fundings which are being received by political parties, and Article 14 of the Constitution, so I'll explain tomorrow, equality before law. But you understand that if it is a right for me as a citizen to be able to enjoy my speech and expression, to be very clearly in awareness of how my political representatives and political parties are receiving their resources, and unless I know what their antecedents are, I can't express my, what you can say, anger or my dissent against them. And since expressing your dissent is a part of your fundamental right under Article 19(1)(a), it is necessary for being able to exercise the right of dissent. There has to be a right to information. I can only make a better speech and expression about my dissent when I have the correct information. Okay, so the, what you can say, the amendments made to 1, 2, 3, 4, these laws have been subjected to a strike down by the Supreme Court of India under its powers of Article 13, Clause 2 of the Constitution. Right? Now, this does not mean that corporate donations are not allowed. It means that intransparent corporate donations are not allowed. People can still pay to political parties, but they have to maintain a book record upon how much money they have paid to the political party, and the political party also have to maintain a record about how much money they have received from corporations. So it is not the case that corporations cannot fund political parties or political parties cannot get money from the corporations. It is not a judgment which is curbing the right of corporations to give funds or rights of the political parties to receive funds. But what it is doing is, it is taking all these provisions which are making these political contributions non-transparent, opaque, and in a way kind of insidious. It is striking down all of these provisions. So for example, if you take a look at the Companies Act today, in Companies Act all these provisions have been struck down with the application of the judgment of the electoral bonds by the Supreme Court. All of this in orange has been struck down, but whatever is given in green is still there. So if today, for example, the question is how can contributions be made to corporations by political parties, so how can what you can say contributions are made to political party by corporations, if that kind of a question is asked today, the answer to that question is given under section 182 of the Companies Act even today. Do we get an understanding of this class? So it again does not at all imply that the Companies Act does not allow corporate contributions. It does not only allow this part. So this part has been struck down. This part in orange has been struck down in the Income Tax Act. The RBI Act, that part has been struck down, where RBI's position has been taken to be valid that promissory notes cannot be issued by a scheduled bank apart from the Reserve Bank of India. And the provisions of the RPA Act under section 29 subsection C, 29C, this part, it has been struck down. And the way in which political contributions can be made by corporations has been reverted to the status quo before the Finance Act 2017. So even today political contributions can be made by corporations, but they have to follow the procedure of section 182, which is to record them, which is again under the provision of section 13(1)(13)(a), that the political parties have to record them. Again the section of RPA, that they have to be submitted to the Election Commission of India, and the submission of the, what you can say, Income Tax Act, that they have to be subjected to be presented to authorities on demand. Okay, all of those provisions remain exactly the same, but any of these amendments which have been made to these provisions have been struck down as unconstitutional. Right? So I have in a way very simply and categorically presented before you the entire, what you can say, activity about how the electoral bond scheme was introduced, what were the constitutional challenges to it, and what was the logic applied by the Supreme Court of India along with its entirety of provisions by which this particular law was struck down, and the corporate contributions of intransparent, opaque nature were struck down by the Supreme Court of India. No, right to information is not under Article 21. Right to information is under Article 19(1)(a). It is Administrative Association for Democratic Reforms versus Union of India 2002 case, and it is Indira Gandhi versus Rajnarayan 1975 case. These two cases, they decide that right to information is a fundamental right under Article 19(1)(a) of the Constitution. It is not under Article 21. Under Article 21, you may have something like right to knowledge, which may be something completely different. When we talk about right to information, it is given under Article 19(1)(a) of the Constitution. Class, are we clear about this entire part? We've discussed the conceptual framework of the electoral bond scheme, the background of the electoral bond scheme, the constitutional provisions from which electoral bond scheme and the judicial review over it arises, and how the electoral bond scheme was conceptualized and dismantled by the Supreme Court, and what is the nature of political contribution as it exists today. Those parts we have taken a very clear look at, right? All right, class. ठीक है, I take your point about the sending of PDF etc. एक तो पहले ये बोर्ड वाला ही मैं आपको भिजवा दूंगा, so that you have an understanding of what I've written over here, and then the later parts, yes, we'll start delivering the documents also as soon as we can just get a sense of how far we are in the court. ठीक है, so this was a part to be covered today. नहीं तो वही तो बात है ना, आप रिकॉर्ड नहीं करेंगे तो बैंक में तो रिकॉर्ड हो ही जाएगा ना. अब सो फॉर एग्जांपल इफ आई एम मेकिंग अ see the whole thing about electoral bonds is that it is not paid. It's a see electoral bonds में क्या है कि स्टेट बैंक ऑफ इंडिया से आपको पैसा आएगा, मेरे से नहीं आएगा. तो मैं इलेक्टोरल बॉन्ड्स में स्टेट बैंक ऑफ इंडिया को पैसा दूंगा और स्टेट बैंक ऑफ इंडिया आपको पैसा देगी. You see the point? So in your account the money will not show from me but from the State Bank of India. If I give you a demand draft or a check, then of course it is coming from me directly. So even if you don't record it in your documentation, अगर आपके बैंक अकाउंट की हिस्ट्री खोले के देखी जाए तो पता चल जाएगा ना कल को, अगर इन्फोर्समेंट डायरेक्टोरेट या सीबीआई या कोई भी आपके बैंक अकाउंट की हिस्ट्री खोल के देखती है, आप अकाउंट मत मेंटेन करो पर पता चल जाएगा ना चेक कहाँ से गए. लेकिन इलेक्टोरल बॉन्ड्स में the money is not given by me but it is given by the State Bank of India to which you have submitted the electoral bonds. अब स्टेट बैंक ऑफ इंडिया से इंफॉर्मेशन निकालना मुश्किल है क्योंकि उसके लिए लॉ चेंज करना पड़ेगा. और मान के चलियो आपने स्टेट बैंक के इंफॉर्मेशन निकाल भी ली तो क्या पता मैंने शेल कंपनी से पैसे डलवा दिए स्टेट बैंक ऑफ इंडिया में. सो रादर देन आई परचेजिंग इलेक्टोरल बॉन्ड्स, आई क्रिएट अ शेल कंपनी which can purchase electoral bonds from the State Bank of India, and the State Bank of India gives it to your bank account. Then the traceability of where the money comes is going to become almost impossible to assess. Whereas if I give a direct check or a cash or something like that, it is easily traceable in that sense. You see the point? So we were finishing up yesterday the concept of electoral bonds. Okay, we were taking a look at the concept of electoral bonds yesterday. I think the fundamental nature of electoral bonds, we had taken a look at how that activity was persisting. That was there basically dealing with the question of how, for example, you have within the electoral bonds, you have amendments that were made amendments that were made by the Finance Act 2017 to the RBI Act, the RP Act, these are the acts to which the amendments have been made, right? And in this particular, the section which has been amended was section 31 in the RBI Act, right? So amendment was made to that, and then the section which was amended in the RPA was section 29C. Section which was amended in Companies Act was section 182, and the section number 13C, 13A, sorry, was amended in the Income Tax Act. Okay, so these are the amendments which were made in this particular categorization. And what we have seen, for example, is that the Supreme Court has said in the electoral bonds case that the amendments are unconstitutional as they violate Article 19(1)(a) and Article 14. These amendments are unconstitutional because they violate Article 19(1)(a) and Article 14. Okay, so we have seen, for example, the whole idea about how this particular activity was yesterday placed before us, that the question over here, the little bit of a revision what we can take from here is on the question of judicial review, right? So what you see in the case over here is, the case that you see over here is that the powers of the judicial review of the Supreme Court were exercised under Article 13 clause 2. Okay, now take a look at this, just looking at the constitutional provision of it. When we take a look at, for example, the concept of judicial review, one of the ways in which judicial review can be understood is under Article 13 clause 2. Okay, so if you take a little bit of a revision of this part, Article 13 clause 2 of the Constitution of India, Article 13 clause 2 of the Constitution of India says that a law that takes away or abridges fundamental rights shall be declared void. A law that takes away or abridges fundamental rights shall be declared void to the extent the law violates a fundamental right. Okay, this is what basically Article 13 Clause 2 states. A law that takes away or abridges fundamental rights shall be declared void to the extent that the law violates a fundamental right. Right? And of course, this power is given to the Supreme Court and the High Court both. The power of judicial review over here is given to the Supreme Court and the High Court. The Supreme Court and the High Court put together, they are known as constitutional courts. The Supreme Court and the High Court put together, they are known as the constitutional courts. Right? Clear? Now, if you take a look at the next point, the Finance Act 2017 that has amended the provisions of the RBI Act, the RPA, Representation of People Act, the Income Tax Act, and the Companies Act. Violates the right to information which is derived as a fundamental right under Article 19(1)(a) and right to equality under Article 14. Therefore, these provisions which collectively created the electoral bond scheme is declared unconstitutional. And struck down. Okay, this is how basically you can get a very simple understanding of the logic that has been used by the Supreme Court in exercising its powers of judicial review. I hope that this is comprehensible. See, just take a look at the statement. This is a kind of a statement directly which can come in the prelims examination as it is. Law that takes away or abridges fundamental rights shall be declared void to the extent the law violates a fundamental right. Finance Act 2017 that has amended the provisions of the RBI Act, the Representation of People's Act, the Income Tax Act and the Companies Act violates the right to information which is derived as a fundamental right under Article 19(1)(a) and right to equality under Article 14 of the Constitution. Therefore, these provisions which collectively created the electoral bond scheme is declared unconstitutional and struck down. This is what basically we are taking a look at with we understand the concept of the judicial review which has been subjected on these matters with regard to the electoral bond scheme. Okay? So I have in a way pointed out to you that, for example, let's say if we have taken a look at the judgment yesterday given by the Supreme Court directly, it is a case called ADR versus Union of India in the year 2002, which was again given by the Supreme Court of India, that declared a right to information on the antecedents of political parties right to information on the antecedents of political parties and the nature of contributions made under politics is a fundamental right under Article 19(1)(a). तो ये सुप्रीम कोर्ट का पुराना जजमेंट था जहां पर इस प्रकार की एक राइट को फंडामेंटल राइट की तरह डिक्लेयर किया गया था. This was the previous judgment of the Supreme Court in which this kind of a right was declared as a fundamental right. Okay, it was the previous judgment of the Supreme Court in ADR versus Association for Democratic Reforms versus Union of India in 2002, in which the right to information was declared, right to information on the antecedents of political parties and the nature of contributions made under politics is a fundamental right under Article 19(1)(a). Okay, so this is basically how we are going to take an understanding of this part very clearly, right? तो ये हमारा जो आर्टिकल 19(1)(a) का तो वो था, that is done, and आर्टिकल 14 में सुप्रीम कोर्ट ने ये दलील दी थी while Supreme Court were talking about Article 14 of the Constitution. Supreme Court said that allowing loss-making companies to make anonymous corporate contributions is not reasonable and is considered arbitrary. According to the allowing loss-making companies to make anonymous corporate contributions is not reasonable and is considered arbitrary according to the principles of equality under Article 14 of the Constitution. The main argument of the Supreme Court in this particular sense, in this particular question, The main argument that was given by the Supreme Court was that the removal of the cap, क्योंकि आर्टिकल 182 में देखा था कि removal of cap on corporate fundings can also lead to what you can say the removal of cap on corporate fundings and the removal of criteria of how many, or let's say for example of which corporations ठीक है. तो इसमें सुप्रीम कोर्ट का आर्गुमेंट ये था, the argument which was given by the Supreme Court in this particular matter under Article 14. Try to look at the logic of the Supreme Court. Why was the electoral bond scheme struck down under Article 14 of the Constitution? Under Article 14 of the Constitution, you have equality, but also with regard to Article 14, you have equal, unequals cannot be treated as equally, right? And for example, what we are looking at today with regard to the electoral bond scheme is that before the amendment that was made to the electoral, what you can say, before the amendment was made to the electoral, let's say for example, section 182 of the Companies Act, the criteria for a corporation to donate to a political party remained. Okay, before an amendment was made in section 182 of the Companies Act, there was a criteria of how a corporation can donate to a political party, and that criteria was, as I had mentioned yesterday, that what you can say, a corporation which has 3 years of, let's say, existence, and that corporation can give 7.5% of the net profits of the last 3 financial year as a maximum, which means basically that first of all a corporation must have existed for 3 years, and second, that corporation must be making a profit. These were the two conditions given for a corporation to be able to contribute to a political party, right? That is what we read, that 7.5% of the net profits of the corporation in the last financial years, this has to be made as a contribution, right? And the fact that there was an eligibility criteria for corporations who can make a donation. The eligibility criteria was that a corporation must be existing for at least 3 years, and second, it must be a profit making corporation. Okay, so there was a kind of a reasonable, what you can call, discrimination that was made between profit making corporation and loss making corporation, and saying that loss making corporations should not be allowed to make political party fundings, because then the idea is that if you're a loss making corporation, you may fund a lot of money into a political party on the basis of a quid pro quo, and then the political party may in a way create a special advantage for you. You see, so the point that this basically realized was, so for example, let's imagine that if you have, let's say, all these are all companies in the country, okay, these are all corporations in the country, okay, and let's say for example this includes the profit making corporations and the loss making. Clear? Now let's say for example, by removing the fact that loss making corporations can contribute to corporate or political funding, okay, so if a corporation is loss making, it can contribute to a political party, and that too in an anonymous manner. Okay, and let's say for example, to cover up the losses or to become a profitable corporation, when the political party gets into power, it can start favoring the loss making corporation. And if a loss making corporation is going to be favored by a political party, this would be called a discrimination, or what you can call as a inequality before the law. Because then loss making corporation would be able to outcompete the profit making corporations because they have a kind of a indulgence with the government. They have a kind of a special association with the government that they are dealing with. Do you see the point? So on this basis, Article 14 was specifically used to strike down the part of the Companies Act Article 14 was specifically used to strike down the part of the Companies Act that allows loss making corporations to make infinite anonymous corporate contributions. ये था point. Okay. It allows the loss making corporations to make infinite and anonymous corporate contributions. You see, this is exactly what is going to be a kind of a prelims examination thing. So if we take a look at, for example, today, if you ask the question that can corporations make funding to the political party? Yes, they can do. Under section 182, before it stood, before the amendment made by the electoral bond scheme, section 182 as it stood prior to that is how, for example, a corporation can still make the funding. So what do you need to become a corporation which is eligible funding? You have to follow all the procedures that I had mentioned before. You have to be a corporation 3 years in existing. You have to have profit, and 7.5% of that profit only you can maximum make a contribution. You have to keep a list of records of what contributions are made in particular, and that corporate funding can be tax deductible, meaning you can claim some kind of an exemption upon the income taxes by the virtue of that corporate funding under article section 80 GC of the Income Tax Act. Okay, so that you can do very clearly. You can create a kind of a corporate funding structure by which you can exempt yourself from certain income tax. The political party which is receiving the funds also is exempt from income tax. Okay, as we have seen yesterday, section 13A of the Income Tax Act talks about the fact that political parties are exempt from income tax. Please mark this point very clearly because you may see a question upon this overall. Political parties are exempt from income tax. Okay, they don't have to pay the income tax, but income tax can be charged upon them in case of a default or a penalty. So for example, if the corporate if the political parties are receiving payment in cash format, or if the political parties are receiving let's say um, are not creating a proper documentation of the people who have contributed to them and what are the amount of people who are contributing to them, if the documentation etc is not clear, then the income tax department can charge income tax upon the political party. But if everything is complied with, commonly speaking, generally speaking, political parties are exempt from income tax. That is given under section 13C of the Income Tax Act, right? So I feel that this is one of the important points that you have to remember for the prelims examination this time. In addition to this, the political parties under section 29C also have to present 29C of the Representation of People's Act. Also, they have to present an entire memorandum of all the corporate fundings that they have received and to submit that memorandum with the Election Commission of India. So they have to give that kind of a notification to the Election Commission of India as to what are the kind of corporate fundings it has received. Okay, so if, for example, you ask the question that after the judgment of the Supreme Court on 15th February 2024, what is going to be the nature of corporate funding? The nature of corporate funding is that corporate funding is allowed. It is not disallowed. The act of corporate funding itself is not unconstitutional. But the fact that the corporate fundings are going to be transparent and will take in account all the relevant provisions of the Companies Act, Section 182, Representation of Peoples Act, Section 29C, the Income Tax Act, Section 13A, and according to these compliance, it has to make a clear documentation of the kind of money that has come from whichever companies. But it is also a matter of fact today, for example, today, if we ask about this rule applies. Now, this is something that you have to take a very crucial understanding from the prelims perspective. Making corporate, what you can call loss making organizations, a company which is loss making cannot make any corporate fundings. This is one of the most, what you can say, clear implications of this judgment of the Supreme Court. Let me write it again. Okay, very simply, today, after the judgment of the Supreme Court, after the judgment of the Supreme Court, a loss making organization cannot make contributions to a political party. This is the point that you have to be very clearly in understanding of. Okay, after the judgment of the Supreme Court, a loss making organization cannot make contributions to a political party. Okay, do we understand this point? Are we clear? Okay. And also the question that we are taking a look at, the question that we started with when we're taking a look at the Finance Act. अब ये वाला जो question है, so it was not needed at this point of time to strike down the law which amended these provisions into the RBI Act and etc. because it was not needed at this time. Finance Act को इस basis पे strike down नहीं किया है that it was passed as a money bill. Okay, the strike down did not happen because it was passed as a money bill, but the strike down happened because it was in a violation of certain fundamental rights. For this particular question, as I have told you yesterday, that a 7-judge bench is currently going to consider questions like these, which is basically the whole idea of how a money bill comes into picture and what are the ideas of a money bill, and can, for example, the PMLA, Prevention of Money Laundering Act, can, for the example of the Aadhaar Act, and even, for example, the case of Finance Act 2017, which contained these provisions, can they be passed as money bill? So this is going to be referred by the Supreme Court to a 7-judge bench, which is going to be one of the important events which are going to come forward in the future. Clear? Organization more than 3 years shall be eligible, yes, but it has to be a profit making organization. If it is lesser than 3 years, it shall not be eligible. If it is more than 3 years, it shall be eligible. Okay, so these are the two conditions again today for corporate funding. Please note it out for your prelims examination clearly. An organization which is at least in function for the last 3 years, and for the last 3 years it has made profit. That is what is the criteria for corporate funding. So an organization which is 2-year old and making a profit, it is not eligible. An organization which is 5-year old but is not making profit is not eligible. Okay, these are the two things that we have to understand in this context. Okay, so this covers the part of electoral bonds. Okay. Just let me take a look at some questions that you have asked. I'll address the doubts and then move on with the next part that I want to cover. Does judiciary have the power for judicial review in case of money bill? Yes, yes. The Supreme Court, in what is known as the Aadhaar 5-judge bench judgment in 2016, had declared that the power of the Supreme Court is there to review. I think I gave the answer yesterday in detail. The Supreme Court can review the decision of the Speaker in cases of money bill. Yes, this is basically the answer to the question, that the judicial review powers are given to the Supreme Court. It is correct. It says if the Finance Act 2017 was struck down because it was passed as a money bill, it is incorrect. It was not struck down because it is passed by as a money bill. That question is still to be answered by a 7-judge bench. So your statement is absolutely correct. Okay, is it true that appeal against CAT shall lie before High Court? Yes. As we have seen, for example, when we take a look at the CSAT paper there, we know for a fact that the appeal which is made, a decision which is made by a central administrative tribunal, shall be appealed before a high court. So it is correct to say that. Himachal Pradesh MLA disqualification. Yes, so I think you are already able to read some newspapers around it, the disqualification of MLAs, and not only Himachal Pradesh, by the way. In Andhra Pradesh also there has been MLA disqualification. If you have seen, for example, a news yesterday only, using exactly the same thing, which is the anti-defection law, you have had disqualification of MLAs. Right, so it's happening all over. अब आपको करंट अफेयर पढ़ना समझ में आ गया इसमें. You see, this is the Speaker of the Andhra Pradesh Legislative Assembly, and you see Andhra Speaker disqualifies 8 MLAs under the anti-defection law. तो ये वाला भी एक न्यूज़ आर्टिकल है जो कि रेलेवेंट आ रहा है चीज़ों में. हाँ, अच्छा, अब ये वाली जो एक बात है ना, मैं थोड़ा सा इसको आगे करूंगा. लेट मी जस्ट मूव अ लिटिल बिट अहेड, बट आई विल एड्रेस दिस क्वेश्चन वंस. व्हाट इज द नेचर ऑफ, ये थोड़ा सा आई कम टू दिस क्वेश्चन अ लिटिल लेटर ऑन. बस मैं इसको लिख के आपको बताता हूँ कि आई विल डिस्कस दिस. व्हाट इज द नेचर ऑफ whip and anti-defection law in the case of Rajya Sabha elections. ठीक है, इसको मैं थोड़ा सा करूंगा अभी आगे. हिमाचल में दो चीजें हो रही हैं साथ साथ, एक तो लोकसभा मतलब लेजिस्लेटिव असेंबली में भी क्रॉस वोटिंग हो रही है, और एक यहाँ पर भी मतलब राज्यसभा के इलेक्शन में भी क्रॉस वोटिंग हो रही है. बट एज द पोजिशन गोज दैट अ विप पावर इज नॉट एप्लीकेबल इन द राज्यसभा. जो राज्यसभा होता है उसमें विप की पावर है जो उसकी एप्लीकेबिलिटी नहीं मानी जाती है. Yes, so we can, let's say for example, if you take a look at the editorial of the Hindu yesterday, I'm glad that you read the editorial yesterday about Hindu. ये वाला जो एडिटोरियल है इसको हम करेंगे पूरा ढंग से. Issuing whips in Rajya Sabha elections may stir a debate. As the legal debate on whips continues, interpretations could have consequences for rebel MLAs and their parties, governments. ठीक है, ये वाला जो है ना एडिटोरियल, इसको पूरा करेंगे हम. ठीक है, आप बिल्कुल निश्चिंत रहिए. We are going to take a look at this entire part as a section as to why whips cannot be issued against MLAs in the case of a Rajya Sabha elections. Okay. ठीक है, इस चीज को थोड़ा सा करेंगे, आप थोड़ा इस पे वेट करिए हल्का सा. It means judiciary can declare the Finance Act as unconstitutional or void. Yes, it can declare it, and the impact of it would be that the Parliament would then be requested to pass the Finance Act, meaning pass the provisions of those bills which have been kept in the Finance Act, not as money bills but as ordinary bills, which is not bypassing the Rajya Sabha. Okay, मतलब राज्य सभा की बात आपको माननी पड़ेगी अगर आपको इस प्रकार के बिल्स में चेंजेस लाने हैं. ठीक है, देखिए फाइनेंस एक्ट तो बजट की बात करता है, तो फाइनेंस एक्ट तो मनी बिल है ही. क्वेश्चन इज दिस दैट कैन वी टेक सर्टेन पार्ट्स एंड हाइड देम इन द फाइनेंस एक्ट एंड गेट देम पास्ड. ठीक है, इमेजिन अ ट्रक इज गोइंग अक्रॉस अ टोल प्लाजा. ठीक है, नाउ द ट्रक इज अलाउड टू गो थ्रू द टोल प्लाजा, बट you can keep some illegal substances in the truck, knowing that along with the truck the illegal substances would also cross the toll plaza. This is what the government has done. The Finance Act is anyway passed by the Parliament as a money bill, but putting RBI Act, Income Tax Act, Companies Act and RPA and hiding them in the Finance Act, that is what is a problem. And therefore the question is not whether the Finance Act is unconstitutional, but the question is, can other provisions be included in the Finance Act and be passed off as a money bill? That is the important question. अच्छा ठीक है. Speaker decision of a bill being a money bill can be judicially reviewed now, as it was said in SC in Hadar case. Yes, it can be. It can be reviewed now. Now, for example, the whole 7-judge bench thing is going to come into that. हाँ, ये जो this decision is going to be in the 7-judge bench. Okay, this is interesting. Recently, Maharashtra Legislative Assembly passed a bill regarding disallowing RT quota in private school if there is government school within 1 kilometer distance. Isn't it depriving children of fundamental rights to education? हाँ, I have not been able to read this. Okay, ठीक है, I note this down. ठीक है, I'm taking a note on this. Sorry, I've not been able to read about this properly, clearly till now, but I have heard about this. ठीक है, ये वाला एक केस है जो महाराष्ट्र RT वाला कोटा है. I'll take a look at it. And also, by the way, if the fact is such, then it is a violation of the Right to Education Act, क्योंकि Right to Education Act में लिखा हुआ है that it is imperative that the government shall itself set up schools under the RT. Okay, so if you take a look at the Right to Education Act, Section 6 of the RT Act, if you take a look at it, अगर ऐसा हुआ है तो फिर गलत है, मतलब इसका वायलेशन है RT Act का. Take a look at this. This is what you're saying clearly is a violation of Section 6 of the RTE Act, because the Section 6 of the RTE Act does not prescribe an area limit. ठीक है. So though I have not read the act entirely, since you have pointed it out, I will read it. But just as a kind of a in, initial thought that I had while looking at this particular activity was this. Take a look at this section 6 of the Right to Education Act. Duty of appropriate government and local authority to establish school. For carrying out the provisions of this act, the appropriate government and the local authority shall establish within such area or limits of neighborhood as may be prescribed a school where it is not so established within a period of 3 years from the commencement of this act. ओके तो इसमें यहाँ पर कोई 1 किलोमीटर का दायरा है नहीं किसी भी प्रकार का. तो इसका मतलब है कि दो सरकार, द महाराष्ट्र गवर्नमेंट, इफ इट इज मेकिंग अ पॉलिसी और अ रूल विच इज नॉट हैविंग its basis under section 6, then you know what happens. It is called ultra vires. The RT Act. So it is liable to be struck down. And since it is ultra vires the RT Act, and RT itself is a fundamental right, it can be covered under Article 32 and 226 and even under Article 13 clause 2. Okay. ठीक है ना. तो ये आपका इस पूरे स्ट्रक्चर में आ जाएगा, वायलेट करेगा आर्टिकल सेक्शन 6 को. ओके. Local and non-local reservation and employment opportunities can curtail under Article 16. Local, see what you mean by local. If I understand the question, जो आप कह रहे हैं कि local का क्या होगा, दो तरह की चीजें होती है. एक तो होता है reservations on the basis of place of birth. ठीक है. और दूसरा होता है reservations on the basis of residence. These are the two kind of things that you are, I hope, indicating when you say local or not local. Okay. Now it is said very categorically under Article 16 कि where you can not make residences on the basis of the place of birth. So for example, a Gujarat cannot make a reservation for a person who's born in Gujarat, who's a Gujarati who's born in Gujarat. Okay, but you can in certain cases make reservations for residence, and that is given under 16 clause 3. In our previous classes we have taken a complete understanding of Article 16 clause 3. ठीक है. और 16 clause 3 में ये दे रखा है हमने कि if a reservation for residence has to be made, if a reservation for residence has to be made, it can only happen through a law made by Parliament. Not a state legislature. ठीक है. तो इसलिए हरियाणा वाला हमने जो लॉ था वो इसीलिए कवर किया था इसमें, right? The law which was made by the government of Haryana, and that was not even talking about offices under the state, that was talking about private employment. Of course that was unconstitutional, right? This is the only way by which you can make reservations for local residents, I am assuming, under Article 16 of the Constitution. Okay. हाँ, हिमाचल वाला भी केस एक बार हम थोड़ा सा देख लेंगे इसको करके. National awards was decoration, but what about PM accepting the Grand Cross? Again the same thing. What you see under Article 18 clause 2 of the Constitution also talks about title, and then again the reading of the Supreme Court was in that particular case itself that it is not a title, it is a decoration, right? So it says that no citizen of India can accept a title from a foreign state. That's what basically it says, right? Article 18 clause 2. If you take a look at Article 18 clause 2, it says that no citizen of India can accept a title from a foreign state. No citizen of India shall accept any title from a foreign state. What they said that the Grand Cross is not a title, it is again a decoration. So for example, how the Bharat Ratna is a decoration and it is not a title, Grand Cross is not a title, it is a decoration. Okay. Right. So that's basically how that was justified. ठीक है. Why doesn't Supreme Court penalize the governments for manipulating the passing of bills? Well, ऐसा भी नहीं, देखिए सुप्रीम कोर्ट लेजिस्लेटिव एक्टिविटीज में बहुत ज़्यादा इंटरफेयर कर नहीं सकता है. इट इज़ नॉट करेक्ट फॉर द सुप्रीम कोर्ट to assume the role of the legislature and tell its own business. Okay, so it can only check and balance, but it can't, become overreaching in these situations. After all, if you have attained the majority in the parliament, you have the primacy over that function. And if you make some, things here and there, the Supreme Court can check you, but it can't, start becoming a disciplinating a kind of a authority, which is, getting a higher order on these things. वो नहीं कर सकता सुप्रीम कोर्ट. ठीक है, चलो, I'll take up another matter that you are saying over here, which is simultaneous elections. एक बार थोड़ा सा एक छोटा सा पॉइंट कर लेते हैं. What we know as one nation, one election. Right, this has been in news recently for some time, and it can be discussed somewhat. One nation, one election. Okay, so how do we take a understanding of this part about one nation, one election? The first thing that we understand, for example, in one nation, one election, is that the idea is also known as simultaneous elections. ठीक है, अब ध्यान से कॉपी किताब लेके बैठिएगा, थोड़ा नोट करते रहिएगा चीज़ों को. Simultaneous elections. इसका मतलब होता है कहने का कि in the Republic of India you have elections for the president, for the vice president, for the Lok Sabha, for the Rajya Sabha, for the Vidhan Sabha, for the Vidhan Parishad, and for what are known as the, what you can say, the elections at municipalities, panchayats, and now at cooperatives, right? So these are the areas in which elections are supposed to happen. Okay, now the concept of a simultaneous election basically says that the two major elections in India, for example, what it basically says that all the direct elections all the direct elections except the local bodies all the direct elections except the local bodies. So if you take a look at the specification of this, what are the direct elections, right? So what are the direct elections in India? You have the elections of Lok Sabha, which are direct. You have the election of Vidhan Sabha, which are direct, right? So you have the state legislature elections, which are direct, and the union legislature election, which are direct. Other than that, you have the panchayat and municipality and cooperative elections, which are direct. The elections to the President of India, the Vice President of India, the Rajya Sabha, and the Vidhan Parishad are indirect elections, right? So they are just basically understood as elections which are considered to be a larger part of a scheme. But their whole idea about electoral activities is slightly different in terms of select electorates and all of these things. Okay, but what are known as popular elections or elections which happen meaning among the people, etc., etc., that kind of an election, they shall be conducted simultaneously. ठीक है, तो जो यहाँ पर एक आर्गुमेंट रहता है वो ये होता है कि जो इलेक्शंस लोकसभा के हैं और राज्यसभा के हैं, विधानसभा के हैं, इनको एक ही समय पे साइमल्टेनियसली करा लिया जाए. जैसे फॉर एग्जांपल द आइडिया वुड मीन that now let's say for example you have in 2024 elections of the Lok Sabha. The concept of a direct election means that the Lok Sabha elections, when they are happening at the same time, during the same time, you will have elections across the country, right? When you are having elections of the Lok Sabha right now, at the same time you will have elections across the country for the Vidhan Sabha, right? This is basically the argument that simultaneous elections can take place once. So all the let's say Maharashtra, Karnataka, Tamil Nadu, etc., all the Vidhan Sabha elections happen exactly simultaneous with the Lok Sabha elections. That's basically the idea of a simultaneous elections. Now, if you take a look at, for example, the purposes of the simultaneous election from a political perspective, the question is that why would a political party want that there is something like simultaneous elections that should happen very often? The answer is simple. The answer is political parties before elections generate what is called a wave, right? So just before elections, there are some things that the political parties have to do to be able to, let's say, kind of excite the masses, right? So for example, on the least amount, what they can do is that they can make petrol prices come down quite a bit 2 months before election. On the most amount, there could be a huge propaganda or activity, which is basically, let's say, for example, organizing an event, or sometimes there is political violence and all of that. So the idea is that the mood of the nation is quite spontaneous, right? And if you do something instantly right now, that becomes the mood of the nation. Generally in a democratic system, that is basically the concept कि चुनाव से पहले अगर आप कुछ कर देते हैं तो वो जो जनता है उसी मूड में वोट करती है. You see, you can create a mahal. Something you do with before a election, you can create a kind of a mahal out of it, because the people generally go with the mahal. They generally go with the mood that has been created just before the elections. अब 4 साल तक आप कुछ काम ना करो, लेकिन आखिरी 1 साल में आप बहुत सारी चीजें करो एकदम से, तो जनता फिर 4 साल भूल जाती है. वो स्पॉन्टेनियसली उसी माहौल में वोट देती है जो कि आपने अभी बना के रखा है. And then once you are recontesting elections and after that mahal has been created, you are certainly riding a wave, you see. So anything can happen. For example, you can have a scam which is exposed. 2013 में यूपीए के अगेंस्ट इतने सारे स्कैम आ गए थे बाहर because of the report by the CAG, the Comptroller Auditor General of India, who had issued a report. You had Colgate scam and 2G spectrum scam and A Raja and Kane Mozi, and even the coal scam, in which somewhat the prime ministership of Dr. Manmohan Singh was kept under a lot of consideration, right? Meaning a question. So just before elections, if something like this happen, it kind of shapes the mood of the nation, right? Now imagine, for example, let's say that you have to shape the mood of the nation all the time today. Okay, so for example, there is a Lok Sabha elections jahan par you have to shape the mood of the nation, but also there are legislative assembly elections. Now just in 2023, November 2023, there were elections at the, what you can call, legislative assemblies. You have elections at the level of let's say Rajasthan, Chhattisgarh, Madhya Pradesh. All of these states had undergone elections, and in this time you have to create a separate individual mahal for these states, right? तो आपने राजस्थान में कुछ कराना है, आपने मध्य प्रदेश में कुछ कराना है, आपने छत्तीसगढ़ में कुछ कराना है, and all of that. Now that is a lot of expenditure from the political parties, है ना, कि हर समय उन्हें किसी ना किसी तरह से या तो राज्य में या केंद्र में किसी प्रकार का माहौल बना के रखना पड़ता है, right? Now, I'm thinking it from a perspective of a political party, right? I hope that you can correlate with this kind of an understanding. So a concept of a one nation, one election, what it allows a political party basically is that if all elections, let's say for example, just imagine, for instance, if all the state elections of India were happening right now in 2024. There is already mahal going on, there is already a mood setting going on, right? Then one could have, for example, with that kind of an entity, a direct, what you can say, linkage, a single pointed effort in which you can intensify this mahal more and more. And in this mahal, you create a giant wave. And then every person who's getting into an election booth votes for your political party, whether at the union or at the state level. You get the point over here, class? So the idea of, if you look at it from the perspective of a political party, the idea is that a one nation, one election helps you consolidate, concentrate, focus upon single things, upon a kind of a single big moment or event. The mahal creating, the kind of, you know, the mindset creating, the mood creating event. And when that kind of a mindset or mood is created for the entire country with one intensity, when the voter is going to go inside the poll booth, he is going to vote for your political party. फिर उसका, you know, understand how the mood of the electorate depends, right? You have a electorate which is very easily swayed by big activities and all of that, despite the fact that they may long term think something differently, but in the short term they may not necessarily be thinking exactly the same, right? So the idea of a one nation, one election, it suits political parties because then they will have a consolidated, intensifying attempt to be re-elected into the power. And that's basically the origin point of the one nation, one election. Of course, as you can see, that the moment I mention something about a one nation, one election, and you create a kind of a mood of the entire nation, it has very clear implications for the concept of federalism. तो जैसे ही अगर the moment I say something about one nation, one election, it has implications directly for the concept of federalism. You see, because of course, if you create a kind of a, if you create a kind of a movement which is going to dilute in the mind of the electorate the difference between the vote given to the union party or at the union level, or difference given to a vote at a state level, if you're going to kind of in a way shed that barrier in the mind of the electorate, then of course both at the union and the state level one political party may be able to dominate, and this will have very clear, what you can say, you know, centralizing instincts, that the central people who are dominating the political union will also be end up being dominating the state legislative assemblies, right? So from the perspective of a political party, this is what the essence of a one nation, one election looks like, a simultaneous elections. And also, of course, it will have some positive implications which are ancillary. The positive implications are going to be, for example, about how election commission would be able to manage all of this better, and this consistent, you know, obsession of India with one election and the other election and this haphazard cacophony of elections, this is going to be somewhat, you know, tamed and a kind of, you know, taken into some kind of a regulation. So organizational perspective, so this is of course going to be a positive side, but also in the background of it, if you are going to have that kind of a critical analysis of it from a political perspective, it may not be the best thing for the concept of federalism, which may dilute in the mind of the voter that he is voting for the center of the state, then he will vote for the political party both at the center of the state. So imagine if you're entering into one room, and in one room, in one block you have the Lok Sabha elections, in another block you have the state assembly elections, and you are under a lot of mood and mahal and etc etc. It is very hard for you to be able to keep that kind of a distinction or understand it conceptually, that you are voting for the Lok Sabha election or you're voting for the लेजिस्लेटिव असेंबली इलेक्शंस. तो आपके दिमाग में वो सेंटर और स्टेट का डिफरेंस वहां पर थोड़ा सा डाइल्यूट हो सकता है अगर if a kind of a mood or an event or a, you know, a kind of a impact has been created upon your consciousness to that sense, right? That's basically what you can say, the background logic of one nation, one election, right? That's the part that we are taking a look at now. Let's say The ministry which is going to organize this is the Ministry of Home. This is the most prominent, what you can say, critique that has come up of the concept of one nation, one election. Okay, so for example, if you take a look at this part, just a little bit of a current update brushing upon this idea. Okay, if you take a look at the first paragraph over here, please, if you can read it. In September 2023, most prominently, again a very fertile part of your current updates, huh? So I'm taking it at a little bit of a high priority. And by the way, if you want to take a look at the sideline of this update only, the Economic Offences Wing initiates probe against Uddhav Balasaheb Thackeray Sena following complaint lodged by Sena's Shinde camp. Right? Just take a look at this paragraph now. Okay, so you understand the most important, what you can say, question from a constitutional perspective is with regard to the concept of federalism, right? So the idea is that the power at the union and the state shall be subdivided between two categories. The powers must be properly divided. Again, the question is that if you create a kind of a mood, a very clear impact, which is a wave of consciousness traveling through the entire nation, if it is going to come in the mind of the voter, then the voter may not necessarily be able to distinguish between a state assembly election and the parliamentary election. ठीक? And of course, this is going to be one of the most prominent things which is going to come up before the Supreme Court of India, right? So what it says is there are compelling reasons to believe that the high level committee is likely to return a recommendation in favor of a common schedule comprising elections to the Lok Sabha and the state legislative assemblies, overlooking genuine constitutional and legal concerns. This is why all the attention in the aftermath of this exercise could entirely focus upon the Supreme Court of India. This would be India's Baker versus Carr moment, where the Supreme Court of US's deliberated the concept of entering the political thicket. The Indian Supreme Court, which has self-characterized its constitutional role as sentinel on the quivi, would be called upon to determine quickly and purposefully the ultimate fate of the Indian democracy. Right. So this is, of course, going to be one of the, what you can say, ways in which the Supreme Court of India is going to work upon. Right. The Law Ministry had conducted a poll and it had taken public suggestions upon these things. And the result of the poll are here. For example, it says 81% of citizens, this is January 22, 2024, by the way, 81% of responses have affirmed simultaneously elections. The ministry issued a press statement after the committee held its third meeting, and the next meeting will take place on January 27. Okay. 81% of them have affirmed that idea of simultaneous polls. So you can see already the ministry is gathering the data to support the idea of a simultaneous poll elections, right? However, you have to be very clear that this 81% is given by altogether 20,972 responses, right? So this is the sample size out of which it has been taken. Okay, are common elections feasible? Take a look at this. One of the reasons assigned in support of one nation, one election is the high amount of expenditure towards the conduct of elections. It is reported that the 2014 general elections cost the public exchequer 3,870 crore. Okay. It is argued that common elections for the Union Parliament and state assemblies would reduce the expenditure significantly. Another reason put forth by proponents of a common election is that the model code of conduct comes into effect twice in a 5-year cycle, which affects the seamless conduct of government business and results in governance downtime. So, of course, meaning that if, for example, the Election Commission of India is going to organize elections, it is going to impose a model code of conduct, and every person who is sitting inside the parliament or the state legislative assembly is contesting elections again, then these people, because of the imposition of the model code of conduct, cannot perform their everyday legislative and government functions. So it kind of introduces a lag. It kind of introduces a lag in the functioning of the government, which is basically one of the reasons why one nation, one election can come as a good point. Opponents of the common elections contend that these reasons are logically and factually untenable. The cost of holding free and fair elections to elect government of the choice is a price that can never be high. There are occasions where a government may not complete a full term for 5 years and elections may be held again. Such occurrences are expressions of the democratic system and not to be accepted. Likewise, the model code of conduct and other guidelines issued by the Election Commission are a necessary pains to ensure that executive influence over voters is kept to a minimum and the playing field during the election period remains level. In any case, it sounds strange for a union government and the Election Commission that have refrained from holding assembly elections in Jammu and Kashmir for nearly 5 years to express strong concerns regarding governance downtime. So that's a little bit of a personal opinion here. In SR Bommai versus Union of India, the Supreme Court declared that the states have an independent constitutional existence and they have as important a role to play in political, social, educational, and cultural life of the people as the union. The constitution provides for a specific tenure to the state legislatures, which is 5 years from the date of the appointed for the first meeting. A similar provision also exists for the tenure of the union parliament. Therefore, the introduction of a common election process would necessarily require alteration of the existing duration of a number of state legislatures. This would go against the express language in the constitution and be in violation of the view expressed by the Supreme Court in the SR Bommai case. Therefore, any such action that impinges upon the independent constitutional existence of a state by altering the duration of its legislative assembly would naturally be anti-federal and unconstitutional. Okay, now just please give one entire minute to this argument and take a look at this interpretation of the SR Bommai case. Now, in your classes, of course, you must have taken a good understanding of the SR Bommai case, but I want you to align this with this current update part, the SR Bommai case, and the fact how, for example, one nation, one election can have a kind of a lagging impact upon the federal structure of the constitution by altering the duration of the legislatures within the states. Okay, so you of course understand that the idea that is given over here is that the legislatures, the state legislatures today are moving at different paces, right? Basically, for example, let's say you may have a state legislature which has completed 5 years today, some standing at 4, some standing at 2.5, some standing at 3, some standing at 3.5, okay, some standing at 3.25. These are the years which state legislatures have completed. Now, if you're going to introduce one nation, one election, then you will have to bring it all to a zero, right? Let's say, for example, if you say from 2025 or let's say 2029, you will have one nation, one elections. If you say that from 2029 you're going to have one nation, one elections, then this diversity is going to be brought to a zero, right? And then we'll start again for a 5-year tenure. Now, this is what basically it says, that for the parliament, in any case, to bring about a kind of a alteration in the duration of the years of the state legislature assembly is going to be a violation of the observation made by the Supreme Court in the SR Bommai case. Again, take a look at this. In the SR Bommai case, the Supreme Court declared that the states have an independent constitutional existence and they have as important a role to play in the political, social, education, and cultural life of the people as the union. The constitution provides for a specific tenure for the state legislatures, which is 5 years from the date appointed for the first meeting. A similar provision also exists for the term of the union parliament. Therefore, the introduction of a common election process would necessarily require alteration of the existing durations of a number of state legislatures. This would go against the express language in the constitution and be in violation of the view expressed by the Supreme Court in the SR Bommai case. Therefore, any such action that impinges upon the independent constitutional existence of a state by altering the duration of its legislative assembly would naturally be anti-federal and unconstitutional. Okay, take a look at this. The next part. The next text would be that of bias, exclusion, and inequality adapted in this exercise. A cursory glance of the website created by the high level committee intended to be a repository of all relevant information on the subject and act as a platform for interaction from all stakeholders shows that it is available only in English and Hindi. That is to say that such a landmark consultation process is being conducted in one of the 22 official languages of the union, right? So that's another point about it, that it has a kind of a union centralizing instinct about the fact that the consultation process which is being conducted by the union has only English and Hindi as the language in which you can register your consultations. Finally, there is a question that goes to the root of the independence of election commission. A constitutional body is endowed with autonomy to take independent decisions regarding elections. Similar to demonetization when the Reserve Bank of India was kept in the dark, the Election Commission seems to be a silent spectator to the entire process undertaken by the high level committee set up by the union government. Can one nation, one election be stopped? In the UK, home of the common law jurisprudence, Parliament is supreme. However, the Indian constitutional architecture is structured differently, granting higher courts inherent and broad powers of judicial review when executive actions transgress fields assigned to them. Right? This is the point at which all of this is going to come and stop. So, of course, one of the most important matters that will develop before the Supreme Court in the coming times is going to be about the one nation, one election. The stage is set for a constitutional showdown in the not too distant future, one that will raise the question of whether constitutional courts, especially the Supreme Court, will enter the political thicket. At the moment, there seems to be no alternative but to enter and wade through the thicket if the constitutional architecture of this country is to be preserved. Okay, so you get the point, which is basically given over here with regard to the what you can understand as the idea of one nation, one election. Okay, if you take a look at, for example, a little bit of a data upon this matter, this is something that you can take a look at, that how different legislative assemblies are ending their terms. Okay, so table 1 shows when the term for the assemblies of each state ends and the number of months that would be curtailed if simultaneous elections are held in these states in the June 2024. Okay, so just take a look at this part. Okay, so this is basically the argument which is being made, that if you are going to impose a one nation one election scheme somewhere or the other, certainly the number of months which are going to be lost by these legislatures in their legislative activity is going to be a direct violation of the concept of federalism, where the union parliament, for the sake of union parliament, all the legislatures had to be reset at zero. This is the data basically that establishes that kind of a discrepancy, right? Take a look at this chart. Table 2 shows the number of Lok Sabha seats, assembly representatives, urban local wards, and elected panchayat representatives for each state. Now, this is the point basically. For example, the idea that is given out over here is that when these elections are, let's say, conducted separately, the Lok Sabha elections are conducted separately, when the Lok Sabha elections are conducted separately, assembly elections are conducted separately, municipality and panchayat elections are conducted separately. The idea would be then, of course, to make sure that the voters' minds are looking at these issues in a separate manner. Okay, the mind of the voters are looking at these issues in separate manners. So, for example, what is important for the union central government or central issues, what are important state issues, what are important municipal issues, and what are important panchayat issues. These are dealt by the voter in a distinct manner. But a kind of a unionization of these entire processes would be able to evaporate the lines in the mind of the electorate between A, B, C, and D. That these lines, which are supposed to guard the different, you know, brackets of what you can call legislative bodies, these are going to be blurred, and one kind of a wave or a mood or a sentiment would be able to overcome the chambering of this particular setup. So that is again, obviously, from a political perspective, going to be a little bit of a disturbing event, right? Okay, so this is one basic idea that we have covered about one nation, one election. Right now, if for example, if you take a look at the high-powered committee, the committee, for example, which is the Ramnath Kovind committee, the former president of India is heading this committee. The most recent update upon this particular activity, which is going to concern our questions on the constitution, is this one. Okay, now the first important thing, for example, this committee has done, if let's say, for example, if you want to take a look at the structure and the nature of the committee, it is over here. Okay, high level committee on one nation, one election, a high level committee constituted by the government under the chairmanship of Sri Ramnath Kovind. If you want to take a look at the composition of this committee, the high level committee constituted by the government and the chairmanship of Sri Ramnath Kovind, former president of India, to examine the issue relating to holding of simultaneous elections in the country and make recommendations thereon, held its second meeting here today. Sri Amit Shah, Home Minister and Minister of Cooperation, Sri Ghulam Nabi Azad, former Leader of Opposition of Rajya Sabha, Sri Arjun Ram Meghwal, Minister of State, Ministry of Law, etc., etc. So you can see these are people generally from the, what you can say, the union executive, and there are certain, for example, constitutional experts, Mr. Subhash Kashyap, Mr. Harish Salve, right, senior advocate Sri Sanjay Kothari, former chief vigilance commissioner, etc., etc. इस पे questions नहीं आएंगे दो आपके. But what you are looking at is the setting up of a committee is basically what has happened over here. Now, if you, for example, get a question on the high level committee, which is dealing with the concept of one nation, one election, you have to understand very categorically that this is what is known as a non-statutory body. Okay, a body which has been created by the government of India, nor by the parliament, nor by the constitution, is known as a non-statutory body. Right. So, a high level committee on the one nation, one election is what we can understand very simply as a non-statutory body. Clear? And the composition is not important. You have certain advocates, certain union ministers, certain retired judge, certain constitutional expert, etc., etc. Okay. As you can see, resignation of Sri Adhir Ranjan Chaudhary, Mr. Adhir Ranjan Chaudhary, who was the part of the committee who was from the single largest party in the Lok Sabha, that was approved by the committee over here. So you can see the political boycott of this particular activity from the entire thing. Okay. Now, when we talk about, for example, this entire setup of a high level committee, the most important aspect of this committee, the most important question that this committee is going to decide, which is going to be the groundwork of it, this entire thing, is going to be, let's say, for example, we understand the biggest important point about this particular idea called one nation, one election. And the one nation, one election idea in itself has one particular problem, that the duration of state legislatures shall be compromised. है ना, ये सबसे बड़ा constitutional objection है इसका, right? We've seen the data, and again the fact that you cut short if the union parliament makes activity, very simply, if you put it like this, if the union parliament does some kind of an activity, if the union parliament does some activity by which the duration of the state legislative assemblies or the state legislatures is compromised, then of course, does it become a question from the perspective of federalism? That's the important question. Okay, ये क्वेश्चन है, ठीक है, जो कमेटी को डिसाइड करना है. और इसके साथ साथ जो लगा हुआ क्वेश्चन है वो ये है, मतलब द real important question which is associated with this question is this. What is the question? The question is, one nation, one election are to be provided as an amendment in the constitution. ठीक है, तो वन नेशन वन इलेक्शन है, इसको भारत के संविधान में संशोधन करके लगाया जाएगा by what is known as the procedure of Article 368. Clear? One nation, one election are to be provided as an amendment of the constitution by the procedure of Article 368. Now, what I'm going to write down next is going to be the most important, what you can say, perspective on the question that the high level committee is supposed to decide. Okay, does this Constitution Amendment Act which institutes one nation, one election. Does this Constitution Amendment Act, which institutes one nation, one election, need to be ratified by 50% of states through their legislatures? So you know, for example, the procedure of Article 368 of the Constitution. How does the procedure of Article 368 go? ये आपको पता है. The question is whether one nation, one election, while it is going to be given a place inside the Constitution, will certainly require the procedure of Article 368 of the Constitution. But does this procedure will also include the ratification part? So you know for a fact that Article 368 of the Constitution under clause 2 gives the procedure, and the procedure is divided into two parts. There are parts of the Constitution which can be amended by a special majority of the parliament only. Okay, but then there are certain parts of the Constitution which also require a ratification by 50% of the states through their legislatures. Are we clear? So the question that we are basically concerned with at this point of time is that when, this is the main important question that the committee is supposed to decide as a constitutional question. The committee is supposed to decide whether the Constitutional Amendment Act, which institutes one nation, one election, needs to be ratified by 50% of the states through their legislatures. That's the important question that the Constitution is going to ask, the committee is going to ask and answer. You see, so that's basically the the fulcrum question which is presented before the committee, which is a non-statutory body. Take a look at this part. This is the most important question that the committee is supposed to answer before the parliament can take up this question made by the committee and present it before the before the government can take up this question answered by the committee and present it before the parliament and then introduce a Constitution Amendment Act. Okay, the Union government on September 2 set up a committee under the leadership of former President India Ramnath Kovind. So this is also known as a Ramnath Kovind committee, to look into the feasibility of simultaneous polls to state assemblies in Lok Sabha. The 8-member high-level committee is set to examine one nation, one election idea and make recommendations for holding simultaneous elections in the country. So these are the members as we have seen this. In light of this development, a key question that is going to be answered by the committee is how is the Constitution okay, so take a look at this. The Law Ministry has outlined 7 terms of reference for the panel. One of them is to examine and recommend if the constitutional amendments required to facilitate simultaneous elections would require ratification by the states, right? So just from the perspective of a current affair update, okay, very simply speaking, just from the perspective of a current affair update, if a question comes, which of the following is a key question which is supposed to be answered by the high level committee set up on one nation, one election, right? If that kind of a question comes, that which of the following is a key question to answer the to be answered by the high level committee set up for one nation one election under the Ministry of Law, which is a non-statutory body, then that is the question. Are there going to be constitutional amendments made under Article 368 which will require the ratification by the states? तो आर्टिकल 368 में जो स्टेट के रैटिफिकेशन का जो प्रोसीजर है, क्या उसको फॉलो करके वन नेशन वन इलेक्शन लाया जाएगा या नहीं? This has raised concerns since the implication of such proposal only through a vote in parliament. Implementation of such a proposal only through a vote in the parliament where the union government is in majority without the consent of the state would have an adverse impact upon federalism. You see, so that's basically the point that we are trying to understand. Now, in relation to this, the question that is going to be answered by the high powered committee most importantly is going to be this question. Okay? If the high powered committee gives the answer that the state ratification is not needed, then the parliament, on the basis of the high powered committee report, will introduce a constitution amendment act under Article 368 of the constitution, which will not require the amendments to be ratified by 50% of the state legislatures, and introduce provisions within the constitution which deal with one nation one election, right? But certainly these provisions, as you can see, for example, the point over here will not stop. Let's say if Article 368 is amended to introduce one nation one election, then such an amendment act is subject to judicial review on the ground of the basic structure doctrine. I hope that you are able to make sense of this statement entirely. Okay, this is the first part, and in addition to this, what we see basically is that federalism is a basic feature of the constitution. So on the grounds of that, it is subject to judicial review. Therefore, it was written in the previous editorial that the final authority to decide the future of one nation one election on the concept of federalism shall be the Supreme Court. ठीक है, तो ये आगे चीजें डेवलप होंगी. Now the parliament doesn't have any more sessions for this Lok Sabha, but as soon as a new session of the Lok Sabha comes in action, you will possibly start seeing all of these activities happening, unfolding, right? So okay, do we understand this? Okay, so these are the parts that you're going to take a look at while we take a look at one nation one election. हमने सब कुछ कवर कर लिया, इसके constitutional background कवर कर लिए, इसके political aspects कवर कर लिए. We have taken a look at the details of the committee, and we've taken a look at the implications that this particular activity is going to have on federalism specifically and how, right? So currently one nation one election is a proposal which has been initiated by the government of India. The law ministry has instituted a non-statutory body known as a high level committee, which is headed by the Prime Minister of the former President of India, Mr. Ramnath Kovind. And this committee has been given several agendas, but the most important agenda which has been given to this committee is to understand whether the law which is to be made for doing one nation, one elections is supposed to be a constitution amendment law which requires the ratification of the 50% of the states or not. As of course, the suspicion is that the one nation, one election, for two reasons, is going to be some kind of a encroachment by the union parliament upon the states' powers. As stated in the SR Bommai case, the states are a legislative entity or into themselves. They are not a kind of a extension of the parliament. They have a independent existence and independent identity of their own. And first of all, the question is constitutional and legal, which means that if one nation, one elections has to be implemented, it is going to disturb the cycles of the state legislative assemblies as how they are running. And that kind of interference by the union parliament, which we a kind of a disruption in the way that the state activities are happening, which may be considered a violation of the concept of federalism, right? And second is of course a political question, which means that once the state elections and union elections happen in the same order, the walls which are kept in the mind of a person, that I want this for my locality, this for my state, this for the country, etc., etc., these walls could be blurred by altering the mood of the nation in a certain way, right? So a big impact can be created once, and that can create a kind of a blast or an explosion which would impact the consciousness of the nation, and then that would be reflected in a kind of a, what you can say, a vote giving activity. And that basically again would have very major centralizing tendencies and anti-federal activities, by which the state's politics and the state's powers, the regional political parties, may be in a way subverted, and the political parties at the central level may be the ones who are taking the entire control of the situation, right? So that's basically the whole idea about one nation, one election. The principle which is standing at the center of this entire exercise is the concept of federalism. ठीक है, अगर इससे कोई क्वेश्चन आएगा, which I feel is a important topic, that is why this is one of the topics that I've taken, because this is entirely 2023. ये सारी चीज़ें 2023 में हुई हैं, और ये अभी तक मतलब करंट अपडेट का ही पार्ट है सारा, पॉलिटी से रिलेटेड डायरेक्टली. तो वी आर गोइंग टू बी श्योर दैट वी take a look at any of these updates clearly. Okay class? ठीक है. Okay, just you can take a look at this part also. There's a law commission report in 2018. This law commission report is slightly important. This was the last law commission which was instituted. That report also gave a bit of a observation upon the one nation, one election. Okay, this was also known as the Justice B.S. Chauhan Commission. Okay, so this was the last law commission which was instituted. Okay, so एक बार इसको देख लीजिएगा. Just take a look at this part slightly to get a little bit of a more update upon the current affairs on this point. Okay, just take a look at this once, please. right? So this is another thing that you can take a look at with regard to the Law Commission report upon the one nation, one election to form the basis of a prelims question answer over here. Okay, so this is one thing that we are just briefly mentioning. And while I'm doing this, let me just with you revise the static portion on this part also. So for example, if I take a look at Article 368 of the Constitution, just let me take a bit of a revision with you on Article 368 of the Constitution. Okay, Article 368 of the Constitution, as you know, talks about amendments to the Constitution. Okay, Article 368 of the Constitution talks about amendments of the Constitution, and it is under Article 368 of the Constitution that you have three clauses. There are three clauses which are given under Article 368. Okay, so just a quick revision of how the Article 368 is constructed, just as kind of a simple revision of these activities. Under Article 368 of the Constitution, the first clause is what is concerned with what is known as a constituent power. Okay, the Parliament's power to amend the Constitution is known as the constituent power. The second clause, there is a concept which says procedure for amending the Constitution, and this procedure, of course, is divided into two elements. This procedure is divided into two elements. One is a part of the Constitution which is flexible to be amended, and the other part of the Constitution is rigid to be amended. This requires, let's say, the procedure for amending the Constitution with the flexible thing. This requires a special majority from the Parliament, right? And it concerns with provisions not dealing with the powers of the states. Okay. And on the other hand, the rigid provisions of the Constitution require a special majority. Let's say, for example, if I call special majority X, the rigid provisions require special majority plus ratification by state legislatures, which is the 50% state legislature ratification rule. And B, they are covering the provisions that describe the powers of the states. Right, so this is basically a very simple anatomical summary of Article 368 of the Constitution. Okay, so if you take a look at, let's say, for example, just focusing upon this part, procedure for amending the constitution. Now, you know, for example, that the concept, the idea of amendment of the constitution is divided into whether we have a flexible constitution or a rigid constitution. That's the basic governing idea which calls upon a constitutional amendment procedure, flexible constitution or a rigid constitution. The flexibility of the Indian constitution we have derived from the UK constitution, right? On the other hand, the rigidity of the Indian constitution we have derived from the US constitution. And it has to be remembered that the, what you can say, the standard by which we analyze the rigidity or the flexibility of the constitution is always federalism. Okay, so the standard by which we realize the rigidity or the flexibility of the constitution is federalism. Federalism is a standard by which we realize the rigidity and flexibility of the constitution, right? Now flexibility का मतलब, but the idea is, देखिए simple सा idea बहुत सरल है इसको समझने के लिए. If you take a look at, for example, the US constitution, right? In the United States of America constitution, what you have basically is the fact that let's say 1, 2, 3, 4, 5, 6, these 6 states are coming together and creating the union, right? So union is a kind of a coming together of these states. Okay, and therefore the way the contract, let's say for example, it is known as a contract or a compact sometimes. The contract or the compact which has been signed by these states to form a union is known as the Constitution of the USA, right? So all these elementary, what you can say, constituent parts within the USA are the components which have come together to create the union, and this kind of a coming together is what is known as a Constitution of the USA, right? So it's an agreement which has been signed by these parties which form the constitution, right? And they have created a union. Now let's say for example, in instances when, let's say for example, these states come together, right, and they want to curtail the powers of these states, they want to curtail the powers of these states, right? They want to impose something upon these states. The rights of these states are secured in the constitution. At the time of the commencement of the constitution, the rights of each of the states were secured in the constitution. That is the condition upon which in the first place these states became a part of the USA, that my rights have to be secured. So for example, let's say take a look at this, that under the 5th and the 6th schedule, states like Assam, Manipur, Nagaland, they became part of India under the condition that their tribal interests are going to be secured, right? If other states of India and the Union of India promise that their tribal interests, etc., are going to be secured, then only they will become a part of the Union of India. So imagine, for example, if states become part of the United States of America under certain promises made to them by the Constitution, as these promises are kept over here. Now, if imagine, for example, if these people come together and they form the majority political party at the Union, and they amend the constitution so as to dilute their promises and in a way exert influence upon them. You see, this is going to be, of course, a violation of the principle of federalism. Right? This is going to be a violation of the principle of federalism, and therefore to secure, what you can say, the federal character of the American Constitution has been made extremely rigid, right? The procedure for amending the American Constitution is extremely rigid. I will not go into the procedure at the current juncture because it is not relevant for our prelims examination, but procedure for amending the entire Constitution is extremely difficult to achieve. Why? Because even if, for example, a few states have a majority and they come together as a group and they form the union, and when they are, let's say, for example, forming the union, by the formation of the union, they should not be able to take away certain essential promises which have been given to each state, despite the fact that these states are not able to politically become strong at the union. Okay, so to dilute their promises, to in a way manipulate their promises, the union can amend the constitution, right? The union legislature, the US Congress, can amend the constitution and change these promises. But to secure the federal nature of the US polity, the US constitution provides a very strict procedure by which the amendments can be made, if at all. And that is what basically we have drawn from the US constitution itself. And that's the point I'm trying to make. That when we talk about the rigidity of the amending procedure, the rigidity of the amending procedure is based upon the fact that the Indian constitution also is a kind of a union of states. We are a federal constitution by our own admission, in which certain states have been given their own particular promises. Okay, for example, scheduled areas are given, subjects are given under the 7th schedule to the state list, upon which only the states can exclusively make laws. Those laws cannot be made by the union, right? So on this categorization, on this context, what we take a look at is that if the union is going to change those promises, put subjects in the state list in the union list by amending the constitution all by itself, it is going to be a violation of the principle of federalism. But at the same point, it is also to be understood that the parliament is the will of the people, and the parliament carries the constituent powers, as I am mentioning over here. And therefore, by the wielding of the constituent power and being the will of the people, it is necessary that the parliament should be able to make the right kind of modifications to the constitution according to the day and age that we are in, right? So in that context, we had to strike a balance between flexibility and rigidity. And therefore, what we did was that we create a flexible procedure, meaning a special majority from the procedure under Article 368, Clause 2. If we have a special majority in the parliament alone can amend the constitution, but for those matters which are not dealing with the powers of the state. So, for example, parliament can amend the constitution under Article 368, Clause 2, but the Article 368, Clause 2 cannot be used in such a way that it can amend the constitution by which Schedule 7 has list 2, a state subject is introduced into a central subject. It can't do that. So any kind of an amendment which is made with regarding a power of a state has to be ratified along with the parliamentary special majority. It has to be ratified by the 50% of the state legislatures, right? So this is what basically we take yesterday also, while we were dealing with this concept. Yesterday, while we were dealing with this concept, we were taking a look at the Cooperative Societies Act. And in that only we have seen how, for example, in the Rajendra N. Shah, the idea was that Article 368 has not been followed properly because the procedure is not inclusive of ratification of the states, right? And similarly, we had seen in the Quixote Holohan case also that paragraph 7 was struck down because paragraph 7 was talking about the rights which were given to the judiciary, which is the, what you can say, mediator between the state and the center. So similarly, any kind of a amendment which is made to the constitution which is touching the powers of the state has to follow a complicated procedure which includes a special majority from the parliament first of all, plus a ratification by the 50% of the state legislatures. When these two things come together and combine, then you have an activity within which you can amend the constitution. But also it lays out before you the distinction between the flexibility and the rigidity of the Indian constitution, the balance that has been struck by the Indian constitution, incorporating both flexibility and rigidity, right? That kind of a balance is what is the virtue of the Indian constitution with regard to its amending procedure. Clear? So you know for a fact. The question is now again, if you're going to create provisions in the constitution which talk about one nation, one election, if you're going to create provisions in the constitution which talk about one nation, one election, then the question that we're basically asking is, how are the amendments to the constitution supposed to be made? Is it supposed to be only a special majority of the parliament, or is it supposed to be ratification by the state legislatures as well? And of course, any kind of an amendment which is made incorporating one nation, one election will then be subject to judicial review, because it is a set law by the Keshwananda Bharati case that the laws made by the parliament which are amending the constitution shall be subject to judicial review to get the answer to the question, do these amendments violate the basic structure of the constitution? And incidentally, federalism happens to be a basic feature of the constitution. So on that basis, the final analysis of the one nation, one election shall actually be in the hands of the judiciary. That is going to be one of the most important things coming up in the late parts of the 2024 year. So you'll have to keep your eyes open for that. But for now, I think a prelims question on these matters can be covered from the literature that we are covering inside the classroom. Money bill can be rejected or approved but cannot be returned by parliament. It means suspensive veto is barred. Rejected means what? Is it absolute or pocket veto that can be used on money bill? Yes, you're right. Absolutely correct. If you take a look at, for example, a money bill, very simply, if I have to give you a little bit of an introduction to a money bill can be understood by these articles of the constitution. Just a little bit of a revision on the part of money bill. Article 109 and Article 110. So what I'm saying is that if I have to give you a little bit of a description about a money bill, then we have Article 109 and 110, which are the central articles for a money bill. Article 109 talks about the procedure for passing a money bill, and Article 110 talks about the definition of a money bill. Right? Now, when we take a look at, for example, the procedure of money bill, the following points can be noted about it. Just as a multiple choice question format, I'm presenting it before you. Okay. For example, the first thing that you understand about a procedure for passing a money bill is that it can be introduced by the recommendation of the president. But the powers of the president in this part are not discretionary powers, right? So unlike the veto powers of the president, which are discretionary powers, unlike the veto powers of the president, which are not discretionary powers, which are discretionary powers, these are not discretionary powers. These are supposed to be done by the president at the aid and advice of the council of ministers, right? So the president over here is really nominally giving his powers. Okay. Second, it can be introduced only in the Lok Sabha. Okay, this is another part which you have to be a little bit aware about. It can be introduced only in the Lok Sabha. A money bill can be introduced only in the Lok Sabha. Okay. Third part, then thereafter it is going to be it can be transmitted to the Rajya Sabha but does not need to be voted by it. Rajya Sabha doesn't vote on the money bill in terms of passing or failing the money bill, right? Meaning Rajya Sabha does not have any powers to fail a money bill is what I mean. Okay, you can still vote for the money bill in the form of making it a resolution for recommendations, but the Rajya Sabha does not have the powers to pass or fail a money bill. Instead, Rajya Sabha can only make recommendations. Okay, this is the fourth part. Fifth part, Rajya Sabha's recommendations are not binding upon the Lok Sabha. Okay, this is the fifth part. Presenting it exactly in a multiple choice question format. Rajya Sabha's recommendations are not binding upon the Lok Sabha. Point number 6 after this is Rajya Sabha has to return the bill with recommendations within 14 days. If the bill is not returned within 14 days, Rajya Sabha has to return the bill with the recommendations within 14 days. If the bill is not returned within 14 days, the bill shall be considered to be passed in the form it is passed by the Lok Sabha. And then the bill is presented to the President for his assent. The bill is presented to the President for his assent. Right? This is the part. Just take a look at this and then I'll deal in detail the part of the presidential assent, as you can call it. Right? Just take a note of this. Is a little bit of a, what you can say, simplification of the multiple choice questions that can be asked with regard to a money bill. One more point which I can add over here is that a money bill, point number 8 I can add over here, joint sitting cannot be held for a money bill. A joint sitting cannot be held for a money bill. Okay, now just let me give you the position of the assent of the president. ठीक है, तो मैं पूरा assent का ना आपको एक डायग्राम बना देता हूँ जिससे कि आपको एक क्लैरिटी रहे कि assent of the president को हम किस तरह से पढ़ सकते हैं. Give a very simple clear in understanding of the assent of the president. It is basically article 111 of the constitution that talks about the assent of the president. Okay, it is article 111 of the constitution that talks about the assent of the president. Okay, now generally assent has three characteristics to it. The concept of assent has three characteristics to it. The first is granting assent, that when a bill is presented before the president, he grants assent, right? And then the next characteristic of assent is what is written in the constitution itself under article 111 is withholding assent, right? Or the next kind of what you can say characteristic of assent is returning the bill to the parliament for reconsideration. Okay, so if a bill is introduced to the president can do the following things with the bill. Now, by the way, this is all, these powers of the president are not powers of the president which are used by the president under the aid and advice of the council of ministers. These are what are known as the discretionary powers of the president. Okay, the logic that goes behind these things is this, that the parliament, if you call it, let's say for example, if you take a look at the subject of parliament, the parliament is composed of three parts. Three parts compose the parliament. You have the president, who is a part of the parliament, then you have the Lok Sabha, and then you have the Rajya Sabha. President is a part of the parliament, Lok Sabha is a part of the parliament, and the Rajya Sabha is a part of the parliament. So the concept of assent of the president is the what you can call legislative function of a parliament, of the president, not the executive function. You see the point? The idea of what you can call assent is the legislative function of the president, and since president is a part of the parliament and also a part of the executive, most of the functions that are performed by the president as the head of the executive are what are called functions which are performed by the president with the aid and advice of the council of ministers. Okay, again I'm kind of re-emphasizing for you that article 111 gives discretionary powers to the president. Why? Because under article 111 the president is not acting as the head of the executive branch. He's acting as a part of the legislative branch. So these functions which are given under article 111 to the president are legislative functions of the president, right? Because the nature of president is to be included in the parliament also. And therefore, for example, if you take a look at granting assent, which means a bill, if it comes to the president and if the bill is, let's say, presented before the president, if a bill is presented before the president and the president grants assent to that bill, the bill is determined to be an act. And then the last thing that it happens is that it is notified. And then next thing that happens is that it is enforced. Okay, so this is basically what happens with a bill which is passed by the president. A bill which is passed by the president, which is given assent by the president, becomes an act, After that it is notified, and after that it is enforced. Okay. If a withholding assent, okay, just let me come to withholding a little while later on. When we talk about withholding or returning the bill to the parliament for reconsideration, means that the president can return the bill to the parliament for reconsideration. After reconsideration, after reconsideration, if the parliament returns the bill, then it cannot either be returned back or be withheld. Full stop. It must necessarily be given assent. ये वाला एक पार्ट इसको थोड़ा सा पढ़ के समझने की कोशिश करिए. Just take a look at this. When we are saying, for example, a bill is granted assent, okay, then it becomes an act, and then it is notified, and then it is enforced. If it is returned for the recommendation or the reconsideration of the parliament, if after reconsideration the parliament returns the bill to the president, अगर मतलब मान के चलिए कि प्रेसिडेंट ने एक बार पार्लियामेंट को रिटर्न कर दिया बिल, if the bill has been returned by the parliament to the if the bill has been returned by the president to the parliament, and the parliament has reconsidered the bill, and the parliament doesn't feel that there is anything wrong with the bill, okay, if the parliament has reconsidered the bill and according to the parliament there is nothing wrong with the bill is absolutely fine, it can give the bill back to the president, and once the president receives the bill back from the parliament after the parliament has reconsidered the bill, then the president can neither withhold the bill nor can it again return the bill. That is a point that has to be understood carefully. Okay, let me again elaborate this a little bit more schematically. If, for example, let's say we have the parliament, okay, and if the parliament has given a passage to a bill and the bill has been presented to the president, if we have a parliament, if the parliament gives passage to a bill and the bill has to be presented to a president, right, the president, in the case of a what you can call instance, return the bill for reconsideration. The president can return the bill for reconsideration, right? But let's say, for example, after the bill has been reconsidered by the parliament and it is again sent back to the president, okay, after the bill has been returned by the parliament and sent back to the president, okay, Now when the president gets the bill, he has only one option. Okay, the president cannot withhold the bill, nor return the bill again. Okay, so both of these activities are not allowed for the president. The president cannot withhold the bill, nor can the president return the bill. It is necessary that the president must pass this bill. Okay, just take a look at this part. This is very simply a kind of a brief format which can come in the multiple choice questions of this kind. Okay, please take a look at this properly, please, class. Okay, you can understand this in the overall functions as I have laid out over here. So for example, this is, let's say, the first time the bill has been given. Okay, and this is again the first time the bill has been returned. Okay, now this becomes the second time the bill has been given, and the second time the bill must pass. The second time bill can neither take this nor this. Okay, so basically what it does in cases in which the president does not agree with the government or the parliament, then the president, in a way to cast his vote upon the bill, this is what is known as a suspensive veto. Suspensive veto. Okay, so the fact that suspensive veto allows some time, or the president, what he can do is president can hold the bill for some time. Let's say, for example, let's imagine Citizenship Amendment Act. Okay, now let's say Citizenship Amendment Act has been passed just before the elections, and a lot of, what you can say, activities are to be done in the Citizenship Amendment Act by the, what you can call, consideration of what are known as how, let's say, in 2-3 months a lot of immigrants have to be captured and deported under the Citizenship Act, which has been enacted by the Parliament, Citizenship Amendment Act, and that activity has to happen 2-3 months before elections, let's say, to create an impact. Now if the bill is going to the president, and if the president returns the bill for the reconsideration of Parliament, the Parliament again has to convene and by a simple majority give the bill back to the president. But this is at least 10 to 15 days of lapse. Okay, so in the case of a suspensive veto, as we understand it, it is possible for the president to create a kind of a cushion, a kind of a gap, or kind of buy the time against a bill which he feels is unconstitutional. You see the point? That is the highest power that the president can use in these kinds of bill, right? So he can return the bill for reconsideration, and by that process of reconsideration there may be a gap within which the parliament may not be able to enforce its will, and therefore what according to the president is unconstitutionally done by the parliament, that may not be completely correct. Okay, but at the same time, when we take a look at, for example, the fact that once the parliament has sent the bill back to the president after reconsideration, the president can neither withhold the bill nor return the bill again. He can't keep on looping suspensive veto. Then he has to necessarily pass the bill. Okay, that's basically what we want to understand about what is known as the suspensive veto. So this is the description that I have written over here. Returning the bill to the parliament for reconsideration. After reconsideration, if parliament re-returns the bill, then it cannot either be returned back or be withheld. Okay, and if we come to the last part of what we are trying to understand over here, when we try to understand the nature of withholding assent, then in the what you can say context in chapter of withholding assent, in the context in chapter of withholding assent, we see that the president can keep the bill and take no decision on it. By this, the president can frustrate the application of the bill. So if, for example, if the president feels that a particular law is not according to him constitutionally correct, if in the opinion of the president a particular law is not constitutionally correct, right? Again, I'll repeat, if in the opinion of the president a particular law is not constitutionally correct, then the president can keep the bill and to take no decision on it. By this, the president can frustrate the application of the bill. That, for example, a citizenship act which the president feels is unconstitutional can be withheld by the president. Now, one of the important things about withholding assent is that, of course, you are not letting a bill carry out an activity. It is not becoming an act and it is not being enforced. And also, what is very important to understand with a withholding of a bill is that the bill can be withheld indefinitely. Okay, so the bill can be withheld indefinitely, meaning there is no time limit till which the president can withhold a bill. There is no time limit within which the president has to withhold a bill. The president can withhold a bill indefinitely. Okay, which means it can go on ad infinitum without any kind of a time boundation. So that is basically what we understand by withholding the bill, and that is how the entire chapter of assent can be constructed. Okay, now the simple question that we can ask in addition, just to answer a set of questions, is that what are the ways in which different bills are treated by the president. So for example, let's say I write the kinds of bill which are over here. Ordinary bill, which are given under article 107. Okay, now if we talk about ordinary bills, let's say if I put a little bit of a structuring over here. For an ordinary bill, let's say if I write like A, B and C. For an ordinary bill, A, B and C. Basically what I mean to say is, for an ordinary bill, you can have A or B or C. For an ordinary bill, you can have A, B or C. Okay, for an ordinary bill. For a, let's say, Money bill, that's the important question that you're asking, right? I'm just trying to put all of this in context so you have the entire chapter also along with it with your own consideration. For an ordinary bill, you can grant assent or you can withhold assent, but you can't return the bill for reconsideration. Okay, so I hope you're taking a understanding of this part, class. For an ordinary bill, you can grant an assent, you can withhold an assent, and you can also return the assent. The president has the power. But for a money bill, you can either grant or assent or withhold an assent, but you cannot send the bill back to the president for reconsideration. Okay, and then let's say, for example, if you take a look at the next category over here is financial bills, type A and type B. Financial bill type A and type B, if you take a look at this, then you can do A, B, C, all of them. For a financial bill which is mentioned, for example, under article, money bill is mentioned under article 109 and 110. Money bill is mentioned under article 109 and 110, and financial bill type A and type B, they are mentioned under article 117 clause 1 and 117 clause 3. Okay, so financial bill type A is mentioned under article 117 clause 1 and financial bill type B is mentioned under article 117 clause 3. Now for a financial bill, you can do all the three activities. Okay, for a financial bill, you can do all the three activities. And the last category of bill that we generally take an understanding of is known as a constitution amendment bill, right, which is made under article 368 of the constitution. You have a constitution amendment bill which talks about that the only thing that can happen in a constitution amendment bill is A, no B or C. Okay, class, with this reference, I hope that you can follow the point that I'm trying to make very clearly and categorically over here. Okay, so this is the entire, what you can say, chart of what happens to a bill after it has been passed by the parliament and it has been sent to the president for his assent. In this way, what I'm doing is I'm presenting before you an anatomy of article 111 of the constitution. Okay, अगर आपको ये चार्ट समझ में आ गया ढंग से, if you have noted it down properly, आपके प्रीलिम्स के क्वेश्चन सारे इससे निकल जाएंगे. For your reference, again, let me give the understanding. This is what is known as the concept of a pocket veto, and this is known as the concept of a suspensive veto. ठीक है, clear? Similarly, for example, if I create a similar kind of a little bit of a understanding on this question about what is known as a joint sitting. Okay, so if I give a little bit of a brief about a joint sitting of the parliament, which is a kind of a concept related to it, You find the concept of joint sitting under Article 108 of the Constitution. Joint sitting, right? Now, if I write certain points which are important about joint sitting, okay, one can be that if a bill is rejected by one house but passed by other, then the president may, not shall, okay, the president may, then the president may call for a joint sitting of the two houses. Okay. Second, in a joint sitting, the bill in dispute is referred. In a joint sitting, the bill in dispute is referred for deliberation and vote of the parliament. The total strength of both the houses is combined together into one house. For example, let's say if individually Lok Sabha stands at 100, let's imagine for an example, and the Rajya Sabha stands at 50. Okay, if individually Lok Sabha stands at 100 and Rajya Sabha stands at 50, then in the joint session, the total strength of the house will stand at 150. Okay, and then to pass a bill in the joint sitting, majority, which means 50% plus 1, majority 50% plus 1 of the members of 150 shall be taken. Okay, if you can get this detail out, any kind of a question on the joint sitting shall be answered properly over here. And the last part about joint sitting is that no joint sitting is permissible for a money bill or a constitution amendment bill. Money bill is given under Article 109,110 and Constitution Amendment Bill is given under Article 368, which means joint sitting is only applicable on ordinary bills and financial bills. Okay, so this is an entire bureau of what is known as joint sitting. ठीक है, अगर कोई joint sitting से क्वेश्चन आएगा स्टैटिक पोर्शन से तो इसी पूरे स्ट्रक्चरिंग से आ जाएगा. Okay, so for example, if a question comes like this was the last year UPSC Prelims question, quite a dicey question actually. Last year UPSC had asked a question which was a little tricky overall. It was a question on joint sitting itself. I'll just pull out a paper for you. Okay. Now, just in addition to this, for example, if I can just go out on a limb and cover something which is remaining, which is in remainder of it. If, for example, we have to take a little bit of a reference of what is the distinction between a money bill, a financial bill, and a finance bill. Okay, this is again in reference to a question that was asked last year, which became a huge issue for us to take a look at. Okay, what is the difference between these three categories? Okay, so let's say, for example, I start writing the differences. Money bill is defined under Article 110. Definition of money bill is given under Article 110, and the procedure for passing a money bill is given under Article 109. Okay, for financial bill, 117 clause 1 is type A and 117 clause 3 is type B. Right, and the finance bill, by the way, is itself a money bill, as we have discussed yesterday. कल हम लोगों ने डिस्कशन किया था कि जो फाइनेंस बिल है वो मनी बिल ही होता है, राइट. इट इज प्रेजेंटेड ड्यूरिंग व्हाट इज नोन एज द एनुअल फाइनेंशियल स्टेटमेंट. मैंने आपको कल बताया था कि व्हाट इज फॉर एग्जांपल ए फाइनेंस बिल, और फाइनेंस बिल के साथ साथ आप एक और बिल लिख सकते हो यहाँ पर, अप्रोप्रिएशन बिल. दोनों में सिर्फ एक ही डिफरेंस है, दैट अप्रोप्रिएशन बिल इज यूज्ड टू टेक द मनी out of the consolidated fund of India, and finance bill is used to take the money inside the consolidated fund of India. Okay, you have a money bill, you have a financial bill, and you have the finance and appropriation bill, which are following the same pattern as a money bill. Okay, now if you take a look at the procedure of a money bill, this I've already given to you previously. तो ये वाला मैंने आपको पहले लिखवा दिया ना, the procedure of how you can make a money bill. तो यहाँ पर आप इसको कर सकते हो align, right? We've already taken a look at the procedure of passing a money bill. ठीक है. In addition to this, right exactly here, if I want to take a little bit of a cut to ask the question, the procedure or let's say the definition and procedure of financial bills. Just keep your eyes open over here, please. If I take a look at this part as a definition and procedures of financial bill, and I write a kind of a multiple choice question format, point by point idea, then what do you get as a point? Point number one that you get is with the definition and procedure of a financial bill. The first point that you get in this entire idea is that financial bills can be divided into two categories. You have financial bill type A and financial bill type B. That is what everyone basically understands. Financial bill type A, financial bill type B. Okay. Now if I have to take for example, definition of financial bill type A is given under article 117 clause 1. Definition of financial bill type B is given under article 117 clause 3. Okay, so definition of financial bill type A is given under article 117 clause 1 and of type 3 is given under 117 clause 3. Right, that's the first point. Okay, second point, if you take a look at about financial bill type A is that by this bill money is moved into the consolidated fund of India. By this bill money is moved into the consolidated fund of India, right? And it deals with the items mentioned under article 110 clause 1 A to F. Okay, so just a little bit of a focus upon this. Yesterday I had given you the understanding of what you can call consolidated fund of India is. Now when we talk about financial bill type A, which is given under article 117 clause 1, it deals with all those items which are mentioned for the money bill. Okay, the only difference actually is it does not deal only with those items. Okay, so definition and procedure of financial bills is financial bill type A and type B under article 117 clause 1 and 117 clause 3. Financial bill type A, it says by this bill money is moved into the consolidated fund of India and it deals with items mentioned under article 110 clause 1 A to F, but it does not deal only with those items. So the distinction actually, if it, for example, very simply, this is I think something which maybe have been covered under your what you can say prelims classes. If you take a look at the question on the difference between a money bill and a financial bill in terms of its definition, money bills deals with the imposition, abolition, reduction or cancellation of any tax. These are items which are given under article 110 clause 1 A to F, right? So a money bill deals with only these items. Okay, a money bill deals only with these items. The items which are given under Article 110, Clause 1, A to F. A money bill deals only with these items, right? But a financial bill deals with these items, but not only with these items. A financial bill type A, which it is called over here. So that's the distinction between a money bill and a financial bill, right? So for this, you'll have to go back and take a little bit of a reference to the classes that you have taken in the foundational batches to understand the difference between the money bill and the financial bill. Okay, so financial bill type A, type B, we are creating a distinction of. Okay, can only be introduced and moved with the recommendation of the president. If it is creating a new tax or increasing the tax rate. Okay, ठीक है, जस्ट इसका नोट लिख लीजिए, ये प्रीलिम्स के लिए आपके बिल्कुल सिंपल भाषा में मैं आपको थोड़ा कॉम्प्लिकेटेड जो टेक्निकल टॉपिक है थोड़ा सा आपको पास ऑन कर रहा हूँ. ठीक है, टेक अ लुक एट पॉइंट नंबर 4 as it is given over here. Please take a look at it properly. Point number 4, क्या कहना चाह रहा पॉइंट नंबर 4? Just take a look at it. When we talk about a financial bill type A, please focus upon this. It's a very technically challenging point. When we talk about a financial bill type A, first of all, let us understand about it. Financial bill type A talks about money that is moving into the consolidated fund of India. So naturally it talks about imposition of tax, right? So this is the, let's say, the people of India, their money is moving into the consolidated fund of India. So any kind of a bill, as I have pointed out to you yesterday, any kind of a bill which is to be presented for imposing a tax upon the people of India, but not only for imposing a tax upon people of India. Okay, if it is only, then it is a money bill, but if it is not only, then it is a financial. So if a tax is to be imposed upon the people of India, a bill which has to be presented before the parliament, this bill is known as a financial bill, right? ठीक है? Are we clear? A bill which is introduced into the parliament for the imposition of a tax, but not only for the imposition of a tax, is known as a financial bill type A. And if you take for example, the way that the financial bill type A moves is that it can be divided into two categories. Let's take a look at this. If the bill is let's take a look at this, can only be introduced at the recommendation of the president, okay, and two, can only be introduced in the Lok Sabha. Please take a sense of this class. Okay, try to understand. It is slightly technically challenging, but I'm trying to make it as easy as possible. A bill which has been imposed for the imposition of taxes is what is known as a financial bill type A. Okay, but this bill is not a, but the way that this bill is distinct from a money bill is because it is not only for imposition of taxes. The term which is different in Article 110 and Article 117 is only. Otherwise, Article 110 and Article 117 are exactly similar to each other, right? The only thing that is missing or different is only. ठीक, तो पहली बात तो ये है. अब लेके चलिए थोड़ा सा इसको आगे. If we take a little further, try to please be perceptively understood about it. When, for example, a money bill has been passed by a financial bill, type A, once passed by Lok Sabha, must be transmitted to the Rajya Sabha. Okay, a financial bill type A, once passed by the Lok Sabha, must be transmitted to the Rajya Sabha. Okay, but यहाँ पर transmission में एक चीज है. If the financial bill type A is creating or increasing a tax, then president's recommendation for transmission is necessary and if it is, decreasing or not necessary. ठीक है? Once the bill moves from the Lok Sabha to the Rajya Sabha, the bill can either be passed by the Rajya Sabha or failed by the Rajya Sabha. Rajya Sabha has a power to vote upon financial bills. ठीक है, थोड़ा सा इसको लिख लीजिए, आपके प्रीलिम्स में बहुत काम आएगा. एक बार देखिए, थोड़ा टेक्निकल टॉपिक है, इट इज़ वेरी सिवियरली टेक्निकल, आई एम नॉट गोइंग टू डिनाई दैट, बट इसको थोड़ा सा लिख के अगर आप चार्ट बना के अपने पास रखेंगे एंड ट्राई टू अंडरस्टैंड व्हाट आई हैव रिटन ओवर हियर, बिकॉज़ आई हैव ट्राइड टू सिंप्लीफाई इट एज मच एज पॉसिबल, then you would be able to understand this part a little more clearly and better. Okay, we are talking about financial bill type A and I am trying to introduce the dynamics of it. Financial bill type A is one which is talking about imposition of taxes, and since every bill which is imposing taxes has to be produced before the parliament as a bill, it is produced before the parliament by the government of India. First of all, it can only be introduced at the recommendation of the president. The financial bill type A can only be introduced at the recommendation of the president. And second of all, financial bill type A can only be introduced in the Lok Sabha. Clear? A financial bill type A can only be introduced in the Lok Sabha. Now, when the bill has moved from the Lok Sabha to the Rajya Sabha, or let's say when the bill has been passed by the Lok Sabha and it is going to go to the Rajya Sabha, if the financial bill type A is creating or increasing a tax, then the president's recommendation before transmission is necessary. I will repeat again. If the financial bill type A, which is imposing a tax, or which is, let's say for example, talking about a tax, okay, if it is increasing a tax or creating a new tax, then it cannot move from the Lok Sabha to the Rajya Sabha without the permission of the president, without the recommendation of the president. Okay, but if a financial bill type A is decreasing or abolishing a tax, if a financial bill type A is decreasing or abolishing a tax, then president's recommendation at the time of moving into the Rajya Sabha is not necessary. You see the point? So president's recommendation is necessary for a financial bill type A and type B to be introduced before the parliament. But the way that the financial bill type A will move to the Rajya Sabha from the Lok Sabha will depend if the financial bill type A is creating a tax or increasing the tax rate. It can only move from the Lok Sabha to the Rajya Sabha via the recommendation of the president. But if the financial bill type A is reducing or abolishing a tax, then it can be moved from the Lok Sabha to the Rajya Sabha without the recommendation of the president. And the power of the Rajya Sabha with regard to the financial bill is accurate, which means that the Rajya Sabha cannot be bypassed in the cases of financial bill, either type A or type B. A Rajya Sabha cannot be bypassed in the case of a financial bill. Rajya Sabha can either pass the financial bill or fail the financial bill, it has the power to vote on the financial bill. Okay. Once the financial bill has been passed by the Rajya Sabha, the financial bill moves to the President of India for assent. And the President of India, as we have seen, has all the options for assent. He can grant assent, he can do a what you can call a pocket veto, or he can do a what you can call a suspensive veto, right? So this is the entire what you can call structuring of a financial bill type A. Again, it is necessary for you to understand how this entire thing works, because we are going to take a look at financial bill type A and type B as two categories of financial bill. It is arguably the most technically challenging part of the constitution, but it is not undecipherable. We are trying to do as much as we can to make a case for understanding it properly. A. The way that the financial bill type A has been given, but the place at which the financial bill type A has been given is with article ठीक है। इस चार्ट को अगर आप पकड़ लेंगे और थोड़ा इसको याद करने की कोशिश करेंगे तो आपके फाइनेंशियल बिल टाइप ए के सारे क्वेश्चन इससे निकल जाएंगे। ठीक है, तो यू सी व्हाट आई कैन in a way understand this by saying that a financial bill type A can only be introduced and moved with the recommendation of the president if it is creating a new tax or increasing a new tax rate. But if it is decreasing a tax rate or abolishing a tax rate, then it needs to be introduced by the president, but need not be moved by the president, moved from the one house of the parliament to another house of the parliament. It need not be moved by the president in that sense. Okay. And of course it goes without saying that both financial bill type A and type B need to be passed by the Rajya Sabha. They cannot just bypass Rajya Sabha, both of them. Okay. Now, for example, let's say if I talk about financial bill type 2 or type B, they are given under article 117 clause 3 of the constitution. Okay. They are dealing with the expenditure from the consolidated fund of India. They are dealing with the expenditure from the consolidated fund of India. They can be introduced in either house of parliament. Okay, so just if you want to take a look at the references over here, we take a look at Article 117, Clause 3. This is a simple part which talks about financial bill type B. A bill, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India, shall not be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Okay, but here is no position. First of all, that you understand with financial bill type A is type B is that it involves expenditure from the CFI. It involves the expenditure from the Consolidated Fund of India. That's the first thing that we understand. Okay, and second thing that we understand is that there is no provision over here given which says that it has to be, it cannot be introduced in the Rajya Sabha. So for example, for financial bill type A, it is very clearly given that it has to be introduced only in the Lok Sabha. Article 117 clause 1 says that a financial bill type A cannot be introduced in the Council of States. A financial bill type A cannot be introduced in the Council of States. That is very clearly given. But on the other hand, for financial bill type A, it can be introduced. It is not clearly given that it cannot be introduced into the Lok Sabha or the Rajya Sabha. So that is why we write very simply something like this. They can be introduced in either House of Parliament. Okay. Fourth thing that we can write is they can be introduced and moved only by the recommendation of the President. They can be introduced and moved only by the recommendation of the President. Okay. They can be introduced or be moved only by the recommendation of the President. Okay. And both the houses need to pass a financial bill type B, which is also true for financial bill type A. Okay, so I can just write over here also. Both the house need to pass financial bill type A. Both the house need to pass financial bill type A and type B. Okay, so as we see, for example, the most common distinction between a financial bill type A and a financial bill type B. Okay, so for example, if you say, take a look at this, the most common what you can call distinction between a financial bill type A and type B is that in financial bill type A, you are giving the money via taxes to the Consolidated Fund of India. So the bill that you're presenting before the House, is what is known as a financial bill type A for the collection of taxes and storing it in the Consolidated Fund of India. By this, the money is moving inside the Consolidated Fund of India, right? And additionally, when we take a look at, let's say, financial bill type B, I draw the point about financial bill type B over here. In this sense, we are clearly taking a look at the fact that money is being withdrawn out of the consolidated fund of India for expenditure, है ना, पैसा यहाँ से बाहर निकल रहा है. So you see that the money is being placed inside the consolidated fund of India by collection of taxes. In financial bill type B, money is being withdrawn from the consolidated fund of India for expenditure. It is written there, from the expenditure out of the consolidated fund of India. Okay, and when we are like aligning this part categorically, and what we are seeing basically is that a consolidated fund of India से अगर आपको पैसा निकालना है और अगर आपको बिल रखना है पार्लियामेंट के सामने, तो फर्स्ट ऑफ ऑल can only be introduced at the recommendation of the president. Okay, can only be introduced at the recommendation of the president. Financial bill type A, and can be introduced in either house. Can be introduced in either house. Okay, okay, so this is the structure of financial bill type B, which is given under Article 117 Clause 3 of the Constitution. Right, so the two basic distinctions between financial bill type A and financial bill type B you can see on the face of it. The two basic distinctions that you can see in financial bill type A and type B are the fact that financial bill type A can only deal with money which is coming inside the consolidated fund of India, meaning taxes are imposed by financial bill type A under Article 117 Clause 3 of the Constitution. Okay, and with financial bill type B, as it is given under Article 117 Clause 3, money is being spent out from the consolidated fund of India. So a bill is presented to the Parliament for the expenditure from the consolidated fund of India. It is a financial bill type B. Okay, money which is presented before the Parliament for the expenditure from the consolidated fund of India, it is financial bill type B. And the second distinction between financial bill type A and B is that a financial bill type A can not be introduced in the Rajya Sabha, but it has to be passed from the Rajya Sabha. A financial bill type B can both be introduced into the Rajya Sabha and also can be passed from the Rajya Sabha. This is the characteristic difference between these 2 points. Okay, let me repeat it again. 2 major distinctions between the financial bill type A and financial bill type B is that financial bill type A deals with money which is going into the consolidated fund of India, which is imposition of taxes, and financial bill type B deals with money which are moving out of the consolidated fund of India. Okay, so this is the distinction between financial bill type A and financial bill type B: money coming in, money going out. And second distinction is financial bill type A cannot be introduced in the Lok Sabha, in the Rajya Sabha, but only in the Lok Sabha. Financial bill type B can be introduced either in the Lok Sabha or the Rajya Sabha. Financial bill type A needs to be passed by both houses, and financial bill type B also needs to be passed by both houses. Okay, and then there is a distinction between the financial bill type A and financial bill type B from the money bill. So for the understanding of this part very clearly, we have already seen the procedure which is required to pass a money bill. मनी बिल को पास करने का प्रोसीजर क्या है वो हमने पहले ऑलरेडी लिख रखा है. ठीक है, so you get a simple sense of this, right? If you take a look at, for example, the way that this can be divided, if I take a look at the bills can be divided into very simple categories. What are known as ordinary bills, okay, what are known as money bills, what are known as financial bills, which are divided into 2 subcategories, type A and type B, and what are known as constitution amendment bills. These are divided under Article 368 of the Constitution, right? These are basically the 4 kind of bills that we can take a look at, and this kind of an understanding can be developed. Now, when we talk, for example, a few other points I have already given to you, that in the annual financial statement, in what we understand and called as the annual financial statement, yesterday we took a look at the annual financial statement. This is dealing with the budget under Article 112 to Article 114. Okay, this is also what is known as the union budget, the annual financial statement, also known as the union budget. Okay, tomorrow we can take a look at the interim budget and the specifications of the interim budget properly. But a union budget which has annual financial statement has 2 bills which are, the centrally pointed bills. One is what is known as a finance bill, not a financial bill. Okay, please be very sure about this. A finance bill, and the other is what is known as an appropriation bill. Now, with finance bill, taxes are imposed upon the people of India, and with the appropriation bill, expenditures are made from the consolidated fund of India. Okay, so in fact, let me just reverse the situation a little bit. If we call this the consolidated fund of India, with the financial bill, with the finance bill, money is going in the consolidated fund of India, and with the appropriation bill, money is coming out of the consolidated fund of India, right? So this is the money going, and this is the money coming out. Money going into the consolidated fund of India and money coming out of the consolidated fund of India, right? And the connection which is made between these 2 activities is that both the financial bill and the both the finance bill and the appropriation bill are certified by the speaker as a money bill. So that is a distinction, that both of these finance bill and appropriation bills are certified by the speaker as a money bill, and thus you have to have a very clear and concise understanding of the difference between what is known as a finance bill and what is known as a financial bill. Finance bill is categorized as a money bill, okay, and therefore the procedure for passing a finance bill is same as of that of a money bill. You see the point? Finance bill is certified by the speaker as a money bill. That is what we saw yesterday about the Finance Act, not the Financial Act. Therefore, it follows the procedure which means Rajya Sabha can be totally bypassed. Okay, please take a look at the statement again. A finance bill as opposed to a financial bill is certified by the speaker as a money bill. Therefore, it follows the procedure of the money bill. Rajya Sabha can be totally bypassed. On the other hand, a financial bill, as you can see it over here, that we've discussed it very clearly, a financial bill is divided into type A and type B, but in none of the financial bills given under Article 117 of the Constitution can Rajya Sabha be totally bypassed. That is the basic distinction between a finance bill and a financial bill. And this is exactly the question that confused everybody in the last prelims paper in 2023. Okay, a financial bill as it is given under Article 117 of the Constitution is made out of what is known as these elements. A financial bill is made out of these elements, in which you have financial bill type A, financial bill type B. But in both these cases, if it is a financial bill type A or financial bill type B, in both these cases, the bill is supposed to get the vote of the Rajya Sabha. The Rajya Sabha cannot be bypassed in the cases of a financial bill. Okay, but on the other hand, if you talk about a finance bill which is passed during the budgetary proceedings, as we have seen yesterday, the Finance Act, the finance bill which is passed during the budgetary proceedings is certified by the speaker as a money bill. Therefore, it follows the procedure of a money bill, in which Rajya Sabha can be totally bypassed. And that is what we want to in a way identify very clearly for us, that the UPSC had asked a question last time as to the term financial bill की जगह finance bill लिखा हुआ था question में. This was question 37, probably the most difficult question in the UPSC paper last year, all subjects combined, was upon this part. And also, by the way, these are difficult points in the polity paper. These are the most technically, what you can say, complicated items, so it would naturally require some amount of focus to understand these things properly. Let's get to a point where we can take a look at this question here. Please take a look at question number 37. This is a question that was a totally, bouncer, googly, dusra, whatever you can call it, last year. Okay, and then of course the option is how many of the above statements are correct, not which of the above statements are correct, but how many of them are correct. Now, very clearly, it talks about finance bill, not a financial bill. The term that is used over here is finance bill, not a financial bill. And as I have explained to you yesterday, that the Finance Act 2017, one of the major problems with the Finance Act 2017 was that it was passed as a money bill, which means that the finance bill and the money bill are the same things. They are not distinct things from each other. They're not different things from each other. Okay, so that's basically what we want to in a way understand in taking this kind of a thing into account. Now please take a look at article question number 37. Read every point of question number 37 clearly and try to answer this question. Now you see the point over here again, the whole dispute over here is that if it is a financial bill, let's assume for example, if you think of it as a financial bill, this is the question. If you think of it as a financial bill rather than a finance bill, just for argument's sake, when the Lok Sabha transmits finance bill to the Rajya Sabha, it can amend or reject the bill, right? Now this is with regard to the financial bill, so then it is correct, right? Statement 1 is correct if I'm talking about financial bill. Okay, but if we're talking about finance bill, which is a kind of a money bill, then of course the statement is incorrect, because with regard to a money bill, you cannot have a decision making power given to the Rajya Sabha at all. Okay, when the Lok Sabha transmits money bill to the Rajya Sabha, it cannot amend or reject the bill, it can only make recommendations. Now this statement is correct in itself, right? So it is only talking about money bill, therefore it is correct. In the case of a disagreement between the Lok Sabha and the Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for a finance bill. Now here there's a look, take a look at this. This is a little bit of a question over here. First of all, let us just think about it, not talking about finance bill, but talking about financial bill. The question is, how do you want to read the term necessary? That's the question. मतलब आप जो ये शब्द है necessary, इसको आप कैसे पढ़ना चाहोगे? In the case of a disagreement between the Lok Sabha and the Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for finance bill. Then, acha, when you read article 108, it says that the president may have a joint sitting. It is not necessary that the president must have a joint sitting. Okay, so again this was a little bit of a doubt last year. So it is not automatically that the disagreement between two houses is referred to the joint sitting. The president may call a joint sitting or may not call a joint sitting. Okay, so the question again stuck upon the part of whether necessary means shall or may. Now if you take a look at the part over here in the Constitution, article 108, it talks about joint sitting, and in that it says the president may call a joint sitting. Then again the question was that what do we understand by the term necessary, because necessary hota hai ki it shall call a joint sitting, है ना? तो necessary is matlab not conducive in harmony with may. Okay, so that is why this question kind of was problematic at different levels, and therefore the only interpretation you could actually give to this question was that they're talking not about the financial bill but about the finance bill, which is a money bill itself. Okay, and of course the answer to that would be only two, because if it is a money bill, it cannot be what you can call passed by the Rajya Sabha, and if it is a money bill, it is certainly not going to follow under this part at all. Okay, so a joint sitting doesn't become necessary for a finance bill. It is a joint sitting doesn't become necessary for a finance bill. It is hardly necessary for even a financial bill, because it is not automatically. The president may call for a joint sitting or may not call for a joint sitting. Now if your question is, for example, is there an article mentioning finance bill? No, the articles of the Constitution do not mention a finance bill. They only mention an appropriation bill. But yesterday, for example, I told you we were taking a look at a document which was issued by the Rajya Sabha Secretariat. I will refer to that document again. It is in the rules of conduct of Parliament. It is in the rules of conduct of Parliament that the question of what you can call finance bill is stated, and I was referring to this part also yesterday, right? So this is the Rajya Sabha Secretariat document, meaning it is coming from the Parliamentary Affairs Ministry directly. It says over here that finance bill which is introduced in the Lok Sabha is certified or as a money bill. Now take a look at this. This talks about what is known as a finance bill which is certified as a money bill. If you take a look at Article 117 of the Constitution, okay, Article 117 of the Constitution doesn't talk about what are known as finance bills, they talk about what are known as financial bills. Right, if you take a look at this, it talks about Article 117 talks about financial bills, not finance bills. On the other hand, you have finance bill which is given over here. Is certified as a money bill, and therefore we also took a look at Finance Act 2017 yesterday, which was certified as a money bill. So answer is no, there is no article mentioning the finance bill, but this terminology has appeared again and again in the language of the parliamentary affairs, and the Rajya Sabha Secretariat and the Lok Sabha Secretariat, they use the term finance bill very frequently to, in a way, ascertain the bill which is making taxes go from the people of India into the consolidated fund of India. But this one is not a financial bill type A, this is certified as a money bill. So Rajya Sabha has power to recommend amendments in the finance bill. However, it is for the Lok Sabha to accept or reject the recommendations. More than one finance bill, however, be introduced during a financial year. ठीक है? Are we clear about this class? So this is what I want to, in a way, arrive at the end of our long discussion on this part. The question which has been somewhat bothering every person who's appeared for the UPSC last year is the differences between financial bill type A and type B, which I hope that I have clarified to you, both in a simple tabular format and also a schematic understanding of this part is given to you very clearly. Type A financial bill, type B financial bill, right? And if you take a look at, for example, the difference between a finance bill and a financial bill, that also has been in a way communicated to you, that a finance bill talks about putting money into the consolidated fund of India through the budget session, which is certified as a money bill. So every year there is a finance bill. So very simply, if you can take a look at this part, I can just very simply think about Finance Act even of 2024. You'll get a PDF from the government of India. You see, this is the Finance Bill 2024, right? And this is a money bill. You can see, as introduced in the Lok Sabha, like a money bill, it can only be introduced in the Lok Sabha, it cannot be introduced in the Rajya Sabha. And the finance bill talks about the rates of income tax, etc., etc., which have been changed, which basically is what we discussed yesterday, that a finance bill is a bill which is introduced during the budget session to make the proper calibration of the rates of income tax and other taxes to give the money to the consolidated fund of India, right? And therefore it is at this point of time, at this stage, that this kind of a question comes before the UPSC about finance bill and financial bill, etc., etc. So again, you have to be aware of the Finance Act 2017 is going to be asked as a question. It must be kept in mind that Finance Act is not a financial act, and the Finance Act 2017 has been challenged as a money bill, has been passed as a money bill. Therefore, the certification of Finance Act as a money bill itself is the question that is at the center of the 7 judge bench judgment, that can, for example, the RBI, the RPA, the Income Tax Act and the Companies Act be subjected to challenge because they are, what do you say, can be subjected to challenge because they are um, not only dealing with money and therefore don't qualify under the definition of a money bill under Article 110. Right, so class, I've tried my best in the briefest of the time to explain to you this very complicated idea, the differences between a financial bill and a finance bill, and also a, what you can say, you have a very clear understanding of the Constitution Amendment Bill also. Ordinary bill is simple. Ordinary bill can be introduced in the Lok Sabha or the Rajya Sabha, has to be passed by both the Lok Sabha and the Rajya Sabha, but ordinary bill can be subjected to joint sitting. And by a joint sitting, the Rajya Sabha can be overcome, because in joint sitting, what you do is you take majority of the members of the Lok Sabha, but the more populous house is the Lok Sabha, less populous house is the Rajya Sabha. If Rajya Sabha is rejecting your bill, then in that scenario, you can join the two houses and create a total, what you can say, sitting, and then you have to have a simple majority of the members present and voting. Since most number of members in a joint sitting are from the Lok Sabha, therefore the Lok Sabha can overwhelm the Rajya Sabha in a joint sitting. So that way you can also bypass the Rajya Sabha in that particular sense also. Okay, right class, are we clear about this? ठीक है, तो ये थोड़ी टेक्निकल चीज़ें थी जो मैं थोड़ा आज टच करना चाह रहा था, इससे आपके क्वेश्चंस आ रखे हैं पिछली बार में, मतलब 2023 में ही यू हैव वेरी मेनी क्वेश्चंस, बट इवन प्रीवियस टू दैट financial bill type A, financial bill type B, all of these are a very difficult set of things sometimes to deal with. So I wanted to just take a little bit of a quick review of all of these things so that you have a clarity on these parts most specifically. Okay, so a money bill is defined under Article 110 clause 1A to F of the Constitution, which deals only with money. Okay, a financial bill is defined under Article 117 clause 1 as financial bill type A, which deals with money but not only with money. Okay, so the distinction between a money bill and a financial bill is that a money bill deals only with money and a financial bill does not deal only with money, but they deal with money in terms of its excesses, right? Now, once we take a look at the difference between a money bill and a financial bill in terms of definition, the difference between a money bill and a financial bill in terms of a procedure is also there. A money bill is supposed to be only introduced in the Lok Sabha. Once it is passed by the Lok Sabha, the Rajya Sabha does not have any power to fail the money bill. The Rajya Sabha can only make recommendations to the money bill and then pass the recommendations back to the Lok Sabha. And the Lok Sabha is not bound by the recommendations of the Rajya Sabha. The Lok Sabha may accept those recommendations or reject those recommendations, and after the said acceptance or rejection, the money bill can be transmitted, can be sent from the Lok Sabha to the President. Now, in the case of money bill, you know that the President cannot return the bill for reconsideration. So there is no suspensive veto on the President's power of money bill. But in that scenario, the money bill which is taken by the President can be subjected to a pocket veto and it can be granted assent. So that's money bill under Article 110. And please make sure that you understand that a finance bill and a appropriation bill, I'll repeat it again, a finance bill or an appropriation bill are categories of money bills, right? A finance bill is separate from a financial bill. As we have seen, Finance Bill 2024 as introduced in the Lok Sabha was passed as a money bill. And similarly, the question that is arising in the electoral bond scheme is about the Finance Act 2017, which is basically to say the fact that the Finance Act 2017 is what you can call a Finance Act 2017 is what you can call a money bill. But since it is also including, as I was giving you, that फाइनेंस एक्ट तो हर साल पास होता है बजट के साथ, लेकिन फाइनेंस एक्ट 2017 में ना उसके साथ साथ ही आपने छिपा के लगा दी प्रोविजंस, आरबीआई की भी, आईटी की भी, आरपीए की भी, इन सब चीजों को भी आपने पास ऑन कर दिया इलीगली. So it is not the entire Finance Act 2017 which was subject to question, even on the ground that it has been bypassing the Rajya Sabha. It was these provisions of the Finance Act which were taken from the RBI Act, Companies Act, all of these, they were in a way camouflaged within the Finance Act and amended using the money bill route, bypassing the Rajya Sabha. This is what, in a way, becomes the severe constitutional question, right? And that is what basically the idea of how the Finance Act 2017 is, and the Prevention of Money Laundering Act and the Aadhaar Act, all of these questions where the government can camouflage things within the Finance Act or brand them as money bills to bypass the will of the Rajya Sabha. Whereas, as you have clearly mentioned, that in that case it should not be a finance bill, it should be a financial bill. And a financial bill does necessarily need the passage from the Rajya Sabha. It is necessary for the Rajya Sabha to pass the finance bill, a financial bill, as we have seen. It may not be introduced in the Rajya Sabha, but it has to be passed by the Rajya Sabha, right? So that's a distinction I think becomes very important in the light of the previous year question between money bill, finance bill, financial bill type A and type B. And overall, if you understand this, I think you would be able to deal with the multiple choice questions which are coming in this format. Keep an eye open on Finance Act 2017 again, because it's probably one of the biggest legislation which has been struck down as unconstitutional by 5 judges of the Supreme Court. So you are expecting a question on that also slightly, prominently. Then we talk about Financial Bill Type 2, which are given under Article 117 Clause 3. They deal with expenditure out of the Consolidated Fund of India, right? Any money which is being subjected out of the Consolidated Fund of India, that has to be dealt with as a financial bill type 2, and they also need to be passed by the Rajya Sabha, and they also can be introduced in the Rajya Sabha, right? So I hope इस वाली चीज से पूरा आपको समझ में आ गया है. One of your questions is one question I noticed with some distinction is that what you're saying is that whether a private member's bill can introduce a money bill. 100% yes, a private member bill can introduce a money bill. There is nothing in the constitution which bars a private member bill from being a money bill. It is just that a private member cannot introduce a money bill in the Rajya Sabha. Okay, that's the point, because the money bill as it is cannot be introduced in the Rajya Sabha. So there is no bar upon a private member introducing a bill, but it is only a private member should be from the Lok Sabha to be able to introduce a bill like that. He cannot introduce a bill into the Rajya Sabha. So there is no question about the fact that the private member has a possibility and the right to give out a money bill, but only a private member from the Lok Sabha can do it, because a money bill can only be introduced in the Lok Sabha. All right, take a class. I feel we are out of our time for today. Tomorrow I will deal with two important things. One is interim budget. This is a year in which we had an interim budget, so we'll have to take a look at the lingo of the interim budget, the cut motion and the stuck motion and all of these things. थोड़ा सा हम पढ़ेंगे interim budget के बारे में. And then I will take up two judgments of the Supreme Court. One is on the same-sex marriages, and also asking the question whether right to marry is a fundamental right, which is a possible question this time of the entire discussion on right to marry is a fundamental right under Article 19 and under Article 21. We'll take a look at the Hadia case and the Navtej Singh Johar cases of the Supreme Court with regard to homosexuality. And also we will possibly take a look at some important judicial doctrines. Judicial doctrines can be a part of the prelims examination. So doctrine of severability, of eclipse, of pith and substance, of harmonious construction, of colorable legislation, create a table of all the judicial doctrines tomorrow and discuss them one by one. Doctrine of proportionality has been there this time. Doctrine of basic structure, I think all of you understand to some extent, but we'll take a revision of that also. So we'll take a little bit of a look at the judicial doctrines, and also we will try to take a look at a list of amendments made to the constitution, so that for example a question like this you can take a look at. इस तरह के प्रश्न का आप उत्तर दे सकें. Another question which came last time, which was a mind boggler, was question number 34. Which are the following constitutional amendments, etc., etc. तो इस तरह के questions देखने के लिए we'll take a look at the list of constitution amendments also. Okay, so I hope that these sessions are coming in handy for you to develop a better understanding, and I hope that you're taking most amount of notes from these sessions. The videos are available for some time, I'm hoping. So if you feel that you've missed out upon something, re-watch the videos, but be very certain about the fact that the way that we're developing the pedagogy of this course is to make sure that you're not only informed about the topic, but the discussions that are happening in the class, they come up as real questions in the prelims paper this time. That's our objective. Our objective is not only to educate you. At this point of time, education is not enough. We have to anticipate for you the questions that are going to be asked and give you as much information and as much conceptual background to be able to answer those questions once they appear in the prelims paper. And that is why we are focusing upon specifically those items which are heavily in the news for the last 15 months, and then taking a overall perspective on these items properly. So I hope this is helping you out somewhat. Thank you for your time and patience. I will see you tomorrow. Thanks a lot.